for admission.
ಕೊಡಿ ಮೆಮೋಸ್ ಕೊಡಿ. ಅಷ್ಟೇ.
My lord, though they have a sale deed of another survey number, they've given them declaration.
ಆಯ್ತು ಮೇಡಮ್, ಸರ್ವೆ ಮಾಡೋದ್ರಿಂದ ನಿಮ್ಗೆ ಏನ್ ತೊಂದರೆ ಆಗ್ತದೆ?
They're conducting the survey on and mutating the records based on the judgment.
ಎರಡು ಹೇಳ್ತೀರಿ ನೀವು, ಮ್ಯುಟೇಟಿಂಗ್ ಬೇರೆ, ಸರ್ವೇನೇ ಬೇರೆ. ಸರ್ವೆ ಮಾಡೋದೇ ಬೇರೆ, ಮ್ಯುಟೇಷನ್ ಮಾಡೋರೇ ಬೇರೆ.
Consequently.
ಆಯ್ತು ಕೊಡಿ ನೋಡೋಣ ನಮ್ಮ ಬರ್ಲಿ. ಲೆಟ್ ಇಟ್ ಕಮ್ ಇನ್ ಯೂಶುವಲ್ ಕೋರ್ಸ್. ಹೇಳಿ. ವೇಟ್ ಮಾಡ್ಬೇಕು, ಕರ್ಸ್ತೀವಿ ಪೇಜ್ ವೈಸ್. ಯಾವ್ದು ನಾಳೆಗೆಲ್ಲ ಕೊಡಕ್ಕಾಗಲ್ಲ ಮೇಡಮ್.
Friday, my lord.
ನೋ, ಲೆಟ್ ಇಟ್ ಕಮ್ ಯೂಶುವಲ್ ಕೋರ್ಸ್. ಸರ್ವೆ ಮಾಡಿದ್ರೆ ಏನಾಗ್ತದೆ? ಸರ್ವೆ ಮಾಡಿದ್ರೆ ಯಾರ ಪ್ರಾಪರ್ಟಿ ಎಲ್ಲಿದೆ ಅಂತ ಗೊತ್ತಾಗ್ತದೆ ಅಷ್ಟೇ. ಆಯ್ತು ಆಯ್ತು ಇರ್ಲಿ.
Mentioning page number 8, 28 to 31, 32 to 34.
Serial number 34, my lads. ಇದ್ರಲ್ಲಿ ರೆಗ್ಯುಲರ್ ಕೌನ್ಸಿಲ್ ಡೆಲ್ಲಿಲಿ ಇದಾರೆ. ಫ್ಲೈಟ್ಸ್ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಆಗಿ ಬರಕ್ ಆಗ್ತಿಲ್ಲ.
ಅವರಲ್ಲೇ ಇರ್ಲಿ, ನಾನು ಓದಿದೀನಿ. ಐ ವಿಲ್ ಪಾಸ್ ಆರ್ಡರ್ಸ್.
ಇಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಮೈ ಲಾಡ್ಸ್. ಮಂಡೇ
ನೋ ಡೇಟ್. Dismiss, confirm, concurrent finding. I have already read the papers.
ಅಲ್ಲ ರೆಗ್ಯುಲರ್ ಕೌನ್ಸಿಲ್ ಇಲ್ಲ, ಸೊ ಫೈಲ್ ಕೂಡ ಇಲ್ಲ ನನ್ನ ಹತ್ರ.
If no assistance, then I will pass orders.
35 to 44, 45 to 50, 51 to 57, 58 to 60.
68 ಮಲೋ.
ನಾ ಹೇಳಿ ಏನು?
58 and for the respondent.
ಹೌದು.
Additional documents which are to be filed.
ನೋಡಿ, ಇದು ಅಡ್ಮಿಷನ್ ಇದೆ. ರೆಸ್ಪಾಂಡೆಂಟ್ ಏನ್ ರೋಲ್ ಇಲ್ಲ. It is between the appellant counsel and the court. ಗೊತ್ತಾಯ್ತಲ್ಲ? Don't seek any adjournment. I have read the papers. 21 rule 97 application was allowed. Issue delivery warrant ಅಂತ ಆರ್ಡರ್ ಆಗಿದೆ. No adjournment. Yes. ನಿಮ್ಗಳಿಗೆ ಟೈಮ್ ಇಲ್ಲ ಓದಕ್ಕೆ, ನನಗೆ ಟೈಮ್ ಇದೆ.
61 and 62, 63 to 65, 66 to 70.
67 madam. Appear by respondent madam. ಅಂದ್ರೆ ಕಡೆ ಹುಷಾರಿಲ್ಲ ಅವರಿಗೆ, ಅಡ್ವೊಕೇಟ್ ಇದೆ.
ಯಾರು ಹುಷಾರಿಲ್ಲ?
ಡಿಪಿ ಮಹೇಶ್. ಟುಮಾರೋ ಆಯ್ಕೊಂಡು ನಾನು ನಾಳೆಗೂ ರೆಡಿ ಇದೀನಿ ಸರ್.
ಹೇಳಿದಿರಾ ಅವರಿಗೆ ಅದರ್ ಸೈಡ್ ಗೆ?
ಬೆಳಿಗ್ಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೆ, ನಾಳೆಗೆ ಬೇಕಾದ್ರೆ ರೆಡಿ ಇದೀನಿ ಸರ್.
Appear for the appellant my lord in 67 my lord. ಅವರು 6 months the time ತಗೋತಿದ್ದಾರೆ. ನಾಳೆಗೆ ಹಾಕೊಂಡ್ರೆ I am ready for the adjournment.
ಇವತ್ತು ಒಂದು ದಿವಸ ಮೇಡಮ್, ನಾಳೆಗೆ ಹಾಕೊಂಡ್ರೆ ಮೈಲ್
ನೋಡೋಣ ರೀಚ್ ಆಗುತ್ತಾ ಇಲ್ಲ ನೋಡೋಣ, ಆಮೇಲೆ ನೋಡ್ರಿ. ಆಯ್ತು, ನೆಕ್ಸ್ಟ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್.
71 and 72, 73 to 76.
73 my lord.
70
ಆಶಾ ಜೋಶಿ ಅವ್ರ ವೈಫ್ ಗೆ ಸಮಯ ಆಪರೇಷನ್. 73 ಸರ್.
3
ಹೌದು.
ನೀವು ಯಾರಿಗೆ?
ರೆಸ್ಪಾಂಡೆಂಟ್.
ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಹೇಳಿದೀರಾ?
ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ತೀನಿ ಸರ್.
ಮಾಡಿಬಿಟ್ಟು ಮೆನ್ಷನ್ ಮಾಡಿ.
ಮಾಡ್ತೀನಿ ಸರ್. ಅವ್ರ ವೈಫ್
ಮಾಡ್ತೀನಿ ಬೇಡ, ಮಾಡಿಬಿಟ್ಟು ಮೆನ್ಷನ್ ಮಾಡಿ. ನೆಕ್ಸ್ಟ್ 230 ಮ್ಯಾಟರ್ ಇದೆಯಾ? ಆಯ್ತು.
Orders matter seal number 1, Maruti GP.
Awaiting service of notice. 812 ಇಶ್ಯೂ ಆಗಿದೆಯಾ? ಹೇಳಿ ಏನು?
ಅದರಲ್ಲಿ the contesting respondent is first respondent.
ಹೌದು.
Malords, before the learned trial judge, malords, they have been placed ex parte. They are none other than my vendors. Concurrent finding.
ಈಗ ನೋಟಿಸ್ ಹೋಗಿದೆಯಲ್ಲ, ನೋಟಿಸ್ ಹೋಗಿದೆಯಲ್ಲ, ಅವೈಟ್ ಅಂತಿದೆ, ಬರ್ಬೇಕಲ್ಲ. ಸರಿ, 812 ಹೋಗಿರೋದ ಮೇಡಮ್? ತಗೊಳ್ಳಿ. 9-1 await notice 9/1/26.
Serial number 2, Patabi Raman C.
And for the appellant my lord.
Yes madam, notice to
time to take
3.
steps to the LR. Steps for this one.
Why you have not paid the PF madam?
I'll pay it.
First you pay, then I will pass order. Otherwise I will dismiss the RSA. First time once you notice PF ಕೊಟ್ಟಿಲ್ಲ.
A week's time may be taken.
12/11/25 order.
ಇವಾಗಲೇ ತಗೊಳ್ತೀನಿ ಸರ್.
ಕೊಡಿ
week's time may be
pass over time ಕೊಡೋದಿಲ್ಲ.
ಅಲ್ಲ ಸ್ವಾಮಿ, a week's time may be taken.
ಪಾಸ್ ಓವರ್ PF ಕೊಡಿ, ಆಮೇಲೆ ಮಾತ್ರ ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡ್ತೀನಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೀನಿ. ಇವತ್ತು ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡಿದ್ರು ಕೊಡಲ್ಲ, ಏನ್ ಮಾಡ್ಬೇಕು? RSA ನಲ್ಲಿ ಫಸ್ಟ್ ಆಫ್ ಆಲ್ ನೋಟಿಸ್ ಆಗದೆ ದೊಡ್ಡ ಇಶ್ಯೂ RSA ನಲ್ಲಿ. PF ಕೊಡಿ ಫಸ್ಟ್. ನೆಕ್ಸ್ಟ್
serial number 3
awaiting
sir 312 ಹೋಗಿರೋದು.
312 61 await notice of 61
4 Raja N.
issue notice to R7 to R10 for second time.
Second, 1 week.
1 week time granted to pay PF. If PF paid, issue notice to R1 to 7 R7 to 10.
10.
R11.
Sufficiency refused. Notice issued against R11 was returned with an endorsement refused and hence sufficient against R11.
Much.
Connected allo same
Same. Same response.
both common order ಮಾಡಿ madam.
serial number 5
ನರಸಿಂಹರಾಜು ಹೇಳ್ರಿ.
I have made ready of the,
2 sets of IA ಅದೆಲ್ಲ
I'll file it in the registry. I have made ready of the memo, madam.
PF ಕೊಟ್ಟಿದ್ದಾರೆ ಅದ್ರಲ್ಲಿ ಡೆಫಿಸಿಟ್ ಇದೆ.
ಆಯ್ತು ಅದನ್ನೇನಾ
ಅದರಲ್ಲಿ ಕಾಪೀಸ್ ಹೌದು ಸರ್ ಕಾಪೀಸ್ ಕೊಡ್ಬೇಕು.
ಈಗ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾ?
Please, madam.
ನೋಟಿಸ್ ಆರ್ಡರ್
ಆಯ್ತು.
ಆಗಿದೆ ಸರ್.
ಆಗಿದೆ. ಯಾವ ಕೊಡ್ತೀರಾ?
I will file it in the registry, madam. I have made
Counsel
ready.
submits that going to comply the office objection today itself. If complied, issue notice as ordered earlier. Returnable by
15/1
15/1 Raja madam. Sankranti sari.
ಸರ್ 19/1
19/1/26.
Obliged, madam.
serial number 6
PF ಕೊಟ್ಟಿದ್ದೀನಿ ನಿಮ್ಮಲ್ಲಿ.
ಸರ್ ಇದರಲ್ಲೂ ಅಷ್ಟೇ ಅವರು 5 sets of IS
Yes,
ಕೊಡ್ಬೇಕು.
one furnish madam. Tomorrow I will furnish.
ಈಗೇನ್ ಕೊಡ್ತೀರಾ ಏನು?
ಕೊಡ್ತೀನಿ sir.
ಇವತ್ತೇ ಕೊಡಿ. Counsel submits that. First time.
First. Yesterday also.
ಯಾರು ಸತ್ತೋಗಿದ್ದಾರೆ? 8 appellant number 2.
Yes madam. Application is filed.
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆ ನೋಡಿ ಕಂಪ್ಲೈ ಮಾಡಿ ತಗೊಳ್ಳಿ.
1 week's time.
ಅದಕ್ಕೆ ಕೊಡೋಣ 1 week ಟೈಮ್. ಬಟ್ ಇದಕ್ಕೆ PF ಕೊಡಿ.
Tomorrow.
ಫಸ್ಟ್ ಟೈಮ್ ಬಂದಿರೋದು.
Yes, madam.
ಟುಮಾರೋ ಇಲ್ಲ ಯಾವ್ದು ಇಲ್ಲ.
Today only.
ಪಾಸ್ ಓವರ್ ನೋಟಿಸ್ ಆದ್ರೂ PF ಕೊಡಲ್ಲ.
PF ಕೊಟ್ಟಿದ್ದೀನಿ sir. Only IA copy system.
ಕೊಡಿ ಅದನ್ನೇ ಫರ್ನಿಶ್ ಮಾಡಿ.
ಆಯ್ತು.
7
ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಅಕ್ನಾನ್ಮೆಂಟ್ ಫಾರ್ ಹ್ಯಾವಿಂಗ್ ಪೇಡ್ ಕಾಸ್ಟ್ ಆಫ್ ₹500 ಟು ದಿ ರಿಜಿಸ್ಟ್ರಿ.
Needful done.
ಏನ್ ನೀಡ್ಫುಲ್ ಡನ್? ಬರೀ ಕಾಸ್ಟ್ ಕಟ್ಟಿದ್ ಮಾತ್ರನಾ ಅಥವಾ ಕಂಪ್ಲೈಂಟ್ ಮಾಡಿದೀರಾ?
ಕಂಪ್ಲೈ ಮಾಡಿದ್ವಿ ಸರ್.
ಮಾಡಿದಿರಿ. ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ CC ಆಫ್ OS ಜಡ್ಜ್ಮೆಂಟ್ ಅಂತಿದೆ. ಯಾವಾಗ ಕೊಟ್ಟಿದ್ದೀರಿ?
ಟುಡೇ ಮಾರ್ನಿಂಗ್
ಕೊಟ್ರಾ?
ಕೊಟ್ಟಿದ್ವಿ.
Counsel submits that he has paid the cost and also furnished the CC of OS judgment.
Yes, sir.
And then list the matter for admission immediately after winter vacation.
My lord, any date in the next week, my lord?
Next week ಯಾವುದು ಡೇಟ್ ಇಲ್ಲ ಅಡ್ಮಿಷನ್ಸ್ ಗೆ. ಈಗ ಆಲ್ರೆಡಿ ಹಾಕ್ಬಿಟ್ಟಿದೀವಿ. ನೆಕ್ಸ್ಟ್
Great.
number 8
non furnishing of PF
My lord,
issue notice to respondents for first time.
I'm searching out for the correct addresses. They have changed it to some addresses. That's
Note
why.
counsel first time ಆರ್ಡರ್ ಆಗಿರೋದು ಚೇಂಜ್ ಆಫ್ ಅಡ್ರೆಸ್ ಪ್ರಶ್ನೆ ಬರೋದೇ ಇಲ್ಲ. ಡೋಂಟ್ ಮೇಕ್ ಫಾಲ್ಸ್ ಸಬ್ಮಿಷನ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್.
ಇಲ್ಲ sir.
ಫಸ್ಟ್ ಟೈಮ್ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿರೋದು. ನೀವೇನು ಈಗ ಸರ್ಚ್ ಮಾಡೋದು? ಹೋಗ್ ಬಂದು ಕರೆಕ್ಟ್ ಅಡ್ರೆಸ್ ಇಲ್ಲ ಅಂತ ವಾಪಸ್ ಬಂದ್ರೆ ಪರವಾಗಿಲ್ಲ.
ಅವರೆಲ್ಲ ಬ್ರದರ್ಸ್ ಅಲ್ಲ
ಮತ್ತೆ?
sir, ಅದಕ್ಕೋಸ್ಕರ.
ಕೊಡಿ PF ಕೊಡಿ, ಇಲ್ಲ ಡಿಸ್ಮಿಸ್ ಮಾಡೋಣ RSA.
ಇಲ್ಲ ಸರ್, ಇವತ್ತೇ ಕೊಡ್ತೀನಿ sir.
ಡೋಂಟ್ ಟ್ರೈ ಟು ಮಿಸ್ಲೀಡ್ ದಿ ಕೋರ್ಟ್. ಪಾಸ್ ಓವರ್ ಒಂದ್ಸರ್ಲು PF ಕೊಟ್ಟಿಲ್ಲ, ಏನ್ ಕರೆಕ್ಟ್ ಅಡ್ರೆಸ್ ಹುಡುಕ್ತೀರಿ? ನೆಕ್ಸ್ಟ್
serial number 9 N Suresh
awaiting service of notice in respect of R2 R6 to 8. ಯಾವಾಗ ಹೋಗಿದೆ ಮೇಡಮ್?
8/12 ಹೋಗಿದೆ ಸರ್.
8/12 9/1
Dismissal, my name is N Suresh ಅಂತ ಬರ್ತದೆ. ಸುರೇಶ್ ಎಸ್ ಅಂತ
ಆಗಿದೆ. ತಪ್ಪಾಗಿದೆಯಾ?
ತಪ್ಪಾಗಿದೆ. N Suresh ಅಂತ ಬರ್ತಾ ಇದೆ.
ಕರೆಕ್ಟ್ ಮಾಡೋಣ.
ಸುರೇಶ್ ಎಸ್ ಅಂತ.
ಆಯ್ತು. Await notice of respondents. This matter on 9/1/26.
ಸರ್ ಅದು
Counsel appearing for the appellant would submit that the name initial wrongly mentioned as S Suresh. ಹೌದಲ್ಲ? ಸುರೇಶ್ S.
ಸುರೇಶ್ ಎಸ್ ಅಂತ.
But correct name is Suresh.
ಸುರೇಶ್ ಎಸ್ ಅಂತ ಆಗ್ಬೇಕು. ಸುಮ್ಮನೆ ಎನ್ ಸುರೇಶ್ ಅಂತ ಬಂದಿದೆ.
ಸುರೇಶ್ S ಇದೆಯಲ್ರಿ? S ಇದೆಯಲ್ಲ? ಸೀರಿಯಲ್ ನಂಬರ್ 9 ತಾನೆ?
ಹೌದು ಸುರೇಶ್.
ಮತ್ ಸುರೇಶ್ S ಅಲ್ವಾ ಇರೋದು?
ಸಾರಿ.
ಸರ್ ಎಸ್
ನಾನೇ ಕನ್ನಡಕ ಹಾಕೊಂಡಿದ್ದೇನ್ರಿ, ನೀವೇನು ಕನ್ನಡಕ ಹಾಕೊಂಡಿಲ್ಲ? ಕರೆಕ್ಟ್ ಆಗಿದೆ, ಅದ್ರದ್ದೇನಿಲ್ಲ. ಇನ್ನೇನ್ ಮೇಡಮ್?
5 ರೆಫ್ಯೂಸ್ ಆಗಿದೆ ಸರ್.
4 and 5 refused. Though notice issued against R4 and R5 returned with an endorsement refused and hence held sufficient against R4 and R5. Next
serial number 10
ಯಾವಾಗ ಹೋಗಿದೆ ನೋಟಿಸು?
ಅದು 8/12 ಹೋಗಿರೋದು.
8/12 9/1 await notice.
Much obliged.
ಕನೆಕ್ಟೆಡ್ ಅಲ್ಲಿ ಸರ್ ಕನೆಕ್ಟೆಡ್ ಅಲ್ಲಿ
Connected
ಕಂಪ್ಲೇಂಟ್
madam, 1 second.
In this case, I am appearing for
ಯಾರು?
appellant.
ನಾರಾಯಣ
Already
ಯಾರು?
complied and
ನಾರಾಯಣ್ ನೀವಾ?
comply ಮಾಡಿದ್ದೀನಿ sir.
ಯಾವಾಗ?
5/11.
5/11 ಕಂಪ್ಲೈ ಆದ್ರೆ ಮತ್ತೆ ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಅಂತ ಬರ್ತದೆ.
ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ ಸರ್.
ಅದ್ರ 3 ಅಬ್ಜೆಕ್ಷನ್
court fee paid on the provisions of all three courts. Ink page number 15, my lord. Already for typed cup. Ink page number 15.
ಕೊಡ್ರಿ ಅದೇನ್ ಮೂರಿದೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್. Court fee paid, ಹಾ.
Court fee provision, the court fee paid and court fee provision of all three courts is stated correctly at valuation.
ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಅಲ್ಲಿ ಹೇಳಿಲ್ಲ ಅಂತಲ್ಲ ನೀವು?
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನ್ ಹಾಕಿದಾರೆ ಅದನ್ನ ಹಾಕಿದೀನಿ.
ಅದ್ ಹೇಳಿಲ್ಲ ಅಂತ ಬರ್ದವ್ರ ಆಫೀಸ್
ಅಲ್ಲ, ಹಾಕಿ.
ನೀವು ಕಂಪ್ಲೇಂಟ್
Ink page number 15
ಮಾಡಿದೀನಿ
ಮೇಲೆ.
ಎಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿಲ್ಲ ನೀವು? ನೆಕ್ಸ್ಟ್
ಅಲ್ಲ, ಇಂಕ್ ಪೇಜ್ ನಂಬರ್ 15 ಮೇಲೆ.
ಇಂಕ್ ಪೇಜ್ ನಂಬರ್ 15 ಕೊಡ್ರಿ ನೋಡ್. ಏನ್ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಸ್ಲಿಪ್?
ಹೌದು ಸರ್, ಡೀಟೇಲ್ಡ್ ವ್ಯಾಲ್ಯೂಯೇಷನ್.
ಎಲ್ಲ ಪ್ರೊವಿಷನ್ಸ್ ಹಾಕಿದಾರಲ್ಲ ಮೇಡಮ್, 24B 7B ಎಲ್ಲ ಇದೆಯಲ್ಲ ಮೇಡಮ್ ಇದರಲ್ಲಿ. ಸಪರೇಟ್ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಸ್ಲಿಪ್ ಇದೆ, ಸಪರೇಟ್ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಸ್ಲಿಪ್ ಹಾಕಿದಾರೆ ಅವರು. ಅವ್ರ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಸ್ಲಿಪ್ ಸರಿ ಇಲ್ಲ ಅಂತನಾ ಅಥವಾ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಮೋಸ್ಟ್ ಇಲ್ಲಿದೆ ನೋಡಿ, ಇಲ್ಲಿದೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ನಿಮ್ ಪ್ಯಾರಾ 7 ಅಲ್ಲಿ.
ಅದರಲ್ಲಿ ಬರೆಯಕ್ಕಾಗಲ್ಲ ಅಂದ್ಬಿಟ್ಟು
ಎಲ್ಲ ಬರ್ದಿದ್ದೀರಿ, ಎಲ್ಲ 7 ತೋರಿಸಿದಿರಿ, ಅದಕ್ಕೆ ರೌಂಡ್ ಅಪ್ ಮಾಡಿದಾರೆ ನೋಡಿ.
ಆಯ್ತು ಸ್ವಾಮಿ.
ಮತ್ ನೀವು ನೋಡೋದಿಲ್ಲ, ಬಂದಿಲ್ಲ, ಮಾಡಿದೀನಿ ಅಂತೀರಿ.
ಅಲ್ಲ, ಡೀಟೇಲ್ಡ್ ವ್ಯಾಲ್ಯೂಯೇಷನ್.
ಡೋಂಟ್ ವೇಸ್ಟ್ ದಿ ಟೈಮ್ ಆಫ್ ದಿ ಕೋರ್ಟ್. ಹಾ,
2 days ಟೈಮ್
ಇನ್ನು 3 ಇದೆ. ತೊಗೊಳ್ಳಿ, ಕಾಸ್ಟ್ ಹಾಕಿದೀವ ನೋಡಿ, 5ನೇ ಸರಿ ಬಂದಿರೋದು. 3 ಸರಿ ಎಕ್ಸಾಮ್ಷನ್, 4ನೇ ಸರಿಯಿಂದ ಕಾಸ್ಟ್ ಸ್ಟಾರ್ಟ್.
ಇಲ್ಲ, ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾರೆ ಕೋರ್ಟ್ ಮುಂದೆ.
ಕೋರ್ಟ್ ಮುಂದೆ ಫಸ್ಟ್ ಟೈಮ್, ರಿಜಿಸ್ಟ್ರಾರ್ ಮುಂದೆ ಎಷ್ಟು ಸರಿ? ರಿಜಿಸ್ಟ್ರಾರ್ಗೆ ಏನ್ ಬೆಲೆ ಇಲ್ವಾ?
ಅಲ್ಲ,
ಕೋರ್ಟ್ನವ್ರಿಗೆ ಮಾತ್ರ ಬೆಲೆನಾ?
ಸಾರಿ ಮೇಲೆ.
ಮತ್ತೆ 1 2 3 4 5 ಇದು 6ನೇ ಸರಿ ಕೋರ್ಟ್ ಮುಂದೆ ಕಂಪ್ಲೈನ್ಸ್ಗೆ. ತೊಗೊಳ್ಳಿ, on cost of rupees 1000, another 1 week time. 1 week ಬೇಕಾ 2 ವಾರ ಬೇಕಾ?
2 ವಾರ.
2 weeks time granted to comply with office objections. If cost not paid and not complied with office objection, appeal will be dismissed in the next date of hearing. List this matter immediately after winter vacation.
11.
ಅದು ಮೇಡಮ್ ಇನ್ನ RSA 41 of 25 ಅಲ್ಲಿ ಅದು. Next
11 is await notice.
awaiting of service of notice. ಯಾವಾಗ ಹೋಗಿದೆ ಮೇಡಮ್?
8/11 ಹೋಗಿದೆ.
28/11 6/1 await.
Skill number 12.
SV Prakash. Notice to R3 to R5 second time, weeks time granted to take steps against R3 to R5. If we have paid within 1 week, issue notice. If not paid, list the matter immediately after winter vacation.
Hearing on IA 13.
Karan Joseph and Arjun Rao.
I appear for the petitioners.
Pleading as R17 filed by counsel for impleading applicant. ಅವರೇ ಹಾಕೊಂಡ್ರದ?
ನಾವು ಹಾಕಿದೀವಿ.
ನೀವೇ ಹಾಕೊಂಡಿದ್ದೀರಿ. ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದಿರಾ?
ಎಲ್ಲ ಅವಲ್ಲೇ ಆಗಿದೆ.
Please,
application file ಮಾಡಿದಾರೆ ಅವರು. We have filed the rejoinder also.
Pleadings are complete in respect of the impleading IA, my lords. There's an element of settlement involved in the matter. If it may be had after vacation, we'll report finally the outcome, my lords.
Your Lordship, that is our instruction as well, Your Lordship. I appear for respondent 1, 3 to 10, 12 and 15, Your Lordship. That is the instruction we've been given as well, that settlement talks are underway.
Petitioner counsel and also the counsel appearing for the respond number 1 to
1, 3 to 10.
1, 3 to 10.
12, 13 and 15, Your Lordship.
12.
13 and 15, Your Lordship.
13 and 15 submits that there is an element of settlement. And hence list the matter immediately after winter vacation.
Grateful, ma'am.
Grateful.
14.
I appear for the.
Recall the order dated 9/7/24 filed by the counsel for petitioner. What is that order?
The order was dismissing the probate petition itself for alleged defaults on the part of the petitioner.
Lord, counsel for the petition submit that issuance of paper publication may be postponed and the said request cannot be considered since an order was passed on 29/23. In spite of this court directing to produce the original will void order dated 9/12/22 to keep the same in safe custody, the same has not been produced. Hence, it appears that the petitioner is not interested in pursuing the matter. Yes. Why it has to be recalled?
The objections were to be filed today, they have not been filed.
I have filed NOC wakalas for 4th respondent, my lords. I have filed NOC wakalas for the 4th respondent.
NOC wakalat.
Please, my lord. The previous advocate,
Who took time to filing of objections?
my lord, the previous advocate had taken time to file objections to this.
Previous advocate appearing for R4 only?
Please, please.
Then why you have not filed objections? Once you come on record,
Today I have come on record, my lords.
you want time?
2 days time may be given, my lords.
R4 counsel seeks 2 days time to file objections and hence list this matter. Next week, other, next take other date code. 18/12.
That's all.
15.
Kurumbaya, ಹೇಳ್ರಿ. Serial number 15. Kurumbaya TA.
I appear for the appellant.
Impleading the applicant as additional respond number R10 filed by advocate Satish.
15, my lord.
Who filed application?
My submission is this, my lord. The appeals are not maintainable. They are sought for leave. They are all subsequent purchases after, in spite of the stay, they go ahead and purchase the property. And they go on converting 2 quintals of land to the deputy commissioner. And they want to come and implead belatedly after almost nearly a year. And what is the locus standi to file an appeal, my lord? And also, one of the appellants has filed the suit.
Now, IA 1/25 filed by whom?
Satish.
Satish. Where is that Satish? You are appearing for Satish?
I have filed my original appeal is not maintainable, my lord. And is covered by judgment of the Supreme Court also.
Lord, I have a judgment by the Supreme Court, my lord.
Para 57.
He's asking.
No, regarding impleading, my lord, in the suit where leave is being sought to file the appeal, my lords, how can he get impleaded himself?
57.
Page 50,
This
para
appeal
57, my
is
lords.
filed by whom? Who is not a party to the party?
Both the
Yes.
suits.
I have filed my
But this
objections
Suit
also.
and appeal, they are not party.
Not
They
the
are
parties.
subsequent purchases.
Subsequent purchaser. On
Purchaser, they
on
are.
what
they
on what
admitting
date
their
it was purchased?
Supreme Court has made very clear, my lord, those
Lord, the
people are not
appellant
under for
one-
leave.
Hmm?
The appellants are under for leave, how can he
With
implead
regard
this
to the
appeal?
fact that respond number 1 and 2 respectively purchased the suit property during the pendency of the suit instituted for specific performance. And that too,
Lord, they are.
by
they are
the injunction
purchaser-
against the
They
original
purchased in
owner
the substance of the suit.
was operating. The respond number 1 and 2 respectively could not be said to have been made out any ground case for grant of leave to appeal. Yes, madam.
My lord, their suit for partition was dismissed. Their RA was allowed, my lord. The appellants, we are the bona fide purchasers of
But
small.
their contention is when there was an order not to alienate the property, at that time you have purchased the property.
We were not aware of it, my lord.
There was an order not to alienate,
We only got to know about it in 2021, my lord.
but there was an order not to alienate.
I am not aware of
In fact,
this.
my lord, some of the purchases of this scheduled property, my lord, they are the defendants in one of the suit filed by the respondents, my lord, for
Yes,
injunction.
I have filed a suit against all of them in 2017. They have appeared. They can defend them, evaluate them. How can they file an appeal here, my lords? If the decree, partition decree is not binding on them, they should seek a declaration. But they want to file an appeal, and I already filed a suit against them in 2017 in 550 of 2017.
Against them also a
Yes,
suit?
they are defendants there.
Some of
Defendants.
the appellants
Yes.
are the defendants in.
They are
in the
defendants in
suit,
that suit. They come and file an appeal here.
Was there any order, was there any interim order in that case? No. But
In that suit also it is there. Partition suit it was there.
my question is, was there any interim order against them?
In the partition suit it was there, my lord. That they violate.
In a partition suit, they are not the party.
Yes, partition was during pendency of the partition, it was an interim order. They purchased the property. I have given complaint to the deputy commissioner, to the assistant commissioner with full knowledge.
But interim order, whether they are having knowledge,
In the suit, the partition suit was interim order, my lord. The suit has been decreed.
that is against whom? Only the against defendants, not against them. That is their contention. They are
Yes,
not,
550 of 17.
they are not.
No,
they are-
in this suit, no interim order.
What now they say is,
In
they were not
550 of
having,
2017, my lords, there is no.
they were
interim
not
order.
having any knowledge about the interim order in the suit for partition. When they have purchased the property,
Yes, during pendency of the suit, they have purchased the property.
but they are not parties.
In both the suit and the
That
appeal,
is,
my lord.
please,
Both the suit,
And the appeal, we were not made as parties.
they had knowledge. They had knowledge.
What is the material? This judgment only applicable
No,
if they are having the
questioning
knowledge.
that matter, I filed a writ petition also in 14424 of 25. It is pending.
Whether they are parties?
Yeah, I have made them a party there.
My lord, kindly look at my judgment, my lord.
And I have produced series of complaints that don't purchase the property. In spite of they go and purchase the property.
But you can take an action against the person who have sold the property in violation of the order passed in the trial court.
I'll place
But
that
here,
also. my
here
lord.
is a case, according to them, they are the bona fide purchasers. They were
place-
not having any knowledge.
I'll place that order also. They had knowledge. And please, my lord, I have produced all the records in my writ petition. In spite of complaints, my lord, in fact, the suit filing against them, they go and purchase the property. And now what they do is they go and enter into 2 guntas conversion order from the deputy commissioner. They want to put up construction. And 8th appellant has already filed one more fresh suit in OS number 88, 89 of 25. She files one more suit against me.
Counsel, you are not answering to court question.
The 8th appellant files one more suit after this application.
Whatever it may be, but their contention is that they were not aware of any stay. But whatever any violation by the defendants in a suit for partition, you can file an application under 39 rule 2A.
No,
and
that is
pursue
the reason I
remedy.
pass on.
But they are the bona fide purchasers. How can you prevent them?
Your lordship, I kindly turn to para 56 and 57 of the
57
judgment.
only
what
I
I-
read. 57 only I
Seven.
read. But they are not aware of the order. They are not parties.
I'll read this under having regard to the fact respondent to respective purchase property pending with the suit instead for specific
Gunjal.
that too, while injunction of the origin.
They were not parties. They were not aware of it. They have purchased it. They are the bona
My
fide
submission
purchasers.
is the no knowledge is not correct, my lord. They had knowledge.
Then what is the material you place? before the
I
court?
please, my lord. 1 minute. Not only that, 1 minute, I'll just show you. My client has put a photograph also there on the plot.
Whether this court can
Yes, I
examine.
got some more
whether
photographs.
This court can examine.
Recently, I got one
on-
more photograph.
On what date this photo was put? Maybe
No, no.
yesterday they put the photo and even,
please, my lord. No, no,
even
ಇಲ್ಲ, ಹೇಳ್ತೀನಿ. I'll show that one.
it appears yesterday only taken the
No,
photo.
that is the reason, my lord. Please, ಅದೇ ನೋಡ್ತಾ ಇದ್ದೀನಿ 2-3 ಫೋಟೋಸ್ ಕಳಿಸಿದ್ದಾರೆ.
It appears dug the mud
ನೋಡ್ತಾ
yesterday.
ಇದ್ದೀನಿ. ಬೆಳಿಗ್ಗೆ ತಂದ್ಕೊಟ್ರು.
ಅಲ್ಲ, it appears dug the mud yesterday and
No. But what?
And
You're
put-
not-
put
no,
the
no,
board.
That's the reason, my lord. ಅಲ್ಲ,
date
I
of
got, it doesn't have the date.
date of entry ಮಾಡ್ರಿ ಯಾವಾಗ?
I'll check up, my lord. So, in the meanwhile, may I should,
ಆಯ್ತು,
this
ನೋಡಿ.
is,
The council
right,
appearing
no,
for
right
the
from 2021,
council
2022, I have
appearing-
given number of complaints.
heard the both counsel and counsel appearing for the respondent Vardhaman Gunjal Eharigiru R124
I'll produce it, my lord.
relies upon the judgment of the apex court in civil appeal number 1180 of 1181 of 2025 dated 29 January 25 and brought to notice of this court paragraph number 57. The counsel appearing for the appellant would rely upon the judgment of 2007 within bracket 10 Supreme Court cases 719. The counsel appearing for the respondent 1 to 4 would submit that even before purchasing of the property, they had the knowledge. Hence directed to place on record the material that the present applicant having the knowledge about the interim order. Hence list this matter immediately after winter vacation.
My lord, that IA may be allowed, my lord.
Which
because
IA, madam?
That IA 1/25 because they are also subsequent purchases, my lord.
Madam, that is now the issue is with regard to that only. Now their contention is that
We were aware of it.
there was an interim order. Even in spite of having the knowledge you have purchased this property, that is their case. That's why I directed them to place on record that they were having the knowledge. Then only IA will be considered.
16.
In filing,
Filing.
post the matter immediately after vacation for admission
17.
along with IA.
16 ಅಲ್ಲಿ
16th
ಸೆಟ್ಲ್ ಆಗಿದೆ ಸರ್, ಮ್ಯಾಟರ್ ಸೆಟ್ಲ್ ಆಗಿದೆ.
16th matter I am.
16 ಈಗ ಮಾಡಿದ್ರು.
ಅಲ್ಲ ಸೆಟ್ಲ್ ಆಗಿದೆ.
ಹೇಳಿ ಮತ್ತೇನು?
ಅಪಲೆಂಟ್ ಅವ್ರಿಗೇನೋ ಹುಷಾರಿಲ್ಲ ಅಂತ ಹೇಳಿ ಬರಕ್ಕಾಗಿದೆ.
ಆಯ್ತು, ಯಾವತ್ತು ಹುಷಾರಾಗ್ತಾರೆ?
18th.
Both counsel submits that matter is settled and going to.
Provided, my lords, I had
the
given
settlement.
my compromise petition. He said I am okay with that. If that is there, then the compromise will be done on the 18th.
Compromise?
Will be done on that date.
ಅದೇ ಅವತ್ತ 18th ಹಾಕಿದೀವಿ.
ಅಲ್ಲ, compromise petition ಇದೆಲ್ಲ, what I gave to them has to be accepted, and they said they have accepted. Tomorrow they should not change that version and then file the compromise petition.
ಸರಿ ರೀ, ಮತ್ ನಾನು ಈಗ ರೆಕಾರ್ಡ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ನಿಮ್ ಕಾಂಪ್ರಮೈಸ್
ಮಾಡಿ
18th ಗೆ ಹಾಕಿದ್ದೇನೆ.
ಅದೇ both
ನೋ ಚೇಂಜ್ ಆಫ್ ವರ್ಷನ್ ತಾನೆ?
ಇಲ್ಲ, ಏನ್ ಚೇಂಜ್ ಇಲ್ಲ ಸರ್.
ಚೇಂಜ್ ಏನಿಲ್ಲ.
ಅಷ್ಟಿದ್ರೆ ಸಾಕು ಅಂತ ಮುಂದೆ ಹೇಳಿದ್ರೆ ಸಾಕು.
Now you want an assurance.
Because what happens now, they have no right in this matters. In spite of it, they have
ಮಂಡ್ಯ ಹಾಕ್ಲಾ ಜಾಸ್ತಿ ದಿವಸ ಆದ್ರೆ ಇನ್ ಮೈಂಡ್ ಚೇಂಜ್ ಆಗೋದಿಲ್ಲ.
ರೆಸ್ಪಾಂಡೆಂಟ್ ಮಗನ್ ಮದುವೆ ಇದೆ.
17th there are number of other
15th.
15th also.
Working 15th.
ಅಲ್ಲ ಸರ್, 14th ರೆಸ್ಪಾಂಡೆಂಟ್ ಮಗನ್ ಮದುವೆ ಇದೆ.
ಆಯ್ತು ಆಯ್ತು.
18th will close this.
ಆಯ್ತು 18th.
Meantime, that
Both
condemnation
counsel submit that already matter is settled and going to report the settlement, and hence list this matter on 18th.
17 CM Nagabhushana.
Respondent number 7, my lord.
Yes, counsel.
IA number 125, 123, my lord, are failed to bring LRs of appellant number 1.
Appellant. Right. Heard on IA number. Any dispute regarding relationship, counsel?
Number 5. My lord, copy has not been served, my lord.
ಕಾಪೀಸ್ ಕೊಟ್ಟಿಲ್ಲೇನ್ರಿ ಅವರಿಗೆ? ಯಾರ್ಯಾರನ್ನ ಎಲ್ಲಾರನ್ನ ತರ್ತಾ ಇದೀರಿ ಅಂತ ಕೊಡಿ ಅವರಿಗೆ. ಎಲ್ಲಾರ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತಿರಿ, ಕಾಪೀಸ್ ಸರ್ವ್ ಮಾಡಲ್ಲ.
ಜಾಸ್ತಿ ಜನ ಅಡ್ವೊಕೇಟ್ಸ್.
5 ಏನೋ 2 3
ಸರ್, ಅದು R1 ಸತ್ತೋಗಿದ್ದಾರೆ.
R1 and R7, my lord. ಚೌಡಾರೆಡ್ಡಿ ಫಾರ್ R1 and R7, my lord.
R1 ಸತ್ತೋಗವ್ರ? R1 ಗಾರ್ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು.
R1 ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು. ಅಪಲೆಂಟ್ ನಂಬರ್ 5 ಗೆ
ಅಪಲೆಂಟ್ಸ್ ಗೆ ನೋಟಿಸ್ ಏನ್ ನಾಟ್ ನೆಸೆಸರಿ.
ಅಪಲೆಂಟ್ ನೋಟಿಸ್.
ಅಪಲೆಂಟ್ ನೀವು ಕೊಡಿ ಅವರಿಗೆ. ನೋಡಿದ್ರಿ ಡೌಟ್ಸ್ ಏನಾರು ಇದೆ ಹೇಳಿ. Heard on IA number 1 of 25 and there is a delay of 497 days in filing LR application. And IA number 2 of 25 prayer is sought to set aside the abatement. And IA number 3 of 25 for bringing LRs of deceased A5 on record as A5 A to E. And copies are also served on the other side, and other side are not objected for the same. And for the reason stated in the accompanying application, the affidavit delay of 497 is condoned and abatement is set aside and permitted to bring LRs of appellant number 5 on record as A5 A to E. The appellant counsel is directed to amend the cast title and file amended cast title. Issue notice against the LRs of R1 on IA number 4 of 25, 5 of 25, 6 of 25, returnable by date code 19/1. Immediate code PFL and notice LRs.
18 A Mahendra.
TI along with statement of
File this
objections.
application for an order of injunction, let them not to alienate, create any charge.
Who filed the application?
Respondents herein, they are the plaintiffs. The concurrent findings of both the courts below, they have also already made an order to bifurcate the property. Now FDP proceeding is going on in the trial court. Now in the meanwhile, they want to alienate the property and lease out the property. And that person who's in possession of the property has already raised the crop. You came to know recently. So let's kindly look into it.
Yes, ma'am.
But I have filed my objections, my lord.
Akir objections.
Still the objection. What else you want?
I am not asking for the time. I am saying I have already
objection.
filed.
I'm sorry. I'm sorry.
Objections ಹಾಕಿದೀನಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
ಅದೇ objection already filed ಅಂತ ನಾನು ಹೇಳ್ತೀನಿ.
ನಾನು ಏನಾದ್ರು ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ಈಗ.
ಅಲ್ಲ, because the urgency I am
ಕೊಡಿ
and what I am submitting, your lordship may kindly see, the relationship is like this, my lord. Appellants 1 to 3. 1 is the father. 2 and 3 are the children of the daughters of the second wife. Your lordship may kindly see, the respondents 1 to 3, 1 and 2 are the daughters of the first wife. Respondent number 3 is the first wife. Respondent number 4 is the second wife. Now what has happened? Respondents 1 to 3 file a suit for partition and separate possession, disputing our relationship. First appellate, both the courts have refused to grant me any share on the ground that I am born out of a void marriage. that by following the earlier judgments of the Honorable Supreme Court in Bharat Mata case and
Now,
other
Revan
cases,
Siddha
which have been totally overruled, and now it is governed by the full bench judgment of the Honorable Supreme Court in Revan Siddha case. Your Lordships have already admitted the appeal. I am also one of the legal heirs of my father. My father also died during the pendency of this appeal. There is one these two are the daughters. They are only cultivating the land. They are entitled to be in possession of the property and cultivate the land. They are not alienating it. It is a clear case of harassment on the part of the children of the first wife, only to ensure that these people don't even survive.
Now, according to them, second wife's children are the cultivating the land.
Yes.
Nimden TA in Bekri?
TA not alienate
They are
because
not
they already.
alienating the property.
Nim relief and application.
Some relief only not to alienate and create any charge.
Yes.
They already leased out the property and received 3 lakhs rupees from the person who is in possession of the property. They are not cultivating it. Somebody is raised the crop, we came to know recently, and that person is from Kerala.
I3 lease out Madidruno. They are not creating any third party rights.
Third party suppose final degree proceedings iddaga and the lease person
not to alienate madana bidi.
That is not to alienate and also create the charge anta.
I am only cultivating the land.
They already received 3 lakhs rupees and raised the crop now. It is for 3 years or 2 years, we don't know. They have not produced any document. Horse grants.
They have gone to the extent of, your Lordship may kindly see how vindictive they are.
This is horse
ಯಾರು cultivate ಮಾಡ್ತಾ ಇದ್ದಾರೆ
leased out.
Leased out ಅನ್ನಕ್ಕೆ ಏನಿದೆ ದಾಖಲೆ?
Document ಇದೆ, I produce it.
ದಾಖಲೆ ಏನು ಕೊಟ್ಟಿದ್ದೀರಿ?
Produce it.
ಈಗ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಇಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ, ನಮ್ಗೆ ಇವಾಗ ಗೊತ್ತಾದಕ್ಕೆ ನಾವು applied for it, we will produce it on Friday.
Let them produce it.
I'll produce it on
Let them
Friday.
produce
Lease ಮಾಡಿರೋದು ಇದ್ರ ಕೊಡಿ ನೋಡೋಣ. What type of lease ನೋಡೋಣ? If it is for a cultivation ಆದರೆ
cultivation ಇಲ್ಲ ಸ್ವಾಮಿ, they have not cultivated it, it is given to lease to somebody else.
ಲೀಸ್ ಅಂದ್ರೆ ಸರಿ ರೀ, ಏನಕ್ಕೆ ಕೊಟ್ಟಿದ್ದಾರೆ?
ಭೋಗ್ಯಕ್ಕೆ ಹಾಕಿದ್ದಾರೆ 3 years ಗೆ 3 lakhs rupees, they already received it.
in registered document
ಇಲ್ಲ unregistered. unregistered ಗೊತ್ತಾಗುತ್ತಲ್ಲ ಅಂತ
ಅವನ ಹಣೆಪಾಡು ದುಡ್ಡು ಕೊಟ್ಟವನು.
ಪ್ಲೀಸ್ ಮೇಲೆ
ಅವನು ದುಡ್ಡು ಕೊಟ್ಟವನ ಹಣೆಪಾಡು ಅದು ಒಂದೇ. If it is not registered document.
Because when they have raised the crop.
ನಿಮ್ prayer and not to alienate ಅಂತ ಕೇಳಿದ್ರಾ?
Lordship may kindly see, as on date, he has
and
not.
Also it can be disposed of.
ಏನು ಹೇಳಿ?
ಇವಾಗ not to alienate, but I may be permitted to cultivate the lands.
Cultivation ಮಾಡಿ
this one.
Not to alienate ಇಲ್ಲ.
We are not selling the property, we are not alienating the property. Your Lordship may kindly hear the matter itself, we are ready to argue the matter. Appeal has been admitted.
Nominees or any person claiming under them right over this property, sir.
ಇದು ಏನಾಗುತ್ತೆ, ತಾವು ಇಂಟ್ರಿ ಮಾಡ್ರು ಕೊಟ್ರೆ ಅಲ್ಲಿ ಹೋಗ್ಬಿಟ್ಟು ಮೊನ್ನೆ ಏನ್ ಮಾಡಿದ್ದಾರೆ, they have actually gone to the extent of trying to use pesticides on the crop only to see that the crop is destroyed. Photos are there. They are extremely vindictive. ಇವರಿಬ್ರು ಹೆಣ್ಮಕ್ಕಳು ಅವ್ರ ಮನೆಯಲ್ಲಿ ಅವ್ರಿಗೆ they don't have anything to depend upon.
Somebody is cultivating.
They are not even working.
These
people want to harass us.
They have raised the crop. ಶುಂಠಿ ಹಾಕೋದಕ್ಕೆ ನೆಕ್ಸ್ಟ್ ರೆಡಿ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಸ್ವಾಮಿ, they have do it.
ಮಾಡ್ಲಿ ಬಿಡ್ರಿ, ಏನಾಗ್ತದೆ ಲ್ಯಾಂಡ್ ಕಲ್ಟಿವೇಟ್ ಮಾಡಿದ್ರೆ
their share is
ಹಾಗಂತ ಹೇಳಿ ನೀವು ಪಾರ್ಟಿಷನ್ ಒಂದ್ ಸೆಕೆಂಡ್ ಇರ್ರಿ, ಒಂದ್ ನಿಮಿಷ ಇರ್ರಿ.
their share is not determined.
ರೀ ಆಯ್ತು, ಈಗ ಸೂಟ್ ಫಾರ್ ಪಾರ್ಟಿಷನ್ ನೀವು ಯಾವಾಗ ತಗೋಬೇಕು ಪೊಸಿಷನ್ ನ? How can you prevent them in cultivation of the property?
No, I am not
ಶುಂಠಿ ಬೆಳಿತಾರೋ ಹಾರ್ಸ್ ಗ್ರಾಮ್ ಹಾಕ್ತಾರೋ ಏನ್ ಹಾಕ್ತಾರೋ?
I am not preventing it.
ಮತ್ತೆ
they already leased out.
ನಿಮ್ ಪ್ರೇಯರ್ ಏನು? not to alienate, ಹೌದಲ್ಲ? ಅಷ್ಟೇ ಅಲ್ಲ?
ಅಷ್ಟೇ, not to create charge.
Your Lordship may make it clear that I am entitled to cultivate the land.
ಆಯ್ತು, heard on
may request my lord,
the appellant counsel and also the counsel appearing.
May kind permission, this is a concurrent finding of the both the courts and covered by the decision of the Revana Siddha package can be disposed of and let final degree proceedings may go on. Ashte my request.
I am ready to argue the main matter also.
ಅದನ್ನೇ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ಸ್ವಾಮಿ.
ಮತ್ತೇನ್ ಮಾಡ್ಬೇಕು?
covered by the Revana Siddha
ಈಗ ನಿಮಗೆ not to alienate relief ಬೇಕಾ ಬೇಡ?
ಬೇಕು ಸ್ವಾಮಿ, ಅದು dispose of
ಮಾಡಬಹುದು. Disposal ಬೇಕಂತ without hearing the argument.
ಒಟ್ಟಿಗೆ dispose of ಮಾಡಬಹುದು ಅಂತ.
ಒಟ್ಟಿಗೆ ಹೆಂಗ್ ಡಿಸ್ಪೋಸ್ ಮಾಡಕ್ಕಾಗತ್ತೆ? ಇವತ್ತು ಏನಕ್ಕೆ ಬಂದಿದೆ ಅಯ್ಯೇ ನೀವು ಅಯ್ಯೇ ಹಾಕೊಂಡಿದ್ರಿ ಬಂದಿದೆ, ಹೌದಲ್ಲ? ತೊಗೊಳ್ಳಿ. heard on ಅಯ್ಯೇ ನಂಬರ್ 1/25 wherein prayer is sought
not to create any charge
not
and
to
also not to
alienate or create any charge over the suit shall property pending disposal of this second appeal, and counsel appearing for the appellant would submit that they are not going to alienate or creating any charge over the property but may be
they are cultivating the land.
I'm allowed to cultivate the property, and hence in view of the submission of the counsel appearing for the appellant that they are not going to alienate, and the same is taken note of, and in view of the said submission, IA is disposed of that not to alienate or create any charge over the suitable property till the disposal of this appeal, and accordingly IA is
Your
disposed
lordship
of.
may kindly
IA
say
is
that
disposed
this
of.
order should not be interpreted to mean that I cannot be prevented from
And
cultivating the
this
land.
order should not help the respondent in preventing the cultivation of the property.
Much by the appellants, my lord.
By the appellants, appellants new.
Correct.
The respondent shall not prevent
Interfere with the cultivation of the property by the appellants.
Appellants in cultivating the
In case
property.
if the third person is there in possession of the property.
Appellants in cultivating the property.
Allah, in case if the third person is in possession cultivating the land.
Let them produce the documents, my lord. We can't take an order in air.
Right.
I am ready to argue
Post
the
the
main
matter
matter also.
post the matter immediately after winter
Yes, my
vacation.
lord.
That may request.
ನಾನೇನು ನೆಕ್ಸ್ಟ್ ರೋಸ್ಟರ್ ನಾನು ಕೂರಲ್ಲ, ಕೂಡೋದಾದ್ರೆ ನಾನೇ ಕೊಡ್ತಾ ಇದ್ದೆ ಡೇಟು, ನಂಗೆ ಗೊತ್ತಿಲ್ಲ, ನಾನೇ ಕಂಟಿನ್ಯೂ ಆದ್ರೆ ನಾನೇ ತಗೋತೀನಿ, ಮೂವ್ ಮಾಡಿ ಆಗ್ಬೋದಾ? ಅಷ್ಟು ಅಸೂರೆನ್ಸ್ ಐ ಕ್ಯಾನ್ ಗಿವ್. ಇಲ್ಲ ಅಂದ್ರೆ ನೀವು ನೆಕ್ಸ್ಟ್ ರೋಸ್ಟರ್ ಜಡ್ಜ್ ಯಾರು ಇರ್ತಾರೋ ಅವ್ರ ಮುಂದೆ ಮೂವ್ ಮಾಡಿ, ಅರ್ಜೆನ್ಸಿ ಇದೆ ಅಂತ ಮೂವ್ ಮಾಡಿ ಅಷ್ಟೇ.
19 Srinivasa DC, sorry, filing.
In this case, my lord, notice may be issued. There's a delay of 56 days, my lord.
Filing.
Post the matter for admission after winter vacation along with IA.
20 Vishwanath Arhette, idu ashtu.
Same order.
21
21 also same order, filing.
My lordship, kindly delete the name of the counsel. Already I'll file the NOC wakalat on 13. ನಾನು ಹಾಕಿನ my lordship 1310 ಗೆ ಹಾಕಿನ my lordship.
1310
ಹೌದು, ನಾನು ವಕಾಲತ್ ಹಾಕಿನ my lordship.
ಯಾವ್ದ್ರಲ್ಲಿ
21ರಲ್ಲಿ 1733
ನಿಮ್ ನೋಟ್ ಪುಟಪೇ ಆಗಿಲ್ವಲ್ಲ ನಿಮ್ಮ ಒಕ್ಕಲ?
ಅದಕ್ಕೆ my lordship.
ಹೋಗಿ ಅಲ್ಲಿ ನೋಡಿ ರಿಜೆಕ್ಟ್ ಆಗಿರ್ಬೇಕಾ ಅಥವಾ ರಿಟರ್ನ್ ಆಗಿದೆಯೋ ಏನಾಗಿರ್ಬೋದು ನೋಡಿ.
ವಕಾಲತ್ ಹಾಕಿನ my lordship.
ತಗೊಳ್ಳಿ ದ ಕೌನ್ಸಿಲ್ ಶ್ರೀ
ಶಿವಶಂಕರ್ my lordship.
ಶಿವಶಂಕರ್
filed the wakalat.
that he has filed wakalat on
13/10/2025.
Yes, ma'am. ಇದೆಯಾ? ಬಟ್ ಇದೆಯಾ? ಇದೆ. And hence and the same is put up but not shown in the cause list. And hence show the name of the counsel Shivashankar. Initial ಏನಾದ್ರು ಇದೆಯಾ?
ಇಲ್ಲ ಇಲ್ಲ my lordship.
MS ಅಂತ ಇದೆ.
MS ಅಂತ ಇದೆ ಅಂತ.
ಶಿವಶಂಕರ್ ಅಷ್ಟೇ ಇರೋದು.
ಶಿವಶಂಕರ್ MS ಅಂತ.
ಇಲ್ಲ ಇಲ್ಲ
ಶಿವಶಂಕರ್ MS ಅಂತ. ವರಲಕ್ಷ್ಮಿ ಅಂತ ಇದೆ ಸರ್.
ಶಿವಶಂಕರ್ ಅಂತ.
MS ನೀವು ಅಲ್ವಾ?
ಇಲ್ಲ ಇಲ್ಲ my lordship. ಶಿವಶಂಕರ್.
ಒಕ್ಕಲತ್ ತೆಗೀರಿ ಹೋಗ್ಲಿ. ವಿತ್ NOC ನಾ?
NOC my lordship.
ಅದ್ರಲ್ಲಿ ಇಲ್ಲ. ಮತ್ತೆ ಇವ್ರ ಹೆಂಗ್ ಹಾಕಿದ್ರು ಮೇಡಮ್? ವರಲಕ್ಷ್ಮಿಗೆ ಇನ್ಶಿಯಲ್ ಇದೆಯಾ? ಶಿವಶಂಕರ್ ಅಷ್ಟೇನಾ? ಶಿವಶಂಕರ್ ಅಂಡ್ ವರಲಕ್ಷ್ಮಿ MS
MN.
MN. And hence registry is directed to show the name of the new counsel who filed wakalat with NOC and delete the name of Harish Kumar MC. ಹೌದಾ?
Yes ma'am.
List the matter for admission immediately after winter vacation.
22
Malik Patil. Inu filing immediately after winter vacation along with IA. Next one also. Next one also.
My lord, there is a connected matter arising out of
Number
the
kodi
same
ಏನು?
OS.
Number.
Serial number 23.
RSA number ಹೇಳ್ರಿ.
951 of 2025.
Appellant counsel submits that another connected RSA 950/24 25 is pending. Arising out of same judgment, arising out of same judgment, and hence registry is directed to put up the same along with this appeal and post both the matters for immediately after winter vacation. 24 also same.
Parted in orders 25.
Vishwanath Shetty. Memo for retirement filed by advocate for appellant.
Memo, I got the details. It is being served on the past. In page number.
Acknowledgement ಕೊಡ್ತೀರಾ?
ಇಲ್ಲ ಅವರೇ ಕೊಡ್ತಿದ್ದಾರೆ ಸರ್. I will do that.
ಅವ್ರು ಕೊಡ್ತಾ ಇದಾರೆ ಅಂದ್ರೆ ಪೋಸ್ಟಲ್ ಸ್ಟಾಕ್
ಪೋಸ್ಟಲ್ ಸ್ಟಾಕ್ ಇದೆ ಸರ್. ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಇದೆ.
ಯಾವಾಗ ಜಾರಿ ಆಗಿದೆ ಅವರಿಗೆ? ಡೇಟ್ ಇದೆಯಾ?
Right in page number 4.
ಅಪಲೆಂಟ್ ಈಗ
8/11/2025.
ನೀವೇನು ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಇದೆ ಅಂದ್ರಲ್ಲ ಕೊಡಿ.
ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಇಲ್ಲ ಸರ್.
ಮತ್ತೇನಿದೆ?
ಪೋಸ್ಟಲ್ ರಿಸಿಪ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್.
ರಿಸಿಟ್ ಅಲ್ರಿ, ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ನಾ ಕೇಳಿದ್ದು ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಸರ್ವಿಸ್ ಆಗಿದೆ ಯಾವಾಗ ಆಗಿದೆ
ಸಮ್ ಪೇಜ್ ನಂಬರ್ 4 ಇದೆ ನೋಡಿ ಅದರಲ್ಲಿ ಐಟಮ್ ಟ್ರಾನ್ಸ್ಮಿಟೆಡ್ ಟು ಸಂತೆಕಲ್ಲಳ್ಳಿ BO ಅಂತ ದೊಡ್ಡದಾಗಿದೆ ಸ್ವಾಮಿ. In the middle, my lord, last nothing but sixth one, my lord, please. On 28/11/2025.
ಹೆಸರೇನು ಹೇಳಿ
ಸ್ವಾಮಿ
ಹೆಸರೇನು ಪಾರ್ಟಿ ಹೆಸರು
ಲಕ್ಷ್ಮೀನಾರಾಯಣ.
ಲಕ್ಷ್ಮೀನಾರಾಯಣ.
ಯಾರು ಲಕ್ಷ್ಮೀನಾರಾಯಣ ಅನ್ನೋದು ಯಾರ್ದು ಇಲ್ವಲ್ಲ
ಮೇ ಶೋ
ಲಕ್ಷ್ಮೀನಾರಾಯಣಪ್ಪ ಹೌದಾ
ಹೌದು
ಯಾರ ಸಿಗ್ನೇಚರ್ ಇದೆ ನೋಡಿ ಇಲ್ಲಿ ಅದ ಕೊನೆಯದ
ನೇಮ್ ಬರಲ್ಲ ಸ್ವಾಮಿ 4 ಕೊನೆಯಿಂದ 6ನೇ ಸ್ವಾಮಿ
6ನೇದಲ್ರಿ ಲಕ್ಷ್ಮೀನಾರಾಯಣಪ್ಪ ಅಂತ ಹೆಸರು ಅಪಲೆಂಟ್ ಪಾರ್ಟಿ ಹೆಸರೇನ್ರಿ ಲಕ್ಷ್ಮೀನಾರಾಯಣಪ್ಪ ಅಂತ ಇದೆಯಲ್ಲ ಅದೇನಾ
ಇದೆ
ಹಾ
ಇಲ್ಲಿ ಲಕ್ಷ್ಮೀನಾರಾಯಣಪ್ಪ
ಅಟ್ಯಾಚ್ಡ್ 6 ಅಲ್ಲಿ ಇದೆ
ಬಿನಾ ಇದೆಯಲ್ಲ ಯಾರ ಹೆಬ್ಬೆಟ್ಟಾಗಿ ತಗೊಂಡಿದ್ದಾರೆ
his wife, my lord, please.
Wife has taken it.
His wife ಹಂಗ್ ಬರ್ದಿ ಏನೋ ಬರ್ದಿದ್ದಾರೆ
ಚಂದನನ
ನೇಮ್ ಆಲ್ಸೋ ರಿಟರ್ನ್
ವೈಫ್ ಗಂಡ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ತಗೊಂಡಿರ್ತಾರೆ ಗಂಡ
ಚಂದ್ರಶೇಖರ ಏನಾಗಿದೆ ನೀವು
ಚಂದ್ರಮ್ಮ ಸಮಥಿಂಗ್ ಮೈ ಲಾರ್ಡ್ ಪ್ಲೀಸ್
ನೀವು ನೋಡ್ರಿ ವೈಫ್ ಅಂತೀರಿ
ಇಲ್ಲ ಏನೋ ಚಂದ್ರಮ್ಮ ಸಮಥಿಂಗ್ ಇನ್ your name it is not particularly
ಚಂದ್ರಮ್ಮನಾ
ಚಂದ್ರಮ್ಮ
ವೈಫ್ ಹೆಸರು ಚಂದ್ರಮ್ಮನಾ ಗೊತ್ತಾ
I'm not exact.
I am also not conversant, my lord.
ಬಟ್ ಇದು ಯಾವತ್ತಾಗಿರೋದು
27
ನೋಡಿ counsel for the respondent himself files report generated by the postal department that notice has been served on B. Lakshminarayanappa's wife Chandramma. The same is taken on record. The retirement memo illide kodi madam. In view of the postal track report held sufficient for notifying the appellant having served the retirement letter and hence counsel is permitted to retire from the case. However, in the ends of justice 2 weeks time granted for appearance of appellant either in person or through an advocate. If fails to appear, the appeal will be dismissed in the next date of hearing. List this matter on ಒಂದು 2 ವಾರ ಬಿಟ್ಟು ಅಂದ್ರೆ reopening ಕೊಡಿ 6/1/26.
Started in admission 26. Chandraya.
Respondent number 1. In order to clarify which are the properties I failed, made an application for appointment of the commissioner in which I have in detail stated as what all the properties and their D schedule.
Last time order sheet kodi madam. Or the learned counsel for the appellant in part. Learned counsel for the appellant submit that FDP court while mentioning in the order portion mentioned as D schedule property and the same has to be read as C schedule property. The learned counsel submit that some of the parties have filed affidavit that it can be divided among them and no need to keep the property till the lifetime of petitioner number 5. Learned counsel submit that petition number 5 is not in occupation of the said property from 17 years. Learned counsel for the respondent number 4 seeks to time make submission to that effect.
Okay, for respondent number 4. My instruction is that respondent number 4 is the only person who is residing there. And
Only residing
in the property, in the she's scheduled property. And he has no consent for that lord until
consent
to divide the property during the lifetime of the mother. That's what is my instruction.
Respondent number 4 is mother.
No. 5 is mother. 4 is one of the sons.
One of the son. He is also.
That means 4 is in occupation. Yes. Earlier partition prakara.
Partition prakara adana the C schedule property is the house in which my friend has addressed. It is in the occupation of the respondent number 4. Galan Kumar. Somehow it has impressed the court that property shall not be sold during the lifetime of the mother who is under occupation when the written statement is filed. Thereafter, the events have been changed. Whereafter that lady.
But now the mother is not in the house.
Mother is not in the station. She filed a memo along with others stating that the property which is involved there must be divided. He has filed long back. That has not been taken into consideration by the trial court. This is the application she has been made. This is the certified copy, my lord.
Oh, that is made by her.
Made by her. And
now what is the difficulty
in support of it? Other four
dividing the property.
My lord, grandmother, the lady, that old lady is still there, my lord.
Still there where?
In another house.
ಬೇರೆ house ಅಲ್ಲಿ ಇದ್ದಾರೆ.
ಬೇರೆ ಮನೇಲಿ ಇದ್ದಾರೆ.
ಆಯ್ತು.
ಅವರಿಗೆ ಹಂಗ್ ಡಿವೈಡ್ ಮಾಡ್ಬಿಟ್ರೆ ಇರಕ್ ಜಾಗನೇ ಇರಲ್ಲ.
But ಆ ಮನೇಲಿ ಇಲ್ಲ ಅಲ್ಲ.
Respondent number 4 does not have any other means to.
ಇಲ್ಲ ಇಲ್ಲ. DLSA was appointed advocate also through DLSA.
I am appearing through the legal services committee. He has no means apart from that house. All that he is asking until his mother is alive, let him stay there. After that he will
as per
some other accommodation.
As per the decree.
That's all he is asking. As per the decree, FDP says that.
ಅದನ್ನ ಅಮೆಂಡ್ ಮಾಡ್ರಿ ಅಂತ ಹೇಳ್ತಾರೆ ಇವರು.
ಅಮೆಂಡ್ ಅಂತಲ್ಲ, ಅದನ್ನ ಡಿವೈಡ್ ಮಾಡಿ ಅಂತ.
Divide ಮಾಡಿ ಅಂತ not I am saying the party that mother herself has stated, filed an affidavit application, and along with it 4 of the respondents who are sailing with her have stated it is in the year 2000.
ಅದ್ರ ಕಾಪಿ ಕೊಡಿ ಅವರಿಗೆ.
ಇಲ್ಲಿ ಅದ್ರ ಕಾಪಿ ಅವರ ಹತ್ರನೇ ಇದೆ ಸ್ವಾಮಿ. ನಾನು ಕೋರ್ಟ್ ನೋಡ್ರಿ ಒಂದೇ ಒಂದು ಕಾಪಿ.
ಸರಿ ರೀ, ಮದರ್ herself has
stated not now in the year 2015.
Maybe R4 is staying in that house. But this is a suit for partition, ಹೌದಲ್ಲ? ಡಿವೈಡ್ ಆಗ್ಲೇಬೇಕಲ್ಲ. He cannot squat and enjoy the property alone.
The trial court also has not said that it should not be divided. All the trial court has said that until the lifetime of the mother.
But mother is not living ಅಲ್ಲೇನ್ರಿ ಆ ಮನೆಯಲ್ಲಿ. If mother is living, then your submission is correct. But here mother is not living. Mother herself says that it can be divided.
In the 2015, my lord. In the year 2015.
She is not before this court, my lord. She is not represented.
She has told in the FDP proceeding.
ಅದೇ FDP ನಲ್ಲೇ ಹೇಳಿದಾರಲ್ಲ. ಮತ್ತೆ FDP ನಲ್ಲಿ ಹೇಳಿದ್ಮೇಲೆ ಮತ್ತೇನು?
Court do not take cognizance of those things.
ಮಾಡಕ್ ಬರಲ್ಲ.
ಮತ್ತೆ
ಆಗ ಅವ್ರು ಹೇಳಿದಂಗೆ ಮಾಡಬೇಕಾಗ್ತದೆ. ಆದ್ರೆ ಅವ್ರದ್ದು
ಅಪ್ಲಿಕೇಶನ್ along with other respondents.
ಈ RSA ನಲ್ಲಿ ಡಿಸ್ಪ್ಯೂಟ್ ಈಗ ಇರೋದು ಅಷ್ಟೇನೆ.
ಅದು ಇನ್ನೊಂದು ಪ್ರಾಪರ್ಟಿ ಇದೆ ಸ್ವಾಮಿ, ಅದು ಹೇಳ್ತೀನಿ. ಇದನ್ನ ತಾವು ಇದನ್ನ ರೆಡಿ ಮಾಡಿ. ಇನ್ನೊಂದಿದೆ, ಇನ್ನೊಂದು ಹೇಳ್ತೀನಿ ನಾನು.
ಸುಶೀಲಮ್ಮನ ಇವರು?
ಸುಶೀಲಮ್ಮ ಮದರ್. ನಾವು last time also
is not under the occupation or use of me since 17 years, as I am old and if I was not having any good sight, I could not manage myself. I am residing with my daughter Archana and occasionally with my another daughter Rajani since 17 years. Mother herself says that should be modified, that's all. Their grievance is also with regard to that item of the property.
This is with regard to C schedule property.
C schedule.
That is the C schedule, but court has printed it as.
ಅದೇ ಬಟ್ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ ಅಂದ್ರೆ ಅದನ್ನ it has to be read as C instead of D ಅಂತ.
ಅಷ್ಟೇ ಸ್ವಾಮಿ.
ಹೌದಲ್ಲ, ಇನ್ನೊಂದೇನು ನಿಮ್ದು ಈಗ ಈ ಅಪೀಲ್ ಅಲ್ಲಿ
B schedule property ನಾನು ಇದೆ ಸ್ವಾಮಿ. B schedule property is a house site. B schedule property is a house site measuring 34 feet east to west and 135 feet north to south.
ಆಯ್ತು.
It is declared that we have also not contest with regards to declaration. It is declared that the senior son Jivan Kumar is entitled to 10/18 share. We have no dispute it.
10/18 share.
10/18 share because his grandfather has made a will or some settlement in which he has stated that this portion of the property must go to his son and grandson.
So, but ನಿಮ್ಮ ಪ್ರಕಾರ 10/18 share he has got.
I agree. I do not dispute. Only the dispute is 10/18 share ಗೆ 155 feet road ಕೊಟ್ಟಿದ್ದಾರೆ. 155 feet road ಇದೆ. Remaining people they have no right. They have no access.
ನೀವು ಅದರ ಪ್ರಕಾರ ನೀವು ಯಾವ್ದ್ರ ಪ್ರಕಾರ ನೀವು ಕ್ಲೈಮ್ ಮಾಡ್ತಿರೋದು ಅದನ್ನ?
ಇವಾಗ ನಾವು ಕ್ಲೈಮ್ ಮಾಡಿದ್ದು ರಿಮೈನಿಂಗ್ 8 shares ಇದೆ ಸ್ವಾಮಿ. 1/8 ಹೋದ್ಮೇಲೆ ರಿಮೈನಿಂಗ್ 8 shares. 8 shares accessible road ಇಲ್ಲ ಸ್ವಾಮಿ.
ರೋಡ್ ಇಲ್ಲ ಸರಿ, ಬಟ್ ದೇ ಆರ್ ಎಂಟೈಟಲ್ ಫಾರ್ ಎ ಶೇರ್ ಅಲ್ವಾ?
They are entitled for share where they have to enjoy according to the commissioner. Commissioner has made a mistake by allotting the road side to the major shareholder, no rights for the remaining shareholders. This is the grievance. I am not claiming the extent of the share. My claim is that while accepting the report of the commissioner, we made an application in order to meet the deficiency. Mother, who is now is in the position, she has made an application stating that he do not want share, it must be divided among all the sons and daughters. So her.
That is B schedule property.
That is in B schedule property.
ಆಯ್ತು, ಈ B schedule property commissioner ಯಾವ ರೀತಿ ಡಿವೈಡ್ ಮಾಡಿದ್ದಾರೆ?
ಕಮಿಷನರ್ ಒಂದು ಈಸ್ಟ್ ಗೆ ಮತ್ತು ವೆಸ್ಟ್ ಗೆ ಮತ್ತು ನಾರ್ತ್ ಗೆ 124, 155 ಫೀಟ್ ಅವರು ರೋಡ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. ನಮಗ್ 20 ಫೀಟ್ ನಮಗ್ ಬರ್ತಕ್ಕಂತ 285 ಫೀಟ್ ಅಲ್ಲಿ 344 ಸೀಟ್ ಅಲ್ಲಿ ನೀವು 80 ಫೀಟ್ ರೋಡ್ ನಿಮ್ಮಲ್ಲೇ ನೀವು ಬಿಟ್ಕೊಂಬಿಡಿ, ಆ ರೋಡ್ ಇಂದ ನೀವು ಪಬ್ಲಿಕ್ ಗೆ ಅಕ್ಸೆಸ್ ತಗೊಳ್ಳಿ ಅಂತ. ಸ್ಕೆಚ್ ತೋರ್ಸಾರ ಅವ್ರ ಹತ್ರ ಸ್ಕೆಚ್ ಇದೆ.
ಕಮಿಷನರ್ ರಿಪೋರ್ಟಿಂಗ್ ನೀವು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದೀರಾ?
ಅದಕ್ಕೆ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದೀವಿ, ಇದನ್ನು ಹಾಕಿದೀವಿ ಸ್ವಾಮಿ ನಾವು.
ಏನ
ಈ ತರ ಅಪ್ಲಿಕೇಶನ್ ನಮ್ಮ ಮದರ್ ಈಸ್ ಆಲ್ಸೋ ವಿಲ್ಲಿಂಗ್ ಟು ಗಿವ್ ಅಪ್ ಅವರ್ ಶೇರ್ that may be allotted to the members ಅಂತಾನೂ ಹಾಕಿದೀವಿ. We have convinced
members ಅಂದ್ರೆ ಎಲ್ಲರಿಗೂ ಅಂತ.
ಎಲ್ಲರಿಗೂ
ಆಯ್ತು. ಅದ್ರ ಬಗ್ಗೆ ಏನ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್
ಅದ್ರ ಬಗ್ಗೆ ಏನು ಹೇಳಿಲ್ಲ ಸ್ವಾಮಿ. ನಾವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ವಿ, ಅಫಿಡವಿಟ್ ಹಾಕಿದ್ವಿ, ಬೇರೆಯವರೆಲ್ಲ ಹಾಕವ್ರೆ, ನಮ್ಗೆ ಏನ್ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಆಗಿದೆ ಅಂತಲೂ ಹೇಳಿದೀವಿ. The court is not taken cognizance of it, just they simply
confirm. ಏನ್ ಅಂತ ಮಾಡಿಫೈ ಮಾಡ್ಬೇಕು ಹೇಳಿ?
ಏನಂತ ಮಾಡಿಫೈ ಬೇಕು ಅವ್ರಿಗೆ 50/10 ಒಂದ್ ಕಡೆ ಈಸ್ಟ್ ವೆಸ್ಟ್ ಕೊಟ್ಬಿಡಿ ಸ್ವಾಮಿ ಅವ್ರಿಗೆ.
ಯಾರಿಗೆ?
ಅವ್ರಿಗೆ ಜೀವನ್ ಕುಮಾರ್ is entitled to 10/18 share. He is entitled for it. ಈಸ್ಟ್ ವೆಸ್ಟ್ ಮೆಜರ್ ಮಾಡಿದ್ರೆ ಟೋಟಲ್ ಅಲ್ಲೇ ಅವ್ರಿಗೆ ಬರ್ತದ ಅವ್ರ ಶೇರ್. ಬಟ್ ಅವ್ರಿಗೆ
ನೀವ್ ಯಾರು? ನೀವು ಜೀವನ್ ಕುಮಾರ್ ಅಲ್ವಾ?
ನಾನು ಐ ಆಮ್ ನಾಟ್ ಜೀವನ್ ಕುಮಾರ್, ಐ ಆಮ್ ದ ಸೀನಿಯರ್ ಡಾಟರ್ ಅಂಡ್ ಮಿಡಲ್ ಡಾಟರ್ ಆಫ್ ಸುಶೀಲಮ್ಮ.
ಆಯ್ತು.
ನಾವು ಕೇಳ್ತಾ ಇರೋದೇನು, ನಮಗ್ ಬಂದಿರೋ
ಜೀವನ್ ಕುಮಾರ್ ಕೋರ್ಟ್ ಬಂದವ್ರ ಈಗ? ನೀವೇ ಜೀವನ್ ಕುಮಾರ್
till Jeevan Kumar was alive, we were negotiating, we were settling the matter. He died after filing of this appeal.
ಅವಾಗಿಲ್ಲ ಈಗ ಅವರು
ಎಲ್ಲ ಅಪೀಲ್ ಹಾಕಿ ಹೋಗಿದ್ರು ಸ್ವಾಮಿ.
RSL ಇಲ್ಲ ಸ್ವಾಮಿ.
LRs ಇದ್ದಾರೆ.
Because of its demise, we could not settle out of court. He has agreed. He has agreed to settle the matter and he would like to share it.
ನೀವಿಬ್ರು ನೋಡ್ಕೊಳ್ಳಿ ಅದೇನು ಬಿ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ.
ಅವ್ರಿಗೆ ಎಲ್ ಬೇಕೋ ಅವ್ರು ತಗೊಳ್ಳಿ ಸ್ವಾಮಿ. ಮೇಜರ್ ಈಸ್ಟ್ ವೆಸ್ಟ್ 40 ಫೀಟ್ ಬಿಡ್ತಿರೋದ್ರಿಂದ ಅವ್ರಿಗೆ ಬಂದಿರೋ 10/18 ಶೇರ್ ಅಲ್ಲಿ ಎಷ್ಟು ಬೇಕೋ ಅವ್ರಿಗೆ ಅಷ್ಟು ತಗೊಂಡ್ಬಿಡ್ಲಿ ಸ್ವಾಮಿ. ಪ್ಲಸ್ 1/9 ಶೇರ್ 10/18 ಶೇರ್ ಬಂದ್ರೆ ಬರುತ್ತೆ ಸ್ವಾಮಿ. ಈ ರಿಮೈನಿಂಗ್ ಬಂದ್ರೆ ಈ ಬೇರೆ ಶೇರ್ ಹೋಲ್ಡರ್ಸ್ಗೂ ರಸ್ತೆ ಸಿಗ್ತದೆ. ಅದರಲ್ಲಿ ಇನ್ನೂ ಒಂದೇನು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದಾರೆ ಅಂದ್ರೆ ಮದರ್ ಅಂಡ್ ಡಾಟರ್ ಅಲಾಂಗ್ ವಿತ್ ಒನ್ ಸನ್ ಅವ್ರದ್ದೆಲ್ಲ ಶೇರ್ ಒಂದ್ ಕಡೆ ಅಲಾಟ್ ಮಾಡಿ, ಆ ಅಲಾಟ್ ಮಾಡೋದ್ರಲ್ಲಿ ಒಂದು ಈಸ್ಟ್ ವೆಸ್ಟ್ ಅಲಾಟ್ ಮಾಡಿದ್ರೆ ನಮಗೂ ಸಬ್ಸ್ಟಾನ್ಶಿಯಲ್ ಸ್ಪೇಸ್ ಜಾಗ ಸಿಗ್ತದೆ. ವಿ ವಿಲ್ ವಿಲ್ ಎಂಜಾಯ್, ವಿ ವಿಲ್ ಸೇರ್ ಅಂಡ್ ವಿ ವಿಲ್ ಬಿಲ್ಡಿಂಗ್ ಅಂತ.
ಈಗ ಅಲಾಟ್ಮೆಂಟ್ ಮಾಡುವಾಗ ಆತರ ಅಲಾಟ್ಮೆಂಟ್
ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ. ಇಟ್ ಈಸ್ ನಾನು ಹೇಳ್ಬಾರ್ದು.
FDP ಶೆಡ್ಯೂಲ್ ಎ ಪ್ರಾಪರ್ಟಿಗೆ ಪೆಂಡಿಂಗ್ ಇದೆ ಸ್ವಾಮಿ. ಆರೇದಲ್ಲಿ ಅದನ್ನೇ ಹೇಳಿದ್ದಾರೆ.
ಶೆಡ್ಯೂಲ್ ಎ ಅಲ್ಲ ಅವ್ರು ಹೇಳ್ತಾರೆ,
ಶೆಡ್ಯೂಲ್ ಬಿ ಪ್ರಾಪರ್ಟಿ
ಇರೋದ್ರಿಂದ ಬಿನು FDP ಕೋರ್ಟ್ FDP ಕೋರ್ಟ್ ಡಿಸೈಡ್
ಆಗ್ಲಿ ಸ್ವಾಮಿ.
ಅಲ್ಲ ಬಿ ಶೆಡ್ಯೂಲ್ ಬಿ ನೋ ಈಗ FDP ಪೆಂಡಿಂಗ್ ಇದೆ.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಅಲ್ಲಿ ಗೋಲ್ ನಂದೇನ್ ತಕರಾರ್ಲಿಲ್ಲ. ಅದು ಆರ್ಡರ್ ಕನ್ಫರ್ಮ್ ಮಾಡ್ಬಿಟ್ರೆ ನಮ್ಗೆ ಸೈಟ್ ಎಂಜಾಯ್ ಮಾಡಕ್ ಆಗಲ್ಲ. ಅದಕ್ಕೆ ರೋಡ್ ಇರಲ್ಲ.
ಈಗ ಈ RSA ಬಂದಿರೋದು ಯಾವ ಇದ್ರ ಮೇಲೆ?
ಅದು FDP ಮೇಲೂ ಫೈನಲ್ ಆರ್ಡರ್ ಮಾಡುವಾಗ ಅದು ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಿದ್ರು, ನಮ್ಗೆ ಕನ್ಸಿಡರ್ ಮಾಡಿದೆ. ಅದ್ರ ಮೇಲೆ
ನಿಮ್ಮ ಪ್ರಕಾರ FDP ನಲ್ಲಿ ಎ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ಇನ್ನು ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತಿರಲ್ಲ?
ಎ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ಐ ಡೂ ಅಗ್ರಿ ಬಿಕಾಸ್ ವಿ ಹ್ಯಾವ್ ಗಿವನ್ ಅಪ್ ಅವರ್ ಶೇರ್. Daughters have given up their share in the A schedule property.
ಇಲ್ಲ ರೀ, ಇಲ್ಲಿ FDP ಮೇಲೆ ಬಂದಿರೋದು.
ನಾಲ್ಲ ಸರ್, FDP ಮೇಲೆ ಬಂದಿದ್ವಿ. ಅದ್ರ 4 properties are there. Out of 4 properties,
FDP ನಲ್ಲಿ ಎಷ್ಟು ಪ್ರಾಪರ್ಟಿ?
4 properties ಇದೆ ಸ್ವಾಮಿ.
4 ಪ್ರಾಪರ್ಟಿನೂ ಡಿಸೈಡ್ ಆಗಿದೆ ಇಲ್ಲ?
4 properties ಡಿಸೈಡ್ ಆಗಿದೆ. ಆದ್ರಲ್ಲಿ ರಿಮಾಂಡ್ ಮಾಡಿದ್ದಾರೆ. We have no objection.
ಪೆಂಡಿಂಗ್
ಇದೆ. We have no objection for it.
ಅದಕ್ಕೆ ಅಲ್ಲೇ ಹೋಗಿ ಶೆಡ್ಯೂಲ್
FDP in respect of A schedule property is pending itre, in view of this B schedule property no let it be decided in the FDP court.
I have no objection.
ಮಾಡಬಹುದಾ?
ಮಾಡಬಹುದು.
ಈ RSA ಹಂಗೆ ಡಿಸ್ಪೋಸ್ ಮಾಡೋದು.
ಆಮೇಲೆ ಇದು ತಿರ್ಗಾ ಇದು ಒಂದು ಆಗ್ತದೆ ಸ್ವಾಮಿ. C schedule property ಹೌಸ್ ತಂದು ಡಿಸೈಡ್ ಆಗ್ಬಿಟ್ರೆ ಆಯ್ತು. C schedule property ಅನ್ನು ರೆಫರ್ ಮಾಡಿ. ನಾನು ಐ ಹ್ಯಾವ್ ನೋ ಅಬ್ಜೆಕ್ಷನ್.
ಅಲ್ಲೇನೇ ಮಾಡ್ಕೋಬಹುದಲ್ಲ?
ಆಗಬಹುದು ಸ್ವಾಮಿ. ಐ ಹ್ಯಾವ್ ನೋ ಅಬ್ಜೆಕ್ಷನ್. ಇಟ್ ಮೇ ಬಿ ಡಿಸ್ಪೋಸ್ಡ್.
ಮೂರು D is already sold. That is not in question.
We are not questioning.
Already sold.
Yes, property.
Other than dispute ಇಲ್ಲ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದ್ರ ಬಗ್ಗೆ ನಾನು ಕೇಳಿಲ್ಲ ನಾನು.
ಆಯ್ತು. Heard the appellant counsel and also the counsel appearing for the respondent, and both parties submit that no dispute with regard to the D schedule property is concerned since the same is already sold. ಹೌದಾ?
ಹೌದು.
The counsels appearing for the appellants also submits that FDP is pending in respect of the A schedule property is concerned. And counsel appearing for the appellant would submit that the decision taken by the FDP court in respect of B schedule property,
B and C schedule properties.
B and C schedule property is not correct, and the same is also objected before the FDP court, but those objections are not considered.
Yes, ma'am.
Considered. The counsel appearing for the respondents would submit that the matter may be remitted back to the FDP court for consideration of A, B and C schedule afresh in view of the objections raised by the parties.
Yes, ma'am.
And matter can be heard and disposed of.
Fixing your time, my lord. Fixing your time.
Disposed of. Consider in view of the objections raised by the appellant for the beneficial enjoyment of the property. Parties. Agboda? And hence the order passed by the trial court in FDP is set aside, and confirmation, confirmation, confirmation made by the first appellate court in respect of A, B and C schedule.
Also.
B and C schedule property is also set aside, and in view of the said submission, now the issue remains only in respect of A, B and C schedule properties. And counsel also brought to notice of this court earlier, while mentioning in FDP, wrongly mentioned the
schedule C as D, D as C.
Schedule C as D schedule property.
And D as C schedule.
And D as
C schedule.
C schedule property. Houdala? And hence the FDP court is directed to dispose of the same within a time bound period of 6 months, 3 months.
ಇಲ್ಲ ಮೇಡಮ್ 6 months ಆಗ್ಲಿ ಅವ್ರು, ಯಾಕಂದ್ರೆ ಇದೆಲ್ಲ ಹೋಗಿ ಆಗುತ್ತೆ.
6 months. And hence parties are directed to appear before the FDP court on 6/1/2026 without expecting any notice.
Much okay.
My lords are not opined on merits ಅಂತ. Lords are not opinion on merits.
Afresh ಅಂತ ಹೇಳಿದ್ರು.
Afresh ಅಂತ ಹೇಳಿದ್ರು.
And the FDP court is directed to consider the grievances of appellants and respondents on merits.
Yes. Much grateful.
7. SK Acharya.
Hardship permits. Say.
Why it was parted in the earlier occasion?
That time may not.
Order sheet kodi madam.
For the purpose of producing the citation, that one judgment of this. How?
Matter heard in part, matter is listed for admission and the learned counsel for the respondent.
On Supreme Court judgment.
He will quote a decision.
Yes, my lord.
Yen first one to recollect madi memory na yen matter and what is that
memo? It's a suit for partition. Dependent 1 to 6 are the appellants.
1/3 share grant aaytu. Ammanna having 1/3 share and his share devolves upon his children, that is first plaintiff and defendant number 7 to 9. Hence they are entitled for 1/12 share in the plain schedule property. Jeremiah Ammanna having 1/3 share and his share devolves upon his children, that is yak 1/12 yak barutte. 1/12 ಅಂದ್ರೆ 1/3 ಅಲ್ಲಿ 1/12 ಅದು ಡಿವೈಡ್ ಆದಾಗ ಆಯ್ತು. ಅಲ್ಲೇನು ಅಪೋರ್ಷನ್ಮೆಂಟ್ ಅಲ್ಲೇನು ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲ. 1/12 is correct.
Entitlement of the plaintiff to claim partition itself is there.
ಅದು ನೀವು
We are the
ಡಿಪೆಂಡೆಂಟ್ಸ್ ಅಪೀಲಲ್ಲೂ ಕನ್ಫರ್ಮ್ ಆಗಿದೆಯಾ?
ಹೌದು.
Now what is your ground?
Yes. The plaintiff's claim is that Hassel, Jeremiah and Benoni, they were the children of one Daniel Ammanna.
Daniel
Ammanna.
ಯಾರ್ಯಾರು ಅದು ಪ್ಲೇಂಟಿಫ್ ಮತ್ತೆ?
ಅಲ್ಲ, Hassel, Jeremiah
ಅದೇ ಪ್ಲೇಂಟಿಫ್.
Benoni.
Plaintiff herself.
Plaintiffs 2 and 3.
2 and 3 ಅಂದ್ರೆ
10th defendant.
2 is Reginald Ammanna.
Yes.
And Hebik Ammanna. ಹೌದಾ?
ಆನಂತರ 10th defendant. They are the children of Jeremiah.
And 10th defendant
Jeremiah.
Margaret Ammanna.
ಹೌದು.
Margaret Ammanna. ಹೌದಾ?
ಆನಂತರ first plaintiff, defendants 1 to 9 are the children of Hassel Ammanna.
ಅಲ್ಲ, ಫಸ್ಟ್ ಒನ್ ಯಾರ ಮಕ್ಕಳು? ಪ್ಲೇಂಟಿಫ್ 2 and 3 and defendant
2 and 3 Jeremiah. ಇವರು first plaintiff is the
ವತ್ಸಲ
ಹೌದು
ಅವರು
ಅವರು ಹಸ್ಸೆಲ್ ಅಮ್ಮಣ್ಣ ಆ ನಂತರ ಡಿಪೆಂಡೆನ್ಸ್ 7 to 9.
plaintiff number 1
ಹೌದು ಮತ್ತೆ ಡಿಪೆಂಡೆನ್ಸ್ 7 to 9.
7 to 9
ಹೌದು
are children of
ಹಸ್ಸೆಲ್
Harshal.
ಹಸ್ಸೆಲ್
Harshalla.
ಹೌದು ಡಿಪೆಂಡೆನ್ಸ್ 2 to 6 and deceased Jayamal. Jayananda.
This is
Jayananda. Where are the children of Benoni Amman. Dependent 2 to 6 are the contesting person.
2 to 6 are contesting.
ಹೌದು
ಈಗ appeal ಬಂದಿರೋದು ಯಾರು?
ನಾವೇ.
ನೀವೇನೆ D 2 to 6
ಹೌದು ಡಿಪೆಂಡೆಂಟ್ಸ್ 1 to 6 are the appellates. First dependent is the wife of Jayananda.
Wife.
ಹೌದು
first appellant.
Yes. Now according to the plaintiffs.
ಜಯಾನಂದನ್ ಎಷ್ಟನೇ ಮಾಡಿದ್ರು ರೆಸ್ಪಾಂಡೆಂಟ್?
ಅಲ್ಲ ಅವರು ತೀರಿ ಮೊದಲೇ ಹೋಗಿದ್ದಾರೆ.
ಸೂಟಲ್ ಇರ್ಲಿಲ್ಲ.
ಇಲ್ಲ
ಸೂಟಲ್ ಇರ್ಲಿಲ್ಲ. ಬಟ್ ನೀವೀಗ ಅಪಲೆಂಟ್ ನಂಬರ್ 1 ಅಂದ್ರೆ ಸೂಟಲ್ ಇಲ್ಲ ಅಂದ್ರೆ ಹೆಂಗ್ ಬರ್ತೀರಿ ಇಲ್ಲಿ?
ಅಲ್ಲ ಸೂಟಲ್ ಅಂದ್ರೆ ಅವರ ಹೆಂಡತಿ ಇದ್ದಿದ್ದು.
ಹೆಂಡತಿ ಇದ್ರ?
ಹೌದು ಫಸ್ಟ್ ಡಿಪೆಂಡೆಂಟ್.
ಅದೇ ಫಸ್ಟ್ ಅಪಲೆಂಟ್.
ಹೌದು
ಅಲ್ಲಿ D1.
ಹೌದು
D1 ಹೌದಾ? D1
ಹೌದು.
ಈಗ D2 to D1 to 6 ಈಗ ಅಪಲೆಂಟ್ಸ್. ಹೌದಾ?
ಹೌದು.
ಪ್ರಾಪರ್ಟಿ ಒರಿಜಿನಲಿ ಬಿಲಾಂಗ್ಸ್ ಟು
property schedule according to the plaintiffs. It was a Mulageni property. One Vishay put Palanna had taken the property on Mulageni on 9/2/1933. One Nabirajaya Maramma Hegade was the Mulagar of the property. Thereafter, the Vishay Palanna transferred it to 3 children of Daniel Ammanna. As per Mulageni dated 4/10/1934.
1934. Originally basis 9/12/33.
33
and 4/10/34 transferred to the
Hassel, Benoni and Jeremiah. That is Mulageni transfer. Now after the advent of Karnataka Land Reforms Act, Benoni Ammanna filed declaration. And
only one.
ಹೌದು
Benoni Ammanna.
ಹೌದು. And occupancy right was granted in his name on 5/4/1978. This the plaintiff's claim that the declaration was filed for and on behalf of all the other children of Daniel Ammanna. Therefore, it inures to their benefit. This is the contention. Now, Benoni Ammanna has contended that it was his individual lease. He has filed the declaration in his individual capacity. Therefore, that will not inure to the benefit of the other children. Now, if your lordship sees the order of the tribunal and the form number 7, the claim is made against one Kamala Pujar. The lease and the tenancy is claimed under one Kamala Pujar. The tribunal has granted the occupancy right. And this order is not questioned by the plaintiffs. The lease that is claimed by the plaintiff and the lease that is claimed by the Benoni Ammanna are totally different. They are not claiming under that lease. Now that order of the tribunal has become final. Therefore, they cannot claim that the claim made by the.
What do you say with regard to the earlier Mulageni of 1933 and also 4/10/1934?
ಅಲ್ಲ 4/10/34 ಇರಬಹುದು ಆದ್ರೆ lease is claimed under Kamala Pujar.
But what is the basis for that?
ಅಲ್ಲ ಅದನ್ನು ನಾವು we cannot question, my lord. We cannot question in this proceeding.
ಆಯ್ತ್ರಿ, ಬಟ್ ನಾನ್ ಹೇಳ್ತಾ ಇರೋದು ನಿಮ್ಮವನೇನ್ ಬೆನೋನಿ ಅಮ್ಮಣ್ಣ ಕೇಳ್ತಾನಲ್ಲ, ಅವ್ರಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದ್ ಯಾವ ಬೇಸಿಸ್ ಮೇಲೆ? ಅರ್ಲಿಯರ್ 3 ಜನದ ಪರವಾಗಿ ತಾನೆ?
ಹೌದು. ಆನಂತರ there was a mortgage
in favor of Hassel Ammanna.
ಹೌದು.
Ammanna and Benoni Ammanna.
ಹೌದು.
When the same is given in favor of all the 3, maybe in the individual name Benoni Ammanna has.
That was under a different landlord, my lord. That was under a different landlord.
Where landlord?
Nabiraj. Vishay Palanna was the Mulageni tenant.
ಅಲ್ಲ ಅದೇನೋ
ಹೌದು.
ವೇಷಯ ವೇಷಾಯ ಪಾಲಣ್ಣ.
ಹೌದು, ಅವರು ಇಲ್ಲಿ ಕಮಲ ಪೂಜಾರ್ತಿ.
ಕಮಲ ಪೂಜಾರ್ತಿ ಅಂದ್ರೆ ಅವ್ರವ್ರಿಗೆ ರಿಲೇಷನ್ ಹೆಂಗೆ?
ಮಿಲಾಡ್, ವಾಟ್ ಹ್ಯಾಸ್ ಹ್ಯಾಪನ್ಡ್ ಇಸ್
ವೇಷಾಯ ಪಾಲಣ್ಣನ್ಗೂ ಕಮಲ ಪೂಜಾರಿಗೂ ಏನ್ ರಿಲೇಶನ್ಶಿಪ್?
ಏನಿಲ್ಲ. There is no relationship. But what has come in evidence is,
ನಿಮ್ಮ ಪ್ರಕಾರ once it was ಮೂಲಗೇಣಿ by one ವೇಷಾಯ ಪಾಲಣ್ಣ son of Manuel Palanna from Nabriyaza Maramma Hegade as per terms of registered ಮೂಲಗೇಣಿ 9/12/33, and the same was transferred in favor of the three persons, Hassel Ammanna, Jeremiah Ammanna and Benai Ammanna. ಮೂರ್ ಜನ ಹೆಸರಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ಮೇಲೆ how this Kamala Pujari comes into picture?
There was a mortgage in favor of Kamala Pujari.
Mortgage ಮಾಡಿದ್ದಾರೆ.
Mortgage ಮಾಡಿದ್ದಾರೆ.
ಯಾರು ಮಾಡಿದ್ರು?
48 ಅಲ್ಲಿ.
ಯಾರು ಮಾಡಿದ್ರು?
48 ಅಲ್ಲಿ ಇವರು ಮೂರು ಮಾಡಿದ್ದಾರೆ.
ಮೂರು ಜನ ಸೇರ್ ಮಾಡಿದ್ದಾರೆ.
That was released by Benoni Ammanna. He exclusively released it.
ರಿಲೀಸ್ ಅನ್ನೋದಕ್ಕೆ ಎಲ್ಲಿದೆ ದಾಖಲೆ? ಅದಕ್ಕೆ ನೀವು ರಿಲೀಸ್ ಮಾಡಿದ್ಕೆ ಎಕ್ಸ್ಕ್ಲೂಸಿವ್ಲಿ ರಿಲೀಸ್ ಮಾಡ್ಕೊಂಡಿರೋದಕ್ಕೆ ಎಲ್ಲಿದೆ? ಈಗ ಆಲ್ ದಿ ತ್ರೀ ಮಾರ್ಟ್ಗೇಜ್ ದಿ ಪ್ರಾಪರ್ಟಿ ಇನ್ ಫೇವರ್ ಆಫ್ ದಿ ಕಮಲ ಪೂಜಾರ್ತಿ. ಹೌದಾ?
ಹೌದು.
ದೆನ್ ಈ ಬನಾನಿ ಅಮ್ಮಣ್ಣ ಗಾಟ್ ರಿಲೀಸ್ಡ್ ಇನ್ ಹಿಸ್ ಫೇವರ್ ಅಂತ ತೋರ್ಸಕ್ ಎಲ್ಲಿದೆ ದಾಖಲೆ? 1948 ಅಲ್ಲಿ.
That is stated and that is not disputed. What dependent number 1 says, DW1 says he does not know. And he does not know whether.
ಆಯ್ತು, ನಿಮ್ ಬೆನ್ನನಿ ಅಮ್ಮಣ್ಣ on what capacity he filed an application before the authority?
As tenant.
Tenant.
As tenant.
Tenant only in individual capacity.
He and his family. His family includes his wife and children. They have.
The application ಇದೆ. Copy of the application ಇದೆ. How you can exclude other two? How you can exclude others too?
I have released the mortgage.
ಅದಕ್ಕೆ ಎಲ್ಲಿದೆ ಅದು ಡಾಕ್ಯುಮೆಂಟ್ ಎಲ್ಲಿದೆ?
It is not disputed at all, my lord. Evidence ನೋಡಿದ್ರೆ
ಅವ್ರ ಕ್ಲೈಮೇ ಹಂಗೆ. ಇಲ್ಲ ಒರಿಜಿನಲ್
ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಹೀಗೆ ಹೇಳ್ತಾರೆ.
ಒರಿಜಿನಲ್ ಮೂಲಗೇಣಿ in the year 1933
ಇಲ್ಲಿ
and the same was transferred by way of registered ಮೂಲಗೇಣಿ in favor of 3.
ಹೌದು.
Then all this got the
ಇಲ್ಲಿ ಅವರ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ. ನಂತರ ಪ್ರತಿವಾದಿ 2-3 ತಂದೆ ಕಮಲ ಪೂಜಾರ್ತಿ ಅವರಿಂದ ಸದರಿ ಆಸ್ತಿಯನ್ನು ಗೇಣಿಗೆ ಪಡೆದುಕೊಂಡು ಅವರು ಅನುಭವಿಸುತ್ತಾ ಬರುತ್ತಿದ್ದಾರೆಂದರೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ದಾವಾ ಆಸ್ತಿಯ ಮೂಲತಃ ಗೇಣಿ ಆಸ್ತಿ ಆಗಿದ್ದರೂ ಸಹ ಪ್ರತಿವಾದಿ 2-6 ಅವರ ತಂದೆ ಕಮಲ ಪೂಜಾರ್ತಿಯನ್ನು ಗೇಣಿಗೆ ಪಡೆದ ಎಂದರೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಆದ್ದರಿಂದ ದಾವಾ ಆಸ್ತಿ
ಅವರು ಬರಲಿ ನೋಡೋಣ. ನೋಟಿಸ್ ಇಶ್ಯೂ ನೋಟಿಸ್
ರೆಕಾರ್ಡ್ಸ್
ಇಶ್ಯೂ ನೋಟಿಸ್ ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್. ಏನ್ ಮಾಡ ಪಾರ್ಟೆಡ್ ಫ್ರಮ್ ರಿಲೀಸ್ ಹರ್ಡ್ ಮಾಡ ಪಾರ್ಟೆಡ್ ಆದ್ಮೇಲೆ ಈಗ ನೋಟಿಸ್ ಮಾಡಾಯ್ತಲ್ಲ ಆರ್ಡ್ರು. ಪಾರ್ಟೆಡ್ ಹೋಗ್ತದೆ ಹಂಗೆ ಬೇಕದು. ಆಯ್ತು, ರಿಲೀಸ್ ಫ್ರಮ್ ಪಾರ್ಟೆಡ್ ಇಶ್ಯೂ ನೋಟಿಸ್ ಅಂಡ್ ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್. ಯಾಕೆಂದ್ರೆ ಅದು ಹಂಗೆ ಉಳಿಯುತ್ತೆ ಅಂತನಾ? ಆಯ್ತು, ನೆಕ್ಸ್ಟ್
Admission matter 28.
ಹರೀಶ್ ಭಂಡಾರಿ ಟಿ ಚಂದ್ರಕಾಂತ್ ತಾರೀಖ್ ಏನಾಯ್ತು? ಸೆಟಲ್ಮೆಂಟ್ ಆಯ್ತಾ?
ಅಳತೆ ಮಾಡೋದಂತೆ 30 ಸೆನ್ಸ್ 20 ಸೆನ್ಸ್ 4 ಸೆನ್ಸ್ ಅಲ್ಲಿ ಮಾತ್ರ ವ್ಯತ್ಯಾಸ ಇದೆ. ಭಾನುವಾರ ಅಳತೆ ಮಾಡಿ ಡಿಮಾರ್ಕ್ಮೆಂಟ್ ಮಾಡೋದು ಅಂತ ಫೋನ್ ಮಾಡಿ ಹೇಳಿದ್ರು ನನಗೆ.
ಆಯ್ತು, ಈಗ ಯಾವತ್ತು
ಅಡ್ವೊಕೇಟ್ ಸ್ಪೋಕನ್ ಟು ದೇರ್ ಆಲ್ಸೋ ಕಮ್ಯುನಿಟಿ.
ಯಾವಾಗ ರಿಪೋರ್ಟ್ ಮಾಡ್ತೀರಿ?
ಭಾನುವಾರ ಆದ್ಮೇಲೆ ಒಂದು ಡೇಟ್ ಕೊಡಿ.
ಯಾವತ್ತು ಬೇಕು ನೀವೇ ಹೇಳಿ. Appellant counsel submit that they are going to survey the land on Sunday. Hence list this matter on ಬುಧವಾರ ಹಾಕ್ಲಾ?
ಬುಧವಾರಕ್ಕೆ ಬೇಡ ಸರ್, ಬುಧವಾರಕ್ಕೆ ಶಾಲೆ.
ಮತ್ತೆ ಯಾವಾಗ ಕೇಳಿ. ಆಮೇಲೆ ಇರೋದೇ 2 ದಿವಸ ವೆಕೇಶನ್.
ವೆಕೇಶನ್ ಬೇಡ. ಗುರುವಾರಕ್ಕೆ ಹಾಕೊಳ್ಳಿ ಸ್ವಾಮಿ.
ಗುರುವಾರ 18-12 ಆಯ್ತು. Hence list this matter on 18-12.
US matter ಫೈನಲ್ ಡಿಗ್ರಿ.
ಏನ್ ಫೈನಲ್ ಡಿಗ್ರಿ?
ಡ್ರಾಯಿಂಗ್ ಆಫ್ ದಿ
ಏನಾಗಿದೆ? ಸ್ಟೇಜ್ ಏನಿದೆ ಅದು?
ಫೈನಲ್ ಡಿಗ್ರಿ ನೋಟಿಸ್ ಆಗಿದೆ
ಅಷ್ಟೇ, ಬರೀ ನೋಟಿಸ್
ಆಗಿ
ಏನಿಲ್ಲ. ಯಾಕೆಂದ್ರೆ ನೀವ್ ಹೇಳೋ ಥಿಯರಿ ನಾನು ಐ ಆಮ್ ನಾಟ್ ಅಕ್ಸೆಪ್ಟೆಡ್ ಎನಿ ಹೌ ಇನ್ ದ ಪ್ರೆಸೆನ್ಸ್ ಆಫ್ ದೆಮ್ ಓನ್ಲಿ ಯು ಕ್ಯಾನ್ ಡಿಸೈಡ್ ಅಂತ. ಯಾಕೆಂದ್ರೆ ಮೂಲಗೇಣಿ ಒರಿಜಿನಲ್ ಟ್ರಾನ್ಸ್ಫರ್ ಇನ್ ಫೇವರ್ ಆಫ್ ದ 3 persons ಬಟ್ ಓನ್ಲಿ ಒನ್ ಅಮಂಗ್ ದೆಮ್ ಹ್ಯಾಸ್ ಫೈಲ್ಡ್ ಅನ್ ಅಪ್ಲಿಕೇಶನ್. ಓಕೆ, ಹೌ ಕುಡ್ ಇಟ್ ಬಿ? ದ ಕೆಳಗಿನ ಕೋರ್ಟ್ 2 ಕೋರ್ಟ್ ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡಿದ್ದಾರೆ. ಆಯ್ತು, ಬರ್ಲಿ ನೋಡೋಣ ಅವ್ರನ್ನ. ಆಯ್ತು, 18-12 ಏನೋ ಸರ್ವೆ ಮಾಡ್ತಾರಂತಲ್ಲ. ಆಯ್ತು, ಬನ್ನಿ ಅವತ್ತು ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ ಇಟ್ಕೊ ಬನ್ನಿ ಇಬ್ರು. Suit for specific performance.
Specific performance 61 cents ಅಲ್ಲಿ ಆಯ್ತು ಅರ್ಧ ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ನಾನು ಮಾತಾಡ್ದೆ.
ನೋಡಿ
29, Vaikant Sharma.
Vaikant Sharma.
I appear for the appellants, my lord.
Yes.
This matter, suit for partition is filed, challenging the sale deed made by the father and his brothers. And
ಆಯ್ತು
where
ನಾನು ಓದಿದ್ದೀನಿ ಕೇಳಿದ ಉತ್ತರ ಕೊಟ್ಬಿಡಿ ಅಷ್ಟೇ. ಐಟಮ್ ನಂಬರ್ 2 ಗೆ 1/4 ಶೇರ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಸರಿ.
ಹೌದಾ?
ಹೌದು ಐಟಮ್ ಅದು ಮನೆದು. ಬಟ್ ದಿ
ಫಸ್ಟ್ ಐಟಮ್ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದಾರೆ.
ಹೌದು.
ಅಪೀಲ್ ಅಲ್ಲಿ ಅದನ್ನು ಕೂಡ ಕನ್ಫರ್ಮ್ ಮಾಡಿದ್ದಾರೆ.
ಹೌದು.
ಈಗ ನಾವು ದಿಸ್ ಅಪೀಲ್ is against the dismissal of item number 1.
One only.
Now there is a concurrent finding.
Yes.
What is the error in the order of both the courts in respect of issue number 1?
Yes. Your lordship may kindly see, the property is claimed as ancestral property by us. They are mentioned even in the sale deed executed in favor of the third defendant that it is a pitrarjita. And plaintiffs are not parties to the sale deed. Our paravagi
sale ಮಾಡಿದವರು ಯಾರು?
Sale ಮಾಡಿದ್ದು father and father's brothers and not the plaintiff who was one of them is a major, others minors. Minor paravagi ಅಥವಾ ಇನ್ನೊಬ್ಬ ಮಗನ ಪರವಾಗಿ ಅಂತಲೂ ಬರೆದಿಲ್ಲ ಅದರಲ್ಲಿ. And that sale deed mentions ಪಿತ್ರಾರ್ಜಿತವಾಗಿ ಬಂದ ಅಂತ.
ಪಿತ್ರಾರ್ಜಿತವಾಗಿ ಬಂದ ಅಂತಿದ್ರೆ ಸೇಲ್ ಮಾಡಕ್ ರೀಸನ್ ಏನು?
ಅಲ್ಲ ಇನ್ನೊಂದು ಹೇಳ್ಬಿಡ್ತೀನಿ. ದಿ
ಸೇಲ್ ಮಾಡಕ್ ರೀಸನ್ ಏನು?
ರೀಸನ್ ತಂದೆಯಿಂದ ಮೊದಲು ಬಂದಿದ್ದು.
ಆಯ್ತು ಬಂದಿದ್ದಾಯ್ತ್ರಿ. ಫ್ಯಾಮಿಲಿ ನೆಸೆಸಿಟಿಗೋಸ್ಕರ ತಂದೆ ಚಿಕ್ಕಪ್ಪದಿರು ಎಲ್ಲರೂ ಸೇರಿಸಿ
ಅದು ಸೆಕೆಂಡರಿ ಥಿಂಗ್. ಅದಕ್ಕೆ ಮೊದಲು ಇದನ್ನು ನಾನು ಫಿನಿಶ್ ಮಾಡಿಬಿಡ್ತೀನಿ. ಐ ಆಮ್ ನಾಟ್ ಕ್ಲೈಮಿಂಗ್ 3 acres. ಐ ಆಮ್ ಕ್ಲೈಮಿಂಗ್ ಓನ್ಲಿ 1 share of ಬಸವರಾಜು ದ ಫಾದರ್, 1 acre ಮಾತ್ರ. ಅಂಡ್ ಇನ್ ದ ಅದರ್ 2 acres sold by the uncles.
You are not answering to the court question, counsel.
Yes, my lord.
ಅಣ್ಣ ತಮ್ಮದಿರಿಗೆ ಎಲ್ಲರಿಗೂ ಸೇರ್ ಬರೋದೇ 3 ಎಕರೆ. 3 ಎಕರೆನಲ್ಲಿ ನಿಮ್ಮ ತಂದೆಗೆ ಬರೋದು 1 ಎಕರೆ.
ಹೌದು.
But sale was made by the father and uncles for the family necessity. How can you challenge that sale?
ಅದರಲ್ಲಿ ಎವಿಡೆನ್ಸ್ ಇಲ್ಲ. The burden is on the purchaser to prove legal necessity.
ಸೇಲ್ ಆಗಿದ್ದು ಯಾವ ವರ್ಷದಲ್ಲಿ? ಅಪ್ಪನೂ ಚಿಕ್ಕಪ್ಪದಿರು ಮಾರಾಟ
94.
ಅದೇ ಐಟಮ್ ನಂಬರ್ 1 ಅದೇ ತಾನೆ?
Yes, my lord.
ಐಟಮ್ ನಂಬರ್ 1 ಅದೇ ಅಲ್ವಾ?
Item number 1, exhibit D1 is the original sale deed.
ಅದೇ ಯಾವ ವರ್ಷದ್ದು ಅಂತ ಕೇಳಿದೆ.
94 my lord. 1994.
ಯಾವಾಗ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದು? ಸೂಟ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದು ಯಾವಾಗ?
That is in 2012 because I did not know about that only when we were in possession of 1 acre and when they tried to disturb, I came to know, then I learned about the sale deed ಅಂತ ಹೇಳಿದ್ದೀವಿ. That is not a travel.
When all of them have sold 3 acres of land, how can be possession with you?
Allala, I am not claiming other 2. They have further sold and they are in possession of different persons. But ಈ portion
ಮೂರು ಜನ ಸೇಲ್ ಮಾಡಿದ್ಮೇಲೆ whether they have parted with the possession or not on the date of sale in the year 1994 ಕೊಂಡ್ಕೊಂಡವನು ಪ್ರಾಪರ್ಟಿ ಸ್ವಾಧೀನ ತಗೊಳ್ದಲ್ಲ ಹಂಗೆ ಇರ್ತಾನ. How can you claim that you are in possession in 2012?
That aspect has not been gone into by the courts below. But
that is the reason only both the courts passed an order against you only in respect of.
Correct. ಅದರಲ್ಲಿ ಔಸ್ಟರ್ ಇಲ್ಲ.
Is concerned.
No, ಔಸ್ಟರ್ ಇಲ್ಲ. My right is not sold. Father might have sold it, but father had no right to sell my right unless he has mentioned in that sale deed on behalf of the children also. ಆತರ recital ಇಲ್ಲ. And the legal necessity is not true.
That was in the year 1994.
ಹೌದು.
Why you kept quiet in 2012?
That is a question of
for about 18 years. For about 18 years.
I have stated there is no ouster. We were in possession of that portion. My father died. Then he died, my lord. Basavaraju is no more now. And
go to the reasoning of the trial court.
Trial court, my lord. The trial court, your lordship gets it in para.
In respect of issue number 1 is concerned.
Yes, my lord.
Because item number 2 is concerned, already granted 1/4 share.
Correct. No dispute. And there is no dispute regarding the other 2 acres also. I am not claiming it because they have further sold.
Item number 1 is concerned.
Yes, my lord. Item number 1 is concerned. Your lordship will see the trial court, my lord. Trial court, your lordship gets it in para 15 and 17. Para 15.
16 nodi.
Para 15.
Now the client is only questioning the sale deed executed in favor of defendant number 3 executed in respect of item number 1 property, but the said sale deed was executed by Jayanamma and her 3 sons Basavaraju, Ivanna and Siddhappa on 21/2/1994, but this suit was filed in the year 2012, even though as per plaintiff number 1 to 3, they are minors at the time of execution of the sale deed, but as per Article 60 of Limitation Act, to set aside a transfer property made by guardian of a ward, the suit has to be filed within 3 years when ward attaining the majority. Now in the case cast title, the age of the plaintiff number 1 to 3 shown as 33, 35, 30 respectively, but this suit filed after 3 years of attaining the age of majority. Further, as per Article 58 of the Limitation Act, to obtain any other declarations, suit has to be filed within 3 years when the right to sue first accrues. So in this case, the sale deed in respect of item number 1 was executed in the year 1994, but suit was filed in the year 2012. Hence, this suit is clearly barred by time. Further, suit item number 1 property was allotted to defendant number 1 in the oral partition. Hence, the said property is self-acquired property of defendant number 1, even though the sale deed was executed by Javanamma.
Yes.
Defendant number 1, defendant number 2, and deceased Sivanna, but only on the ground that it cannot be held that the suit item number 1 is joint family property. Hence, the defendant number 3 prays that suit item number 1 property is not ancestral and joint family property, and it is self-acquired property of Moolahatti Sannappa. Hence, the plaintiffs cannot claim share in the item number 1 of suit property. Then go to the appellate court order.
No, appellate court order. Yes, my lord. Appellate court order para 26, my lord. 26. Of course, 22 ಅಲ್ಲಿ class 1 class 2 ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. Para the other part is decided refer to in the para
23 ಹೋಗಿ
23 ಅಲ್ಲಿ item ನೋಡಿ item number 1 property self-acquired property of Sannappa, and he died leaving behind children, etc. This is absolutely wrong against the facts. It is mentioned as ancestral. It is not a self-acquired property of anybody. Anyway, that's another. The rule of construct heritage applies to this ಅಂತ ಹೇಳ್ತಾರೆ. This rule is absolutely wrong. Section 8 ಅಲ್ಲ section 6 ಬರಬೇಕು ಇದರಲ್ಲಿ. That is a wrong application of section the law by both the courts, and it is an ancestral property.
Whether section 6 applies or 8 applies, that is immaterial when the suit is filed for the relief of partition, when the same is barred by
when a relief suit is filed for partition, limitation is not there as against the son who is not a party.
Here is a sale in the year 1994 itself, then limitation attracts.
But I was not aware.
Para 16 of the trial court judgment.
My lord, one submission, my lord. If the sale deed is mentioned to as on behalf of the minors as well as the other son, I am out of court. But it is not executed on my
even if it is not mentioned for the legal necessity or any other reason, if any sale is made, once the minor attains the majority, they have to challenge that sale deed within 3 years. Whether they have challenged
that if it is sold on behalf of the minor. But I am not a party to the sale deed. If I am shown as party to the sale deed, it is different. Other aspect of
that's all your argument.
No, the other aspect. One submission, my lord. The other aspect, what your lordship observed, that legal necessity not is proved. It is not proved. And in the sale deed, it is mentioned that it is a pitarjita. The other 2 sale deeds also is exhibit P22, 23. It is mentioned as pitarjita.
You kept quiet for a period of 18 years.
Limitation aspect, I am only mentioning that I came to know of it. We were in possession, and when they disturbed, I filed the suit. That aspect has not been gone into
possession ನಿಮ್ಮ ಹತ್ರ ಇತ್ತು ತೋರ್ಸಕ್ಕೆ ಏನ್ ದಾಖಲೆ ಕೊಟ್ಟಿದ್ದೀರಿ?
ಅದಕ್ಕೆ ನಾನು ಎಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕಿದ್ದೆ ನೋಡಿ. ಎಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ ಐ ಇಸ್ ರಿಜೆಕ್ಟೆಡ್. ಅದರಲ್ಲಿ ಬಸವರಾಜ ಹೆಸರಿಗೆ ಇದೆ, ಫಾದರ್ ಹೆಸರಿಗೆ ಇದೆ ಅದು. ಎಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ ನೋಡಿ.
ಸೇಲ್ ಡೀಡ್ ಆದ್ಮೇಲೆ ಅವ್ರು ಖಾತೆ ಮಾಡಿಸ್ಕೊಂಡಿಲ್ವನು?
ಇಲ್ಲ, ಅದೇ ಪ್ರಾಬ್ಲಮ್. ಅಲ್ಲಿ ನಮ್ಮ ಐಎ ಜೊತೆ ಇವ ಲಕ್ಷ್ಮಿ ಕೈಲಿಸಿ ಐಎ ಜೊತೆ ನಾನು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹಾಕಿದ್ದೀನಿ, ರೆವೆನ್ಯೂ ರೆಕಾರ್ಡ್ಸ್. ಅದರಲ್ಲಿ ಪಿತ್ರಾಜಿತ್ ಅಂತ ಬರೆದಿದ್ದಾರೆ. ಇವರ MR ಇವರ ಹೆಸರಲ್ಲಿದೆ, ಬಸವರಾಜ್ ಹೆಸರಲ್ಲಿದೆ. ದಟ್ ಇಸ್ ಫಾದರ್. Additional document ನೋಡಿ, I have filed, that is rejected. So no ouster, and I came to know, that is why when I came to know, then the question comes, limitation, no ouster. That is why it's being a suit for partition. I am not challenging the sale deed on the ground that it is on behalf of the minors, etc. Not on behalf of even the major. One of them was a major at the time of sale. Legal necessity idru kuda alli prove ಮಾಡಬೇಕಲ್ಲ. No evidence regarding legal necessity. Enquiries ಮಾಡಿಲ್ಲ. Bona fide purchaser ಅಲ್ಲ. That aspect has to be, and section 6 is to be applied, not 8. ಈಗ para 20 ತಾವು ಓದಿದ್ರಲ್ಲ, ಅದರಲ್ಲಿ ಅವರು ಹೇಳ್ತಾರೆ once a partition takes place, oral partition, it is their separate property. ಅದು ಆಗೋದಿಲ್ಲ. It can't be separate property. It is a property of the family. Basavaraj and his sons, son and daughters, ಅದೆಲ್ಲ ಬರ್ತಾರೆ ಈಗ. And first son was major at that time. He never joined the sale deed. Legal necessity ಮಾತ್ರ ground. ಅದನ್ನು ಪ್ರೂವ್ ಮಾಡಿಲ್ಲ. Purchaser has not proved that. ಇನ್ನೆರಡು ಸೇಲ್ ಡೀಡ್ ಇದೆ ನೋಡಿ, ಅನ್ಕಲ್ಸ್ ಮಾಡಿದ್ದು, ಅದರಲ್ಲೂ ಬರೆದಿದ್ದಾರೆ ಪಿತ್ರಾರ್ಜಿತವಾಗಿ ಬಂದು ಓರಲ್ ಪಾರ್ಟಿಷನ್ ಬಂದ 1 ಎಕರೆ ಅಂತಲೇ ಬರೆದಿದ್ದಾರೆ. ಅದು P22-23 ಎಕ್ಸಿಬಿಟ್. ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಆದ್ರನ್ನ ಈ ಲಿಮಿಟೇಷನ್ ಆಕ್ಟ್ ಅಲ್ಲಿ ಆ ಸೆಕ್ಷನ್ಗಳು ಬರೋದಿಲ್ಲ. ಬಿಕಾಸ್ ಐ ವಾಸ್ ಇನ್ ಪೊಸೆಷನ್, ಬಸವರಾಜ್ ವಾಸ್ ಇನ್ ಪೊಸೆಷನ್. ಅದರ ಬಗ್ಗೆ ಎವಿಡೆನ್ಸ್ ಮಾಡಿಲ್ಲ, ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ. Courts below have not considered that possession and that part of the limitation, simply because it is beyond 3 years or 12 years or after attaining majority ಅಂತ ಮಾತ್ರ ಲಿಮಿಟೇಷನ್ ಹೇಳಿದ್ದಾರೆ. ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಅಲ್ಲಿ ಲಿಮಿಟೇಷನ್ ಇದಕ್ಕೂ ಬರುತ್ತಲ್ಲ.
ಈ D1 and D2 ಯಾರು?
D1 and D2 ಅಂದ್ರೆ ಡಿಫೆಂಡೆಂಟ್ಸ್ ಬೈ ಲಾಟ್. D1 is one uncle and D2 is a purchaser. D3 is the purchaser.
D3 is purchaser. D1 and D2.
ಹೌದು. D1 D2 ಅಂದ್ರೆ ಸಿದ್ದಪ್ಪ and ಬಸವರಾಜ.
ಮೂಲೆಹಟ್ಟಿ ಸಣ್ಣಪ್ಪ.
Yes. ಬಸವರಾಜು D1 is the father. D2 ಸಿದ್ದಪ್ಪ is his brother. D3 is ಅರಸು purchaser.
His uncle.
ಹೌದು, uncle, plaintiff uncle.
Plaintiff's uncle, ಹೌದಾ?
ಬಸವರಾಜು ತಮ್ಮ.
Told. This matter is listed for admission. I heard the counsel appearing for the appellant. The second appeal is filed against the concurrent finding. The factual matrix of case of plaintiffs before the trial court that defendant number 1 is the father of plaintiff number 1 to 3 and husband of plaintiff number 4. And while seeking the relief of partition and separate possession, contend that defendant number 1 and 2 are the brothers. They have sold the property in favor of defendant number 3. Sale deed dated 21/2/1994 in respect of item number 1 of the property, and the same not binds the plaintiffs and direct the defendants to put them in possession of 1/4 share each in the suit settled properties and grant such other relief. It is also the contention of plaintiffs that they are entitled for 1/4 share in the suit settled properties. And defendant number 3 appears and files the written statement that the suit is barred by limitation, and further contend that plaintiffs have no right in the suit property, and the defendant number 3 had purchased the property on 21/2/1994. And there cannot be any granting of share in favor of the plaintiff as claimed. The trial court allowed the parties to lead evidence and granted the relief in respect of item number 2 is concerned. And in respect of item number 1 is concerned, comes to the conclusion that sale deed was executed on 21/2/1994 and suit was filed in the year 2012. And also taken note of the fact that as on the date of filing of the suit, date of the sale, plaintiff number 1 to 3, they are minors at the time of execution of sale deed. But as per Article 60 of Limitation Act, to set aside a transfer of property made by the guardian of a ward, the suit has to be filed within 3 years when ward attaining the majority. Now in the cast title, the age of the plaintiff number 1 to 3 shown as 33, 35 and 30 respectively. Suit is filed after 3 years of attaining the majority. In paragraph number 17 also, the trial court comes to the conclusion that Article 58 of Limitation Act, to obtain any other declaration, the suit has to be filed within 3 years when the right to sue first accrues. So in this case, the sale deed in respect of item number 1 was executed in the year 1994, but the suit was filed in the year 2012, and hence comes to the conclusion that the same is barred by time. And also taken note of the fact that suit item number 1 property was allotted to the defendant number 1 in the oral partition, and hence the property become separate property of defendant number 1. And though it is mentioned as self-acquired property, and the same is separate property of defendant number 1. Even though sale deed was executed by Javanamma, defendant number 1, defendant number 2, and deceased Sivanna, but only on the ground it cannot be held that the suit item number 1 is joint family property, and hence in respect of item number 1, the plaintiffs cannot claim any share over the property and hence dismiss the suit in respect of item number 1. Being agreed by judgment and decree passed by the trial court, dismissal of suit in respect of item number 1 is concerned, an appeal is filed before the appellate court. The appellate court, having considered grounds urged in the appeal memo, when an application is also filed under Order 41 Rule 27 of CPC, and also considering the grounds, the point for consideration is also framed. Dismissal of suit in respect of item number 1 is based on sound and proper reasoning, and whether it requires interference of the court. And trial court, appellate court, having reassessed both oral and documentary evidence, answered the issue number 1 as negative and answered issue number point number 2 as affirmative, in coming to the conclusion that reasons are given in dismissing the suit in respect of item number 1 is concerned, and answered point number 3 also negative, confirming the judgment of the trial court. The first appellate court in detail discussed the material on record, particularly in paragraph number 20, that trial court has given anxious consideration to the arguments advanced by the parties, and specifically contended that suit item number 1 property originally belongs to Mule Hatti Sannappa, who died leaving behind his wife and 3 children. The plaintiffs are the children and wife of the first son of Mule Hatti Sannappa. In other words, the plaintiff number 1 to 3 are the grandchildren of the said Sannappa, and the plaintiff number 4 is the daughter-in-law of the said Sannappa. It is not in dispute that defendant number 1, who is the father of the plaintiff number 1 to 3 and husband of the defendant number 4, died during the suit. According to the plaintiff, the property originally belongs to Mule Hatti Sannappa and he died as rightly argued by the defendant number 3, Section 8 of the Hindu Succession Act 1956 applies to the case on hand with regard to the general succession, and Section 8 also taken note of, and in para 23 also taken note of. Defendant number 3 further content that since property is alienated much prior to 2005 Hindu Succession Act Amendment Act, the alienation made prior to 9/9/2005 are saved. Hence, even assuming that the property in dispute is the ancestral property of the plaintiffs, they are not entitled for share in the suitable property. Admittedly, the children of Mulehatti Sannappa and his wife by name Javanamma has alienated the property on 21/2/1994. The sale deed exhibit P5 certified copy of the sale deed would go to show that all the children of deceased Sannappa and his wife Javanamma has executed the sale deed, wherein it also appears that possession of the suitable property is delivered on the date of the sale deed. And when the possession was parted with in the year 1994, limitation attracts. And having reassessed both oral and documentary evidence available on record, confirmed the judgment of the trial court. Being agreed by the concurrent finding, present second appeal is filed before this court. The main contention of the counsel appearing for the appellant before this court that both the courts have committed an error in not framing of proper issues and not casting and in not casting burden on the respondent number 2, defendant number 3 to prove the legal necessity for the alleged sale deed 21/2/1994. The counsel also vehemently contend that it is not the specific case that property was sold for legal necessity, and also contend that both the courts committed an error in while interpreting Section 6 and 8 of the Hindu Succession Act, and hence matter requires reconsideration. The counsel also would contend that the first appellate court committed an error in rejecting the application filed under Order 41 Rule 27 of Code of Civil Procedure, and hence it requires interference.
One more
Having
submission,
heard
one more submission there, my lord. The plaintiffs are not parties to the sale deed. Minors
the
and
counsel
major.
also would submit that plaintiffs are not parties to the sale deed. Having heard the appellant counsel and also on perusal of material, it is very clear that the property came to the father in a partition along with their brothers, and also sold the property by the plaintiff father as well as their uncles, and the same is not disputed by the plaintiff. It is also not a dispute that sale was made in the year 1994. The counsel appearing for the appellant would submit that the plaintiffs are minors at the time of sale, and trial court taken note of.
No, one was major, my lord. Only 2 minors. age alli haag barutte. Anyway, that's all.
Right. One was major, another 2 are minors. Howda?
Sari.
Major adavanu immediate agi hakbek suit.
Sari, avani partilla. That's all right.
That will not make any difference. Next,
it may not. Yes.
Taken note of the same. In paragraph number 16, when the relief is sought for the relief of partition and separate possession, and when the property was also sold in the year 1994, possession was delivered. But counsel would submit that possession is with the plaintiffs. And if that is the case, if possession with the plaintiffs and they came to know about only recently, no need of seeking for the relief of separate possession while seeking the relief of the partition and separate possession. And also relief is sought that sale deed of the year 1994 is not binding. The plaintiffs oblique appellants are not disputing the fact that property was sold on 21/2/1994. That sale deed was executed by the Javanamma and her 3 sons Basavaraju, Sivanna and Siddappa, and suit was filed in the year 2012, that is after 18 years. The trial court was also taken note of Article 60 of Limitation Act, to set aside a transfer of property made by the guardian of a ward, comma, the suit has to be filed within 3 years when ward attaining the majority. The trial court also taken note of the age mentioned in the plaint, wherein it is clearly mentioned that the age of the plaintiff number 1 to 3 respectively shown as 33, 35 and 30 respectively, and also taken note of the fact that suit is filed after 3 years of attaining their majority. And appellate trial court also in paragraph number 17 taken note of Article 58, wherein also discussion was made when the declaration is sought that so a sale deed is not binding. Suit has to be filed within 3 years when the right to sue first accrues. And sale deed was executed in the year 1994, but the suit was filed in the year 2012, and hence it is clearly barred by limitation. The very suit filed by the plaintiffs on the ground of limitation itself lacks, and other ground urged by the appellant counsel that the trial court as well as the appellate court having confusion with regard to attracting of section 6 and section 8. And no doubt it is settled law. No doubt it is the provision of law that in case if it is a coparcenary property, section 6 attracts. If it is a person, male Hindu, dies, section 8 attracts. But in the case on hand, when the suit is filed after lapse of 18 years, that too after the limitation period, whether it is section 6 attracts or 18 attracts are immaterial. And apart from that, the counsel appearing for the appellant would contend that the sale is not for the legal necessity, and whether it is for legal necessity or not also to be taken note of. When the suit is filed after 18 years, it is nothing but an attempt is made to make a wrongful gain, filing a suit after lapse of 18 years. And also when the sale deed was executed in the year 1994 itself, and family lost the property to the entire extent of the property of the father as well as their uncles who have joined in selling the property in the year 1994 itself with the grandmother and also the father and uncle. And when such being the case, the counsel appearing for the appellant would contend that they are in joint possession also cannot be accepted when the sale was made in the year 1994. And both the trial court as well as the appellate court taken note of material available on record, both question of fact and question of law, in filing a suit after lapse of 18 years, and answered the issue with regard to the limitation is concerned that suit is barred by limitation. And when suit is barred by limitation, under the circumstances, I do not find any ground to admit and frame any substantive question of law. In view of the discussions made above, I pass the following order. The second appeal is dismissed.
30. CG Ram Mohan.
Here for the appellant, Your Honor. Lord, the appellant is the member of a housing cooperative society, and the respondent is the housing cooperative society, Your Honor. The appellant was allotted site number 12 in the year 2000 on payment of rupees 91,500, Your Honor. Then in the year September 2000, lease cum sale deed was executed by the respondent society for a period of 10 years, Your Honor. Subsequently, the
lease cum sale yavaga?
Lease cum sale on September 2000.
And the same year?
Same year. Allotted 1 month prior. Allotment is on
allotment site number 12 in 2000.
Yeah. And this cum sale deed was executed in September 2000 after 1 month. And possession of the site was given after 1 year, that is June 2001, possession of the site was given, my lord. Then this is a dispute between member and a housing cooperative society, Your Honor, which has been expressly barred under section 70 of the Karnataka Cooperative Societies Act, my lord. Such being the case, after lapse of 8 years, the respondent society, they demanded a higher amount for the site in order to execute the registered sale deed, which my appellant refused to pay, my lord. So then the cause of action started for the society to file the suit.
Lease cum sale execute ಮಾಡ್ಕೊಟ್ ಮೇಲೆ ಮತ್ತೇನ್ ಸೇಲ್ ಡೀಡ್
ಅಂದ್ರೆ ಸೇಲ್ ಡೀಡ್ ಅದು
ರೆಗ್ಯುಲರ್ ಸೇಲ್ ಡೀಡ್ ರೆಗ್ಯುಲರ್ ಸೇಲ್ ಡೀಡ್ ಮಾಡ್ಕೊಡ್ಲಿಲ್ಲ.
ಇದು ಲೀಸ್ ಕಮ್ ಸೇಲ್ ಅಂತ ಇಟ್ಬಿಟ್ಟಿದ್ರು. ಅಂಡ್ ಇಫ್ ಎನಿ ಅಮೌಂಟ್ ಇಸ್ ಟು ಬಿ ಪೈಡ್, ಎಕ್ಸಸ್ ಅಮೌಂಟ್ ದಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಪೈಡ್ ಅಂತ ಒಂದು ದಟ್ ಇಸ್ ಅ ಕಂಡೀಷನ್.
ಆಯ್ತು.
ದೆನ್ ದಿ ಅಪೆಲೆಂಟ್ ರೆಫ್ಯೂಸ್ ಟು ಪೇ when
excess amount.
Excess amount demanded after expiry of.
Whether demand is in writing or
that is on dated 28/8/2007 they have demanded. That is by way of show cause notice. They issued a show cause notice demanding excess money at the rate of 717 rupees per square yard, my lord. So which is not fair and also not legal. It is not logical also. So my client, that is the appellant, he sought some information in the year August 2008 by writing a letter. So they have not furnished the information sought for by the appellant to Your Honor. So they actually cause of action started at that point of time. So here instead of raising a dispute under the provision of 70 of Cooperative Societies Act, which is a special enactment for deciding a dispute between a member and the cooperative society. Section 71, subsection 1, B, my lord, it is very clear. It clearly says 70, subsection 1, B, notwithstanding anything contained in any law for the time being in force, if any dispute touching the constitution, management or business of a cooperative society arises, B, clause B, between a member, past member or person claiming through a member, past member or deceased member and the society, its board or any officer, agent or employee of the society, then such dispute shall be referred to the registrar for decision, and no civil or labor or revenue court or industrial tribunal shall have jurisdiction to entertain any suit or other proceeding in respect of such a dispute. And further, my lord, section 70, subsection 2A, that's also very clear touching this issue regarding business of the society, my lord. A claim by the society for any debt or demand due to it from a member of the nominee, heirs or legal representatives of a deceased member, whether such debt or demand be admitted or not. So the position of law is very clear, my lord. Here, the respondent society, instead of raising a dispute before the competent forum authority, they straight away filed a suit, my lord. That too after expiry of 13 years, filed a suit before the civil court under section 31 of the Specific Relief Act for cancellation of the lease cum sale deed and recovery of possession, which we have disputed, my lord. In a similar case, similarly situated case, my lord, there is next number RSA 126 of 23, actually listed before this honorable court. The honorable court has admitted the matter, and they have also issued a stay, my lord. This is the interim order dated 5th June 2023.
Issue involved between the parties is similar.
It is identical facts and law is involved in this matter, my lord. Similar matter, and also in another matter, RSA 95 of 23, that has now come for final hearing, my lord. In that case also stay has been issued. Matter has been admitted and stay has been issued. My humble submission to your lordship is,
alri hengri ondsari site allotment ಮಾಡಿದ ಮೇಲೆ ದುಡ್ಡು ಕಟ್ಟಿಸ್ಕೊಂಡ ಮೇಲೆ ಲೀಸ್ ಕಮ್ ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ಬರ್ಕೊಟ್ಟ ಮೇಲೆ ಕ್ಯಾನ್ಸಲ್ ಹೆಂಗ್ ಮಾಡ್ತೀರಿ?
My lords, because they refuse to pay The errors which was,
Why you have enhanced?
because the development charges.
You cannot once again demand higher rate.
The condition
At the time of grant, allotting the site itself, you have fixed the rate. Huda 91,500.
But a clause was mentioned saying
ಏನಂತ
that
clause?
if in case some extra amount ನಮ್ಗೆ ಏನಾದ್ರು ಖರ್ಚಾದ್ರೆ
Extra amount ಅಂತ ನೀವು ಬಾಯಿಗೆ ಬಂದಂಗೆ ಕೇಳಿದ್ರೆ?
ಇಲ್ಲ ಕೇಳಿರೋದೇ
ಮೊದಲೇ ಸೈಟ್ ಅಲಾಟ್ಮೆಂಟ್ ಸೈಟ್ ಅಲಾಟ್ಮೆಂಟ್ ಮಾಡುವಾಗ್ಲೇನೆ ನೀವು ಡೆವಲಪ್ಮೆಂಟ್ ಮಾಡಿ ಸೈಟ್ ಕೊಟ್ಟಿದ್ ತಾನೆ? ಅವಾಗ್ಲೇ ನೀವು ಫಿಕ್ಸ್ ಮಾಡಿ ತಾನೆ?
ನಾಟ್ ಕಂಪ್ಲೀಟ್ ಡೆವಲಪ್ಮೆಂಟ್.
ನಾಟ್ ಕಂಪ್ಲೀಟ್ ಮಾಡಿದ್ರೆ ಹೆಂಗ್ ಸೈಟ್ ಹೆಂಗ್ ಅಲಾಟ್ ಮಾಡ್ತೀರಿ ನೀವು?
But the errors which we are sought for is 1,24,000.
ಹೌದು ಆಯ್ತು, ಯಾಕೆ ಕೇಳ್ಬೇಕು ಜಾಸ್ತಿನಾ ನೀವು? At the time of allotment itself, you have fixed the rate 91,500. ಹೌದಾ? ಅಂದ್ ಕಟ್ಟಿಸ್ಕೊಂಡೇನೆ ನೀವು ಲೀಸ್ ಕಮ್ ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ಕೊಟ್ಟಿದ್ದು, ಹೌದಿಲ್ಲ? Then how you can demand more amount?
Even this issue
And
of
my lords, the suit is filed for cancellation of lease cum sale.
ಹೌದು, ಕ್ಯಾನ್ಸಲ್ ಹೆಂಗ್ ಕೇಳಿ ಮಾಡ್ತೀರಿ ನೀವು? ಒಂದ್ಸರಿ ನೀವು ದುಡ್ಡು ಇಸ್ಕೊಂಡು ಬರ್ಕೊಟ್ ಮೇಲೆ ಕ್ಯಾನ್ಸಲೇಷನ್ ಹೆಂಗ್ರಿ ಮಾಡಕ್ಕಾಗುತ್ತೆ? ನೀವು ಕೇಳಾಗುತ್ತೆ?
Because my lord,
ಎರಡು ಕೋರ್ಟ್ ಕಣ್ಣು ಮುಚ್ಕೊಂಡು ಆರ್ಡರ್ ಬರ್ದಿದ್ದಾರೆ, ಹೌದಿಲ್ಲ?
ಇದರಲ್ಲಿ ಲಿಮಿಟೇಷನ್ ಬಾರ್ ಆಗುತ್ತೆ ಸ್ವಾಮಿ. ಆಫ್ಟರ್ 13 years,
limitation, my lords, notice is issued in 2010.
ಬೇರೆ ಕೋರ್ಟ್ ಬೇರೆದ್ರಲ್ಲಿ ಇದೆಯಾ? ಸಬ್ಸ್ಟಾಂಟಿವ್ ಕ್ವಶನ್ ಆಫ್ ಲಾ ಇದೆಯಾ ಅಡ್ಮಿಟ್ ಆಗಿರೋದು? ಸೇಮ್ ಸಿಮಿಲರ್ ಮಾಡೋಣ, ಕಾನ್ಫ್ಲಿಕ್ಟಿಂಗ್ ಬೇಡ, ಎರಡು ಒಟ್ಟಿಗೆ ತಗೊಳ್ಳೋಣ ಎರಡು ಮ್ಯಾಟರ್ನ.
My lords, I have to approach civil court itself for cancellation of instrument. There is no.
How can you seek for that order ಅಂತ ನಾನು ಕೇಳ್ತಾ ಇರೋದು. You are not entitled.
6 ಇಲ್ಲೇ ಇದೆ.
Section 70 angry attract ಆಗ್ತದೆ.
70 because of this is a dispute between a member and housing society regarding the business of the society.
ಆಲ್ರೆಡಿ ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ಕೊಟ್ಟಿದಾರಲ್ಲ, ಮತ್ತೆ ಹೆಂಗ್ ಬರ್ತದೆ?
ಅಲ್ಲ, ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ಕೊಟ್ರು ಸ್ವಾಮಿ. ದಟ್
ಸೇಲ್ ಕಮ್ ಅಗ್ರಿಮೆಂಟ್ ಬರ್ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅಲ್ಲ, ಡಿಫರೆನ್ಸ್ ಅಮೌಂಟ್ ಅವ್ರು ಏನು ಈಗ ಇನ್ಸಿಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ, ದಟ್ ಹ್ಯಾಸ್ ಬೀನ್ ಸೆಟೆಡ್ ನಾಟ್ ಬೈ ದ ಕಾಂಪಿಟೆಂಟ್ ಕೋರ್ಟ್ ಇನ್ ಅನದರ್ ಮ್ಯಾಟರ್ ಸ್ವಾಮಿ. ಇದ್ರಲ್ಲೂ concurrent finding agide. KT also upheld
that
the
is
decision.
pending, my lords. Writ is filed. A stay is given
95 of 2023 matter nalli.
Third, heard the appellant counsel and also the counsel appearing for the respondent. And similar issue was raised in RSA number 26 of 23. And parties are also same. That is Health and Family Welfare Department and also the allottee. And a similar question was also involved in the matter. Matter already admitted and framed the substantive question of law. The substantive question of law framed in other appeal also, whether both the courts are justified in decreeing the suit notwithstanding the specific bar of jurisdiction of civil court under section 70 of the Karnataka Cooperative Societies Act to entertain a suit. And when such issue is already framed, the similar issue also arises in the second appeal also. Hence, registry is directed to post both the ಏನು ಅದ್ರ ಜೊತೆ ಬಂದಿದೆಯಾ? ಮತ್ತೆ ಅಡ್ಮಿಟ್ ಆಗಿರೋದು ಯಾವುದು? ಅದು ಅಡ್ಮಿಟ್ ಆಗಿದೆ. Non filing of ವಕಾಲತ್ by counsel for ಪ್ರಕಾಶ್ ತಿಮ್ಮಣ್ಣ. ವಕಾಲತ್ ಹಾಕಿಲ್ಲೇನ್ರಿ?
I'll file ವಕಾಲತ್.
ಹಾಕ್ತೀರಾ? ಹಾಗಾದ್ರೆ ಸೇಮ್, ಹಂಗಾದ್ರೆ ತಗೋಬೇಡಿ, ಪೋಸ್ಟ್ ಅನ್ನೋದು ಬೇಕಾಗಿಲ್ಲ. ಏನ್ ಮಾಡಿದ್ವಿ ಹೇಳಿ? And hence similar issue involves in similar substantive question of law arises in RSA 121 of 23 as well as RSA 1067 of 23. And hence these two appeals are admitted. And instead of framing similar issue, all these similar question, substantive question of law, all these appeals will be considered together, and common question of law already framed, substantive question of law framed in RSA 126 of 23 would be considered, and hence list the matter for final hearing. ಅದ್ ಮಾಡೋಣ, ಅದಿರ್ರಿ. ಆಯ್ತು, full stop. Heard on IA number 1 of 23 and there is a delay of 166 days in filing appeal in RSA 1067 of 23 and for the reason stating the accompanying application and already another similar matter is listed and framed substantive question of law. Delay of 165 days is condoned. ಆಯ್ತಾ? ನೆಕ್ಸ್ಟ್ ಏನ್ ಸ್ಟೇ ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಇದರಲ್ಲಿ?
ಎಸ್ ಸ್ವಾಮಿ.
ನಿಮ್ದ್ರ ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದೀರಾ?
ಹಾಕಿದೀವಿ ಸ್ವಾಮಿ. IA
1 of 23 for stay na?
Yes.
Heard the application filed by the appellant and there shall be an interim order of stay of operation, execution and implementation of the judgment and decree passed in OS number so and so and also in RA ಅಂತ ಹಾಕೋಬಿಡಿ ಮೇಡಮ್. And call for records ಇದ್ರದ್ದು separate ಅನ್ನ call for records both the courts. records ಬಂದ್ಬಿಟ್ಟಿದೇನಪ್ಪ, ಯಾವ್ದ್ರಲ್ಲಿ ಒಂದ್ರಲ್ಲಿ ಇದೆಯಲ್ಲ, 121 ಅಲ್ಲಿ ಇದೆ. ಈ 1067 ಅಲ್ಲೂ ಸೇಮ್ ರೆಕಾರ್ಡ್ಸ್ ಬೇರೆ ಬೇರೆ ರೆಕಾರ್ಡ್ಸ್?
ಅದು ಬೇರೆ ರೆಕಾರ್ಡ್ಸ್. ಬಟ್ ಮೈ ಲಾರ್ಡ್
ಯಾವುದು ಡಿಡಿ ಫೈಲ್? ಡಿಡಿ ಯಾವುದು? ಇನ್ನೊಂದು ಬೇರೆ ಅಲ್ವಾ ಹಂಗಾರೆ? ಆಯ್ತು. ರಿಜಿಸ್ಟ್ರಿ ಇಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್ ಆಫ್ ಬೋತ್ ದಿ ಕೋರ್ಟ್ಸ್ in respect of RSA 121 of 23 and RSA 1067 of 23. Post the matters, post all these matters immediately after winter vacation.
One submission my lord. ಇದು serial number 13 ಅಲ್ಲಿ ಬ್ರಾಕೆಟ್ ನಲ್ಲಿ ಫೈಲಿಂಗ್ ನಂಬರ್ 95 of RSA 96 of 23 ಅಂತ ಅದನ್ನ that is connected matter ಅಂತ ತೋರಿಸಿದ್ದಾರೆ. ಅದು that is a wrong ಇದು this is not pertaining to our case. It is
ಅಲ್ವಾ? ಅದು ಬೇಕಾಗಿಲ್ಲ. ಅದು ಯಾಕೆ ತೋರಿಸಿರ್ ಮತ್ತೆ ಅದು ಆರ್ಡರ್ ಇತ್ತಾ?
ಒಂದು ವಿಡ್ರಾ ಮಾಡೋದು
ಅದು ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ ಅಂತ ತೋರಿಸ್ತಾ ಇದೆ. ಬಟ್ ಇಸ್ ನಾಟ್ ಅವರ್
ಸೆಟಲ್ಮೆಂಟ್ ಅಂತ ವಿಡ್ರಾ ಮಾಡಿದ್ರು.
RSA 95
ಔಟ್ ಆಫ್ ಕೋರ್ಟ್ ಸೆಟಲ್ಮೆಂಟ್ ಅಂತ ಒಂದು ವಿಡ್ರಾ ಮಾಡಿದ್ರು.
ಬಟ್ ಇದು ಹಂಗಾರೆ ಇದು ಸಂಬಂಧಪಟ್ಟಿದ್ದಲ್ವಾ?
ನಮ್ದಲ್ಲ.
ಆಯ್ತು. ಅಪೆಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಟ್ಸ್ ದಟ್ RSA 96 of 23 DD file not connected to this appeal and hence registry is directed to delink the same. Delink ಮಾಡಿ ಅಷ್ಟೇ.
RSA 95 of 23 is a connected matter my lord. ಅದು ಡಿಫರೆಂಟ್ ಸುದರ್ಶನ್ ಅಂತ. ಬಟ್ ಇಲ್ಲಿ 96 ತೋರಿಸಿದ್ದಾರೆ.
ಮೊದಲು 96 ಅಂತ ತೋರಿಸಿದಾರಾ? 95 ಬೇಕಾ?
95 is has reached
95 ಬೇಕಾ?
ಬೇಕು ಸ್ವಾಮಿ, ಬೇಕು.
The registry is directed to put up RSA 95 of 23, correct?
Yes my lord.
95 of 23. Please list the matter in the third week of August. ಇದು ಅಂತ ಹಾಕ್ಬಿಡಿ, January 2026. Next 31. Non filing of amended cost title. Amendment ಹಾಕಿ ಮಾಡಿಲ್ಲ?
ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀನಿ.
ಹಾಕ್ಲಿಲ್ವಾ?
ಈಗ
ಹಾಕ್ಲಿಲ್ಲ?
ಈಗ ಆಗ್ತಾ ಇದೆ.
ಆಯ್ತು ಹೇಳಿ.
ಊರಲ್ಲಿ ಇರಲಿಲ್ಲ. Divergent findings, my lordship.
Why there are 4 appeals?
Lord, another 2 appeals are filed by me. Originally OS 2000 of 2006 was filed for partition.
Original suit number?
OS 2000 of 2006.
2000 of 2006
was filed for partition and separate possession. That was decreed on 15/11/2021, allotting 1/5 share. Thereafter, RA number 15002 of 22 was filed. 15002 of 22 was filed, challenging the judgment and decree by the first defendant.
So that is by first defendant.
First defendant. Innondu RA number 15014 of 2022 was challenged, was filed by the plaintiffs. Plaintiffs challenging the judgment and decree. Both these appeals, RA number 15002 is dismissed. RA number 15014 of 22 is allowed by order dated 26/7/2023, granting half share. Half share to
only
plaintiffs.
Instead of 1/5.
Instead of 1/5, it is only granted to defendant number 1 and plaintiffs half share based on a partition deed.
Defendant number 1 and plaintiff
only.
Female heir has been
This appeal is by the daughters who had got 1/5 share. Since it is denied in the appeal, they have come. I have come before the court challenging this on the count that this suit schedule property entirely falls to my share and I am the owner of this property. That is the one.
D1.
D1. There are two partition dates. One is 14/3/1973 and another is 33/1974.
33?
33/1974. ಮೊದಲನೇದು
74.
14/3.
First partition between whom?
Between father and sons.
Father and sons.
ಎರಡನೇದು between father and sons where signatures of the daughters are also there in the second partition.
Second one.
ಹೌದು. ಮೊದಲನೇದ್ರಲ್ಲಿ ಅಲಾಟ್ಮೆಂಟ್ ಇದೆ ಆದ್ರೆ ಅವ್ರ ಸಿಗ್ನೇಚರ್ಸ್ ಇಲ್ಲ.
ಅಲಾಟ್ಮೆಂಟ್ ಇದೆ ಅಂದ್ರೆ
ಅವ್ರಿಗೂ ಹೆಣ್ಮಕ್ಳಿಗೂ ಬೇರೆ ಪ್ರಾಪರ್ಟೀಸ್ ತೋರಿಸಿದ್ದಾರೆ.
ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅದ್ರಲ್ಲಿ ಹೌದು ಮೊದಲನೇದ್ರಲ್ಲೂ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಸಿಗ್ನೇಚರ್ ಇಲ್ಲ.
ಅವ್ರ ಸಿಗ್ನೇಚರ್ ಎರಡನೇದ್ರಲ್ಲಿ ಸಿಗ್ನೇಚರ್ಸ್ ಇದೆ.
ಬಟ್ ಅವರಿಗೂ ಅಲಾಟ್ಮೆಂಟ್
ಅವ್ರಿಗೂ ಅಲಾಟ್ ಮಾಡಿದ್ದಾರೆ ಆದ್ರೆ ಈ ಸೂಟ್ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿನ ಅಲಾಟ್ ಮಾಡಿಲ್ಲ ಹೆಣ್ಮಕ್ಳಿಗೆ.
ಯಾರಿಗೆ ಅಲಾಟ್ ಮಾಡಿಲ್ಲ?
ಹೆಣ್ಮಕ್ಳಿಗೆ ಕೊಟ್ಟಿಲ್ಲ, ಬರೀ ಗಂಡ್ ಮಕ್ಳಿಗೆ ಅಂತ ಇದೆ.
ಕೊಟ್ಟಿದ್ದಾರೆ.
ಹೌದು.
ಪಾರ್ಟಿಷನ್ ನಾವು ಅದನ್ನ ಇನ್ಸರ್ಷನ್ ಮಾಡಿದ್ದಾರೆ. ಯಾರಿಗೂ ಇಲ್ಲ. ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ಇನ್ಸರ್ಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ದಿಸ್ ಇಸ್ ಸೆಲ್ಫ್ ಅಕ್ವೈರ್ಡ್ ಪ್ರಾಪರ್ಟಿ ಆಫ್ ಗಿಡ್ಡಪ್ಪ, ವಿಚ್ ವಾಸ್ ನಾಟ್ ಅಟ್ ಆಲ್ ಪಾರ್ಟಿಷನ್ at any point of time. Therefore, we come before this honorable court. We are also entitled for 1/5 share. ಇದನ್ನ ಇವರು ಸಬ್ಸಿಕ್ವೆಂಟ್ ಆಗಿ ಇನ್ಸರ್ಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
ನೀವು 1/5 ಅನ್ನ ಕೊಟ್ಟರದ್ನ
only one property is involved in this particular suit, my lordship. That property has been.
ಆಯ್ತು, ನಿಮ್ದ್ರಲ್ಲಿ ಸಬ್ಸ್ಟಾಂಟಿವ್ ಕ್ವಶನ್ ಆಫ್ ಲಾ ಏನ್ ಅರೈಸಸ್ ಆಗೋದು? ಓನ್ಲಿ ಹಾಫ್ ಶೇರ್ ಮಾಡಿರೋ ತಪ್ಪು.
Yes, my lordship.
ಹೌದಾ?
Yes, my lordship.
That is the only substantive
Yes,
question of law.
moreover, my lordship, that findings, it is lot of confusion in the findings.
Confusion ಬಿಟ್ಬಿಡಿ, ಈಗ ಅದನ್ನ ಆಮೇಲೆ ಡಿಸೈಡ್ ಮಾಡೋಣ ಮೆರಿಟ್ಸ್ ಮೇಲೆ.
It go to the extent that, my lordship, that judgment itself is not applicable to us. In the Supreme Court judgment, my lordship, Rakesh Sharma, Vinita Sharma and Rakesh Sharma is not applicable to us ಅನ್ನೋ ತರನು ಬರೆದಿದ್ದಾರೆ.
ಆಯ್ತು.
That is also
heard the appellant counsel and also the counsel appearing for the respondent, and these appeals are filed by the new plaintiffs.
ಅಲ್ಲ, ಅವರು
defendant 2 to 6, my lordship.
Defend number
count claim ಮಾಡಿದೀವಿ
2 to 6.
Yes, my lordship. Defendant
and also the defend number 1. ಹೌದಾ? Defend number 1. And at the first instance, trial court granted the relief of 1/5 share in OS number 2000 of 2006. And in the appeal filed by the first defendant, RA number 15002 of 22 was dismissed. And the appeal filed by the plaintiffs 1501422 was allowed and granted the share, equal share in respect of plaintiff and defendant number 1. And there is a divergent finding considering the decree passed in the original suit and also in the appellate court. It is also the contention of the first defendant that already there was a partition on 14/3/1973.
And I rely on that partition.
ಅದೇ ನೀವು ರಿಲೈ ಮಾಡ್ತೀರಾ?
ನಾನು ರಿಲೈ ಮಾಡ್ತಾ ಇರೋದು 14/3/1973. Plaintiffs ರಿಲೈ ಮಾಡ್ತಾ ಇರೋದು 33/1974.
Plaintiffs are relying upon the partition of 33/1974, and hence matter requires reconsideration. Admit the following substantive question of law arises for the consideration of this court are: in RSA 1437 of 2023, whether the first appellate court committed an error in reversing the finding of the trial court passed in OS number 2000 of 2006, granting equal share only between plaintiff and the first defendant, and the same amounts to perversity. Onde alla nimdu substantive question of
that will answer that.
Nimdralli ಒಂದು. Next, whether the ನಿಮ್ದು ಎರಡು ಅಪೀಲು, ನಿಮ್ದು ಒಂದು D1, ಇನ್ನು
ನಂದೇ ಎರಡು ಅಪೀಲು.
ಒಂದು ಡಿಸ್ಮಿಸಲ್ ಮೇಲೆ
ಡಿಸ್ಮಿಸಲ್ ಗೆ ಒಂದು ಅಲೋ ಮಾಡಿರೋದಕ್ಕೆ.
ಯಾವ್ದು ಅದರ ಡಿಸ್ಮಿಸಲ್ ಯಾವುದು?
ಡಿಸ್ಮಿಸಲ್ 1728 dismissal.
28. Whether the first appellate court committed an error in dismissing the appeal filed by the first defendant in RA 15002 of 22, and the such dismissal amounts to perversity in not considering the both oral and documentary evidence, and the same amounts to ಅಷ್ಟೇ ಸಾಕು.
Exhibits ಬರ್ಬಿಟ್ಟಿದ್ದೀನಿ. D7 and D32 are exhibit
ignoring exhibit
D7 and P32. ಇವೆರಡೇ ಇರೋದು.
and
P32
ಅಲ್ಲಿಗೆ ಅದು ಇಶ್ಯೂ ಅದರಲ್ಲಿ. ನೆಕ್ಸ್ಟ್, in RSA 1730 of 2023, whether the ಇದರಲ್ಲಿ ಮೋಸ್ಟ್ಲಿ
33 ಅದ್ರದ್ದು ಎರಡರದ್ದು ಹೇಳ್ಬಿಟ್ಟಿದ್ದೀನಿ, ಎರಡಕ್ಕೂ ಕಾಮನ್ ಆಗ್ಬೋದು ಅನ್ಸುತ್ತೆ.
ಯಾವ್ದು?
ಈ ಎರಡನೇದ್ರಲ್ಲಿ ಅಲೋ ಮಾಡಿದ್ದಾರೆ, ಅದಕ್ಕೆ ತಾವು ಮೊದಲನೇ ಕ್ವಶನ್ ಆಫ್ ಲಾ ಫ್ರೇಮ್ ಮಾಡಿದ್ರಿ, ಅದೇ ಕವರ್ ಆಗುತ್ತೆ ಇದ್ರಲ್ಲಿ.
ಫಸ್ಟ್ ಒಂದು.
ಹೌದು, ಈ ಎರಡು ಸಬ್ಸ್ಟಾನ್ಷಿಯಲ್ ಕ್ವಶನ್ ಆಫ್ ಲಾ ರಿಲೆವೆಂಟ್ ಫಾರ್ ಆಲ್ ದಿ ತ್ರೀ
ಒಂದೇ ಆಗುತ್ತೆ. ಅವಾಗ ಮೇಡಮ್ ಇದನ್ ಮಾಡಿ, ಫಸ್ಟ್ ಒನ್ ಏನ್ ಮಾಡಿದ್ವಿ, RSA 1437 ನಮ್ 23 ಇದೆಯಲ್ಲ ಅದು, ಮತ್ತೆ RSA 1730 of 23 ಕಾಮನ್ ಸಬ್ಸ್ಟಾಂಟಿವ್ ಕ್ವಶನ್ ಆಫ್ ಲಾ ಅಂತ ಮಾಡಿ ಸಾಕಾಗುತ್ತಲ್ಲ, ಸರಿ ಆಗುತ್ತಲ್ಲ?
1730 ಆಗುತ್ತೆ.
ಆಗುತ್ತೆ. ಸಪರೇಟ್ 1728 ಗೆ ಡಿಸ್ಮಿಸಲ್ ಗೆ
ಕನ್ಸಿಡರೇಷನ್ ಆಫ್ ದಿಸ್. ಕರೆಕ್ಟ್,
ಅಷ್ಟೇ ತಗೊಳ್ಳಿ. Records are already received and no need of filing of paper book. List the matter for final hearing in 4th week of January 2026.
Interim order already granted, my lordship.
Interim order granted earlier is extended till next date of hearing.
Disposal ತನಕ ಯಾಕಂದ್ರೆ ಅಡ್ಮಿಟ್ ಆಗಿದೆ, till disposal.
Till disposal.
32 ರಚಿತಾ ರಾಜಶೇಖರ್.
The appellant's lords kindly pass over the matter, my lords. Senior, kindly pass over the matter, my lords. Senior.
Pass over.
My lords, the decree has attained final. It may be called on Monday, my lords. There is.
Monday ಎಲ್ಲ ಇಲ್ಲ ಮೇಡಮ್, ಇವತ್ತೇ. ಮಂಡೇ ಇಲ್ಲ ಅಂದ್ರೆ ಮತ್ತೆ after winter vacation. Pass over. Pass over. ಆಯ್ತು.
33 ಹರೀಶ್ ಭಂಡಾರಿ.
Suit for partition, lordship.
Half share.
Half share.
In respect of a scheduled property.
Yes. Lordship, page 65 is the genealogy I have produced, your lordship. That your lordship, that one Giriam Shetty was a propositor, your lordship. Had two children, Nyabanna Shetty and Padmavati alias Paddu Shetty. Page 65, your lordship.
Yes, I'm seeing.
Yes. The Appi Shetty, there is the daughter, your lordship. This Paddu Shetty, your lordship, it seems to have deserted her husband for a while, that Vittal Shetty. And Boja Shetty has been born, your lordship, out of this such a desertion, your lordship.
Through second husband.
Through second husband. Second husband's name is not known to anybody now. And that Boja Shetty is born, your lordship, to the Paddu Shetty, claims to be married to Sushila. Sushila is filed the suit for partition now, your lordship, that is. On the contrary, your lordship, the elders of the Appi Shetty have filed the written statement claiming that, your lordship, that Boja Shetty has died bachelor. And way back in the year 1996 itself, this Sushila Shetty once issued the notice for partition. And after delay of 16 years, they filed the present suit. And there is a couple of delay, your lordship, all this, on this counts it has been filed, your lordship. And another ground was raised, your lordship. At the most, your lordship, the alias Santana will come into play because of the reason, your lordship, that is the governed by alias Santana law once, your lordship. Then 1/11th share will be entitled for the plaintiffs. But unfortunately, your lordship, the defendant DW1 who has examined himself and has not tendered for cross-examination, the court holds that, your lordship, the half share of the property to the plaintiffs. Against which, your lordship, appeal was also filed, your lordship, that is also been dismissed. Now, your lordship, my only submission, your lordship.
Only apportionment.
Apportionment. Apportionment is the subject, your
issue
lordship.
Between the parties.
Yes. That is one the subject, your lordship. Now, what the appellate court holds, your lordship. Appellate court judgment, your lordship, at get at.
ಅಲ್ರಿ ಇಲ್ಲಿ ಅಳಿಯ ಸಂತಾನ ಹೆಂಗ್ರಿ ಬರುತ್ತೆ ಇಲ್ಲಿ ಆಕ್ಚುಲಿ ಇಬ್ರು ಮಕ್ಳೇ ಅಲ್ವಾ?
ಅಲ್ಲ, ಇದು ಬಿಕಾಸ್ your lordship,
ಇಬ್ರು ಗಂಡ್ ಮಕ್ಳೇ.
ಇಲ್ಲ
ಅಪ್ಪಿ ಶೆಟ್ಟಿ ಅದು
ಲೇಡಿ, ಅದು
ಡಾಟರ್
ಲೇಡಿ,
ಡಾಟರ್ ಆಫ್ ವಿಠಲ್ ಶೆಟ್ಟಿ.
ಡಾಟರ್ ಪದ್ದು ಶೆಟ್ಟಿ ಇದು.
ಇವನ್ ಬೋಜಾ ಶೆಟ್ಟಿ.
ಹೌದು. And moreover, your lordship, this Elders, your lordship, that's Appi Shetty, those are the defendants therein. That Anita Bhaskar Shetty and Pramila Harish Shetty have the sons, your lordship, they are not arrayed as a defendants. So non-joiner of the necessary party is also one of the issues, your lordship, we have raised. So only issue.
ಎಲ್ಲ ತೋರಿಸಿದಿರಲ್ಲ ಅದನ್ನ, ಡಿಫೆಂಡೆಂಟ್ 1A 1B 1C 1D
ಅಲ್ಲ
ಅಂತೆಲ್ಲ ಇದೆಯಲ್ಲ.
ಅಲ್ಲ, ಅನಿತಾ ಭಾಸ್ಕರ್ ಶೆಟ್ಟಿ 1B ಎಲ್ಲ ಇದಾರಲ್ಲ, ಮತ್ತೆ ಪ್ರಮೀಳಾ ಶೆಟ್ಟಿ ಅವರಿಗೆ ಮಕ್ಕಳು ಇದಾರಲ್ಲ, ಅಲಿಯಾಸ್ ಸಂತಾನದಲ್ಲಿ ಬಂದಾಗ ಒಂದು ಕವರ್ ಅವ್ರಿಗೂ ಬರುತ್ತಲ್ಲ.
ಅವ್ರ ಮಕ್ಳನ್ನ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ ಅಂತ.
ಹೌದೌದು.
ಅವ್ರಿಬ್ರಿಗೆ ಮಾತ್ರ ಮಕ್ಳಿರೋದ?
ಅಲ್ಲ, ಅವರಿಬ್ಬರಿಗೆ ಅಂದ್ರೆ ಹೆಣ್ಣು ಮಕ್ಕಳಲ್ವ ಅವರು? ಅನಿತಾ ಮತ್ತೆ ಪ್ರಮೀಳಾ.
ಮೇಲ್ ಮೆಂಬರ್ಸ್.
ಹಾ, ಬಾಕಿದವರೆಲ್ಲ ಮೇಲ್ ಮೆಂಬರ್ಸ್.
ರತ್ನ ಅಲ್ಲ, ಅದು ರತ್ನಾಕರ. ಆಯ್ತು, ನೋಟಿಸ್ ಇಶ್ಯೂ ನೋಟಿಸ್, ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್.
Proceedings of the FTP lordship.
ಏನಾಗಲ್ರಿ ಅಲ್ಲಿ FDP
ಮಾಡಿದಾರೆ ಅಂತ
ನೋಟಿಸ್ ಹಾಕಿ ಬರ್ಲಿ. ನೋಟಿಸ್ ಹೋಗಿ ಬಂದ್ಮೇಲೆ ನೋಡೋಣ, ಸುಮ್ಮನೆ ಸ್ಟೇ ಕೊಡೋದೆ. ಡೇಟ್ ಕೊಡಿ, ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್ ನೋಟಿಸ್ ಆದ್ಮೇಲೆ 19/1.
34 Poonam N.
In this case. ರೆಗ್ಯುಲರ್ ಕೌನ್ಸಿಲ್ ಇಲ್ಲ, ನಾಳೆಗೆ ಇವತ್ತು
ನಾಳೆಗೆಲ್ಲ ಯಾವ್ದು ಡೇಟ್ ಇಲ್ಲ. ಒಂದ್ ನಿಮಿಷ ಇರಿ,
ಶೆಡ್ಯೂಲ್ ಆಗಿದೆ. ಟಿಕೆಟ್ ಕೊಡ್ತಿದ್ದೀನಿ ಸರ್. ಫ್ಲೈಟ್ ಟಿಕೆಟ್ ಶೆಡ್ಯೂಲ್ ಆಗಿದೆ ಇವತ್ತಿಗೆ. ಇವತ್ತು ರಾತ್ರಿಗೆ ಬರ್ತಾರೆ, ನಾಳೆ ಬೆಳಗ್ಗೆಗೆ. 1/4
ರಿವರ್ಸ್ಡ್. ಅದರ್ ಸೈಡ್ ಇಲ್ವಾ ಇದ್ರಲ್ಲಿ ನೋಟಿಸ್ ಆಗಿಲ್ವಾ?
ಇಲ್ಲ, ಆಗಿಲ್ಲ.
ಮುನಿಯಮ್ಮ ಸರ್ವ್ಡ್ ಅಂತ ಇದೆ ಮೇಡಮ್. ಡಿಸ್ಪೆನ್ಸ್ ವಿತ್ R4 ಮುನಿಯಮ್ಮ ಸರ್ವ್ಡ್. 35 ತಾನೆ? 34 ಆಗಿಲ್ವಾ ಮೇಡಮ್? ಇನ್ನೂ ಅದೊಂದು ಇದೆಯಾ?
ನಾಳೆಗೆ
ಡಿಸ್ಮಿಸ್ಡ್ ಪೂನಂ ಕನ್ಫರ್ಮ್ಡ್. ಏನ್ರಿ ಇದು?
ಫೈಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ನನ್ನ ನಾಳೆ ಬೆಳಗ್ಗೆಗೆ ಅವ್ರು ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೂ ನಾನೇ ಮಾಡ್ತೀನಿ.
Told proxy counsel seeks time on the ground that counsel appearing for the appellant could not able to appear before this court in view of delay of flight and hence list this matter after winter vacation.
35 Mohan Chandra K.
Suit for specific performance. Trial court dismissed the entirety, my lord. The appellate court is granted alternative remedy. The alternative relief, my lord, refunding.
Trial court alle grant ಮಾಡಿದಾರ್ರಿ ಶೇರು?
ಇಲ್ಲ ಅಲ್ಲಿ
1/4 share in suitable property suit alle grant ಆಗಿದೆ. appellate court ಅಲ್ಲಿ ರಿವರ್ಸ್ ಆಗಿದೆ ನೋಡಿ.
ಅಲ್ಲ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನಲ್ಲಿ ಸಾರಿ 36 my lord, sorry, very sorry, 36 my.
ಮೋಹನ್ ಚಂದ್ರ ಇಲ್ರಿ? ಮೋಹನ್ ಚಂದ್ರ ಇಲ್ಲ, ಪಾಸ್ ಓವರ್. ನಾವ್ ಓದ್ಕೊ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನಾವು ಕನ್ಫ್ಯೂಷನ್ ಆಗ್ಬಿಡ್ತೀವಿ.
36 ಮೆರಡ್ ಸೂಟ್ ಫಾರ್ ಸ್ಪೆಸಿಫಿಕ್ ಪರ್ಫಾರ್ಮೆನ್ಸ್
ಡಿಸ್ಮಿಸ್ ಆಯ್ತು. ಅಪ್ಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ರೀಫಂಡ್ ವಿತ್ 6% ಇಂಟ್ರೆಸ್ಟ್ ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಹೌದಾ? ನೀವೀಗ ರೀಫಂಡ್ ಚಾಲೆಂಜ್ ಮಾಡ್ಕೊಂಡ್ ಬಂದಿದ್ದೀರಾ?
ಹೌದು.
I've just received the brief today morning, my lords. I've received the brief and instructions today in the morning. I'll just
have you filed the wakalat?
ಇಲ್ಲ, one week's time
undertake ಮಾಡ್ತೀರಾ?
please.
counsel
Both the respondents.
both the respondent ಹೆಸರು ಹೇಳ್ರಿ.
ರಕ್ಷಿತಾ BM.
ನೀವೇ ವಕಾಲತ್ ಹಾಕದಾ?
Please.
counsel ರಕ್ಷಿತಾ
BM.
undertakes to appear on behalf of R1 and R2.
Please.
And seeks time to file wakalat, and if wakalat is filed, show the name of the counsel in the cause list. List the matter immediately after winter vacation.
37 HV Devaraju.
The plaintiff's appeal that the suit for partition, that the concurrent findings, where not that relationship is not disputed. Only where not that the land trial court not the joint family has not been proved, and taking that not that revenue entries that showing in the name of the father of the first dependent and in the name of the first dependent, and not the whole that presumption in their favor, and dismissing the suit not that trial court. The appellate court not that confirming the findings. Not the admittedly not that Uchappa and Tammegoda were the brothers. Not that Uchappa children's not that these that first plaintiff and father of the plaintiff's 2 to 5 and husband, and not the father of the first dependent. That the Tammegoda and not that Uchappas represented by Doddapillappa, family members not that partition was took place 22/9/1961. The property is allotted not to Uchappa's not branch, that in the name of Doddapillappa, because he was represented in the partition deed.
But that is negatived by the trial court with regard to the earlier partition is concerned.
That negative not that on account of documents has not been produced. That in the appellate court not that I have filed an application not by producing the Same
ಆ ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕಿದಿರಾ?
ಹಾಕಿದ್ವಿ.
Partition deed.
Partition deed. Additional evidence also produced. Let the trial appellate court might without looking to that those documents. The partition deed itself has been produced. That is a specific ground which has been raised by me also in this appeal. That without considering this, not that it is proceeded to confirming the finding of the trial court.
ಐಎ ಕನ್ಸಿಡರ್ ಮಾಡ್ಲೇ ಅಲ್ವಾ?
Consider ಮಾಡಲಿಲ್ಲ, ಏನು ಮಾಡಲಿಲ್ಲ.
ಯಾವ ಡೇಟ್ ಅಲ್ಲಿ ಹಾಕಿದ್ರಿ ನೀವು?
That same along with client, along with appeal memo I have filed.
ಆರ್ಡರ್ ಶೀಟ್ ಇದೆಯಾ?
I produce that. I may pass on. I number 4 not that next page.
ಏನೇನ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹಾಕಿದಿರಾ?
Partition deed I have produced.
ಆಮೇಲೆ
other nothing has been
earlier 1961.
1961.
Good. How did the appellant
But
counsel
even
and
that in
appellant
this
counsel
RSM let that
appellant counsel brought to notice of this court that along with appeal IA number 4 of 22
that later 61 by
under order 41 rule 27 was filed, and while disposing of the appeal not considered the said IA and disposed of the appeal only framing a point for consideration whether the judgment and decree passed by the trial court is illegal, perverse and capricious, and hence issue notice against the respondents and call for records. List this matter on date kodi madam.
19/1.
19/1.
38 Vedamurthy.
Appear for appellate case.
Is the regular second appeal filed with the defendant, my lord. Is the two concurrent findings rendered by the trial court and the first appellate court, my lord. The matter involves 6 properties, 3 agriculture lands and 3 sites, my lord. The plaintiffs 1 to 4 and the respondents here 1 to 4 filed suit for partition and separate possession in respect of the suit schedule properties, my lord. The contention of the plaintiffs are that the suit items in the schedule against the defendant invoice number 670 or 2013 merit. The contention of the plaintiff is 1, 2 and 4 suit items 1, 2 and 4 are self-acquired.
This appeal is filed by the defendant.
Pardon, my lord.
This appeal is filed by the defendant.
Yes, my lord. Yes, my lord. And item number 3 and 5 are ancestral properties. Item number 6 is a self-acquired property. This is story of the plaintiff, my lord. Respondents 1 to 4 in this particular regular second appeal. On the other hand, the contention of the defendant is suit schedule items 3 to 6 are already divided in the year 7, and suit schedule item number 1, 2 are also divided in the year 2001 as per exhibit P6, my lord. The mutation entry, it has been acted upon and they are not available for partition is the contention taken by the defendant, my lord.
Whether plaintiffs are parties to those documents? Whether plaintiffs are parties to those documents?
Plaintiffs are parties to those. ಇಲ್ಲ ಪ್ಲೇಂಟಿಫ್ಸ್ ಇಲ್ಲ 2001 ಆಗಿರೋದ್ರಿಂದ ಸ್ವಾಮಿ ಅವ್ರಿನ್ನ ಪಿಕ್ಚರ್ ಗೆ ಬಂದಿರಲಿಲ್ಲ, ಹಂಗಾಗ್ಬಿಟ್ಟು ಅಮೆಂಡೆಡ್ ಆಕ್ಟ್ ಕೂಡ 6/5/2009 ಫೈನಲ್ ಬಂದದ್ರಿಂದ the respondents 1 to 4 were not parties to that partition. It was acted upon as per exhibit P6, my lord, and the contention of the defendant 1 and 2 they are not available for partition is the specific contention taken by the defendants, and the trial court has committed serious error in not accepting that. And just because the defendant 1 admitted in the cross examination that the properties 3 to 5 are ancestral properties, and the trial court has jumped to the conclusion that they are not divided and they are continued to be the joint family properties. The finding of the trial court is absolutely bereft of any legal sanctity, my lord. And
mutation ಯಾವಾಗ ಆಗಿದ್ದು?
2001, 10/3/2001, my lord.
10/3/2001.
ಅದು ಓವರ್ ಪಾರ್ಟಿಷನ್ ಆಯ್ತು ಸ್ವಾಮಿ. ಅದ್ರ ಮೇಲೆ ಇದು ಮ್ಯುಟೇಷನ್ ಕೂಡ ಆಯ್ತು. It was acted upon and that was not available. Those two properties, especially the suitable item number 1 and 2 were not available for partition. And the other properties are also divided on 25/6/2007, my lord. Of course, we have no case so far as these properties are concerned, because 2007 after the Amendment Act came into force, they have taken up the stand that it was partitioned.
That is in respect of item number? Item number?
Item number 3, 5 and 3 to 6, my lord.
3 to 6 nimden dispute illa.
Nam contention in
1 and 2 ge?
1 and 2 only, my lord.
Yak why there was 2 partition nim prakara?
The parties divided.
Why there were 2 partition in 2001 and 2007?
The parties themselves agreed to divide the properties. Should item number 1.
Sari yake anta kelide nanu. If already there was a partition in the year 2001, why again there was a partition in 2007?
Partition in respect of item number 3 to 6.
That means the court has not accepted your contention that there was a partition in 2001.
No, there is a different contention taken by the
Should schedule item number 3 to 6, 2007 lights for me. But
in the admission is nodi, go to paragraph number 17.
OS judgment ಅಲ್ಲಿ they taken a stand that it's a granted land, it's not available for partition ಅಂತ ಹೇಳ್ತಾರೆ.
ಅದೇ ಡಿಫೆನ್ಸ್ ಅದಕ್ಕೆ ಇಶ್ಯೂಸ್ ಫ್ರೇಮ್ ಮಾಡಿದ್ದಾರೆ.
Yes my lordship, ಇಲ್ಲಿ ಬಂದು
ಅಡಿಷನಲ್ ಇಶ್ಯೂ ಏನ್ ಗೊತ್ತಾ, whether the defendant number 1 proves that suit item number 1 and 2 are granted lands. That is an additional issue.
One submission, Swami. Idral plaintiff contention, should schedule item number 1, 2 are self-acquired properties antare. No document is produced. And the specific contention of the defendant appellant is they were granted by the government antare. Adu documents yavadu hajar padisilla. Actually, these are admittedly Inam lands and vested with the government upon for passing of the Inam's Abolition Act. The application was filed, but the lands have not been re-granted by the Deputy Commissioner.
But RTC entry ಇದೆ.
ನಿಮ್ಮ ಇದರಲ್ಲಿ ನೋಡಿ para 17 ಅಲ್ಲಿ ನೋಡಿ. Mutation order bearing number 7 2003-2004, it clearly indicates that defendant number 1 and 2 got divided so item number 1 and 1 property by submitting partition deed dated 10/3/2001. The above document clearly indicates that the suit item number 1 and 2 properties along with other properties have been partitioned only by defendant number 1 and 2 in this year 2001. Out of suit number 4 to 6 properties, 1 property is standing in the name of mother of the parties, namely government. Remaining 2 properties are standing in the name of defendant number 1 and 2 herein. Documents referred to that suit properties are joint family properties of the parties to the suit, and particularly suit item number 3 property is ancestral in nature as awarded by the plaintiffs. In the cross examination, DW1 also admitted that suit item number properties ancestral in nature. He also admitted that suit item number 4 to 6 are self-acquired properties of their father Siddappa. That is the admission now. It is pertinent to note in the cross examination dated 22/2/22 that defendant number 1 has specifically admitted that they have been cultivating the suit item number 1 and 2 properties since lifetime of his great grandfather Shantayya. This admission clearly established the fact that suit item number 1 and 2 properties are acquired the nature of ancestral properties. The defendant number 1 and 2 have already got divided the said properties and enjoying them, but they are contending that they are not available for partition since those 2 lands have not been re-granted. If so, they would not have mutated the said properties in their names. The counsel for defendant number 1 would argue that married daughters are excluded from the defendant joint family in the Land Reforms Act. As such, the plaintiffs cannot claim partition in suit item 1 of 2 properties relied upon the judgment so and so. Specifically contend that said properties are Inam lands. Furthermore, the documents produced by the defendant number 1 himself, exhibit D33-34, clearly establishes that suit item number property has been granted to the father of the plaintiff and defendants, namely Siddappa, under Inam Abolition Act 1955. Hence, with due respect to the judgment referred above, I am of the opinion that it is not helpful to the case of defendant number 1. This is the reason. Case in hand sufficient material is on record to show that the suit item number 1 and 2 are in cultivation and enjoyment of the family of the parties since their ancestors. Defendant number 1 himself admitted that suit item number 3 to 5 are ancestral properties of Siddappa. Hence, I am of the opinion that 1 to 3 and 5 are ancestral properties of plaintiffs and defendants. Suit item number 4 and 6 are joint family properties. So and so. These are the reasoning.
ಸಿದ್ದಪ್ಪ ಅವ್ರಿಗೂ ಕೂಡ ಗ್ರಾಂಟ್ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ ಅದು. ರೀಗ್ರಾಂಟ್ ಆಗಿಲ್ಲ ಅನ್ಲೆಸ್ until the
Regrant ಆಗ್ಲಿ ಆಗ್ದವಲ್ಲಿ. Now property is vested with the family. You cannot claim that you are an absolute owner.
In support of the stand taken by the parties, my lord, no tangible document is produced before the trial court, my lord.
ನೀವೇ ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಂಡ್ಮೇಲೆ ಇನ್ನೇನ್ರಿ? Item number 1 also granted in favor of the father in the year 1955.
That itself is wrong, my lord. They have not produced any document.
Admission ಮಾಡ್ಕೊಟ್ರೆ ನೀವೇ admission ಕೊಟ್ಟಿರೋದು.
Therefore, my contention is before this honorable court is, my lord, that the finding of the trial court stating that they are joint family properties and ancestral properties is absolutely baseless and not correct. The reasoning assigned by the trial court is also not judicious, my lord. They have jumped to the conclusion solely on the basis.
DW1 is cross examination admitted that item number 1 and 2 properties are Inam land and said item number 1 and 2 cultivating scenes from their great grandfather Shantayya and said item number 1 and 2 are the granted in favor of the father of the plaintiffs and defendants. Further, it is clear from the evidence on record that there was no partition between the plaintiffs and defendants in respect of suit schedule properties. Defendant number 1 and specifically admitted in his class examination that suit schedule item number 1 and 2 so and so item number 3 ancestral property and item 4 to 6 self-acquired property of their father. 1 and 2 no father ಗೆ ಸೇರಿದ್ದು, 4 to 6 also father ಗೆ ಸೇರಿದ್ದು. Item number 3 you have admitted that it is a self ancestral property. All this material clearly discloses.
Number specific contention, so 1 and 2 are already divided, they are not available for partition. That is our specific contention.
ಅಲ್ಲ ರೀ ಫಾದರ್ ಗಲಾಟ ಆದ್ರೆ ಅದ ಹೆಂಗ್ರಿ ನೀವು ಇಬ್ಬರೇ ಡಿವೈಡ್ ಮಾಡ್ಕೋತೀರಿ? Section 8 attract ಆಗಲ್ವಾ? Even assuming that there was a partition between you two brothers excluding the plaintiffs.
ಹೌದು ಸ್ವಾಮಿ, ಹೌದು ಸ್ವಾಮಿ.
ಮತ್ತೆ Section 6 ಗಾರೆ 2005 amendment.
In respect of other properties, the partition was deferred between the defendant number 1 and 2.
ಆಗಿಲ್ಲ. ನಿಮ್ ಪ್ರಕಾರ 2007 ರಿಲೈ ಮಾಡ್ತೀರಿ. 7 ಮಾಡಕ್ ಬರಲ್ಲ. ಆಯ್ತಲ್ವಾ? 1 and 2 ನವೆ the property was granted in favor of the father. ಹೌದಲ್ಲ? It is a property of a male member of the Hindu family.
Before the amendment.
Family. Section 8.
Before the amendment.
Amendment section 6 attract ಆಗೋದಿಲ್ಲ. Item number 1 and 2.
ಅಲ್ಲ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಕ್ಟ್ ಬರೋದಕ್ಕಿಂತ ಮುಂಚೆ ಪಾರ್ಟಿಷನ್ ಆಗಿದೆ ಸ್ವಾಮಿ.
ಅರ್ಥನೇ ಮಾಡ್ಕೋತಾ ಇಲ್ವಲ್ರಿ ನೀವು?
It was acted
property belongs to the father.
Correct ಸ್ವಾಮಿ.
Who are all successors to the property of the father? If father died intestate.
ಅಲ್ಲ by 2001, my lord, only male persons were entitled as were treated as co-partners. The daughters became into the picture.
ಕಾಪಾಡಬೇಕು ನಿಮ್ಮ.
Daughters came into
Section 6 ಗೋ 8 ಗೋ ಡಿಫರೆನ್ಸ್ ಏನ್ರಿ?
ಆಮೇಲೆ in addition to that, my lord, second condition.
Addition ಬಿಡ್ರಿ. ನೀವ್ ಏನ್ ಹೇಳ್ತಾ ಇದ್ರಿ? ಪಾರ್ಟಿಷನ್ ಆಗೋಗ್ಬಿಟ್ಟಿದೆ 2001 ಇಬ್ರು ಅಣ್ತಮ್ಮಂದಿರು ಹಂಚ್ಕೊಬಿಟ್ಟಿದೀವಿ, ಹೆಣ್ಮಕ್ಳಿಗೆ ಹಕ್ಕಿಲ್ಲ ಅಂತ. ಅದು ಯಾವಾಗ? If section 6 attracts. If section 8 attracts.
ಅಲ್ಲ ಅವಾಗ
If section 8 attracts.
ಅವಾಗ ಆಕ್ಟ್ ಇರಲಿಲ್ಲ ಸ್ವಾಮಿ, ಅಮೆಂಡ್ಮೆಂಟ್ ಆಕ್ಟ್.
ಆಕ್ಟ್ ಇರ್ಲಿಲ್ವಾ?
ಅಲ್ಲ
Section 1956. Section 56
2005 ಬಂತು.
1956 act ಇತ್ತಲ್ರಿ?
56
property belongs to a male member of the family. ನಿಮ್ಮ ಪ್ರಕಾರನೇ ಗ್ರಾಂಟ್ ಆಗಿರೋದು ಫಾದರ್ ಹೆಸರಲ್ಲಿ.
But daughters were not treated as co-partners, my lord. And the second point, my lord,
ಬಡ್ಕೋಬೇಕಷ್ಟೇ.
As per the provisions of the Land Reforms Act, the married daughters are not included in the word joint family or family. On account of that, they are not.
ನಿಮ್ಮ admission property was allotted in favor of the father in the year 1955. ಹೌದೇನ್ರಿ?
ಹೌದು ಸ್ವಾಮಿ.
ಫಾದರ್ ಏನಾದ್ರು ಟೆಸ್ಟಮೆಂಟರಿ ಡಾಕ್ಯುಮೆಂಟ್ ಮಾಡಿದಾರಾ?
ಅವ್ರಿಗೂ ರಿಗ್ರಾಂಟ್ ಆಗಿಲ್ಲ, ಬರೀ ಆಕ್ಯುಪೆನ್ಸಿ ರೈಟ್ಸ್ ಕೊಟ್ಟರು ಸ್ವಾಮಿ. ಆದ್ರೆ ಒಂದು ಸಬ್ಮಿಷನ್, ಮೈ ಲಾರ್ಡ್, ದೇರ್ ಕೆನಾಟ್ ಬಿ ಎನಿ ಟೆನೆನ್ಸಿ.
ಸೆಕ್ಷನ್ 6 ಅಟ್ರಾಕ್ಟ್ ಆಗಲ್ರಿ. ಹೆಸರು ಹೇಳದ್ ನಿಮ್ಗೆ. ಮೇ ಬಿ an amendment act, central amendment act subsequently. ಫಸ್ಟ್ ನೀವು ಸೆಕ್ಷನ್ 6 ಸೆಕ್ಷನ್ 8 ಗೂ ಡಿಫರೆನ್ಸ್ ನೋಡ್ಬೇಕು. ಏನ್ ಮಾಡೋಣ ಹೇಳಿ? ಓಕೆ ತೋಳಿ. This matter is listed for admission. I heard the counsel appearing for the appellant and respondent, and the second appeal is filed against the concurrent finding. Suit is filed for the relief of partition and separate possession by the sisters.
Yes, my lordship.
Sisters against the brothers. claiming that suit schedule properties are ancestral and joint family properties of themselves and defendants. And defendant number 1 took the specific contention that item number 1 and 2 are granted lands. The trial court, considering the material available on record, particularly the DW1, admitted that item number 3 property is an ancestral in nature, and item number 1 and 2 are granted in favor of the father, and item number 4 to 6 are the self-acquired properties of their father Siddappa, and the same is discussed in paragraph number 15, 16, 17, 18 and 19. And also counsel would contend that there was earlier division between the brothers in the year 2001 in respect of item number 1 and 2. And also counsel would contend that sisters are not entitled for any share since there was a partition in the year 2001 itself. And counsel also would contend that subsequent partition in the year 2007. But the same is not unfairly submits that the same is not binds on the plaintiffs that since they are not the parties. The trial court, having considered the admission on the part of DW1, granted the relief of 1/6 share in respect of the suit schedule properties, and in respect of item numbers 3 also there was no any prior division subsequent earlier to the 2005 amendment. And appellate court also, having reassessed both oral and documentary evidence in keeping the grounds which have been urged in the appeal, formulated the point and answered the same as negative, considering the admission on the part of DW1 in the cross examination, particularly in paragraph number 20, 21, 22. And in paragraph number 22, taken note of DW1 is cross examination admitted that item number 1 and 2 properties are Inam land, and said item number 1 and 2 are cultivating since from their great grandfather Shantaya, and said item number 1 and 2 are granted in favor of the father of the plaintiffs and defendants. Further, it is clear from the evidence on record that there was no partition between the plaintiffs and defendants in respect of suit properties. And defendant number 1 specifically admitted in his cross examination that suit schedule item number 1 and 2 are Inam lands, and item number 3 ancestral property, and item number 4 to 6 are self-acquired property of their father, and all the suit properties are joint family properties and are available for partition, and hence comes to the conclusion that trial court has not committed any error and confirmed the order. Being agreed by the concurrent finding, this second appeal is filed, and main contention of the counsel appearing for the appellant before this court, indicating the substantive question of law, mutation entries effected in the name of defendant number 1 and 2 pursuant to the oral partition taken place between defendant number 1, which is duly effected and acted upon, is not amounting to division. Whether a married daughter can be treated as a co-partner or a joint family member when the land is granted by the land tribunal, since the married daughters are excluded from the definition of joint family under the Karnataka Land Reforms Act. And hence, this court has to frame substantive question of law. For contra, the counsel appearing to the respondent would contend that the trial court as well as the appellate court taken note of that there was a grant in favor of the father in the year 1955, and the same is admitted by DW1, and father had not left any testamentary document, and also any division in respect of item number 1 and 2 as contended by the appellant counsel, and the same not binds on the plaintiff, and section 8 attracts and not section 6 attracts in respect of item number 1 and 2 is concerned, and hence no ground is made out. Having heard the appellant counsel and also the counsel appearing to the respondent, and also considering the pleadings of the parties, though it is pleaded in the plaint as ancestral properties and joint family properties, and during the course of evidence, it emerges that item number 1 and 2 properties are granted in favor of the father, and item number 3 is the only property as an ancestral property, and item number 4 to 6 are also the self-acquired property of the father. And admittedly, father has not left any testamentary document when he passed away, and these And the plaintiffs are the sisters of the defendant number 1 and 2. And even though there was any partition between the defendant 1 and 2 in 2001 also, the same not binds on the plaintiff since the plaintiffs are not parties to the said partition. And apart from that, the item number 1 and 2, in which the appellant counsel contend that there was a division and the same is a property of the father, and section 8 attracts and not section 6 attracts. And when such being the case, and when there is no any partition in respect of item number 3 and as an ancestral property, and the same is also admitted, and in respect of item number 3 is concerned, there was no any partition prior to the amendment. And when such being the case, I do not find any perversity in the finding of trial court and appellate court in granting the share in favor of the plaintiffs and defendants equally, and hence not made out any ground either to admit and frame substantive question of law, and both question of fact and question of law considered by both the courts, and there is no any perversity, and hence not a case to invoke section 100 of CPC. In view of the discussions made up, I pass the following order. Second appeal is dismissed.
39, Ishwara HH.
The appellant, my lords, short accommodation, my lords. It's a NOC file, we received it today morning.
ಯಾವಾಗ NOC ತಗೊಂಡಿದ್ ನೀವು?
We filed wakalat last Friday, my lords, but file we have received it. We filed the wakalat last Friday, my lord.
ಆಯ್ತು, ಏನಿದೆ ಸೂಟ್ ಫಾರ್ ಪಾರ್ಟಿಷನ್ 1/6 ಶೇರ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಏನಿಲ್ವಲ್ಲ ಕೇಸಲ್ಲಿ. ನೀವು ಯಾವಾಗ NOC ತಗೊಂಡ್ರು ಅಷ್ಟೇ. ಏನಾದ್ರು ಇರ್ಬೇಕಲ್ಲ ಸತ್ವ ಕೇಸಲ್ಲಿ, ಏನಿಲ್ವಲ್ಲ. 1/6 ಕೊಟ್ಟಿದ್ದಾರೆ, ಮತ್ತೆ ಸೇಲ್ ಡೀಡ್ ಎಕ್ಸಿಕ್ಯೂಟೆಡ್ is not binding on the plaintiffs because plaintiffs are not parties, and also even D6 and D7 also not parties to the sale, not binding.
Short accommodation, my lords, will make us.
Why short accommodation? Counsel, court has no time to again read the papers. You assist the court, that's all. ಸೇಲ್ ಡೀಡ್ ಮಾಡಿರೋದು D1. ನೀವ್ ಯಾರಿಗೆ? ನೀವು D1 ಗ ಅಥವಾ ಯಾರಿಗೆ ನೀವು?
Appellants, my lords, in this case. We are the defendant number 1 in the trial court.
Defendant number 1 ನಾ?
Yes, my lords.
Defendant number 1 ಏನೇ ಕೊಂಡ್ಕೊಂಡಿರೋದು ಪ್ರಾಪರ್ಟಿನ? Plaintiff share ಇಲ್ಲ. Plaintiffs they are not parties. You can claim equity in respect of the properties which have been sold by your vendors before the appellate court ಅಷ್ಟೇ. ಅಪೀಲ್ ಅಲ್ಲೂ ಏನು ಇಲ್ಲ. ನಿಮ್ಮ ಹೆಸರು ತೋರಿಸಿಲ್ವ ಇದ್ರಲ್ಲಿ? ಯಾರ ಈಶ್ವರ HH ಅಂತ ಇದೆಯಲ್ಲ ವಿತ್ NOC ಅಂತ.
We filed it last Friday, my lords.
ಮತ್ತೆ ನಿಮ್ಮ ಹೆಸರೆಲ್ಲ ತೋರಿಸಿದಾರಲ್ಲ, ಆಲ್ರೆಡಿ ವಕಾಲತ್ತು ಹಾಕಿದಿರಿ, ಮತ್ತೇನು?
File we received it today morning. The file we received it today.
ವಕಾಲತ್ತಿಂದಲೇ ಫೈಲ್ ಇಂದಲೇ ವಕಾಲತ್ತು ರಿಸೀವ್ ಮಾಡ್ತೀರಾ? ಏನಿಲ್ಲ ಕೇಸಲ್ಲಿ. ಫಾದರ್ ಪ್ರಾಪರ್ಟಿ ಗಿಫ್ಟ್ ಮೂಲಕ ಬಂದಿದೆ, ಹೌದಾ?
Please.
Plaintiff and defendant 6 and 7 are the children of late Eeranna and Giriyamma. 2 and 3 are the brothers of Giriyamma. So appellant counsel seeks time on the ground that wakalat was filed on Friday and papers are received today. Nice, list the matter after winter vacation.
40. KV Narasimhan.
Lord, I appear for the appellants. Lord, for submitting, Lord, today morning we have filed an application, my Lord, under Order 6, Rule 17, seeking for amendment of plaint, my Lord. Application is not put up. Lord, appellants are the plaintiffs before the trial court, my Lord. Lord, plaintiffs are the children of defendant number 1. Lord, we file a suit for partition. The trial court dismisses my case, my Lord, on the ground of partial partition. Then, my Lord, I prefer an appeal before the first appellate court. First appellate court, my Lord, dismisses my appeal on 3 grounds. Lord, it states in a suit for partition, I have not claimed the relief of cancellation of the sale deeds, which was executed by defendant number 1 in favor of defendant number 2.
Argument last time ಕೇಳಿದೆ ನಾನು ನಿಮ್ಮ
My Lord, my lords raised a question, my Lord, with respect to the second ground, my Lord, by which first appellate
ಬಿಟ್ಟೆಲ್ಲ ಬೇರೆ ಹೇಳ್ತಾ ಇದ್ದೀರಿ ನೀವು. Last time what the question I put to you.
Refreshing my memory. Lord, second ground, my Lord, sale deed was executed in the year 2005 and 2007. And this suit was filed in the year 2012. So on that ground, my Lord, the first appellate court dismissed my suit on the ground of limitation. My lords asked me a question as to whether 3 years limitation period is applicable or 12 years. Lord, with respect to that, I have a judgment of the Honorable Apex Court and my Lord's judgment that in a suit for partition, my Lord, Article 109 is applicable and not Article 58, my Lord, because Article 58 being a general article, my Lord. In a suit for partition, Article 58 is applicable.
But ಇಲ್ಲಿ ನೀವು ಚಾಲೆಂಜ್ ಮಾಡ್ತಿರೋದೇನು?
My Lord, we have challenged, we have sought for declaration that the sale deeds of 2005 and 2007 are not binding on me. I am not a party to the sale deed. It was executed by my father in favor of defendant number 2.
ಯಾವಾಗ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿದ್ರು?
2005 ಅಲ್ಲಿ ಒಂದು 2007 ಅಲ್ಲಿ ಒಂದು.
ಆಯ್ತು, ನಿಮ್ ನಾಲೆಡ್ಜ್ ಗೆ ಯಾವಾಗ ಬಂತು?
My Lord,
sale deed ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿದ ತಕ್ಷಣನೇ parted with possession ಹೌದಿಲ್ಲ?
Please, man, constructive notice.
Constructive notice 1.
Please.
ಎರಡನೇದು possession ಬೇರೆಯವ್ರ ಕೈಗೆ ಹೋದ ತಕ್ಷಣ ನಿಮಗೆ ಗೊತ್ತಾಗ್ಬಿಡ್ತದೆ.
Please.
Property already sold ಅಂತ. Why you have not questioned immediately within 3 years?
Lord, Article 109 prakaram to
partition ಪ್ರಶ್ನೆ ಬರದಿಲ್ರಿ ಇಲ್ಲಿ. There is a sale. You are not only seeking for the relief of partition. Maybe your relief is not binding, but you had the knowledge of sale made by the father. Immediately sale made by the father ಹೌದಿಲ್ಲ?
Please.
That's why.
With my contention, not within a period of 12 years ನಾನು claim ಮಾಡಿದ್ದೀನಿ. So Article 109 is applicable.
ಹೆಂಗ್ರೆ ಆಗ್ತದೆ?
Lords have held that.
ನಿಮ್ಗೆ ಎಷ್ಟು ಏಜ್? 38 years.
Please.
40 years.
Lord, in fact,
ಅವಾಗ ಎಷ್ಟು ಏಜ್? 2005 2007 ಅಲ್ಲಿ ನಿಮಗೆ. You are not the minors.
Not minors.
You are the major persons. When the father has sold the property without your consent, ಯಾವ ಕ್ವಶನ್ ಮಾಡ್ಬೇಕು ಕೇಳಿ?
Lord, in fact,
ಎಲ್ಲ ಬರೀ ಇತರ ಸೂಟ್ಗಳೇ ವಸೂಲಿ. Father had sold the property in 2005 2007 itself.
Please.
You are not challenge the sale deed. Within 3 years you have to challenge the sale deed. Why you are not challenge?
Lord, ಅದಕ್ಕೆ my
Not
submission
challenge.
is submission, Lord, I am not
That's
a
why
party.
last
to
time
this.
I asked you.
Please, my Lord, in fact, my Lord's judgment, my Lord, in the similar case. My Lord said, held, my Lord, in a suit for partition, there is no limitation.
Partition is no limitation.
No limitation.
But here is a sale made by the father. You are having the knowledge about the same. Constructive notice as well as parting with the possession of the property belongs to the family to a purchaser.
Lord, my humble
possession ಬೇರೆ ಕೊಟ್ಟ ತಕ್ಷಣ ನಿಮ್ಮ ನಾಲೆಡ್ಜ್ ಬಂತು ಅಂತಾನೆ ಅದು ಹೌದಿಲ್ಲ?
Please.
ಮತ್ತೆ
Lord, in that
why
case,
you are not question the sale deed?
Lord, in that case, my Lord, my submission is Article 109 apply ಆಗುತ್ತೆ.
ಸೇಲ್ ಮಾಡೋದು ಅಪ್ಪ ಮಕ್ಕಳನ್ನೆಲ್ಲ ಎತ್ಕಟ್ಟೋದು ಮತ್ತೆ ವಸೂಲಿಗೆ ಕೇಸ್ ಹಾಕ್ಸೋದು.
There are multiple properties.
ನಾವು ಕೋರ್ಟ್ ನಾವಿಲ್ಲಿ ಕೂತಿದೀವಿ ಅದಕ್ಕೇನೆ ಡಿಸೈಡ್ ಮಾಡೋದು ನಾವು ಆಮೇಲೆ ಇಲ್ಲಿ.
I have included all the properties, my Lord. So if at all, my Lord, if that is the grievance, that share may be allotted to the father. That is always there, my Lord. Lord, I have 2 judgments, my Lord, one division bench and Supreme Court.
ಆಯ್ತು ಕೊಡಿ, ಅದರಲ್ಲೇನಿಲ್ಲ ಕೊಡಿ, ಅದನ್ನು ನೋಡಿ ಬರೆಯೋಣ.
Lord, I am covered by my lords, my Lord. Even my lords have held Article 58, 59 apply ಆಗಲ್ಲ ಅಂತ.
ನಾನು ಹೇಳಿದೀನಿ but here is a sale.
Please, my Lord, even with the sale, my Lord, Article 109 of Limitation Act may be looked into for a moment.
ಆಯ್ತು ಕೊಡಿ, ಅದು ಏನ್ ಕೊಡ್ರಿ ಹೋಗ್ಲಿ ನೋಡೋಣ. ಅಂದ್ರೆ ಸೇಲ್ ಮಾಡಿ ಯಾವಾಗ ಬೇಕಾದ್ರೂ ಬಂದು ಪ್ರಶ್ನೆ ಮಾಡಬಹುದು ಮಕ್ಕಳು ಅಂತ ಇದೆಯಾ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ? ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ
10 ಪ್ಲೀಸ್.
ನನ್ನ ಪ್ರಶ್ನೆ ಇಷ್ಟೇ, ಅಪ್ಪ ಸೇಲ್ ಮಾಡಿದ್ರು, ಸೇಲ್ ಮಾಡಿದಾಗ ಮಗ ಮೇಜರು, he did not challenge the sale deed within 3 years. So he kept quiet for a longer period. and hence he approaches the court later on. ಏನ್ ಮಾಡ್ಬೇಕಾಗ?
ನೋಡ para 7 may be looked.
ಹೇಳಿ ಏನು? Having regard to the contention, judge, first question for consideration is whether suit is filed by barred by limitation. ಹೇಳಿ ಅದ್ರಲ್ಲಿ ಏನಿದೆ?
Para 8 ಅಲ್ಲಿ there is no dispute that the parties to the suit are Hindus and are governed by Mitakshara law. The plaintiffs have challenged the alienation made by his father, the first defendant, under Exhibit P1, which is a joint family property, in favor of second defendant. Article 58 of the second schedule to the Limitation Act provides for the period of limitation to file a suit to obtain any other declaration. The period of limitation under this article is 3 years from the date when the right to sue first accrues. It is a residual placement.
Right to sue accrue ಯಾವಾಗ ಆಗುತ್ತೆ ನಿಮಗೆ?
According to 58, it accrues in the year 2005.
ಹೌದಾ?
Please, I agree to that fact. My lord, it is a residuary article governing all those suits for declaration which are not specifically governed by any other articles in the Limitation Act. Article 109 is the special article to apply where the alienation of the father is challenged by the son and the property is ancestral and the parties are governed by Mitakshara law. Generally, where a statute contains both general provision as well as specific provision, the latter must prevail. Therefore, Article 58 has no application to the instant case. Article 109 is as under. Article 109 by Hindu governed by Mitakshara law to set aside his father's alienation of ancestral property. Period of limitation 12 years. Time from which period begins to run when the alienee takes possession of the property. Next paragraph, my lord, they have stated that alienation also includes a gifting. So, my lord, when the alienee takes possession, my lord, even if I accept my lords that the possession was taken in the year 2005-2007, I'm well within 12 years is my humble submission. My lords, with respect to that equity, my lords have the power, my lord, to grant that property.
And the right to sue first accrues. That is the issue.
Not 58 apply agutta, 109 apply agutta andag the Honorable Apex Court has held 109 is applicable in case of a alienation made by father of an ancestral property. Lord, in my case, my lord, the trial court and the first appellate court has not disputed the fact that the properties are ancestral property.
It is an ancestral property.
Please, my lord, both the courts have held in my favor. Only ground, my lord, on which the first appellate court holds against me is on the ground, my lord, that it is not within a period of limitation and that relief of cancellation is not claimed. My lords also have held in various
cancellation not necessary, not binding or binding.
Limitation, my lord, even
for partition.
Even a division bench judgment, my lord.
Issue notice, notice over other side appear. Issue notice.
Great.
Call for records. Records bandilala madam?
Illa.
41.
Great.
Hariprasad MB.
Plaintiff is before this court, my lord. Concurrent findings, my lord. Suit for declaration mandatory injunction. Before the trial court, my lord, suit was dismissed for 5 reasons, my lord, stating that the second marriage of Uchai with Kempegowda is void. Since void, she had no legal right or title over the Uchai's property as per the discussion made by the trial court at para 10 to 14, my lord. The second ground was that, my lord, Kempamma could not execute a valid will, that is Exhibit P1, because she never acquired any such title, being a second wife. That's the contention taken. Despite the fact that this plaintiff was born in the year 1942, which goes to say that the second marriage was
property originally
belongs to one Uchaya, my lord.
Uchaya.
Yes, my lord. Uchaya was having a brother by name Yalakaya. Both got partitioned 40 years ago. This Uchaya was married twice. The first wife was Mayamma. The second wife was by name Kempamma. The first wife, Mayamma, is the defendant number 2 in the suit. Both Mayamma and Kempamma happens to be the full blood sisters, married to Uchaya. Both died issueless.
Both died
issueless. During their subsistence, my lord, the plaintiff, she was raised as a foster daughter.
Plaintiff or Kempamma?
A plaintiff by name Puttanarasam.
Foster daughter.
Yes, my lord.
Of whom?
foster daughter of Uchaya and both Kempamma and Mayamma.
Muru jana.
Because they had no issues. Now, my lord, the contention is that, my lord, such being the fact of the case, now the suit is came to be filed seeking declaration stating that the order so passed in the P&SC 1 of 2020 is not binding on the plaintiff for the reason that it is an admitted fact given by the defendant number 2, who happened to be the Yelakaya son, that is the brother's son, class 2 higher for entry number 4. He obtained a succession certificate in order to draw the amount.
Uchayana brother's son.
Who is the defendant number 2?
Defendant number 2 Mayamma andre ನೀವು.
Sir, please, my lord. Yelakaya's son.
Yelakaya's son is the D2 na?
Please, my lord. D1.
Yar D1?
D1 is brother, Uchaya's brother's son.
D1.
D2 is the first wife of the Uchaya. Who was alive during
suit file ಮಾಡಿದವರು ಯಾರು?
Suit file ಮಾಡಿದ್ದು Putnarsamma, the foster daughter.
Foster daughter.
Yes, my lord. And this Mayamma was very much alive during the proceedings. He died during the pendency of the proceedings. When instituted, she was
foster daughter based on what? Will?
Not on will. She was raised, it is admitted even by the Mayamma in a written statement.
Foster daughter claiming the suit for declaration on what basis?
My lord, it is not claiming of the foster daughter. My claim is that the first claim is that the order passed in P&SC of 1 of 2000 is not binding on me. That's the first declaration.
P&SC ಯಾರ್ ಪರವಾಗಿದೆ?
P&SC in favor of defendant number 1.
D1.
Please, my lord.
ಅದು ಯಾವ ಬೇಸಿಸ್ ಮೇಲೆ ತಗೊಂಡ ಅಂತ ಕೇಳಿದೆ.
Please, my lord.
P&SC ಆರ್ಡರ್ ನ ಯಾವ ಬೇಸಿಸ್ ಮೇಲೆ ತಗೊಂಡ ಅವನು?
Stating that he is only the legal heir.
Legal heir ಅಂತ.
Legal heir ಅಂತ ಹೇಳಿ. Despite admitted facts that Mayamma was the defendant number 2 was alive at the institution of this suit. Suit was instituted in the 2001. P&SC order was passed in the 2000. It is not disputed by either of the parties that Mayamma was alive at the institution.
At the time of taking the P&SC. ಹೌದಾ? ಆಯ್ತು. Next.
This was not taken into consideration. The second point.
Trial court dismiss ಮಾಡಿರೋದು on what basis? P&SC basis ಮೇಲ ಅಥವಾ reason ಏನು ಕೊಟ್ರು?
P&SC basis ಮೇಲೆ issue number 2 was formulated, my lord, saying that whether defendant suppressed facts and obtained succession certificate that is not binding on plaintiff, it was answered negative, stating that defendant followed the procedure despite having the knowledge that Mayamma, who is the defendant number 2 in this case, was alive.
So that is not correct.
That is not correct, my lord.
One ground. Then
please, my second one is, my lord,
what first appellate court says with regard to the issue number 2?
Issue number 2 negative.
ಅಲ್ಲ ಅವರುನು ಅದನ್ನ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ತಾರಾ?
ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ತಾರೆ.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೀಸನ್ ನ
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ತಾರೆ.
P&SC ಇರೋದ್ರಿಂದ
ಇಟ್ ಇಸ್ ವ್ಯಾಲಿಡ್ ಅಂಡ್ ಕೆನಾಟ್ ಬಿ ಕನ್ಸಿಡರ್ ಅಂತ ಹೇಳಿ.
ನೀವು ಫಾಸ್ಟರ್ ಡಾಟರ್ ಅಂತ ತೋರ್ಸಕ್ಕೆ ಏನ್ ಮೆಟೀರಿಯಲ್ ಕೊಟ್ರಿ?
That was filed during the first appeal, which never considered. That includes, my lord.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನ್ ಕೊಟ್ರಿ ಅಂತ ಕೇಳಿದೆ.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನು
ಫಾಸ್ಟರ್ ಡಾಟರ್ ಅಂತ ತೋರ್ಸಕ್ಕೆ
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ವಾಸ್ ನಾಟ್ ಪ್ರೊಡ್ಯೂಸ್, ಎನಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ವಾಸ್ ನಾಟ್ ಹಾಕ್ಲಿಲ್ಲ. ಬಟ್ Mayamma, who also happened to be the foster mother of the foster daughter,
she has been examined before the trial.
Not examined, but categorically admitted the entire version of the plaint in the plaintiff. Entire version ನ ಇದ್ ಮಾಡ್ತಾರೆ.
ಯಾರು ಅಡ್ಮಿಟ್ ಮಾಡೋದು?
Mayamma, that is the defendant number 2.
Defendant number 2 filed written statement.
Yes, my lord. May I read out?
She admits the same.
Please, my lord. The entire contention of the plaintiff is admitted.
Suit dispose ಆಗೋಕ್ Mayamma ಇದ್ರ ಇಲ್ಲ?
No, she was not there, my lord.
At the time of evidence ಇರ್ಲಿಲ್ಲ?
ಇರ್ಲಿಲ್ಲ. Written statement. May I read out, my lord? The written statement is admitted by the defendant number 2. She categorically admits, as stated in para 2 of the plaint, is true that Uchaya was in service of VISL at Bhadravati and he was living there during this service along with this defendant and his second wife Kempamma. Since Uchaya had no issues from this defendant as well as from his second wife, Kempamma, he had taken the plaintiff as his foster daughter. The plaintiff was brought up by said Uchaya and his second wife Kempamma. This defendant also take care of plaintiff during her childhood. It is true to say that the Kata of the suicide property of deceased Uchaya was got changed to the name of the second wife Kempamma.
Property is an ancestral property?
Yeah, that is the property of Uchaya.
Uchaya in the self-acquired ಅಥವಾ?
Uchaya had two properties. One is at Nagamangala, Mandya, and since he was working at Bhadravati, he had some properties at Bhadravati. The properties at Bhadravati fell
He
in.
was having both ancestral as well as self-acquired property, na?
Please, my lord. Now the properties which were at Bhadravati fell into the share of the Mayama after the death of Uchaya. That is defend number 2. The properties at.
Why you have not produced any document before the trial court to show that you are a foster daughter of the Uchaya, Mayamma and Kempamma? Why you have not produced?
Lord, at that time it was.
Unless you prove the same, automatically it goes to the heirs of Uchaya.
My lord, I am seeking declaration.
Whether based on P&SC or succession. No.
My basis is, my lord.
ನೀವು ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನ್ ಹಾಕಿದ್ರಿ ದಾಖಲೆನ?
ದಾಖಲೆಗಳು ಸ್ಕೂಲ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್.
ಸ್ಕೂಲ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಲ್ಲೆಲ್ಲ ಎಂಟ್ರಿ ಇದೆಯಾ?
ಪ್ಲೀಸ್ ಮೈ ಲಾರ್ಡ್ ಇದೆ.
41 rule 27 ಡಿಸ್ಮಿಸ್ ಆಯ್ತಾ?
Yes, my lord.
ರೀಸನ್ ಏನ್ ಕೊಟ್ರು?
Reason stating that this will amounts to a de novo trial ಆಗ್ತದೆ ಅಂತ ಹೇಳಿ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ರು.
ಡಿ ನೋವೋ ಟ್ರಯಲ್ ಆಗುತ್ತೆ?
ಹೌದು.
ಎಲ್ಲಿದೆ ಆ ರೀಸನ್? ಡಿ ನೋವೋ ಟ್ರಯಲ್ ಆಗೋದೇನ ಆರ್ಡರ್ 41 rule 27 ಅಲೋ ಮಾಡಿದ್ರು.
It allows to new entry of new facts and it raise to new issues ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಇದು ಮಾಡಿದ್ದಾರೆ.
Additional document produced by the plaintiff in the appeal but not stated any sufficient reason. What was the difficulty to produce the same before the trial court? In this case, documents are taken into consideration is nothing but a contrary to the pleading. Additional documents also not supports the case of the plaintiff. Plaintiff must specifically plead and prove, fail to prove that she is foster daughter, then she is sought. Documents ಮೇಲೆ ಏನು ಹೇಳೋದೇ ಇಲ್ವಾ?
Documents
ಸಾಲ ದಾಖಲಾತಿ ವಿವರ
could not be traced during the trial ಅಂತ ಹೇಳ್ತಾರೆ.
Issue notice and call for records.
Records ಬಂದಿದೆ ಸರ್.
ಬಂದಿದೆಯಾ? ನೋಟಿಸ್ ಹೋಗಬೇಕಲ್ಲ?
ನೋಟಿಸ್.
Right. Notice list this matter 19-1.
Right.
42.
Syed Akbar Pasha.
Appear for appellant. The defendant's appeal, Lord. Suit for a partition filed by the plaintiff. The propositors of the family, Lord, the one Rachaya, but who has not the 5 children, 1 daughter and 4 sons. Lord, one of the son has been Lord having no issues. The properties has been divided between the 3 sons, Lord, the year 2001.
2001. Partition ಆಗಿತ್ತು ಅಂತಲ್ಲ?
Yes, Lord. Unregistered partition.
ರಾಚಯ್ಯ ಬಸಮ್ಮ, ರಾಚಮ್ಮ, ದೊಡ್ಡಸಿದ್ದಯ್ಯ, ಪುಟ್ಟಸಿದ್ದಯ್ಯ, ಲಿಂಗರಾಜು, ಮಂಟಯ್ಯ. ನಿಮ್ ಪ್ರಕಾರ ಯಾರ ಮಧ್ಯದಲ್ಲಾಗಿತ್ತು ಪಾರ್ಟಿಷನ್?
ದೊಡ್ಡಸಿದ್ದಯ್ಯ, ಪುಟ್ಟಸಿದ್ದಯ್ಯ, ಲಿಂಗರಾಜು.
About ಮಂಟಯ್ಯ?
ಮಂಟಯ್ಯ was not
died unmarried, died before partition ಆಗಿತ್ತು ಅಂತ ತೋರ್ಸಕ್ಕೆ ಏನ್ ದಾಖಲೆ ಕೊಟ್ಟಿದ್ದೀರಿ?
The plaintiff themselves has produced, Lord, it is that uncontested by from the defendant, Lord. Defendants contest ಮಾಡಿಲ್ಲ.
ಮಾಡ್ಲೇ ಇಲ್ಲ.
Plaintiff themselves produced, Lord, those that partition deed. Saying
partition
that,
deed.
Unregistered partition palupati.
Unregistered.
Palupati. But the trial court held that, Lord, since excluding the Lord, the plaintiff.
Property was partitioned through unregistered partition deeds also.
ಅದಕ್ಕೆ not considered.
Number 1 and 2 and Rajshekhar.
So therefore, the court comes to the conclusion that Lord, that is not a proper partition in the IF law. Hence, partition is being allowed and for share is being allotted.
ಹೋಗ್ಲಿ, ಈ partition ಮೇಲೆ ಏನಾದ್ರು parties have acted upon?
It is Lord acted upon since Lord.
ನೀವೇನು ಹಾಕಿಲ್ಲ?
ಹಾಕಿಲ್ಲ.
ಮತ್ತೆ?
Partition is acted upon.
ಬರೀ unregistered partition ಮೇಲೆ ಹೆಂಗ್ ಮಾಡಕ್ಕಲ್ಲ?
ಅವರೇ ಹೇಳ್ದ 2005 ಅಲ್ಲಿ ಅವ್ರು ಸೇಲ್ ಮಾಡಕ್ ಇದ್ ಮಾಡ್ತಾ ಇದ್ರು, ಅದಕ್ಕೆ it is came to their knowledge ಅಂತ.
2005 ಅಂದ್ರೆ subsequent to the amendment. First appellate court ಅಲ್ಲಿ ಏನಾಗಿದೆ?
First appellate court, Lord, as there is a delay in approaching the appellate court. So Lord, ಅಂದ್ರೆ delay ಮೇಲೆನೆ ವಜಾ ಆಯ್ತು.
ಎಷ್ಟು ದಿವಸ?
This 1000 days delay.
ಮತ್ತೆ delay ಏನು explanation?
Delay, Lord, So one of them, Lord, the defendant's son who's taking care.
1,700 days.
1,007 days. One of them, Lord, the
Suffering from diabetes and hypertension, and she could not move, cannot be believed. Present at the time of survey of land.
notice already settlement ಏನಾದ್ರು ಆಗ್ಬೋದು.
ಏನ್ ನೋಟಿಸ್ ಮಾಡಕ್ಕೆ ಇರ್ಬೇಕಲ್ಲ, ನೀವು ಡಿಲೇ 1,700 ಡೇಸ್ ಇದೆ.
That's true, Lord, they have not contested.
ಕಂಟೆಸ್ಟ್ ಮಾಡಿಲ್ಲ ಮತ್ತೆ ನೋಟಿಸ್ ಮಾಡ್ಬೇಕು.
They've realized only, Lord, when the FDP proceedings.
Not only on limitation, even answered the other point for consideration. 2 to 3 are also negative. Delay no illa, delay no not satisfactorily explained, and also merits also anta madidare. Not only on limitation. You should point number 2 to 4 also considered alendri.
That is
ಮತ್ತೆ
as it is not, it is the opinion of the trial court.
Plaintiff did not produce any document before trial court. There was no other option for the trial court except to pass a judgment. Contention of the appellant that no opportunity was given them to address the arguments cannot be accepted. Suit item no, one property was granted to one Rachaya. The said Rachaya died intestate. He had 5 children. Plaintiff is one of the daughter. The last son of Rachaya by name Mantaya died unmarried. Appellants are the legal heirs of known Lingaraju, who was the son of Rachaya. Thus all the successors of the so and so section 8 attracts. What is the error in the order? Merits are merits mello consider ಮಾಡಿದ್ದಾರೆ.
38 ಅಲ್ಲಿ ಆರ್ಡರ್. But serial number 38 ಅಲ್ಲಿ ಏನು ಆರ್ಡರ್ ಆಯ್ತು?
38 ಅಲ್ಲಿ
serial your lordship has passed blood order in a serial number 38.
Same. Told. Heard the appellant counsel and also the peruse the impugned order passed by the trial court and appellate court. The suit is filed by the legal heirs of ಯಾರು ಇವನು ಯಾರ ಮಕ್ಕಳು ಇವರು? ಲಿಂಗರಾಜು.
The appeal is filed by.
Appeal ಆಯ್ತ್ರಿ, but
suit is filed by daughter-in-law Rachamma.
Suit is filed by Rachamma.
Children of Rachamma.
Children of Rachamma. And also the property originally belongs to Rachaya. And the Rachamma is the daughter of Rachaya. And it is the contention of the defendant appellant that there was a partition between the brothers, that is Dodasiddhaya, Puttasiddhaya, Lingaraju, who are the children of Rachaya in the year 2001. And counsel also would submit that partition through an unregistered document. And defendants have not contested the matter before the trial court. And trial court, considering the material available on record, held that the plaintiffs are entitled for 1/4 share and they are representing the share of Rachamma. And another son of Rachaya is no more, and only legal heirs of Rachaya is Rachamma, Dodsiddhaya, Puttasiddhaya, Lingaraju. And hence they are equally entitled for a share of 1/4. The defendants have filed an appeal before the first appellate court in RA number 5009 of 2019. And appellate court also even considering number 2 to 3, whether the judgment of trial court is not based on facts and law, whether the appellant proves that the judgment and decree passed by the learned trial judge is illegal and perverse. And even though not satisfied with the reasons assigned with regard to the delay is concerned, even considered the matter on merits while answering point number 2 to 4. And considering the material on record also comes to the conclusion that appellant defendant were remained absent, and trial court granted even an opportunity also, even they did not produce any documents before the trial court. There was no other option to the trial court except to pass the judgment, and contention of the appellant also cannot be accepted. And the appellants also did not produce any documents to prove their contention in the appellate court also. And in terms of the partition dated 3/11/2001, they have acted upon and nothing is placed on record, and taken note of the fact that suit item number property was granted to one Rachaya, and here he has not executed any testamentary document. Under the circumstances, all the children are entitled for a share, invoking sections 8 of the Hindu Succession Act, and confirm the judgment. Being agreed by, the concurrent finding present second appeal is filed before this court. The main contention of the counsel appearing for the appellant before this court is that both the courts have not committed an error in considering the material on record with regard to the earlier partition is concerned. And on perusal of material available on record, though even plaintiffs themselves have relied upon the partition deed, and the same is unregistered document, and the same is not admissible in evidence, and apart from that, no material is placed before the court for having acted upon in terms of the partition also. And defendant appellant also did not choose to place any record before the trial court, even in the appellate court also. When such being the case, when the property is allotted in favor of Rachaya and all the children are entitled for 1/4 share, since the Rachaya has not executed any testamentary document, and such being the case, I do not find any ground to admit and frame substantive question of law. In view of the discussions made above, I pass the following order. Second appeal is dismissed.
43, SK Acharya. 44.
Here for first respondents 1 and 2 in this. May please. Notices or permitted to file objections to IA 1 and may be permitted to file objections to IA 1 and 2.
IA 1 and 2 ಆಮೇಲೆ consider ಮಾಡೋಣ. Our admission guild suit for partition.
Suit for
half share granted in respect of 1 to 3. What are the grounds?
Suit for partition, my lord, between the two brothers. But the brother himself has sold it through the power of attorney.
Through the power of attorney.
And therefore he cannot claim partition with respect to the property. That is one aspect of the matter. Secondly, my lord could say
you are appearing for different number
1 and 2, my lord. The appeal is by defendants 1 and 2.
1 and 2.
1 and 2. There is a registered sale deed in my favor. That is not seriously contested. He does not dispute that there is a sale deed. Under the circumstances, when he admits that I am the owner under that sale deed, he cannot claim partition with respect to the property.
In respect of item number
3, house property.
Item number
3.
3.
In fact, 2 and 3, man. Well, 2 and 3. 2 and 3. The first item is survey number 181 of 1, measuring 6 acres 10 guntas. The second item is 181/2, measuring 7 acres. Third one is the house property with the coconut trees and all that. In order to show that I am in possession of the property, in fact, this house property as such, the house is constructed by me. The site does not belong to the family at all. The owner of the site permitted me to put up the construction. He did not question till today. And for having constructed the house property, my lord, I have taken loan from the banks. All documents are produced before the court. The plaintiff has not established how he is entitled to this house property, which was admittedly constructed by me by taking loan. And of course, I was also in employment, some savings. Therefore, the decreeing the suit with respect to item number 3, house property, prima facie, I may say with great respect, is not correct. Then come to
this partition between whom this 23/8/2008, 23/8/2008 partition.
Between father and sons, my lord.
Between the defendants.
Father and
Defendant, son.
defendants.
Myself.
D2 and father of defendant number 2.
D2 and father of
And his father.
and his father.
Plaintiff is the brother of defendant's father. This partition is amongst their branch. Branch of the defendants.
Whether plaintiff was a party to
No, my
that
lord, he was
earlier-
not party in 2008 partition.
No,
He was not a party. Our Tande Maga, defendant number 2 and his father, they partition the property.
excluding this plaintiff.
Excluding the plaintiff. By saying that it is joint family property, but their contention is that is a joint family amongst themselves. Tande Maga, idರಲ್ಲಿ ಇವರು ಸೇರಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
He was excluded.
He was excluded. Plaintiff was excluded in the 2008 partition.
But in his evidence, my lord, I just take my lord's attention to here and there the evidence of the PW1, in which my lord he admits ನನ್ನ ಅಣ್ಣನಿಗೆ ಬರುತ್ತಿದ್ದ ಸಂಬಳವೆಲ್ಲ ಆತನೇ ಉಪಯೋಗಿಸುತ್ತಿದ್ದ. ಬೆಂಬಲ ಕಾರ್ಮಿಕ ಸಾಲದ ಸೌಲಭ್ಯ ಮತ್ತು ಇತ್ತು ಎಂದರೆ ನಿಜ. ದಾವಾ ಕ್ರಮ ಸಂಖ್ಯೆ 3
ಇಶ್ಯೂ ನಂಬರ್ 5 ಹೋಗಿ ನಿಮ್ ಕಂಟೆನ್ಷನ್ ಏನು ಅಂತಂದ್ರೆ, in the year 1996 the partition taken place between the plaintiff and S. Srinivasa Sastry, and the plaintiff had taken rupees 15,000 from S. Srinivasa Sastry and relinquished his share in the family properties and purchased the site at Bangalore out of the said amount anta nim contention. ಇದನ್ನ ಪ್ರೂವ್ ಮಾಡಕ್ಕೆ ಏನ್ ಮೆಟೀರಿಯಲ್ ಕೊಟ್ರಿ ನೀವು?
We have produced the challans and all those things for having taken the amount, my lord.
15,000.
And for having constructed all the documents, including the license, is in my name. And what he says is, it is a joint family property and therefore he has got a share. But the question is whether the third item.
Is there any document of relinquishing his right, plaintiff?
No, question of relinquishing does not arise because the third site, that is third property where a house is there for long. That site did not belong to the family at all, no, neither to me.
What about item number 1 and 2?
I'll come to 1 and 2. I am particular about the house property where I could show that it is mine. He cannot claim it. And for that, his answers in the cross-examination are relevant enough. Therefore, I just.
Now, share is granted in respect of item number 3 also.
All 3 items.
All the properties. Is there any admission by plaintiff with regard to the item number 3 is concerned?
Even their contention that it does not belong to the family ಅಂತ ಹೇಳೋದಕ್ಕೆ, to whom it belongs ಅಂತ ತೋರಿಸಿಲ್ಲ ಅವರು. They have not shown to whom the property belongs. They are now saying that it does not belong to our family at all. When there are other properties which are.
But once you have filed the suit in respect of item number 3, you first point out this property belongs to the family.
His own one sentence.
By exhibit, by the 2008 partition deed, where they have partitioned even item number 3 saying that it is joint family property.
Item number 3 also.
ಸೇರಿಸ್ಕೊಂಡಿದ್ದಾರೆ. Item number 3 ಸೇರಿಸ್ಕೊಂಡಿದ್ದಾರೆ.
ಪಿತ್ರಾರ್ಜಿತ ಆಸ್ತಿ ಅಂತ ತಿಳಿಸಲು ನಾನು ಯಾವುದೇ ದಾಖಲೆಗಳನ್ನು ಕೊಟ್ಟಿಲ್ಲ.
But your own document of 2008
ಸೇರಿಸ್ಕೊಂತಾರೆ.
discloses that that property also included while partitioning the property.
May I read the recitals?
Item number 3 also.
Joint with me and my father. Not with the.
There they should have told how they have acquired the property.
And further admissions, my lord could see here.
Records bandilalla. Call for records.
Please.
Call for records. And list this matter on 19-1. 45.
45. B. Sidramaya. N. Shivakumar.
Gilva. Pass over. Prasad K.S. Ravishankar Shastri.
Suit for partition filed by the mother on the demise of the son.
Mother against the son.
On the demise of the son.
On demise of this.
And that suit came to be dismissed.
Intersect between whom? Partition. Genealogical tree hogi. Para 60, the page 65.
Suit is filed against the daughter-in-law and her children, my lord.
Daughter-in-law and
her children.
Grandchildren. That is by mother.
Yes.
What is the name of mother?
Srimati Sita.
Srimati Sita.
Yes. In that suit, they have set up exhibit D7, the will, an unregistered will, my lord.
Unregistered?
Unregistered will, exhibit D7, yes. And I have hotly contested the will, saying that the signature found in exhibit D7 is not of the testator. So
will executed by whom?
It is a set up a fabricated will on the death of demise of the son.
I3 yaar execute madidru anta, that is their defense.
Sundara Mulya.
Sundara Mulya.
Yes.
Already executed anta.
Yes. So
what is the finding? What is the finding of trial court?
I have filed application for seeking assistance of the expert to compare the signature found in exhibit D1 document, pension book, as well as this exhibit D7. He filed the report saying that these signatures are not tallies each other.
Not tallies.
Not tallies.
Whether the trial court accepted the will or not?
Now accepted the will.
Accepted the will.
Yes.
Even as against the expert opinion.
Yes. And that observation is concurred by the appellate court also.
Why both the courts comes to such a conclusion?
Now, my lord, that defendant has filed objection to the report of the commissioner. And also filed application to set aside the commission report and go for appointing a fresh commissioner. That application also got dismissed.
Also dismissed?
Yes. So based on ignoring that report, the learned trial court had a conclusion that the will is valid and genuine.
Whether commissioner is examined?
Not examined. He filed the objection. He has not taken assistance of the court to examine the commissioner in contemplation of Order 26 Rule 10(2) of CPC. I have cited judgments before the trial court to hold that it is a part of the record, and the report of the commissioner is the evidence in that suit, and that is not discarded, and my suit is dismissed. My lord may kindly consider the page number 27, page number 13 and para number 27 of the judgment of the first appellate court, my lord.
But Sundara Mulya was also a defendant.
No, he is
the
not
trial court.
No, he is not the defendant. He'll have defendant.
Not defendant.
Not the defendant.
But you are not in good terms with your husband, Sundara Mulya.
Sundara Mulya is my son.
Will, but will work out or yaarri? Sanna?
Yes.
ನೀವು ಅದೇ ಸನ್ ಜೊತೆ ನೀವು ರಿಲೇಶನ್ಶಿಪ್ ಚೆನ್ನಾಗಿರ್ಲಿಲ್ವಾ ಅಂತ ಕೇಳಿದೆ.
ಚೆನ್ನಾಗಿತ್ತು.
ಇಲ್ಲ ಅಂತ ಬರೆದಿದಾರಲ್ಲ.
But only the contention is whether exhibit D stands proved or not, my lord. But the learned first appellate court arrived at a conclusion that in para number 27, it is only after the examination of such expert his report would become.
Whether mother is having any other property or not?
He is having, she is not having any property, except some property which is under dispute. Now she is no more. He executed a testamentary document during the integral period of the suit in favor of her son, bequeathing her undivided right. The learned trial court advanced that exhibit D13 also well documented.
Evidence ನೋಡಿ ನಿಮ್ಮ PW1 ನನ್ನ ಅಣ್ಣ ಸಾಯುವ ಸಮಯದಲ್ಲಿ ಅವರಿಗೆ 62 ವರ್ಷ ವಯಸ್ಸಾಗಿತ್ತು. ನನ್ನ ಅಣ್ಣ ಸಾಯುವವರೆಗೂ ಅವರ ಎಲ್ಲ ವಾರಗಳನ್ನು ಅವರೇ ನೋಡಿಕೊಳ್ಳುತ್ತಿದ್ದಾರೆ. ನನ್ನ ಅಣ್ಣ ಸಾಯುವ ಸಮಯದಲ್ಲಿ ನನ್ನ ಅಣ್ಣನ ಮಕ್ಕಳು ಮೈನರ್ ಆಗಿದ್ದರು. ನನ್ನ ತಾಯಿಯವರು ನನ್ನ ಅಣ್ಣನನ್ನು ಯಾವತ್ತೂ ಅವಲಂಬಿಸಿಲ್ಲ. ನನ್ನ ಅಣ್ಣ ಸುಂದರ ಮೂಲ್ಯ ಜೀವಂತ ಇದ್ದಾಗ ನನ್ನ ತಾಯಿಗೂ ಮತ್ತು ನನ್ನ ಒಂದನೇ ಪ್ರತಿವಾದಿ ವೇದಾವತಿ ಇವರಿಗೂ ವೈಮನಸ್ಸು ಇತ್ತು ಎಂದರೆ ಸರಿ. ವೇದಾವತಿ ಇವರ ಮನೆಯಿಂದ ಸೀತಾ ಇವರನ್ನು ಹೊರ ಹಾಕಿದ್ದಾರೆಂಬ ಬಗ್ಗೆ ವೈಮನಸ್ಸು ಇತ್ತು ಎಂದರೆ ಸರಿ. 2000ನೇ ಇಸ್ವಿಯಲ್ಲಿ ವಾದಿಯನ್ನು ಒಂದನೇ ಪ್ರತಿವಾದಿ ಮನೆಯಿಂದ ಹೊರ ಹಾಕಿರುತ್ತಾರೆ.
ಡಾಟರ್ ಇನ್ ಲಾ.
ವೇದಾವತಿ ನನ್ನ ತಾಯಿಯನ್ನು ಮನೆಯಿಂದ ಹೊರ ಹಾಕಿದ ನಂತರ ಸುಂದರ ಮೂಲ್ಯ ಜೀವಂತ ಇರುವವರೆಗೂ ಅವ್ರ ಮನೆಗೆ ನನ್ನ ತಾಯಿ ಹೋಗಿರುವುದಿಲ್ಲ. The perusal of evidence of PW1 as referred to above, it is evident that plaintiff Srimati Sita never dependent on her son, late Sundara Maulya, at any time further during her lifetime. Sundara Maulya itself, the plaintiff Sita, was not in cordial terms with defendant number 1.
My submission before this court, my lord. That
You are on witness PW1.
I have not objected the report of the commissioner. The defendant himself filed objection to the report of the commissioner.
Who?
Defendant.
Because it goes against him.
But they have not examined the commissioner. And they filed application to settle the report of the commissioner. Now the report of the commissioner is a part of the record. In view of order 26 to 10 of CPC.
Why you are not filed objections to, why you are not summoned the commissioner, madam? When the commissioner report goes against you? And also you filed an application to reject the commissioner report. That is also dismissed. Have you challenged that order?
No.
You don't know. You don't know or no? No. Then
He did not challenge.
then once the commissioner report goes against you, that the signature not tallies with the signature of Sundara Mulya in the service records as well as the signature found in the will.
Yes, my lord. He was Tashildar, my lord, when
Who is Tahsildar?
the,
Sundara Mulya.
yes, my lord. So his signature varies from,
Tahsildar the signature vary agutte.
oh, sir, every time he used to sign and all that time.
Madam, ನಾನು ಜಡ್ಜ್ ಹಂಗಾರೆ ದಿನ ಚೇಂಜ್ ಆಗ್ತದೆ ನನ್ನ ಸಿಗ್ನೇಚರ್. ಎಲ್ಲಿ ನಿಮ್ ಸೀನಿಯರ್?
But my lord, the property
Pass it,
which
I will pass over. Get your senior.
yes,
Remaining matters at 2:30.
ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದೆ ಇದು.
ಯಾವುದು?
ಮೆಮೋ ಹಾಕ್ಬೇಕಷ್ಟೇ.
ಯಾವ್ದು ಕೊಡಿ?
ಪಾರ್ಟೀಸ್ ಇದ್ದಾರೆ ಸ್ವಾಮಿ. 61
ಮೆಮೋನ ಕಾಂಪ್ರಮೈಸ್?
ಕಾಂಪ್ರಮೈಸ್.
60?
61.
61.
Report come. Specific performance.
ಏನ್ ಕಾಂಪ್ರಮೈಸ್ ಪ್ರಕಾರ ಏನು?
3 lakhs ಗೆ ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದೆ ಸರ್. ಇವತ್ತು 50,000 ಡಿಡಿ ನಲ್ಲಿ ಕೊಡ್ತಾ
ಡಿಡಿ ಕೊಡ್ತಾ ಇದ್ದಾರೆ.
ಇನ್ ಬಾಕಿ ಇದೆ 2 ಲಕ್ಷ
18/1 ಅಲ್ಲಿ ಕೊಡ್ಬೇಕು ಅಂತ
18/1/2016.
26. ಅದ್ರಲ್ಲಿ ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಡಬಲ್ ಕೊಡ್ಬೇಕು ಅಂತ ಹೇಳಿ 3 months.
ಯಾರಿಗೆ ಕೊಡೋದು ಈಗ?
ಇವರು ಪ್ರಾಪರ್ಟಿ ಓನರ್ ರೆಸ್ಪಾಂಡೆಂಟ್.
ಇಲ್ಲ ಅಪಲೆಂಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್
ಗೆ ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೊಡ್ತಾ ಇದ್ದಾರೆ ಸರ್. ಅಪಲೆಂಟ್ ಗೆ
ವರಲಕ್ಷ್ಮಿ ಕೊಡ್ತಾ ಇದ್ದಾರಾ?
ಅಡ್ವೊಕೇಟ್
ಇವರು ಸ್ವಾಮಿ.
ರಾಮಚಂದ್ರ.
ಪಾರ್ಟಿ ಹೆಸರು ಮೋಹನ್ ಕುಮಾರ್. ರಾಮಚಂದ್ರ ಯಾರು ನೀವಾ? ಎಷ್ಟು ಕೊಡ್ತಾ ಇದೀರಿ ಇವತ್ತು ದುಡ್ಡು?
50,000 ಡಿಡಿ ಕೊಟ್ಟಿದ್ದೀನಿ. ಇನ್ನು 2.5 ಲಕ್ಷ ಬರುತ್ತೆ ನೆಕ್ಸ್ಟ್ ತಿಂಗಳು 18 ವರೆಗೆ ಕೊಡ್ತೀನಿ.
ಡೇಟು ಸೂಟ್ ಏನಾಗಿತ್ತು? ಡಿಗ್ರಿ ಆಗಿತ್ತಾ?
ವಿತ್ ಇದು ಇಂಟ್ರೆಸ್ಟ್ ಆಗಿ ಸರ್. ರಿಟರ್ನ್ ಆಫ್ ಇಂಟ್ರೆಸ್ಟ್
ಅಂತ
ಇಂಟ್ರೆಸ್ಟ್ ಆಗಿತ್ತು. ಈಗ 12% ಮಾಡ್ಕೊಂಡು
ಬೋತ್ ಎಷ್ಟು?
12% ಈಗ ನಾ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡಿರೋದು. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ 6% ಆಗಿತ್ತು ಸರ್.
ಇದು ಒಂದ್ಸರಿ ಹಿಯರ್ ಮಾಡಿ
ಹಿಯರ್ ಮಾಡಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಗಿ
ಜಾಸ್ತಿ ಮಾಡಿ ಅಂತ ಏನೋ ಅಂದೋದ. Both appellant and counsel for the respondent are present and respective counsels are present, and both of them have filed compromise petition. In terms of the compromise, the respondent has paid the amount of rupees 50,000 by way of DD for this court and agreed to pay the balance amount of rupees 2,50,000 on 18/1/2026. Howda? 6. If failed to make the payment on 18/1/26 and also agreed to pay the double the amount, double the amount.
Remaining amount 2,50,000 ಗೆ
5 ಲಕ್ಷ ಆಗುತ್ತೆ.
5 ಲಕ್ಷ.
ಅದನ್ನು ಯಾವಾಗ ಕೊಡಬೇಕಾಗುತ್ತೆ?
3 months. 3 months again.
Within 3 months. ಡಬಲ್ ದಿ ಅಮೌಂಟ್ ವಿತ್ ಇನ್ 3 months.
3 months.
3 ತಿಂಗಳಲ್ಲೂ ಕೊಡ್ಲಿಲ್ಲ
ಅಂದ್ರೆ ಕೇಸ್ ನಡ್ಸ್ಕೊಳ್ಳೋದು ಅಂತ ಮಾಡಿ.
ಮತ್ತೆ ಕೇಸ್ ನಡೆಸುತ್ತೆ, ಇದು ಕಾಂಪ್ರಮೈಸ್ ಆಗಿರುತ್ತೆ.
ಸ್ವಾಮಿ ಇವ್ರು ಹೇಳಿದ್ದಾರೆ ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ಅವರು ಕ್ಯಾನ್ಸಲ್ ಮಾಡ್ಬೇಕು ಅಂತ ಅವತ್ತು 18 ಮಂತ್ಗೆ ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ಒಂದ್ ಚೆಕ್ ಬೇರೆ ಅವ್ರ ಹತ್ರ ಇದೆ ಸ್ವಾಮಿ, ಅದು ಬೇರೆ
ಮಾತಾಡಿದಾರೆ ಬಿಡಿ ಎಲ್ಲ. ಇಲ್ಲ ಏನಿಲ್ಲ ಸರ್, ಅವರೆಲ್ಲ ಮಾತಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ಕ್ಯಾನ್ಸಲ್ ಮಾಡ್ಬೇಕು ಸ್ವಾಮಿ ಅವರು, ಅವಾಗ 2,50,000 ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ವಿ.
ಆಯ್ತು. It is also agreed to cancel the sale agreement and payment of the amount. And parties understood the terms of the compromise, and hence compromise petition is accepted. And the second appeal is dismissed. 2.5 ಲಕ್ಷ ಕೊಡಬೇಕು 18ನೇ ತಾರೀಕೊಳಗೆ. 18ನೇ ತಾರೀಕೊಳಗೆ ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನೀವು ಆವಾಗ 5 ಲಕ್ಷ ಕೊಡ್ಬೇಕಾಗುತ್ತೆ. ಗೊತ್ತಾ? ಕೊಟ್ಬಿಡ್ತೀರಾ ಎಲ್ಲ? ಬಟ್ ಒಪ್ಕೊಂಡಿರೋ ಪ್ರಕಾರ ಮತ್ತೆ 18/1/2026 3 ತಿಂಗಳೊಳಗೆ ನೀವು 2.5 ಲಕ್ಷ ಬದಲು 3 ಲಕ್ಷ 5 ಲಕ್ಷ ಕೊಡ್ಬೇಕಾಗುತ್ತೆ. ಆತರ ಒಪ್ಕೊಂಡಿದ್ದೀರಾ? 18 ಒಳಗಡೆನೆ ಕೊಡ್ತೀರಿ. ಆಯ್ತು. ಅವ್ರೇನಾರು ಅವಾಯ್ಡ್ ಮಾಡ್ಬಿಟ್ಟವ್ರ ಮೇಲೆ ರಿಸೀವ್ ಮಾಡೋದನ್ನ.
ಅದೇ ರೈಸ್ ಮಾಡ್ದೆ
5 ಲಕ್ಷ ತಗೋತೀನಿ ಅಂತ ಮೇಲೆ 5 ಲಕ್ಷ ಬರುತ್ತೆ ಅಂತ. ಇಲ್ವಾ? ಆಯ್ತು. Accepted, and in terms of the compromise, RSA is disposed of. Please. Court fee ಇದೆಯಾ?
Refund court fee
ಎಷ್ಟಿದೆ? ಆಯ್ತು. Registry is directed to refund the court fee in favor of the appellant on proper identification.
And return of the original or ಏನೋ cancellation ಮಾಡ್ಕೋತಾನ.
ಏನ್ ಒರಿಜಿನಲ್
agreement ಇದೆ. 47ರಲ್ಲಿ registered agreement ಇದೆ.
And return the original agreement.
ಇನ್ನ ಕಡೆ
47ರಲ್ಲಿ ರೆಕಾರ್ಡ್ಸ್ ಬರಬೇಕು ಅಂತ.
ಯಾವುದು?
ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ರೆಕಾರ್ಡ್ಸ್ ಬರಬೇಕು ಅಂತಿದೆ.
ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿಲ್ವಾ? ನೋಡಿ ಮೇಡಮ್.
ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಅದು 47 ಅಲ್ಲಿ.
ಏನಾಗಿದೆ ನೋಡಿ. ಅದರ್ ಸೈಡ್ ಇದಾರಾ?
OS ರೆಕಾರ್ಡ್ ಬರಬೇಕು.
ಅದರ್ ಸೈಡ್ ಇದಾರಾ?
ಅವರು ಇದ್ದಾರೆ.
ಆರ್ಯದ್ ಬರಬೇಕು. ತೊಳಿ. Registry is directed to remind the appellate court to send the records forthwith. List this matter immediately after winter vacation. Okay. Next week ಆಗಲ್ರಿ, ಜಾಸ್ತಿ ಇದೆ. ಇರೋದೇ ಒಂದು ವಾರ ರೀಚ್ ಆಗೋದಿಲ್ಲ. ಆಯ್ತು. ಲಿಸ್ಟ್ ದಿ ಮ್ಯಾಟರ್ ಆನ್ 18/12 ಅಂತ ಹಾಕ್ಬಿಡಿ. ಅಷ್ಟೊಳಗೆ ಬರ್ಬೇಕಲ್ಲ. 17th 17/12 ಅಷ್ಟೊಳಗೆ ಬರುತ್ತೇನ್ರಿ? ನೋಡಿ ಕೇಳಿ.
ಆಯ್ತು.
ಅದರಲ್ಲಿ ಡಿಲೇ ಇದೆ 145 days ಇದೆ.
ಅಷ್ಟೇನಾ? ಇದು ತೋರಿಸ್ಬಿಡಿ ಮೇಡಮ್, ನೋಡ್ಕೊಬಿಡಿ.
ಏನ್ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರು ಕಂಪ್ಯೂಟರೈಸ್ಡ್ ಅದು. ನಾವು ಕೊಟ್ಟ ತಕ್ಷಣನೇ ಫೈನಲ್ ಇದಕ್ಕೆ ತಗೊಂಡು ರೀಚ್ ಆಗ್ತಾರೆ ಎಲ್ಲ. ಅಡ್ಮಿಷನ್ ಎಷ್ಟು ಅಂತ ಅಡ್ಮಿಷನ್ ಆದ ತಕ್ಷಣ ಅದನ್ನು ತಗೊಳ್ಳಿ.
ಒಂದ್ಸರಿ ಸೇಮ್ ಸಬ್ಸ್ಟೆನ್ಷಿಯಲ್ ಕ್ವಶನ್ ಆಫ್
ನಿನ್ನೆ ನನ್ನ ನಿಮಿಷ 9:29 ಮಾಡ್ತಾರೆ ನಿನ್ನೆ ಭಯಕ್ಕೆಲ್ಲ ಕ್ಯಾರಿಯರ್ ಎಲ್ಲ ಬೀಳ್ಸ್ಕೊಂಡು ಅವ್ರ ಮೇಲೆ ಪಾಪ
ಎರಡು 15 ಊಟ ಮಾಡಿ ಕುತ್ಕೊಂಡು ತಕ್ಷಣ
matter at 230, 77, Vinekirtiyam.
Your Lordship, I challenge that charge sheet. I question the charge sheet, Your Lordship. Executive petition.
Can a compliance of office objections raised on statement of objections filed by advocate for.
ಅಂದ್ರೆ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ ಅಬ್ಜೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ ಇದು
ಕೊಟ್ಟಿದ್ದೀರಿ ಅದೇನೋ ಕಂಪ್ಲೇಂಟ್ಸ್ ಇದೆ ನೋಡಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್
ನೋಡ್ತೀನಿ ಸ್ವಾಮಿ ಅದು ಅದರಲ್ಲಿ ಇದು ಮ್ಯಾಟರ್ ಈಸ್ ದ ಡಿಸ್ಪ್ಯೂಟ್ ಈಸ್ ಅವರು ಇಷ್ಟು ದುಡ್ಡು ಕೊಡಬೇಕು ಅಂತ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿ ಇದಾಗಿದೆ FIR ಆಗಿರೋದು.
Your Lordship, the crux of the matter this, Your Lordship. I am the owner of the property. Builder entered the JD. All the responsibility of that market, including marketing, is the responsibility of the JD. Out of the 42 flats I sold, they marketed the 17 flats, and on their marketing I registered the 17 flats. Out of that, whatever the consideration for the 17 less I collected. Now the first accused is the marketing manager. So he collected the
marketing manager of
builder. You only marketing the entire flats. That is the awareness of the complaints also.
Including your flats also.
Including my flats also.
Owner flats also.
So now that he was not deposited the deposit of BWSSB. Charges. So for that reasons, the complaint has been large against the builders and owner. So now based on that charge sheet file, my two contention is that JD and the GPA, which clearly discloses that the builder is sole responsible, that is the specific awareness in the sale deed. Each sale deeds also the same is reflected. They aware about the JD, contents of the JD and the GPA, which was obtained from the owner to builder to take care of all those things. Is that my sole contention is that in spite of that, Your Lordship, I told them is that as a inconvenience happens to you, so I'm ready to pay certain amounts. You tell they calculated that these 13,02,561 rupees, which was collected from the purchase builders against the 17 flats which I was sold. ಅದರಲ್ಲೂ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ ಎಲ್ಲ ಎನಾನ್ಸ್ ಮಾಡಿ ಹಾಕಿದ್ದಾರೆ ಫಾರ್ ದೇರ್ ಓನ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್. ಕೈಂಡ್ಲಿ ಸಿ ದ ಅಬ್ಜೆಕ್ಷನ್. ದೇ ಪ್ರೊಡ್ಯೂಸ್ ಒನ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಲಾಂಗ್ ವಿತ್ ದ ಬ್ರೇಕಪ್ ಲೆಟರ್.
ಈಗ JD ಗೆ ಯಾರು ಅಪೇರ್ ಆಗ್ತಾರೆ?
JD they are not filed any petition. The accused,
whether they have taken any action against the JD?
They filed the proceedings before the consumer court also.
ಯಾರ ಮೇಲೆ? JD ಮೇಲೆ.
ಎಲ್ಲರ ಮೇಲೂ. But consumer they issued the initially 2020 legal notice. Then after initiate the proceedings against the consumer court. Consumer court almost all 4 years they were not appeared. Anybody is not appeared. The same has been dismissed as non-prosecution. ಅವರು civil dispute raise ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ against. But None of them are.
ನಿಮ್ ಪ್ರಕಾರ ಅವ್ನ್ JD ಕೊಡ್ಬೇಕು ಅಂತ ಎಲ್ಲಿದೆ ದಾಖಲೆ ಹಾಕಿದೀರಾ?
ಹೌದು.
ಎಲ್ಲಿದೆ?
Your Lordship, ನನ್ನ kindly see the page 53, Your Lordship.
53.
First paraದಲ್ಲಿ. That it represent me that with the document authority, state government, central government, statutory body and authority, municipal, Bangalore Mahanagara Development Authority, BESCOM and the corporation company, partnership firm, individual, they are all sole responsible for all of that. Now, I'll give an offer. So only that I give a liberty you to go against the builder, whatever the for recovery. Whatever the inconvenience happens to you because of the builders, I am ready to pay up to 6 lakhs rupees. But they are quoted the 13 lakhs.
Sorry, our statutory authority, how can you bargain with them?
No, they are not the statutory. They are the
BWSSB ತಾನೆ ಅವ್ರು ಅಪಿಯರ್ ಆಗೋದು?
ಅಲ್ಲ.
ಮತ್ತೆ ನೀವ್ ಯಾರು ಅಪಿಯರ್?
Association, builders association.
ನೀವು builders association.
Respondent number 2 ಸುಮ್ಮನೆ.
ಅವರು their contention is that ನಾವು ಡೆಪಾಸಿಟ್ ಮಾಡ್ಕೊಂಡಿದೀವಿ ಅದನ್ನ ರಿಕವರಿ ನಾ ಹೇಳಿದೆ.
ಕರ್ನಾಟಕಕ್ಕೆ ಯಾರು ಅಪಿಯರ್ ಆಗೋದು?
ಇಲ್ಲ, ಕಂಪ್ಲೇನೆಂಟ್
ಯಾರು?
ಕಂಪ್ಲೇನೆಂಟ್, they are the complainants.
They are the complainant.
BWSSB ಇಶ್ಯೂ ಇಲ್ವೇ ಇಲ್ಲ ಇವಾಗ.
ಮತ್ತೆ ದುಡ್ಡು ಕೊಟ್ಬೇಕಾರದು ಯಾರಿಗೆ?
ಅವ್ರು BWSSB ಕಟ್ಟಿದೀವಿ, ನಾವು ಕಟ್ಟಿಬಿಟ್ಟಿದೀವಿ, ಓನರ್ಸ್ ಆಸ್ ದಟ್ ಬಿಲ್ಡ್ ಅಸೋಸಿಯೇಷನ್ ಇಂದ ನಾವು ಕಟ್ಟಿದೀವಿ. ನಾವು that is the responsibility of the builder.
They have swindled the amount, Your Honor. They have swindled the amount what they have collected jointly and severally. That amount we sought recovery for the association has sought for the recovery. ಅದರಲ್ಲಿ ಇಷ್ಟು ಅಮೌಂಟ್ 13 lakh.
ನೀವ್ ಯಾರ್ರಿ? SMR ಎಂಬಸಿ ಅಪಾರ್ಟ್ಮೆಂಟ್ ಓನರ್ಸ್
ಅಸೋಸಿಯೇಷನ್.
ನೀವೇ ಜಾಯಿಂಟ್ ಡೆವಲಪ್ಮೆಂಟ್ ಮಾಡಿರೋದಾ?
ಅಲ್ಲ. ಬಿಲ್ಡರ್ ಪರ್ಚೇಸರ್ಸ್.
ನೀವು ಪರ್ಚೇಸರ್ಸ್ ಇವೆಲ್ಲ ನೀವೊಂದು ಅಸೋಸಿಯೇಷನ್ ಫಾರ್ಮೇಷನ್ ಮಾಡಿದಿರಿ.
We are headed by the association. Headed by the secretary of the association.
Andre that means you are the purchasers of the flats.
ಹೌದು.
ಅದರಲ್ಲಿ builders owners ಸೇರಿ they have swindled the amount. What is the amount that has been collected from all the landlords? That has not been.
ನಿಮ್ಮ ಹತ್ರ ನೀವು ಓನರ್ಸ್,
respective land owners.
ನಿಮ್ಮ ಹತ್ರ ಏನ್ ಕಲೆಕ್ಟ್ ಮಾಡಿದ್ರು
ಅದನ್ನ ಡಿಪಾಸಿಟ್ ಮಾಡಿಲ್ಲ, ಏನು ಮಾಡಿಲ್ಲ. ಅದನ್ನ again it has been put to our double geo paradise.
ಬಲ್ಲಿ ಯಾರು ನಿಮ್ಗೆ BWSS ನಿಮಗೆ ಮತ್ತೆ ಕಲೆಕ್ಟ್ ಮಾಡಿದ್ರಾ?
ಈಗ ಕಲೆಕ್ಟ್ ಮಾಡಿದ್ರು, ಇವಾಗ ಕಟ್ಲೇಬೇಕು, ಇಲ್ಲ ಅಂದ್ರೆ ನಾವು ಕಟ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳೋದಕ್ಕೆ both BWSSB and BESCOM authorities.
BESCOM landlord ಕಟ್ಟಿದ್ರು, that is not dispute. Their complaint awareness is that BWSSB ಒಂದೇ that builder was not deposited. So that's ಅದನ್ನೇ ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲೂ ನನಗೆ 13 lakhs 561 rupees
ನಾನು ಹೇಳಿದೆ. ಅವರು ಅಷ್ಟೊಂದು ಇದಾಗಿ ಹೇಳಿದಾಗ ನಾನು ಹೇಳಿದೆ, ನೋಡಿ ಅಬೌಟ್ 10 lakhs ಎಷ್ಟಾದ್ರೂ ಆಫರ್ ಮಾಡಿ ನಾನು ಕನ್ವಿನ್ಸ್ ಮಾಡ್ತೀನಿ, ಕ್ಲೋಸ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದೆ.
neither I am collected that.
I had to have made
ನೀವು ಸೇಲ್ ಡೇಟ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡುವಾಗ ಅವರಿಂದ ಕಲೆಕ್ಟ್ ಮಾಡಿದಿರಾ ಇಲ್ಲ ದುಡ್ಡು?
No, Your Lordship, that is the collected by the builder because builder marketing they aware about the set.
Builder market ಮಾಡ್ಲಿರಿ, ಬಟ್ ನೀವು ಸೇಲ್ ಡೇಟ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡೋರು ನೀವು ತಾನೆ. ನೀವು ಇಂಟರ್ಸೇವ್ ಬಿಟ್ವೀನ್ ನೀವು ನಿಮ್ಮ ಬಿಲ್ಡರ್ ಸೇರಿ ಮಾತನಾಡಿ ಕೊಟ್ಬೇಕಲ್ಲ ದುಡ್ಡನವರಿಗೆ.
But they are only negotiating with the builders. I'm not even seen the overall the purchaser. There is no link between neither purchaser.
ಸೇಲ್ ಡೀಡ್ ನೀವೇ ಮಾಡ್ಕೊಟ್ಟಿದ್ದಲ್ವಾ?
ಸೇಲ್ ಡೀಡ್ ಮಾಡ್ಕೊಟ್ಟಿದ್ದೀವಿ.
ನೀವೇ ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ ಅವರಿಗೆ ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀರಾ ಸೇಲ್ ಮಾಡಕ್ಕೆ?
ಎಲ್ಲರಿಗೂ ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ ಎಕ್ಸಿಕ್ಯೂಟ್ whenever they call I come and execute the sale deed. I give a power of attorney for marketing also.
ನೀವು ಹೋಗಿ ಸೈನ್ ಮಾಡ್ತೀರಿ?
ಸೈನ್ ಮಾಡ್ತಿದ್ವಿ with respect to 17 flats. ಮಿಕ್ಕಿದ್ದೆಲ್ಲ ಫ್ಲಾಟ್ಸ್ ಗೆ ಜನರಲ್ ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ ಉಟ್ಕೊಂಡು they themselves sold the property other.
ಬಟ್ ಈ ಅಮೌಂಟ್ ಎಂಟೈರ್ ಓನ್ಲಿ 17 ಫ್ಲಾಟ್ ಕಾ ಅಥವಾ ಬೇರೆ ಎಲ್ಲಾ ಫ್ಲಾಟ್ ಕಾ?
No, they quoted only 17 flats ಗೆ.
ಈಗ ನಿಮಗೆ
ನಮ್ಮ ಮೇಲೆ ಇಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ ಅಂದೆ what they are stated in the objection.
ಮತ್ತೆ ಈ 17 ಫ್ಲಾಟ್ ನಿಮ್ಮ ಹತ್ರ ಬಂದಿರುತ್ತಲ್ವಾ?
ಇಲ್ಲ, that is the because they made the first accused.
Those 17 flats belongs to you only.
First accused is the Suresh, who is the marketing manager. Their sole allegation.
Marketing manager ಆಗ್ಲಿ ರೀ, ಅವ್ನ್ ಮಾರ್ಕೆಟಿಂಗ್ ಮ್ಯಾನೇಜರ್ ಏನ್ ಮಾಡ್ತಾನೆ ಅಂತಂದ್ರೆ ಯಾವ ಫ್ಲಾಟ್ ಇರ್ತದೋ ಖಾಲಿ ಇರುತ್ತೋ ಅವನಿಗೊಬ್ಬನಿಗೆ ಪರ್ಚೇಸರ್ನ ಅವ್ನು ಹುಡುಕ್ತಾನೆ. ಹೌದಲ್ಲ?
ಹೌದು.
ಸೇಲ್ ಕನ್ಸಿಡರೇಷನ್ ಯಾರಿಗ ಹೋಗುತ್ತೆ?
ಸೇಲ್ ಕನ್ಸಿಡರೇಷನ್ ನನಗೆ ಬಂದಿದೆ.
ಮತ್ತೆ ಸೇಲ್ ಕನ್ಸಿಡರೇಷನ್
ದಿಸ್ ಇಸ್ ನಾಟ್ ದ ಪಾರ್ಟ್ ಆಫ್ ದ ಸೇಲ್ ಕನ್ಸಿಡರೇಷನ್. This amount is not the part of the sale consideration. ನನಗೆ ಬರೋದು ಬರೀ 40 lakh 35 lakhs ಮಾತ್ರ ನನಗೆ ಸೇಲ್ ಕನ್ಸಿಡರೇಷನ್ ಅಲ್ಲಿ 40 ಬರುತ್ತೆ. ಮಿಕ್ಕಿದ ಅಮೌಂಟ್ ದೇ ಆರ್ ಕಲೆಕ್ಟೆಡ್ ಆನ್ ಬಿಹಾಫ್ ಆಫ್ ದ
ಬಿಲ್ಡರ್ ಹೋಗ್ತದಾ? ಬಿಲ್ಡರ್ ಈಗ ಏನ್ ಮಾಡಿಲ್ವ ಇದ್ರಲ್ಲಿ?
ಇಲ್ಲಿ ಬಿಲ್ಡರ್ A1 A2 ಇದಾರೆ, ಅವ್ರೇನ್ ಕ್ವಶನ್ ಮಾಡಿಲ್ಲ. ದೇ ಆರ್
ಸ್ಪೆಸಿಫಿಕ್ ಅಲಿಗೇಷನ್ ಇವ್ರ ಮೇಲೆ ಇರೋದು ಅಂದ್ರೆ ಇಂಕ್ ಪೇಜ್ ನಂಬರ್ 30 31 ಆಮೇಲೆ 46 ಇದೆ ಸ್ವಾಮಿ. ಅಲಿಗೇಷನ್ಸ್ ಏನು ಅಂತ ಹೇಳಿದ್ರೆ ಆರೋಪಿ 1 ಎಲ್ಲ ಡೆವಲಪ್ಮೆಂಟ್ ಇದರಲ್ಲಿ ಕೇಸಿನ ಸಂಕ್ಷಿಪ್ತ ಸಾರಾಂಶದಲ್ಲಿ ಎರಡನೇ ಪ್ಯಾರಾದಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ. 30ನೇ ಪುಟ ಅದರಲ್ಲಿ ನಂತರ SMR MBC ಅಪಾರ್ಟ್ಮೆಂಟ್ ನಲ್ಲಿ ವಾಸ ಮಾಡುತ್ತಿರುವ ಫ್ಲಾಟ್ ಮಾಲೀಕರಿಗೆ ದಿನನಿತ್ಯದ ಜೀವನ ನಡೆಸಲು ಬೇಕಾದ ನೀರು ಮತ್ತು ಒಳಚರಂಡಿ ವ್ಯವಸ್ಥೆ ಸೌಲಭ್ಯಗಳು ಇಲ್ಲ, ತೊಂದರೆಯಾದ್ದರಿಂದ ಫ್ಲಾಟ್ ಮಾಲೀಕರು ಆರೋಪಿ 2 ರಿಂದ 4ರವರೆಗೆ ಹೋಗಿ ಫ್ಲಾಟ್ ಖರೀದಿ ಮಾಡುವ ಸಮಯದಲ್ಲಿ ಆರೋಪಿ 1 ರವರು ಎಲ್ಲಾ ಸೌಲಭ್ಯಗಳು ಇರುತ್ತವೆ, ಯಾವ ತೊಂದರೆಯೂ ಇಲ್ಲ ಎಂದು ಹೇಳಿದ್ದರು. ನಮಗೆ ಫ್ಲಾಟ್ ರಿಜಿಸ್ಟರ್ ಕೊಡುವ ಸಮಯದಲ್ಲೇ ಪ್ರತಿಯೊಬ್ಬ ಫ್ಲಾಟ್ ಮಾಲೀಕರಿಂದ ನೀರು ಮತ್ತು ಒಳಚರಂಡಿ ವ್ಯವಸ್ಥೆಗೆಂದೇ ಒಟ್ಟು 64,08,375 ರೂಗಳನ್ನು ಕಟ್ಟಿಸಿಕೊಂಡಿದ್ದು, ನೀರಿನ ಸಮಸ್ಯೆ ಉಂಟಾಗಿದೆ ಎಂದು ಎಷ್ಟು ಬಾರಿ ಕೇಳಿಕೊಂಡರೂ ಸಹ ಆರೋಪಿ 1 ರಿಂದ 4ರವರು ಫ್ಲಾಟ್ ಮಾಲೀಕರ ಸಮಸ್ಯೆಗೆ ಸ್ಪಂದಿಸದೇ ಇದ್ದುದರಿಂದ ಜಲಮಂಡಳಿಯಲ್ಲಿಯೂ ಹೋಗಿ ವಿಚಾರ ಮಾಡಿದಾಗ SMR ಅಪಾರ್ಟ್ಮೆಂಟ್ ನಿಂದ ಬಿಲ್ಡರ್ಗಳಾಗಲಿ ಮತ್ತು ಲ್ಯಾಂಡ್ ಓನರ್ಗಳಾಗಲಿ ಯಾವುದೇ ಹಣ ಪಾವತಿ ಮಾಡಿರುವುದಿಲ್ಲ ಎಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. ನಂತರ ಫ್ಲಾಟ್ ಮಾಲೀಕರು ಆರೋಪಿ 1ರನ್ನು ಕೇಳಲಾಗಿ ನನಗೂ ಅದಕ್ಕೂ ಸಂಬಂಧವಿಲ್ಲ ಎಂದು ಸುಮ್ಮನಾಗಿರುತ್ತಾರೆ. ಆರೋಪಿ 1
ಆರೋಪಿ 1 ಯಾರು ನೀವಾ?
ಅಲ್ಲ, ನಾನು 4. ಮಾರ್ಕೆಟಿಂಗ್
ಆರೋಪಿ 1 ಬಿಲ್ಡರ್ ಮತ್ತು ಮಾಲೀಕರಿಂದ ಲಾಭ ಮಾಡಿಕೊಳ್ಳುವ ಉದ್ದೇಶದಿಂದ ಹಾಗೂ ಫ್ಲಾಟ್ ಮಾಲೀಕರಿಗೆ ಮೋಸ ಮಾಡುವ ಉದ್ದೇಶದಿಂದ ಎಲ್ಲಾ ಸೌಲಭ್ಯಗಳು ಇರುತ್ತವೆ ಸುಳ್ಳು ಹೇಳಿ ನಂಬಿಸಿ ಫ್ಲಾಟ್ ಕೊಳ್ಳುವಂತೆ ಮಾಡಿ ಬಿಲ್ಡರ್ಗಳಾದ 2 ಮತ್ತು 3 ಆರೋಪಿ 4 ಮತ್ತು ಫ್ಲಾಟ್ ಮಾಲೀಕರ ನಡುವೆ ದಲ್ಲಾಳಿಗಳಂತೆ ಕೆಲಸ ಮಾಡಿ ಫ್ಲಾಟ್ಗಳನ್ನು ಮಾರಾಟ ಮಾಡಿದ್ದರಿಂದ ಬಿಲ್ಡರ್ಸ್ ಕಡೆಯಿಂದ ಕಮಿಷನ್ ರೀತಿಯಲ್ಲಿ ಲಾಭ ಮಾಡಿಕೊಂಡಿದ್ದು, ಆರೋಪಿ 4 ರಿಂದ G5 ಫ್ಲಾಟ್ ಅನ್ನು ಅತಿ ಕಡಿಮೆ ಬೆಲೆಗೆ ಖರೀದಿ ಮಾಡಿರುವುದು ತನಿಖೆಯಿಂದ ಮೇಲ್ನೋಟಕ್ಕೆ ಕಂಡು ಬಂದಿದ್ದು, ಸಾಕ್ಷಿ 13ರವರು ನೀಡಿದ ವರದಿಯಂತೆ ಭೂ ಮಾಲೀಕರಾದ ಆರೋಪಿ 4ರವಾಗಲಿ ಅಥವಾ ಬಿಲ್ಡರ್ಸ್ಗಳಾಗಲಿ ನೀರು ಸರಬರಾಜು ಒಳಚರಂಡಿ ಸಂಪರ್ಕದ ವಿಚಾರವಾಗಿ ಇಲ್ಲಿಯವರೆಗೂ ಸಂಬಂಧಪಟ್ಟ ಕಚೇರಿಗೆ ಆನ್ಲೈನ್ ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ ಮತ್ತು ಯಾವುದೇ ಹಣವನ್ನು ಪಾವತಿ ಮಾಡಿರುವುದಿಲ್ಲ ಎಂಬ ಮಾಹಿತಿಯಂತೆ ಹಾಗೂ ಬಿಲ್ಡರ್ಸ್ಗಳು ಮಾಡಿಕೊಂಡಿದ್ದ ಅಗ್ರಿಮೆಂಟ್ನಂತೆ ಫ್ಲಾಟ್ ಮಾಲೀಕರಿಗೆ ದಿನನಿತ್ಯದ ಜೀವನಕ್ಕೆ ಅಗತ್ಯ ಇರುವ ನೀರಿನ ಸೌಲಭ್ಯ ಮತ್ತು ಒಳಚರಂಡಿಗೆಂದು ಎಲ್ಲ ಫ್ಲಾಟ್ ಮಾಲೀಕರಿಂದ ಹಣ ಕಟ್ಟಿಸಿಕೊಂಡು ಇದುವರೆಗೂ ಯಾವುದೇ ನೀರು ಮತ್ತು ಒಳಚರಂಡಿ ಸೌಲಭ್ಯ ನೀಡುವ ಸಲುವಾಗಿ ಜಲಮಂಡಳಿಯವರಿಗೆ ಹಣ ಪಾವತಿ ಮಾಡದೆ ಫ್ಲಾಟ್ ಮಾಲೀಕರಿಗೆ ಮೋಸ ಮಾಡಿರುವುದು ತನಿಖೆಯಿಂದ ತಿಳಿದು ಬಂದಿರುತ್ತದೆ.
64,08,375 ರೂಪಾಯಿನ ಯಾರು ಕಟ್ಟಿಸ್ಕೊಂಡವ್ರು?
ಎಲ್ಲರೂ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಎಲ್ಲರೂ ಖರೀದಿ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ, ಎಲ್ಲರೂ ದುಡ್ಡು ಕೊಟ್ಟಿದ್ದಾರೆ.
ನಾನು ಈ ದುಡ್ಡು ಯಾರಿಗ ಹೋಯ್ತು?
ಪರ್ಚೇಸರ್ಸ್ ಇವರು ಕಟ್ಕೊಂಡಿದ್ದಾರೆ.
ಪರ್ಚೇಸರ್ಸ್ ಯಾರಿಗೆ ಕೊಟ್ಟರು ದುಡ್ಡನ್ನ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. 64,08,375 ಮನಿ ಗೋಸ್ ಟು ಹೂಮ್?
ಇಲ್ಲಿ ಲಾಸ್ಟ್ 3 ಲೈನ್
ಏನು
ಎಂಬ ಮಾಹಿತಿ ಬಿಲ್ಡರ್ಸ್ ಗಳು ಮಾಡಿಕೊಂಡ ಅಗ್ರಿಮೆಂಟ್ ನಂತೆ ಫ್ಲಾಟ್ ಮಾಲೀಕರಿಗೆ ದಿನನಿತ್ಯದ ಜೀವದ ಅಗತ್ಯ ನೀರು ಒಳಚರಂಡಿ ಎಲ್ಲಾ ಫ್ಲಾಟ್ ಮಾಲೀಕರಿಂದ ಹಣ ಕಟ್ಟಿಸಿಕೊಂಡು ಇದುವರೆಗೆ ಯಾವುದೇ ನೀರು ಒಳಚರಂಡಿ ಸೌಲಭ್ಯ ಸಲುವಾಗಿ ಜಲಮಂಡಳಿಯವರಿಗೆ ಹಣ ಪಾವತಿ ಮಾಡದೆ ಫ್ಲಾಟ್ ಮಾಲೀಕರಿಗೆ ಮೋಸ ಮಾಡುತ್ತೆ ತನಿಖೆಯಿಂದ ತಿಳಿದು ಬಂದಿರುತ್ತೆ. ಸೊ ಬಿಲ್ಡರ್ಸ್ ಎಂಟೈರ್ ಅಮೌಂಟ್ ವೆಂಟ್ ಟು ದ ಬಿಲ್ಡರ್ಸ್. ಅದನ್ನೇ ದೇ ಆರ್ ನಾಟ್ ಆಲ್ಸೋ ಡಿಸ್ಪ್ಯೂಟೆಡ್ that their deeds also discloses that owner ಏನಪ್ಪ their responsibility is that once they enter the JD entire responsibility burden shift to the JD. otherwise there is no
ನಾನು ಕೇಳ್ತಿರೋದು ಈ ದುಡ್ಡನ್ನ ಯಾರಿಗೆ ಕೊಡಬೇಕು
ಎಲ್ಲ ಬಿಲ್ಡರ್ಸ್ಗೆ
ಅಗ್ರಿಮೆಂಟ್ ಪ್ರಕಾರ ಯಾರ ಹತ್ರ ಇದೆ?
ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ಲಿ 46 ಸ್ವಾಮಿ, ಇಂಕ್ ಪೇಜ್ ನಂಬರ್ 46 ಇಂಕ್ ಪೇಜ್ ನಂಬರ್ 46 the owner and the developer shall be deposits that are the payments payable to BESCOM and BSWSSB respective 46 ಈಗ ಕಾಲಮ್ ಪ್ಯಾರಾ ನಂಬರ್ 24 ಸ್ವಾಮಿ. 24
ಪ್ಯಾರಾ 24
ಪ್ಯಾರಾ 24
45 ರಲ್ಲಿ ಇದೆ. 46 ನಿಮ್ದಲ್ಲಿ ಮತ್ತೆ ಕರೆಕ್ಷನ್ ಮಾಡಿ ನಮ್ದಲ್ಲಿ 45 ಅಂತ ಬರ್ತಾರೆ, ಪರವಾಗಿಲ್ಲ. The owner and the developer shall bear the deposit that are payable to BESCOM and BWSSB in respect of the connections that shall be obtained ಅಂತ ನಿಮ್ಮ ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ಲಿ ಇದೆಯಲ್ರಿ?
ಅದನ್ನ ಆ ಅಗ್ರಿಮೆಂಟ್ ಇದ್ರ ಬೇಸಿಸ್ ಮೇಲೆ ಜಿಪಿ ಎಕ್ಸಿಕ್ಯೂಟ್ ಆಗಿರೋದು. ಆ ಜಿಪಿ ನಲ್ಲಿ ದೇ ಅಂಡರ್ಟೇಕನ್ ದಟ್ ಎಂಟೈರ್ ಬಿಕಾಸ್ ದಿಸ್ ಇಸ್ ಎ ಕಪಲ್ಡ್ ವಿತ್ ಪೇಜ್ 53 ನಲ್ಲಿ ಅದೇ ತಾವು ಆಗ್ಲೇ ಓದಿದ್ದು.
53 ಅಲ್ಲಿ
ಹೌದು, ಪ್ಯಾರಾ 1 ನಲ್ಲಿ ಎಲ್ಲದೂ ರಿಜಿಸ್ಟರ್ಡ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್. ಅದಕ್ಕೋಸ್ಕರನೇ ತನಿಖೆ
to represent me, to act on my behalf with any office, department or authority of state government, central government, statutory body or authority, municipal or local bodies, Bruhatman or so authority, BESCOM, BWSSB and the like, any corporation, company, partnership, film or individual. ಆಯ್ತು, ನಿಮಗೆ ಈಗ ನಮಗೆ ನಮ್ಮೇಲೆ ಕೇಸ್ ಹಾಕಿದ್ದಾರೆ ಅಂತ ನೀವೇನಾದ್ರು ಈ GPA ಪ್ರಕಾರ ನೀವು ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿರೋ ಪ್ರಕಾರ ಡೆವಲಪರ್ ಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟು ಆಕ್ಷನ್ ಏನಾದ್ರು ತಗೊಂಡಿದ್ರೆ ನೀವು?
ನಾವು ಇನಿಷಿಯಲಿ they themselves is that several meetings held between them, then the association agreed to that initiate the proceedings against them. So ಅವ್ರ ಮೇಲೆ they started that, they issued the legal notice. ನಾನು ಕಳಿಸಿದ್ದೇನೆ ಫಸ್ಟ್ ಇದರಲ್ಲಿ. They issued the legal notice, they initiated the proceedings before the consumer court because consumer court only they against their service deficiency of the service of the initiate that, but they are not proceeded that.
But ನಿಮ್ಮ ಅಗ್ರಿಮೆಂಟ್ ಪ್ರಕಾರ ಇಬ್ರು ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿ ಅಂತ ಇದೆ, ಹೌದಾ? Now we have executed a power of attorney in favor of them, JD.
Power of
JD has not complied it. Then
power of attorney is a part of their sale deed. They had to initiate the proceedings against the builder. Now they initiated the proceedings against the builder before the consumer court, but they are not proceeded. Instead of that, a civil dispute, since they were instead of proceedings that consumer dispute, so subsequently they filed this complaint. ಅಲ್ಲಿ ಹೋಗಿ ಅಪಿಯರ್ ಆಗಿ they had to deficiency of the service ತೋರಿಸಿ ರಿಕವರಿ ಮಾಡಬಹುದಿತ್ತು.
ಬಟ್ ನಿಮ್ ಡೆವಲಪ್ಮೆಂಟ್ ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ಲಿ ಇದೆಯಲ್ಲ ಇಬ್ಬರದು ಕೆಲಸ ಅಂತ.
That is intested because GPA is also the part of their seal deed.
Seal deed ಆಯ್ತ್ರಿ, ಡೆವಲಪ್ಮೆಂಟ್ ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ಲಿ ನಿಮ್ ಇಬ್ಬರದು ರೋಲ್ ಇದೆಯಲ್ಲ?
ರೋಲ್ ಇದೆ. ಆ ರೋಲ್ ಅನ್ನ
ನೀವು ಕಾಪಿ ಅವ್ರ ಕಡೆಯಿಂದ ರಿಕವರಿ ಮಾಡ್ಕೊಳ್ಳಿ ಅಷ್ಟೇ.
ಆ ರೋಲ್ ನ ಅವ್ರು ವಹಿಸ್ಕೊಂಡಿದ್ದಾರೆ.
ಅದು ನಮಗೆ ಗೊತ್ತಿಲ್ಲ, ಅದು ಇಂಟರ್ಸೆಪ್ಟ್ ಬಿಟ್ವೀನ್ ಯು ಅಂಡ್ ದಿ ಬಿಲ್ಡರ್.
ಇನ್ನು ಕಟ್ಟೋದಕ್ಕೂ ಎಕ್ಸಾರ್ಬಿಟೆಂಟ್ ಕೈಂಡ್ಲಿ ಸಿ ದೇರ್ ಅಬ್ಜೆಕ್ಷನ್.
ಎಕ್ಸಾರ್ಬಿಟೆಂಟ್ ನಾವ್ ಇಲ್ಲಿ ಡಿಸೈಡ್ ಮಾಡಕ್ಕಲ್ಲ.
ಅದನ್ನೇ ನಾವು ಹೇಳ್ತಾ ಇರೋದು ಈಗ. ಕೈಂಡ್ಲಿ ಸಿ ದಟ್ ಅದರಲ್ಲಿ ಐಟಮ್ ನಂಬರ್
ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳ್ಬಿಟ್ಟೆ ಸ್ವಾಮಿ. 10 ಲಕ್ಷದ ಮೇಲೆ ಎಷ್ಟಾದ್ರೂ ಬಿಡ್ ಮಾಡಿ ಕೊಟ್ಬಿಡಪ್ಪ, ನಾನು ಕನ್ವಿನ್ಸ್.
ಲಾಸ್ಟ್ ಟೈಮ್ ನೆಗೋಷಿಯೇಷನ್ ಕೂತಾಗ 8 ಲಕ್ಷ ರೂಪಾಯಿ ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ವಿ ನಾವು.
ಇಲ್ಲ, ನಾನು ಹೇಳಿದೆ
8 ಅಂತ ಹೇಳಿದ್ರೆ
10 lakhs ಅಂಡ್ ಅಬೌವ್ ಎಷ್ಟಾಗತ್ತೋ ಅಷ್ಟು ಮಾತಾಡಿ ಇದ್ ಮಾಡಿ.
ಇಲ್ಲ, ಅವ್ರೇನ 8 ಅಂತ ಹೇಳ್ತವ್ರೆ, ಹೇಳಿದ್ರೆ 8 ಅಂತ ಏನಾರು ನೀವು?
ಇಲ್ಲ ನಾನು ಹೇಳಿಲ್ಲ.
ಅಲ್ಲ, ಈಗ ಅವರೇ ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕಿದ್ದಾರೆ, ಅದರಲ್ಲಿ BWSSB ಮತ್ತೆ ಬೆಸ್ಕಾಂ ಎರಡು 1,15,000 ರೂಪಾಯಿ ಕಲೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಇಲ್ಲಿಗೆ ಲಿಸ್ಟ್ ಹಾಕೊಂಡ್ ಬರ್ಬೇಕಾದ್ರೆ 1,47,500 ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಇನ್ನ ಐಟಮ್ ನಂಬರ್ 3 73,125 is the person collected accused number 1, that flat belongs to accused number 1. ಅದು ಎಲ್ಲದೂ ನನ್ ಮೇಲೆ ಹಾಕೊಂತ ಹೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಆಯ್ತ್ರಿ, ಈ ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ ನಾವು ಡಿಸೈಡ್ ಮಾಡಕ್ಕಲ್ಲ ಎಷ್ಟು ಕೊಡಬೇಕು.
No, my contention is that your lordship, the entire is a civil in nature. They already initiated the civil proceedings. Civil proceedings ಅಲ್ಲಿ instead of continuing the civil proceedings which they were initiated, according to them they initiated the because the findings of the charge sheet also builder ಗಳು ಮಾಡಿಕೊಂಡ ಅಗ್ರಿಮೆಂಟ್ ನಂತೆ ಫ್ಲಾಟ್ ಮಾಲೀಕರಿಗೆ ದಿನನಿತ್ಯದ the findings also against the builders only. Instead of recovery proceedings, they converted into criminal proceedings, even though the owners nowhere connected with that.
ಅರವತ್ನಾಲ್ಕು ಲಕ್ಷ ದುಡ್ಡು ಯಾರಿಗ ಹೋಗಿದೆ ಅಂತ ಕೇಳಿದೆ ನಾನು.
ಬಿಲ್ಡರ್ಸ್ಗೆ.
ಅದಕ್ಕೆ ಎಲ್ಲಿದೆ ದಾಖಲೆ?
ಫೈಂಡಿಂಗ್ಸ್ ಅವರೇ ಇದನ್ನ ಮಾಡ್ಬೇಕು. ಬಿಕಾಸ್ ದೇ ಆರ್ ಡೆಪಾಸಿಟೆಡ್.
ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ
ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲೂ ಎಲ್ಲೂ ಹಾಕಿಲ್ಲ ಅದನ್ನ.
ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಹೇಳಿದಾರೆ
ಅದು ಬಿಲ್ಡರ್ಸ್ ಹೋಗಿದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಬಿಲ್ಡರ್ಸ್ ಗಳು ಮಾಡಿಕೊಂಡ ಅಗ್ರಿಮೆಂಟ್ ನಂತೆ ಫ್ಲಾಟ್ ಮಾಲೀಕರಿಗೆ ದಿನನಿತ್ಯ ಜೀವನಕ್ಕೆ ಒಳಚರಂಡಿಗೆ ಎಲ್ಲಾ ಫ್ಲಾಟ್ ಗಳಿಂದ ಹಣ ಕಟ್ಟಿಸಿಕೊಂಡು.
ನೀವ್ ಯಾರಿಗೆ ಕೊಟ್ಟಿದ್ದೀರಿ ದುಡ್ಡು? ಅದು 64 ಲಕ್ಷ ನಿಮ್ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ 64 ಲಕ್ಷ ಅಂತ ಕೊಟ್ಟಿದ್ದೀರಿ. ಯಾರಿಗೆ ಕೊಟ್ಟಿದ್ದೀರಿ?
ಇವು ಎಲ್ಲ ಬಿಲ್ಡರ್ಸ್ ಅಂಡ್ ಇವ್ರಿಗೆ ಓನರ್ಸ್ಗೆ
ಯಾರಿಗೆ ಅಂತ ಕೇಳ್ತಾರೆ. ಯಾರಿಗೆ ಕೊಟ್ಟಿದ್ದೀರಿ? ಅದರ್ವೈಸ್ ಯು ಕ್ಯಾನಾಟ್ ಇನಿಷಿಯೇಟ್ ಕ್ರಿಮಿನಲ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಅಗೇನ್ಸ್ಟ್ ದೆಮ್ ಅಂಡರ್ ಸೆಕ್ಷನ್ 409. ಫಸ್ಟ್ ಯು ಮಸ್ಟ್ ಬಿ ಸ್ಪೆಸಿಫಿಕ್ ಟು whom you have paid the amount.
ರಾಮ್ ರಾವ್ ಇವ್ರು ಯಾರೋ ಸುರೇಶ್ ಸಿಟಿ ಇದರಲ್ಲಿ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ 123 page number 123.
Nim allegation in the complaint,
yes,
that you have made the payment of rupees 64 lakh and having received that amount, they in turn they have not given any facilities. Then you were forced to again pay the amount. ಹೌದಾ?
ಹೌದು.
ಆಮೇಲೆ ಯಾರಿಗೆ ಕೊಟ್ರಿ ಆ ದುಡ್ಡು ಅಂತ ಕೇಳ್ತಾ ಇದೀವಿ. ನಿಮ್ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಸ್ಪೆಸಿಫಿಕ್ 64 lakh you have paid the amount. To whom you have paid the amount? Whether it is to the owners or to the joint developer. ಈಗ ನೀವು ಪೇಟೇರ್ ಓದಿದ್ರಲ್ಲ,
ಓದಿದ್ದೆ ಸ್ವಾಮಿ.
ಯಾರಿಗೆ ಕೊಟ್ರಿ ಆ ದುಡ್ಡು?
ಹಣ ಇಸ್ಕೊಂಡಿದ್ದಾರೆ
ಮತ್ತು ಒಳಚರಂಡಿ ವ್ಯವಸ್ಥೆಗೆಂದು ಒಟ್ಟು ಅಂತ ಇದೆ. Now you have initiated criminal prosecution against them. ಹೌದಾ? To whom you have paid the amount?
ಬಿಲ್ಡರ್ ಗಳಾಗಲಿ ಅಥವಾ ಲ್ಯಾಂಡ್ ಓನರ್ ಗಳಿಗಲಿ
ಯಾರಿಗೆ ಅಂತ ನೀವು ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಹೇಳಿ. ನಿಮಗೆಲ್ಲ ಹೇಳಿರೋದು ಆರೋಪಿ 1. ಹೌದಾ?
ಹೌದು.
ಆರೋಪಿ 1 ರವರು ಎಲ್ಲ ಸೌಲಭ್ಯಗಳು ಇರುತ್ತವೆ, ಯಾವ ತೊಂದರೆ ಇಲ್ಲ ಎಂದು ಹೇಳಿದ್ದರು. ನಮಗೆ ಪ್ಲಾಟ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿಕೊಡುವ ಸಮಯದಲ್ಲಿ ಪ್ರತಿಯೊಬ್ಬ ಫ್ಲಾಟ್ ಮಾಲೀಕರಿಂದ ನೀರು ಮತ್ತು ಸರಳಾಚರಣೆ ವ್ಯವಸ್ಥೆಗೆಂದು ಒಟ್ಟು 64,08,375 ಕಟ್ಟಿಸಿಕೊಂಡಿದ್ದು ನೀರಿನ ಸಮಸ್ಯೆ ಉಂಟಾಗಿದೆ ಎಂದು ಎಷ್ಟು ಹೇಳಿಕೊಂಡರು ಸಹ ಆರೋಪಿ 1 ರಿಂದ 4 ರವರು ಫ್ಲಾಟ್ ಮಾಲೀಕರ ಸಮಸ್ಯೆಗೆ ಸ್ಪಂದಿಸದೇ ಇದ್ದುದರಿಂದ ಅಂತ ಇದೆ. ಆ ಅಮೌಂಟ್ ಯಾರಿಗೆ ಕೊಟ್ರಿ ನೀವು ಹೇಳಿ. Then we can fix the liability on them.
ಅಸರ್ಟೈನ್ ಮಾಡ್ತೀನಿ.
ಅದೇ ಮೇನ್ ತೊಗೊಳ್ಳಿ.
ಅಸರ್ಟೈನ್ ಮಾಡ್ತೀನಿ.
ಎಷ್ಟು ಬುಧವಾರ ಎಷ್ಟು ಡೇಟ್ ಮೇಡಮ್?
17.
Heard in part and counsel appearing for the R2 seeks time to give details of payment made to the tune of rupees 64 lakh. ಅದನ್ನ page number 30 ಅಲ್ಲಿ ಸಿಗುತ್ತೆ ನೋಡ್ರಿ. And to whom the same was made payment.
ಕೊಟ್ಟಿದೆ.
Seeks time to place it on record. And hence this the matter on ಎಷ್ಟು ಮೇಡಮ್? 17th 17/12.
78. Ganapati Bhatt.
This is the, please my lord, successive will petition my lord. May I pass on the previous order passed by this honorable court.
5093 na?
ಹೌದು. Please my lord. Kindly see my lord, para 6 my lord. Having heard the respective counsel so and so, specific allegation is that the petitioner inflicted injury with a knife, that too on the abdomen, and cause of death is also on account of injury inflicted on the abdomen, and other order passed by this court, but other accused persons will not come to the aid of the petitioner. Since in other connected matters, this court exercised the discretion in favor of the other accused persons, pointed out this petitioner only inflicted the injury. Such being the material available on record, also the CCTV footages disclose the involvement of the petitioner inflict injury with a knife on the stomach portion disease, not a fit case. In this entire case, my lord, we have two new contentions. The fact that there was a counter case, there is one more, my lord, sessions case is not brought to the kind notice of the Sonal Court. Now, my lord, I beg to produce.
What is the change circumstances?
Change circumstances, my lord. There is a counter case which is not pleaded.
Counter case?
There is a counter sessions case, my lord. Incident occurred and 2 FIRs were registered. And there is a counter case where these accused persons were also injured. In fact, the deceased came out with the knife and he started assaulting this group. There was a free fight between the two groups.
That is your private defense. Is it your private defense?
No, it's borne out from the prosecution papers. May I pass on, my lord, city.
But now the material is very clear that you only inflicted the injury on him.
This may have to be analyzed in the light of, this may have to be considered in the light of the fact that there is one more prosecution version says the deceased came out with the knife. The deceased was using the knife.
Counter case
That's also pending.
Charge sheet hakidara?
Haudu.
Adrallu pending ide.
Haudu.
Adralli what was the allegation against him?
Against the deceased, he himself tried to, with the knife, tried to assault others and he assaulted others.
Others andre yaru nimmonga?
Haudu. Haudu.
Is your case that private defense? In order to protect my life only, I inflicted the injury.
My lord, I beg to submit, my lord, the true genesis of the occurrence is not stated with, according to us. The genesis, my lord, they themselves assaulted, my lord, in a free fight. This incident has occurred, my lords.
That's what I am saying.
I understand. Because
he came forward to
the presence at the
injury.
spot, my lord, now, my lord's next sentence would be that one. That's true, man. That's correct. That's correct. But this was not brought to the kind notice of the Sonal Court because if there are case and counter case.
Case and counter case register agide anta.
Agide, charge sheet agide.
Adrinda now he is entitled for bail anta.
ಒಂದನೇ ಗ್ರೌಂಡ್ ಎರಡನೇ ಗ್ರೌಂಡ್ ಈಗ 2019 ಡಿಸೆಂಬರ್ he was arrested. ಹೌದು 2019 my lord 4/12/2019 he is in custody since 6 years. Now next question is, my lord, your lordship has laid on many cases that if the trial has already progressed considerably, my lord,
witnesses exam
that's not a ground, that would not be ground. But here is a case. Trial has not commenced, my lords.
Trial commence
ಆಗಿಲ್ಲ.
2019 ರಿಂದ.
ಹೌದು, HBC ಅಂತಲೇ ಹೋಗ್ತಾ ಉಂಟು. CW1 ಗೆ ಮೊನ್ನೆ ನೋಟಿಸ್ ಆಗಿ ಹೇಳ್ತೀನಿ 5/7/2022 ಇಂದ 25/6/2025 ವರೆಗೆ CW1 ಬಂದಿಲ್ಲ. ಯಾಕಂದ್ರೆ ಅವನ ಮೇಲೇನೂ ಕೇಸ್ ಇದೆ. CW1 ಬಂದಿಲ್ಲ, CW1, 2 ಬರ್ಲಿಲ್ಲ, ಕೋರ್ಟಿಗೆ ಬರ್ಲಿಲ್ಲ. ಆ ನಂತರ BW ಆಗಿದೆ ಅವನಿಗೆ, ಮತ್ತೆ ರೇಟ್ ಹೋಗ್ತಾ ಇದೆ, ಬರ್ಲಿಲ್ಲ ಅವನು. ಸೊ ಇಲ್ಲಿವರೆಗೆ ಒಂದು ವಿಟ್ನೆಸ್ ವಿಚಾರಣೆ ಆಗಿಲ್ಲ. In the meanwhile, my lord, recently, my lord, the honorable coordinate bench, as far as accused number 8 is concerned, there is an order. There is a very recent order, June 25, because only conspiracy and there are no materials for conspiracy anta accused number 8
ಕಾನ್ಸ್ಪಿರಸಿ ಇದ್ರೆ ಕೊಟ್ಟಿರ್ತಾರೆ ಬಿಡಿ, ಆಯ್ತು.
ಅಲ್ಲ ಅದು ಸ್ಟೇ ಆಗಿದೆ ಅಂತ.
ನಿಮ್ ಕೇಸ್ ಅಲ್ಲ,
ನಮ್ ಕೇಸು ಅದೇನು ಪ್ರಶ್ನೆ ಬರೋದಿಲ್ಲ. Yes, ಅದು ಈಗ only two additional points, my lords.
Conspiracy only circumstantial.
ಹೌದು ಅದೇನು ಬರೋದಿಲ್ಲ.
Only in trial.
I brought to the kind notice only for this purpose, that proceeding is also stayed as far as the other person recently. Now, my lord, the inordinate delay of 6 years, it's a very serious matter where he is in custody. He is not responsible for the delay in any manner. And the other accused persons, 8 accused persons, he is added as accused number 2 in the charge sheet, A1 in the FIR. He is the only person who is in custody, my lord. And may I pass on, my lord? The view of the honorable recent view and the other view of the honorable Supreme Court, my lord. The dictum is 5 years or more and 6 years and more, even in 302. Even where witnesses were examined, is 2024, my lord, of the division which is Supreme Court, first one, Balwinder Singh. There, my lord, para 2. Counsel submits 6 of the accused persons have been granted bail. Moreover, only 7 out of the cited 47 witnesses have been examined, etc. More than 4 years he is in custody, etc., etc. And then para 5, 21 witnesses had testified, 17 more to be proposed, etc. High Court, while rejecting the bill, para 6, had asked for conclusion of trial within 5 months. 5 months period distributed to High Court will expire at the end of this month, but as told above, 17 more witnesses, so and so. Then accused, para 7, accused has a right to a fair trial, and while hurried trial is frowned upon, as it may not give sufficient time to prepare for the defense, inordinate delay in conclusion of the trial would infringe upon the right of the accused granted under Article 21. Then, my lord, the same aspect, my lords, considering this, my lord, the bail was granted. On the ground para 11 to cooperate with the trial, appear on all the dates. There was a condition imposed. And page number 4. These are also case of 302 and para 6 in that. That's page number 6, para 6. Petition has been in custody more than for 6.5 years. We do not intend to comment on the merits of the which might be detrimental to the interest of either prosecution or the defense. And last one, page number 7. There are 57 witnesses in this case, my lord. Page number 7. There Chintan Vidyasagar, so and so. The first para shows 302. Para 2, a petition has been in custody for nearly 6 years. Trial is in progress. 28 witnesses have been examined. 12 witnesses, so and so. Having created the record after hearing the parties, with the opinion that they entitled to bail and incarcerated for nearly 6 years. Ground is only that. And other two, but it appears same order, similar orders, my lord. In other cases have been granted, not required. First decision only, my lord. Page number 7 only. On the ground of 6 years custody, other cases also were admitted to bail. Here is a case, 57 witnesses, and the counter case is there. Witness themselves is not appearing, and this aspect I have to satisfy the honorable court that the witness is not appearing deliberately. Kindly see in the paper book itself. Kindly see, my lord. Page
Yes,
number.
Madam, why you have not secured CW1, madam? On what date?
95 in the Surumadi. 95 in the 95, please, my lord. 5722.
Yavag, on what date he was present? Charge witness summons was issued on what date, madam?
5, if I may assist the court, 5722, my lord.
22.
5722. But on witness to 1 to 4 by so and so. Next date ge.
A1 is not produced from JC. Police produced extract of A4. A4 is disposed of as abated. Issue witness summons to CW 1 to 4. That was the order on 5722.
Anantara, kindly see page 96, my lord.
It is reported that CW1 and CW2 are in judicial custody.
3 and 4 remained in spite of service of summons. Issue direction to jail authority. Then kindly at the bottom, CW 1 and 2 are produced from the jail authority physically. So and so are present. Issue direction to concerned jail to produce CW 1 and 2 on the next date for evidence. Next, PP praise time, page 97 at the bottom. Some witnesses were present. CW 1 to 4 absent. PP praise time. Anantara, the witness summons are there.
Page number 105 and 106 produced
105.
10. Issue summons.
Issue summons to CW1 by name. I mean, who is in JC in Belgavi prison and produce him on next date of hearing without fail. Antaito. Produced from JC at 11 AM from Karwar prison. So and so. His remand is extended till next date of hearing.
And again, in the next day,
Right, madam, why you have not examined one when he has produced before the court? What your PP is doing when the witness is secured from jail? He has not let the evidence. Matte next date allu kuda CW1 is produced from Belgavi prison through HC 521. Further CW1 seeks time to depose. Why?
available warrant ಮಾಡಿದ್ರು ಮತ್ತೆ issue.
Issue summons to CW1 on summons ಯಾಕೆ ಬರುತ್ತೆ ಮೇಡಮ್?
ಮತ್ತೆ ರಿಲೀಸ್ ಆಗಿರ್ಬೇಕು.
Once he is in custody.
ಮತ್ತೆ ರಿಲೀಸ್ ಆಗಿರ್ಬೇಕು ಯಾಕಂದ್ರೆ
it was enlarged on bail.
I feel so, my lord. Page 112. 112 shows, my lord. 111 shows bottom, my lord.
You get to the details from PP, madam, who is conducting this case, why he has not examined when the witnesses summons were issued in 2022. Now we are in almost in the end of 2025.
One aspect, my lord. Page 113, my lord. It appears CW1 is now
let them give details.
Now outside, my lord.
Why they have not examined? Or otherwise on the ground of no commencement of trial, I am going to pass an order, madam. From last 6 years. What date he was arrested?
2019.
19 ಯಾವ ತಿಂಗಳು ಹೇಳ್ರಿ?
4/12. 6 years over. 4/12.
Almost 6 years.
6 years ಆಯ್ತು.
25. 4/12 ಅಂದ್ರೆ ಮನೆಗೆ 6 years ಆಯ್ತು.
ಹೌದು.
Additional SPP seeks time to verify and submit regarding non-commencement of trial. Is this matter next Wednesday? 17/12.
Next.
79.
On several occasions, he has produced before the court, madam, from prison. Why he has not been examined? That too from Belgaum. ಈ ಕೇಸ್ ಇರೋದು ಎಲ್ಲಿ? ಯಾವ ಊರಲ್ಲಿ?
ಮಂಗಳೂರಲ್ಲಿ.
ಮಂಗಳೂರು. Belgaum to Mangalore. 79. Furnishing of PF petition copy along with annexure to notice to R2. Dhananjay Kumar, ಹೇಳ್ರಿ ಮೇಡಮ್. Last time order sheet ಕೊಡಿ. So notice against respond number 2 through the jurisdictional investigating officer, learned counsel for the petitioner is directed to furnish one more copy of the petition along with its annexure on the additional SPP. Yes, madam.
We have been produced, we have served the copy to the IO, my lord. We have filed the acknowledgement on the same.
ಯಾರಿಗೆ ಕೊಟ್ಟಿದ್ದೀರಿ?
IO.
IO ಗೆ ಯಾಕೆ ಕೊಟ್ರಿ? ಆರ್ಡರ್ ಏನಿರೋದು? On the additional SPP to serve the same through investigating officer ಅಂತಿದೆ. Why you gave it to the IO? Additional SPP ಕೊಡಿ ಅಂತ ಆರ್ಡರ್ ಮಾಡಿರೋದು.
Yes, my lord.
That is their lookout.
Kindly may have it on the other date, my lord. We'll serve the same.
Other date after winter vacation.
No.
Next week ಅಲ್ಲಿ ಹೆಂಗ್ ಆಗ್ತದೆ? ಸರ್ವಿಸ್ ಹೆಂಗ್ ಆಗ್ತದೆ? Why you have not complied it? ಎಲ್ಲ ಡಿಸ್ಮಿಸ್ ಮಾಡಿ ನನ್ನ petition because of you are not furnished the copy. ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ?
And the next week, my lord.
Next week ಏನಕ್ರಿ? This order was passed on 19/11/25.
Yes, ma'am.
You ಎಷ್ಟು ದಿವಸ ಆಯ್ತು ಇವತ್ತಿಗೆ? Still you have not paid the PF or furnished copy to the additional SPP.
You have furnished the copy.
Totally. Petitioner counsel has not served the copy. ನಿಮ್ಗೆ ಮೇಡಮ್ ನೀವೇನ್ ಮಾಡಿದ್ರಿ? Issue notice against respond number 2 through the jurisdictional investigating officer ಅಂತಿದೆ. ನೀವು ಮಾಡ? ಏಕೆ why? Have you sent any intimation to the IO? ನೀವು ಹಾಗೆ ಅದೇ ಸ್ಥಿತಿ. ಎಲ್ಲಿದೆ? ನೀವು IO ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಿದ್ದು ಎಲ್ಲಿದೆ? ಫೋನ್ ಮೂಲಕ ಆದ್ರೂ ಎಲ್ಲಿದೆ ಮೇಡಮ್? ಏನಿದೆ? ರಿಪೋರ್ಟ್ ಏನಿದೆ? ರಿಪೋರ್ಟ್ ಇಲ್ಲ ನೀವು. ನೋಡಿ. Petitioner counsel has not furnished copy of the petition on the SPP as ordered on 19/11/25 and counsel seeks a day to serve the copy. One day ಕೊಡ್ತೀನಿ serve ಮಾಡಿ on the additional SPP, and the additional SPP is also directed to report the status of whether notice is served on respond number 2 through IO or not. List this matter on 17/12.
80. Reddy.
That's a appeal for respondent number 2. The arguing counsel is held. The arguing counsel has some personal difficulty, my lord.
Serial number 80, my lord,
next
sir.
week, my lord.
Petitioner does not wish to prosecute the petition. Maybe withdrawn. Permitted to withdraw.
Petitioner counsel files memo seeking permission of this court to withdraw the petition and hence permitted to withdraw.
Great. Obliged.
ತಗೊಳ್ಳಿ ಯಾವ್ದು ಫಸ್ಟ್ ಕೇಸ್ ಕಾಪಿ. ಕಂಟಿನ್ಯೂ ಮಾಡಿ.
46, Prasad case.
Respondent, my lord.
I asked some questions to your colleague. Whether your colleague has communicated to you?
My lord, the question regarding, my lord, the not making effort to, my lord, cross-examine the expert, my lord. Lord, here is a case where, my
You
lord.
filed an objections to the commissioner report.
Yes, my lord.
Commissioner report goes against you.
We had filed objection to that commissioner report, my lord, and
Then why
we
you have
have
not summoned and cross-examined the witness?
the plaintiff has not, my lord, taken steps to, my lord, tender evidence by marking that commissioner report, my lord.
That is in favor of them.
But we have filed objection to that.
Then you have to summon. When the commissioner report goes against you, you have to summon and examine.
Whether that commissioner report was accepted by the court by considering our
Also,
objections.
you have filed an application to
Application
reject
for
the commissioner report.
to appoint a fresh commissioner, my lord. we
Then
have filed
reject and
application.
appoint fresh commissioner report.
Yes, ma'am.
That is rejected. Have you challenged that order?
That, my lord, when it was passed, my lord, I am not aware, my lord. Only order speaks. The question would be, my lord, here. The question would be, my lord, so far as the opinion of expert is concerned, my lord, it would be only a piece of evidence, my lord, which the court cannot solely rely upon it. Now, both the courts are fact-finding authorities, my lord, the trial court as well as the first appellate court appreciates the evidence of DW2 and DW3 who are attesting witness, who have spoken about the, my lord, the executant signing, putting the signature in their.
Very fundamental issue before the court with regard to the signature of the executant is concerned.
Yes, my lord.
The expert report before the court is that goes against you. Then how can rely upon the evidence of DW2 and DW3?
My lord, the courts below holds that, my lord, evidence of DW2 and DW3 are more trustworthy than the report of the commissioner. Because, my lord, it is only, my lord, evidence, my lord, of an expert, which is not, my lord, proved in accordance with the law. My lord, para 18.
Court has to see in the same in toto.
Lord, that cannot.
Not only rely upon only the evidence of DW2 and DW3.
Yes, my lord, the courts below, my lord, appreciate these aspects, consider the report of the commissioner and evidence of DW2 and DW3, and my lord gives a finding that, my lord, the report of the commissioner expert has to be ignored, and my lord, evidence of DW2 and DW3 is to be accepted, is the finding of both the courts. Now, here is a case where, my lord, plaintiff being a mother, my lord, files a suit for partition and separation position against a son, my lord, who is the self-acquired property of a son. My lord, there was no cordial relationship.
Para 13 Gogi. DW2 is also subordinate to this Sundara Mulya.
ಹೌದು
ಹೌದಾ?
ಹೌದು, ಅವರ ತಹಶೀಲ್ದಾರ್ ಆಫೀಸ್ ಅಲ್ಲಿ ವರ್ಕ್ ಮಾಡ್ತಾ ಇದ್ರು ಅಂತ. Now, my lord, a case where, my lord, other files a suit against one of the son, my lord, who acquired certain small extent of property, my lord, he bequeaths in favor of his wife and children. My lord, admittedly, my lord, relationship with the mother and, my lord, the daughter-in-law and son was not cordial, my lord, in the year 2002 itself, my lord. There are several litigations filed by the mother-in-law against defendant number 1, that is daughter-in-law. A suits were there, my lord, and it was admitted by interestingly, my lord, plaintiff does not steps into the witness box. A GPA holder, another son comes and deposes before the court, my lord.
Plaintiff is not examined.
Plaintiff was not examined.
PW1 matta?
That
is another son.
Other son. Our defense itself is that, my lord, other son has set up mother to file this suit, and my mother expires. They sets up another will stating that, my lord, undivided right of mother was bequeathed in their favor, and on that ground, my lord, they contest the suit.
As on the date of examination of PW1, mother was not alive?
She was alive. She does not steps into the witness box. Son, as a GP holder, comes and tenders evidence. He admits in the cross-examination, my lord, that aspect lordship may
that is extracted by the appellate court.
Appellate court now extract
Para 21 and 22.
Para 21 and 22, my lord. They accept, my lord, there was no cordial relationship between the mother and son and daughter-in-law. Therefore, my lord, he naturally bequeaths the small extent of land in favor of wife and minor children, my lord.
What is the extent of land?
And 32 cents of land, my lord.
Only 32 cents.
45 cents of land.
That is also his exclusive property?
Yes, my lord, admitted facts, my lord. Sale deed, by virtue of the sale deed, my lord,
He had purchased and
under the registered sale deed.
made provision in favor of the wife and children.
Yes, my lord, because relationship was strained, my lord.
In addition to this, my lord, this mother, daughter-in-law has set up a fabricated one GPA and sold the entire property of this.
But this will is registered will?
Unregistered.
Unregistered.
Unregistered. And prior to this, immediately on the death of the son, Sundaramulya, this his wife, this daughter-in-law, fabricated one GPA and sold 4 acre 30 cents of land in favor of her father. Subsequently, this will has been set up.
GPA.
GPA.
GPA dated?
GPA in 2005.
GPA in favor of whom?
Mother-in, she take the GPA.
Husband.
Mother-in-law in favor of daughter-in-law. After the death of the son, during the mourning period, the mother-in-law joins with the daughter-in-law.
Mother-in-law?
Joins in the house of the daughter-in-law. ಮಗ ಸಾಯ್ತಾನೆ, ತಾಯಿ ಹೋಗಿ ಮಗನ ಮನೆಯಲ್ಲಿ ಇರ್ತಾರೆ. ಆ ಸಮಯದಲ್ಲಿ on 9/4/2005 son expires. During the mourning period, mother joins with the daughter-in-law. During that period, on 24/2005, she fabricates one GPA.
Who fabricates?
Daughter-in-law. And she sells
of the mother-in-law.
Mother-in-law. And alienates the entire property mother-in-law in favor of her father. A case is pending.
And the property belongs to the mother-in-law. Mother-in-law was sold in favor of her
father. Meantime, this will has been set up. So I have disputed signature of the my son in the exhibit D7.
The separate property, separate suit ಹಾಕಿದ್ದಾರೆ. Sir, that suits were pending consideration, my lord. This is a counter suit, my lord. To get this property, my lord, to put pressure, they, my lord, institute the present suit, my lord, alleging that they are having a right in this property. There are previous suits.
After the death of the son.
Yes, my lord.
Whether any power of attorney by the mother in favor of your client and sold the property?
No, that is not the subject matter or not the evidence rendered in this case.
Court has to see the conduct of the parties.
Yes, if they would have placed it on record, my lord.
Here also there is a dispute with regard to the very will is concerned.
Whatever
expert has given the opinion that that is not the signature of the executant.
But whatever my learned friend now argues, my lord, was not, my lord, produced before the trial court or in the appellate court. It's a fresh case, my lord. My learned friend want to argue before this.
Already cross-examined on that point, my lord.
All for records. ಒಬ್ರೇನಾ ರೆಸ್ಪಾಂಡೆಂಟ್?
ಮೂರು ಜನ ಇದ್ದಾರೆ.
ಇನ್ನು ಇದರ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು ಯಾರಿಗಾರು? ಯಾರು ನೋಡಿ?
2 and 3
issue notice against respond number 2 and 3. List this matter on 19/1.
ಸರ್ ನನಗೊಂದು ಅಪೀಲ್ ಮೆಮೊರಾಂಡಮ್ ಅಪೀಲ್ ಮೆಮೊ ಅಂತ
ಅಪೀಲ್ ಮೆಮೊ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಾ ನೀವು?
ಇಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್. ಮೊದಲು ಕೇವೇಟರ್ ಬೇರೆಯವರು ಇದ್ರು. ನಂತರ ನನಗೆ
ನೀವೇ ಇದ್ದೀರಿ ಕೇವೇಟರ್ ಫಾರ್ R1 ಅಂತ ರವಿಶಂಕರ್ ಸರ್
NOC ವಕಾಲತ್ ಆಗ್ತದೆ ಸರ್.
ಇಲ್ಲ ನಿಮ್ಮ ಹೆಸರೇ ತೋರಿಸಿದ್ದಾರೆ. ಕೊಡ್ರಿ ಒಂದು ಕಾಪಿ ಕೊಡ್ರಿ. Appellant counsel is directed to furnish the copy of the appeal memo on the counsel forthwith. Next.
47 and then 48. Venkatachalapati is
Appellant in this case. Okay, the appellant. Sorry. This the appellant has filed a suit before the trial court seeking declaration of sale deed dated 24/4/1973 as null and void and seeking possession of the suit property. The facts of the case before the trial court of the plaintiff that the dependent number 4, who is own brother of plaintiff's mother, have sold the suitable property in favor of dependent number 3 as a guardian. So I have questioned the alienation made by dependent number 4 in favor of dependent number 3, please, Your Honor. So my specific contention is that the dependent number 4 have no any rights to alienate the property in favor of dependent number 3. The property belongs to the plaintiffs, please, Your Honor. So the trial court has, on the ground of limitation and on the ground that the alienation was valid, the suit of the plaintiff was dismissed, please, Your Honor. So I prepared appeal before the first appellate court. Before the first appellate court also, please, Your Honor.
Plaintiff court defendant number 4, what is the relationship?
And plaintiff ಅವರು ತಾಯಿ ತಮ್ಮ ಸ್ವಾಮಿ ಅವರು.
ಅಂದ್ರೆ ಮೆಟರ್ನಲ್
ಆಗ್ಬೇಕು.
ಮೆಟರ್ನಲ್ ಅಂಕಲ್
Maternal uncle, maternal uncle
ಮೆಟರ್ನಲ್ ಅಂಕಲ್
ಆಗ್ಬೇಕು ಸ್ವಾಮಿ.
ಹಾ
ಅವ್ರೇನು he is not permissible to alienate my property. That is my question. That is my question before the trial court as well as
why
first
answered court negative?
ಸ್ವಾಮಿ ಇದರಲ್ಲಿ ಲಿಮಿಟೇಷನ್ ಮೇಲೆ ತಗೊಂಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. See, as on date of filing the plaintiff age was 20 years. So within, as per Article 60 of Limitation Act, within 3 years from the date of attaining of the majority.
Age ಎಷ್ಟು?
As on date of suit 20 years ಸ್ವಾಮಿ.
20 years.
20 ವರ್ಷ.
ಹಾ.
So within 3 years only.
Sale was made on what date?
73 ಸ್ವಾಮಿ.
1973.
73. ಅವಾಗ ನಾನು ಮೈನರ್ ಇದ್ದೆ. Plaintiff was minor.
What was your age?
ನಮ್ಗೆ
73 ಅಲ್ಲಿ.
73 ಅಲ್ಲಿ 73.
Whether mother had challenged the sale deed?
No ಸ್ವಾಮಿ. The plaintiff has challenged the sale transaction, sale deed pleasure.
Why mother has not challenged the sale deed?
Mother father died ಸ್ವಾಮಿ. ಅವ್ರು ಸತ್ತು ತೀರ್ಕೊಂಡ್ಬಿಡ್ತಾರೆ.
ಮದರ್ ತೀರ್ಕೊಂಡ್ರು.
ಹೌದು ಸ್ವಾಮಿ.
ಯಾವಾಗ?
ಮದರ್ ಫಾದರ್ ತೀರ್ಕೊಂಡ್ಮೇಲೆ ಇವ್ರು alienation ಮಾಡ್ರು ಸ್ವಾಮಿ. ಇವರು ಡಿಪೆಂಡ್ ನಂಬರ್ 4.
That's what. That is the reason only maternal uncle came to the rescue of the children, because mother also passed away. They become orphans. That's why property was sold in the year 1973.
He was not obtained any permission under any JNWC Guardian and Wards Act, please, Your Honor, from my lord.
Only on the ground of limitation.
So we see from the data within 3 years from the data pertaining the majority, I have instituted a suit, please, Your Honor, my lord.
It clearly discloses that defendant number 3, being the minor guardian of the plaintiff, has sold the suitable property to the defendant number 3, sum of rupees 4,000, and handed over the possession of the suitable property to the defendant number 3. Further, on looking into the recitals of sale deed, it clearly discloses that suitable property originally belongs to Tammayya so and so, who is none other than the father of the plaintiff. Other hand, defendant number 1 to 4, 6 and 7 also not disputed the ownership of the property. That plaintiff father was the owner of the suitable property. Further, in support of his contention, plaintiff has produced exhibit P2, P3 so and so. They disclose that serial number so and so belongs to the plaintiff father so and so. On the other hand, looking into the conference statement, no dispute that plaintiff father was the owner, was in possession and enjoyment of the property. ನನಗೆ 14 ವರ್ಷ ವಯಸ್ಸಾದ ಮೇಲೆ 5 ವರ್ಷ ನನ್ನ ಮಾವನ ಮನೆಯಲ್ಲಿದ್ದೆ. ಎಲ್ಲ ಅವನೇ ನೋಡ್ಕೊಂಡ್ರು. ಮದರ್ ಮೆಟರ್ನಲ್ ಅಂಕಲ್ ಓನ್ಲಿ ಟೇಕನ್ ಕೇರ್ ಆಫ್ ಹಿಮ್. ಒಂದು ಅಡ್ಮಿಷನ್ ಇದೆ ನೋಡಿ.
ಅಲ್ಲ ಇದೆ ಸ್ವಾಮಿ, ಅಡ್ಮಿಷನ್ ಇದೆ. ಈ ಅವ್ರೇನು he himself he was doing coolie in the hotel actually. The D4 has not sacrificed anything towards the welfare of plaintiff, please, my lord. The entire sale proceeds were misused.
ಏನು ಓದಿದಾನೆ ಅವನು?
ಇವರೇನು ಓದಿಲ್ಲ ಸ್ವಾಮಿ.
PW1
ಓದಿಲ್ಲ ಸ್ವಾಮಿ.
ಇಲ್ಲೇ ಇದೆ ಅವನ ಎವಿಡೆನ್ಸ್ looking after welfare of the himself, and he has provided education to the plaintiff, and further suggests that he has performed his marriage, for which PW1 has denied the suggestion put by the defendants, and further PW1 has denied the suggestion that his maternal uncle, that is brother of his mother, C.C. Puttaswamy, sold a suitable property for purpose of his education, for which PW1 has denied. On looking into the evidence of documents produced by the so-and-so, clearly discloses that the plaintiff was under the care and custody of C.C. Puttaswamy, and he has sold the suitable property for the benefit of family. In favor of defendant, without having any right, title, possession or suitable property, he has no power to sell the property of the minor, section 7, so.
So my specific contention is that the D4 have no any legal rights to alienate the property belongs to me. That is
mother nodri he become orphan. Hauda, sister also passed away, and he was under the care of the maternal uncle.
There is no any evidence such a kind of.
ನೀವೇ
evidence
ಅಡ್ಮಿಷನ್
that was-
ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ, ನಿಮ್ಮ ಅಡ್ಮಿಷನ್ ಇದೆಯಲ್ಲ.
Even he was not provided any education to the plaintiff also, my lord. Education ವಿದ್ಯಾಭ್ಯಾಸನೂ ಕೊಟ್ಟಿಲ್ಲ ಇವರಿಗೆ. So ಇದ್ದಿದ್ದ ಪ್ರಾಪರ್ಟಿ ಅದೊಂದೇ ಪ್ರಾಪರ್ಟಿ that is misused by D4 please, my lord.
ಏನು ಓದೇ ಇಲ್ವೋ ನಿಮ್ಮವನು?
ಇಲ್ಲ ಓದಿಲ್ಲ ಸ್ವಾಮಿ. ಓದಿಲ್ಲ, ಇವ್ರೇನು ಓದಿಲ್ಲ ಸ್ವಾಮಿ.
ನೋಡೋಣ ರೆಕಾರ್ಡ್ಸ್ ಬರ್ಲಿ
ಪ್ಲೀಸ್.
ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್. Justice matter 19-1.
49. Yeah, Abhinav Anand.
Yes, counsel.
Alert suit for specific performance. Filed by the original plaintiff was dismissed.
And the same was dismissed.
And even the RE was also dismissed.
Dismissed but passed an order to refund the amount. ಹೌದಾ?
Please, my lord. But first issues 1 and 2 are answered by the trial court in affirmative. Issues 1 and 2 may kindly be perused, my lord.
And that is with regard to the execution of sale agreement.
Whether the plaintiff proves that the execution of that one Maraya and defendants 7 and 8 executed an agreement of sale in favor of plaintiff on 18/12/2006, agreeing to sell the suitable property for rupees 1,10,000. Whether the plaintiff proves that due execution of agreement of sale dated 18/12/2006. Both these issues have been answered by the trial court in affirmative, my lord. And even in regular appeal, my lord, your lordship may kindly peruse para 67 of
para 18 and 19 of trial court ನೋಡಿ.
My lord, 67 of judgment of the trial, first appellate court.
ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನೋಡ್ರಿ, ಫಸ್ಟ್ ಫೌಂಡೇಶನ್ ನೋಡಿ. ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಹೋಗಕ್ಕಿಂತ ಮುಂಚೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 18 and 19 ನೋಡ್ ಪ್ಲೀಸ್. No doubt accepted trial court. There is an agreement.
But perusal exhibit agreement, it is.
On perusal of exhibit P2 agreement, it is apparent that the last sentence in the second page is deleted by using whitener. From the whitener on the seal of the notary, it is clear that the said recital was deleted after the notary affixed his seal. Neither the parties to the agreement have put their initials near the said correction, nor the notary has made a note of it. Further, strangely, there is no recital in exhibit P2 as to when to hand over the possession of the property. The copy of the exhibit P put by the defendant number 9 discloses recital as to handing over of the suitable property to the plaintiff under the agreement. Then PW1 in his cross examination, Ishana Pete notary ಕೊಟ್ಟಾಗ ಅದರ 8ನೇ ಮತ್ತು 9ನೇ ಸಾಲನ್ನು ಅಳಿಸಿರುವುದಿಲ್ಲ. ನಂತರ ಕಾಳದುರ್ಗಯ್ಯ ಮತ್ತು ಚಿನ್ನಮಾರಯ್ಯನವರು ನನ್ನ ತಂದೆಯ ಬಳಿ ಬಂದು ಸದರಿನ ಇಶಾನ ಪೀಠ ಊಟವನ್ನು ವಾಪಸ್ ಪಡೆದುಕೊಂಡು ನಂತರ ಹಿಂದಿರುಗಿಸಿರುತ್ತಾರೆ. ಕಾಳದುರ್ಗಯ್ಯ ಮತ್ತು ಚಿನ್ನಮಾರಯ್ಯನವರು ಹಾಗೆ ನಿಶಾನಪಿಯನ್ನು ಪಡೆದುಕೊಂಡು 1 ರಿಂದ 2 ಗಂಟೆ ಕಳೆದ ನಂತರ ಹಿಂದಿರುಗಿಸಿರುತ್ತಾರೆ. ನಿಶಾನಪಿ 2ರಲ್ಲಿ ಅಳಿಸಿದ ಭಾಗವನ್ನು ನಾನು ಸುಮಾರು 5-6 ತಿಂಗಳು ಕಳೆದ ನಂತರ ನೋಡಿರುತ್ತೇನೆ. These are the evidence was taken. That is the reason only dismiss the suit.
Well, but issues 1 and 2 are answered in the affirmative.
Answered, but corrections ಇದೆಯಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ.
These factors are not pertaining to the proving of the agreement, my lord. There is no question that they were in possession of the property.
That's why they correctly answered for refund of money. But there is a our regard to the payment of money is concerned. when there is a correction in the sale agreement, question of granting the relief of specific performance doesn't arise.
Well, my lord, if that was the case, the trial court should have held that the execution of the agreement was not proved by the plaintiffs.
That is with regard to the insertion is concerned, not the agreement. Agreement comes to the conclusion, but exercising the discretion comes to the conclusion that not a case for granting the relief of specific performance. Even as a matter of right, even proved the agreement also, you are not entitled for the relief of specific performance as a matter of right. It is the discretion of the court.
Well,
That's why when there is a tampering of document noticed by the court.
Both the courts have come to the conclusion that, my lord, the agreement are proved.
Agreement proved, you cannot seek the relief of the specific performance even on the ground that you are entitled for specific.
Suit is dismissed solely on the point that there is no ready and willingness on the part of the plaintiff.
Not on that, even on the correction also. That's why I asked you to read the paragraphs, relevant paragraphs.
So readiness and willingness is not there. That is the point for which the findings have been given to in dismissing.
I cannot convince you thrice, third time. This is the reason why the court has not granted the relief of specific performance.
Whereas readiness and willingness is there in the pleadings of the plaintiff and also in the legal notices issued, my lord. And even the plaintiff's appellants are ready to deposit the remaining
This matter
balance.
is listed for admission. I heard the counsel appearing for the appellant. This second appeal is against the concurrent finding. The factual matters of case of plaintiff while seeking the relief of specific performance. It is contended that there was a sale agreement and agreed to sell the property to the tune of rupees 1,10,000. Out of that, an amount of rupees 80,000 was paid to Maraya and defend number 7 and 8. And also contend that sale deed came into existence on 18/12/2006. And he was always ready and willing to perform his part of contract. Defendant appeared and filed. Defendant number 1 to 6 and 9 appeared, and defendant number 7 and 8 failed to appear, and they were placed ex parte. Defendant number 9 adopted the written statement of 1 to 6. They categorically denied the execution of the agreements of sale by Maraya and defendant number 7 and 8, contending that land measuring 2 acres 1 gunta in suit survey number being the ancestral property was acquired by the 9th defendant in a family arrangement on execution of a deed of consent dated 17/10/2007 by his father, mother and brothers. And defendant number 9 is the absolute owner of the land in suit survey number. As the plaintiff interfered and tried to cut and remove the standing crops and dispossessed him from the said land, the defendant number 9 filed a suit against him in OS number 309 of 2009 for the relief of permanent injunction. According to defendant number 1 to 6 and 9, the agreement of sale is concocted and created by the plaintiff in collusion with the defendant number 7 and 8. The trial court, considering the pleadings of the plaintiff and defendant, allowed the parties to lead evidence and also answered the issue number 1 and 2 as affirmative in coming to the conclusion that sale agreement was executed. However, while dealing with the issue number 4 is concerned, and the same is in respect of payment of is in respect of ready and willing to perform his part of contract is concerned. Take a note of perusal of exhibit P2. And also notice that it is apparent that the last sentence in the second page is deleted by using whitener. From the whitener on the seal of the notary, it is clear that the said recital was deleted after the notary affixed his seal. Neither the parties to the agreement have put their initials near the said correction, nor the notary has made note of it. Hence, comes to the conclusion that the said deletion is subsequent to the notarizing of the said agreement, and even taken note of admission on the part of PW1, wherein also PW1 categorically says that Plaintiff has not taken any action against the defendant number 7 and 8 regarding the alleged correction, and hence answered the issue number 4 as negative regarding readiness and willingness. So also in respect of issue number 3 is concerned, partly allowed regarding making of payment is concerned to the tune of rupees 60,000 to Maraya, and hence comes to the conclusion that not a case for granting the relief of specific performance and order to refund of amount of rupees 60,000 to the plaintiff. From 18/12/2006, the said finding is challenged before the first appellate court. The first appellate court, having considered the grounds urged in the appeal memo, formulated the point whether the judgment and decree of the trial court is not sustainable under law, and the first appellate court, having reassessed both oral and documentary evidence available on record, taken note of admission on the part of PW1 in the cross-examination with regard to deletion of the contents of the document exhibit P2 in paragraph number 77, and discussed that PW1 admitted the question put forth by the counsel for the defendant number 9 that exhibit P2 at page number 2 deleted the some words, and also deposes his explanation to that effect that when it is tendered for before the notary public, the last lines were not deleted and extracted the same, and taken note of the conduct of the plaintiff is also in place vital role in getting discretionary relief of specific performance. That has been discussed in paragraph number 78. And also taken note of in view of payment is concerned, the trial court also considered the said fact since payment of rupees 60,000 was paid, and hence trial court rightly ordered to refund of the amount and confirm the order. Being agreed by the concurrent finding, present second appeal is filed before this court. The main contention of the counsel that when the trial court comes to the conclusion that agreement is proved by answering issue number 1 and 2, ought to have granted the relief of specific performance. And also counsel would vehemently contend that denying the relief of specific performance in spite of proving the agreement of sale exhibit P2, and when the plaintiff is ready to perform the part of contract to pay the balance sale consideration amount and proved the section 16C of the specific relief act, ought not to have dismissed the suit for specific performance, and hence this court has to admit and frame substantive question of law. Having heard the appellant counsel and also on perusal of the pleadings, and though denied the very execution of the agreement, but trial court comes to the conclusion that agreement was executed, and rightly answered the issue number 1 and 2. But while declining to grant the relief of specific performance is concerned, the trial court discussed in detail regarding deletion of the words in page number 2 of the agreement, and the same is discussed in paragraph number 18, 19, and comes to the conclusion in paragraph number 20 that the said deletion and correction is subsequent to the notarizing of the said agreement, and has declined to grant the relief. And first appellate court also, having reassessed both oral and documentary evidence, particularly taken note of the answer illustrated from the mouth of PW2, that is in paragraph number 17(7) and also in paragraph number 78 with regard to the deletion, and the same is subject to the notarizing of the sale agreement, and there is no any counter signature for deletion also, and hence comes to the conclusion that even if there is an agreement and court has to take note of the conduct of the parties, and particularly in paragraph number 78. As per the settled principles of law, the conduct of the plaintiff is also plays vital role in getting discretionary relief of specific performance of contract. And hence, taking into note of the correction in Exhibit P2, particularly deletion, and the same is subsequent to the notarizing of the document. And admission of PW1 is also very clear that the said corrections are made subsequent to the notarizing of the document. And hence rightly comes to the conclusion that not a case to grant the relief of specific performance. However, with regard to the refund of amount is concerned, passed an order to refund the amount. However, both the courts failed to award any interest amount, and hence it is a case to award 6% interest. And since there is no dispute with regard to the payment of amount of rupees 60,000, and hence the appellant is entitled for interest at the rate of 6%. Except this, not a case for admitting and framing substantive question of law to grant the relief of specific performance.
50. Submit this. PN Harish.
6% from the date of agreement ಅಂತ ಹಾಕೋಬೇಕು ಮೇಡಮ್. ಸಮಿತ್ ಹೇಳ್ರಿ.
Now, this is a plaintiff's appeal in a suit for partition and injunction. There are divergent findings by the trial court as well as the first appellate court.
Divergent only with regard to the modification.
Indeed. Lords, my only submission would be that the short question involved is whether class 2 legal heirs would include half brothers and sisters in the absence of them being excluded under the explanation to Schedule 2 of the Hindu Succession Act. That is my only submission, my lords. Because the suit scheduled property is admittedly not ancestral, and neither is it going to be joint family property. The propositus, Mr. Shivaji Rao, had 2 wives, and there were about 9 children born from the first marriage and about 4 children from the second marriage. Shivaji Rao's mother, Ningu Bai, would give the suit scheduled property to her 2 grandsons from the first marriage. The question now is, my lords, out of the 2 grandsons who were gifted the suit scheduled property, one of them is not survived by any class 1 legal heir. Whether the property falling to his share would open for succession to the children of the second marriage under Schedule 2 of the Hindu Succession Act is the only question for consideration, my lords. I have to admit that Section 18 of the Hindu Succession Act would open against me to say that full blood would exclude half blood. But the explanation under Schedule 2 does not make a distinction between half blood and full blood. It only excludes children born out of the uterine who are related to each other by uterine blood, my lords. In this regard, since there's a common ancestor or the common father, even the children from the second wife would be entitled to a share in the property of those of the first marriage, my lords. That's my only submission.
That is considered by the first appellate court in paragraph number 23,
24. My lords, but there is no reference.
25, 26
yeah, 24
also.
onwards. I agree. Lords, but there is no reference made to the schedule of the Hindu Succession Act at all, my lords.
You read paragraph 23. On the basis of the registered gift deed of the year 1961, it is Nagaraja and Tukaram have got the title over the suit scheduled property.
Correct, indeed.
Therefore, both Nagaraja and Tukaram having equal share in the suit scheduled property, the defendant number 1 and 2 being the wife and son of Nagaraja are entitled for half share over the suit scheduled property. Admittedly, Tukaram died without marriage and without any issues. Therefore, there is no class 1 legal heirs to succeed the half share of Tukarama. Hence, half shares of Tukarama has to be divided between his brothers and sisters equally, as they are the class 2 legal heirs of Tukaram. The class 2 legal heirs of Tukaram are his 2 brothers, who are the plaintiff number 1 herein, and late Nagaraja, and 6 sisters, who are the defendant number 3 to 8. The plaintiff number 2 to 5 are the sons of Shivaji Rao from his second wife, Halubai. Even though they are the sons of Shivaji Rao, they are not the own brothers and sisters of Tukaram born to his mother. Plaintiff number 2 to 5 may be having right over the properties left by Shivaji Rao, if any, but plaintiff number 2 to 5 cannot be the class 2 heirs, legal heirs of Tukaram to succeed his property. Hence, it is the plaintiff number 1 and defendant number 1 to 8, being the class 2 legal heirs of Tukaram, are entitled for the remaining half share. The learned trial court has erred in allotting the share of plaintiff number 2 to 5 when they are not the class 2 legal heirs of Tukaram. Therefore, they are not entitled for any share in the suit schedule property. Then 26. It appears that learned trial court has confused itself in calculating the share, and there is some arithmetical mistakes in allotment of shares. The trial court has allotted 112 shares out of half share of deceased Tukaram to plaintiff number 1 to 5. The trial court has allotted half share in the half share of deceased Nagaraja to defendant number 1 and 2. Half share in this half share means it will be 1/4. In fact, defendant number 1 and 2 being the legal heirs of Nagaraj are entitled for the half share and not 1/4 share. The trial court has allotted 112 share each out of half share of deceased Tukaram to defendant number 3 to 8. Again, it is wrong in view of the above discussion made by me. Considering all these aspects, I have to say that defendant number 1 and 2 are entitled for half share, that is 8/16 share in the suit schedule property. The remaining half share has to be divided equally between the plaintiff number 1, defendant number 1 and 2, and defendant number 3 to 8. The defendant number 1 and 2 being the wife and son of Nagaraj have also entitled for share in the deceased Tukarama. Therefore, plaintiff number 1, defendant number 1 and 2 together and defendant number 3 to 8 are entitled for 1/16 share each in the suit schedule property. So the defendant number 1 and 2 are entitled for 9/16 half plus 1/16 shared, where the defendant number 1 and defendant number 3 to 8 are entitled for 1/16 share each in the suit schedule property. To that extent, impugned judgment has to be interfered. That is modified
Indeed.
in
My lord-
accordance with law.
My only submission would be that the first appellate court has not referred to the explanation to the schedule of the Hindu Succession Act, my lords. If I may only be reading that, the second entry under class 2 would of course be sons, daughter, so on and so forth, and brother and sister. The explanation thereunder is in this schedule, references to a brother or sister do not include references to a brother or sister by uterine blood, which is to say that a uterine blood brother or sister is completely excluded to be a class 2 legal heir, which is not the case for a half blood brother or sister, my lords. That is my only submission. The second submission would be that, my lords, under para 24, where the reference is made by the first appellate court to that the plaintiff number 2 to 5 would be entitled to share of the properties only left by Shivaji Rao, would be incorrect for the reason that the property is not considered to be ancestral property in the first place. If assuming section 16 subsection 3 of the Hindu Marriage Act would operate, which is the legitimacy of the second marriage, then this observation would be relevant, my lord. It is nobody's case that the second marriage occurred during the subsistence of the first marriage. In fact, the second marriage occurred after the first wife passed away.
What judgment of Revana Siddhaya says, madam?
My lords, I apologize.
Even if it is second marriage also. What judgment Revana Siddhaya case, larger bench of the Supreme Court says? That is kept in mind while passing an order by the district judge.
Indeed.
That's why allotted the share. Yes, what do you say?
Kindly see, there are so many appellants before the appellate court. Only this present appellant is aggrieved. All are happy with the shares that has been allotted. He has not joined the other sons of Zagir wife. So my response submission is both the
others have not joined along with the appellant.
Yes.
She cannot force them to come.
Yes.
Howda?
Yes. So because of this person, the entire allotment cannot be changed.
Is there any defect in allotment of share?
No,
made
according
by
to me,
the
it is perfect.
First defendant.
According to me, it is perfect.
That's what the
It is perfect.
first appellate court taken note of recent judgment of the apex court of Revana Siddhaya and allotted the share.
Yes. That's
Even
what-
for them also. Told. Heard the appellant counsel.
But if I may be permitted to at least have one accommodation, or I'll refer to the judgment and revert back by tomorrow.
Madam, no dispute that property originally belongs to ಯಾರದು ಇಲ್ಲಿ?
Shivaji Rao's mother.
Mother. She executed a gift
Gift
deed.
deed.
Indeed,
There
I'm
are
not
two
disputing that. I'm not disputing.
Sons, ಹೌದಾ?
ಇಲ್ಲ.
One is having the legal heirs and their interest also protected. One was not having any legal heirs.
Paid issueless.
They are not the legal heirs, class 1, class 1.
They're not.
Class 2 taken note of it
Indeed.
and the same is given. That's what.
No, my only submission is in the absence of an express exclusion under the explanation to the schedule, there could not
Madam,
have
now
been an
question
exclusion.
arises, when the person is not having any issues, particularly class 1 heirs, then class 2 heirs, it goes to the class 2 heirs. Those are the class 2 heirs, that's why among them it is divided by the first appellate court.
Indeed, but I am also a class 2 legal heirs is what my submission is.
Your share is also protected.
It's not protected, my lords. I am excluded because I am the children of the second wife. The first appellate court excludes all the children from the second wife, my lords, which is what the first appellate court does. If I may kindly see in the paragraph number 26 of the impugned judgment of the first appellate court's judgment.
You are also given share, madam.
But I am not given a share, my lords. The trial court has given me a 1 by 12
number
share.
1.
Lords, I am plaintiff number 3. Plaintiff number 2 to 5 have been excluded.
You are representing whom, madam?
Plaintiff number 3, my lords.
3 Vijayendra, son of late
Indeed.
Shivaji Rao.
Indeed. My share has been excluded.
But Basavaraj, plaintiff number 1 was given.
Basavaraj was another son from the first marriage itself.
So he is first marriage.
He's from the first marriage, indeed.
Third one is through second marriage.
Indeed.
Now,
plaintiff number 2 to 5 are from the second marriage, my lords. My share is excluded.
Plaintiff number 2 to 5 are the sons of Shivaji Rao from his second wife, Alubai. Even though they are the sons of Shivaji Rao, they are not the own brothers and sisters of Tukaram, born to his mother. The plaintiff number 2 to 5 may be having right over the properties left by Shivaji Rao, if any. But plaintiff number 2 to 5 cannot be the class 2 legal heirs of Tukaram to succeed his property. What about plaintiff number 2 and 4 and 5? Only come before this court?
Lords, they were there before the first appellate court.
Hence, it is the plaintiff number 1 and defendant number 1 to 8 being the class 2 heirs of Tukaram are entitled for the remaining half share.
Indeed. So my share has been excluded. I have not been entitled to a share under the modification.
In the absence of legal class 1 heirs, automatically class 2 heirs the property will be succeeded. That is what the appellate court has held. And it is not property of.
Course in the contention that
exclusion.
Exclusion
that is.
But in view of Revan Siddhaya case.
All are equally entitled. But they are not the children of this. What has happened is when Nagaraj and Tukaram have become absolute owners, there is no dispute.
In view 1961. Of the gift.
1961 gift deed. So these are persons are not claiming through them. They are not the children of either Nagaraja or Tukaram. So that is the reason, not the class 1 heirs.
But now the issue is property left by the Tukaram.
Only half share that is left by Tukaram, that is to go when in the absence of.
Now you cannot differentiate the relationship between the parties. If plaintiff number 1 is also a son of this Shivaji Rao.
Son from the first wife.
From first wife.
First wife.
And the plaintiff number 2 to 5 are also the sons
children
through
of
second wife.
Second wife.
Second wife. Now in view of the judgment of the Revan Siddhaya, you cannot distinguish and differentiate them.
That comes into the picture when they are when the sons who are not legitimate, they are claiming. Here it is not the question.
It is a substantive question of law.
Could be from.
They cannot be excluded in view of
Milad,
the constitutional bench.
What I am trying to submit, Milad, that is decision.
But her case is
that exclusion. She depends on.
All are excluded. Not only the plaintiff number 3, 2 to 5 are excluded.
My submission is the Revan Siddhaya decision cannot be applied because this reason that they are not claiming.
Go through the judgment and make submission before the court. Heard in part.
Please.
Heard in part. List this matter next Tuesday or Wednesday?
Indeed.
16. 16. Both you read that judgment 16.
51. Rudrappa P.
Appellant, I need
Lord, to produce certain documents, my lord, additional documents. Lordship may kindly 10 days time may be
No,
granted.
counsel, in second appeal, question of
Lord,
production of document doesn't arise.
The very dispute in this matter, my lord, with regard to the acquisition of the land, my lord.
You have not filed any application along with second appeal also.
My lord,
The case is listed for admission, you cannot seek on the ground that I need to file some documents. Yeah.
my lord, the
Suit
suit
for
for
declaration
declaration
and
and permanent injunction, my lord. My lord, the plaintiff, my lord, filed a suit, my lord, in the year 1998. Previous suit, my lord, filed by her mother, my lord. 821 up to 1968, my lord. That has been ended with the compromise, my lord. Order 23 Rule 3 application has been filed, my lord. Off share has been allotted to the plaintiff, and off share has been allotted to grandfather of the plaintiff, my lord. Therefore, my lord, remaining off share, my lord, has been purchased by the plaintiff, my lord. Total full property, my lord, she has been acquired, my lord, plaintiff. Thereafter, my lord, the land has been acquired, my lord, for the purpose of layout and formation of the road, my lord. My lord, the 23.5 guntas of the land, my lord, out of which, my lord, 9.5 guntas has been remains with the plaintiff. For that, my lord, she has filed the present suit, my lord, for declaration and permanent injunction. The plaintiff has approached the second respondent, my lord, to demarcation and bifurcation of the land, my lord. That, my lord, the authority have not taken any action for the bifurcation of the land. Second respondent being the village panchayat of Marehalli, my lord, of Malwali Taluk. My lord, the second respondent, the panchayat has not taken any action with regard for the demarcation of the land. For that reason, my lord, she has filed the suit, my lord, and also, my lord, defendant number 1, my lord, Javrai is also started, my lord, interfering the suitable property. He wanted to, my lord, encroach the property, and she tried to demolish the one shed, my lord. One petty shop has been constructed by the
Paragraph number 22, counsel.
my lord,
On going through the aforesaid documentary evidence, it is very clear that the contention of the first defendant that about of land out of survey number 292/7 at Tamarahalli village has been acquired, and award was also passed in favor of Sri Lingad Gowda. In this
That
regard, it
we
is
have
relevant to
admitted, my lord.
consider that the plaintiff herself has admitted that 14 guntas of land was acquired, and she has got remaining 9.5 guntas out of 292/7. At the same time, it is also relevant to consider that while mentioning the plain schedule, the plaintiff has shown the land measuring 9.5 guntas out of entire 23 guntas and excluding 14 guntas of land. The schedule is east by house of Vadramma, west by property of Devarasegoda, north by so-and-so, south by property of Pannamma. The plaintiff might have mentioned the said schedule on the basis of Exhibit P6, wherein the said property is shown as vacant site by mentioning the similar schedule and not mentioning its extent. Hence, I am of the opinion that the plaintiff has failed to locate the suit schedule property by relying upon document to show her title in respect of the suit schedule property.
My lord, only the findings with regard to the, my lord, 9.5 guntas, my lord, we have admitted, we are pleaded in the plaint also, my lord. Only 9.5 guntas, my lord, of the land is which remains with the plaintiff. They are not disputing the same, my lord. What their contention is, my lord, entire 23 acres, 23 guntas of land has been acquired. That is the return statement in the return statement. The contention taken by the defendant number 1. Para number 7 of the
Modification ಏನು ಹೇಳುತ್ತೆ acquisition ಗೆ?
Acquisition, my lord, with regard to the acquisition also they have produced some documents, my lord. Where, my lord, they have concocted the documents. There are some overwritings on the.
Whether it is 23 guntas or 14 guntas.
No, only 14 guntas.
ಎಲ್ಲಿದೆ ಹಾಗಂತ ತೋರಿಸಿ ಯಾವ ದಾಖಲೆ ಇದೆ?
That is why, my lord, I need to produce documents. For that reason, I have requested, my lord. Only with regard to the acquisition of the property, only
the evidence of PW1, it is clear that she admitted the schedule of the property of 8 guntas of land which was acquired clearly tallies with the schedule mentioned in Exhibit D14. By this, it can be clearly inferred that the claim of the title or alleged 9.5 guntas by the plaintiff is not sustainable. The possession of the plaintiff over the social property is also clearly disputed by the defendant number one. By considering all these aspects, I hold that plaintiff has failed to prove the title, much less possession over the social property. Hence, I answer the issue number 1 and 2.
Only
Negative.
14 quintas of the land has been acquired, my lord. We have admitted in the plaint itself, we have pleaded.
ನಾ ಕೇಳ್ತಾ ಇದೀನಿ
9.5 quintas, my lord. Your lordship may kindly see for a
14
moment.
ಗುಂಟಾಸ್ ಎಲ್ಲಿದೆ ರೀ? ಓನ್ಲಿ 23 ಗುಂಟಾಸ್ ಇಲ್ಲ, ಬರೀ 14 ಗುಂಟಾಸ್ ಅನ್ನೋದು ಏನ್ ದಾಖಲೆ ನೀವು ಕೊಟ್ರಿ ಅಂತ ಕೇಳ್ತಾ ಇದೀನಿ ನಾನು.
For that reason, my lord, I need to produce the documents, my lord.
ಕೋರ್ಟ್ ಅಲ್ಲಿ ಎಕ್ಸಿಬಿಟ್ P12 ಹಾಕಿದಿರಲ್ಲ 1 to 12 ಅವಾರ್ಡ್, ಎಂಡಾರ್ಸ್ಮೆಂಟ್, ಸ್ಕೆಚ್, ಆರ್ಡರ್ ಶೀಟ್ ಎಲ್ಲ ಹಾಕಿದಿರಲ್ರಿ.
That award, my lord, with regard to the 14 quintas of the land, my lord. Remaining 9.5 quintas, my lord.
ಕಾಪಿ ಅವಾರ್ಡ್ ಇದೆಯಾ? ಕಾಪಿ
produce ಮಾಡ್ತೀನಿ sir,
ಓನ್ಲಿ
ಅದಕ್ಕೋಸ್ಕರ
14.5 ಗುಂಟಾಸ್ಗೆ ಅಂತ ಏನು ಹಾಕಿಲ್ಲ. ಇವನ್ ಫಸ್ಟ್ ಅಪ್ಲೇಟ್ ಕೋರ್ಟಲ್ಲಿ ಯು ನಾಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಎನಿ ಡಾಕ್ಯುಮೆಂಟ್.
ಅಲ್ಲ, recently they got.
ರೀಸೆಂಟ್ಲಿ ಹೋಗ್ಲಿ, ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ? ಈಗ ತೋರಿಸ್ತೀರಾ? ಕೋರ್ಟಿಗಂತೂ ಹಾಕಿಲ್ಲ, ಪರವಾಗಿಲ್ಲ, ನಾನು ನೋಡ್ತೀನಿ, ಐ ಆಮ್ ರೆಡಿ. ತೋರಿಸಿ ಇದ್ರ ನಿಮ್ಮ ಹತ್ರ ಡಾಕ್ಯುಮೆಂಟ್.
ಆರ್ಟಿ ಆಕ್ಟ್ ಅಲ್ಲಿ ಹಾಕಿದಾರಂತೆ, ಒಂದ್ ವಾರದಲ್ಲಿ ಬರುತ್ತೆ ಅಂತ ಹೇಳಿದ್ರು. ಅದಕ್ಕೋಸ್ಕರ ನಾನು ಒಂದು ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಕೂಡ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅಕ್ವಿಸಿಷನ್ ಆಗಿಲ್ಲ ಅನ್ನೋದು ಒಂದು ರೇಟಿಂಗ್ ಅಲ್ಲಿ. ಆಮೇಲೆ ಓವರ್ ರೇಟಿಂಗ್ ಮಾಡಿದ್ದಾರೆ.
ಹೋಗ್ಲಿ ತೋರಿಸಿ, ಆ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ನಾರು ತೋರಿಸಿ.
ಆ ಜೆರಾಕ್ಸ್ ಕಾಪಿ ಇದೆ ಅಂತ ಅವ್ರ ಹತ್ರ, ಪಾರ್ಟಿ ಹತ್ರ ಬೆಳಿಗ್ಗೆ ಫೋನ್ ಮಾಡಿದ್ರು ಅವರು.
ಆಯ್ತು,
ಅದಕ್ಕೆ ಒಂದ್ ವಾರ ಟೈಮ್.
ಯಾವಾಗ ಕೊಡ್ತೀರಿ ಹೇಳಿ? ಥರ್ಡ್ ಪಾರ್ಟ್ ಯಾವಾಗ ಕೊಡ್ತೀರಿ ಹೇಳಿ?
ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ.
ಡೋಂಟ್ ಟ್ರೈ ಟು
ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ
ಎಸ್ಕೇಪ್ ಫ್ರಮ್ ದಿ ಕ್ಲಚಸ್ ಆಫ್ ದಿಸ್ ಕೋರ್ಟ್.
ಆತರ ಏನಿಲ್ಲ ಸ್ವಾಮಿ, ಆತರ ಏನಿಲ್ಲ.
ಆಯ್ತು, ಯಾವತ್ತು ಹೇಳಿ?
ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ.
ಯಾವತ್ತು ಹೇಳಿ? ಕೇಸ್ ಇದ್ರೆ ನಾನೇ ಕೊಡ್ತೀನಿ ರಿಲೀಫ್, ಕೇಸ್ ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ.
ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ.
ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ ಅರ್ಧ ದಿವಸ ಇರ್ತದೆ. ಲಾಸ್ಟ್ ದಿವಸ
18th or 19th, my lord.
17-12.
Oblige.
ನೆಕ್ಸ್ಟ್ ಬುಧವಾರ. ಇವತ್ತಿಗೆ 8 ದಿವಸ ಕೊಟ್ಟಿದ್ದೀನಿ ನೋಡಿ. ನೆಕ್ಸ್ಟ್
ಅಜಿತ್ ಶೆಟ್ಟಿ.
The plaint, my lords, had 7 different prayers. 2, my lords, for mandatory injunction. My lords, the rest, my lords, were for prohibitory injunction. These were the reliefs that were sought. My lords, only prayer number 5 has been granted by the trial court. But the rest were rejected.
1 to 4 and 6 and 7 is rejected.
They have been rejected, my lords, and that has been confirmed by the Honorable First Appellate Court. My lords, the predecessors of these parties, my lords, they were priests of a temple, which is arrayed as second defendant. My lords, they were granted 2 portions of lands, my lords, abutting the temple, my lords, to build houses. My lords, it was a plaintiff's predecessor who built the first house. My lords, thereafter, my lords, the defendants, the contesting defendants' predecessor, they also built a house, but this time what happened, my lords, because of the paucity of space, the northern wall, my lords, of the plaintiff's house was shared as a common wall with the other house as well. So that was a permissive, my lords, license granted to build a house, my lords, abutting this house while utilizing the northern portion of this house. My lords, certain disputes arose. My lords, the disputes were settled, my lords, in terms of a document dated, my lords, 12, my lords, this is dated 1st May 1917, which was, my lords, exhibit P4. Apart, my lords, from the usage of the northern wall, there were certain other, my lords, arrangements also that were entered into, which included, my lords, access to a common well, which was the only source of drinking water. My lords, that is one part. Secondly, my lords, there was a pathway, my lords, to reach the temple, access to the temple through the pathway. My lords, these are the only, my lords, bones of contentions which remained. My lords, the Honorable Trial Court holds, notwithstanding the content of the document, my lords, of the year 1917, the Honorable Trial Court holds that, my lords, there is no exclusive right over the northern wall in favor of the plaintiff. Secondly, my lords, if my lords were to see, my lords, while answering issue number 4 at page 58, the Honorable Court opines that, my lords, the so-called the blockage of the pathway is concerned, my lord, by virtue of appointing a commission, that blockage has been removed. So the Honorable Court comes to a conclusion that yes, there was some sort of interference and blockage, but that has since been removed.
Paragraph 15, 16, 17 of the First Appellate Court ಓದಿ ಗೊತ್ತಾಗ್ತದೆ.
ಅಲ್ಲ, ನಾನು ಓದಿದ್ದೇನೆ ಸರ್. I have read that. I have read that. Both the honorable courts have opined, my lord.
ನಿಶಾನೆ P4ರಲ್ಲಿ ನಾವಾಗಲಿ ಮತ್ತು 1ನೇ ಪ್ರತಿವಾಗಲಿ ಆಗಲಿ ಸಾಮಾನ್ಯ ಗೋಡೆಯನ್ನು ಬಿಟ್ಟು ಪ್ರತ್ಯೇಕವಾಗಿ ನಮ್ಮ ಜಾಗದಲ್ಲಿ ಗೋಡೆಯನ್ನು ಕಟ್ಟಬಾರದು ಎಂಬ ಉಲ್ಲೇಖ ಇಲ್ಲ ಎಂದರೆ ಸರಿ.
ಹೌದು. But then, my lords, content of the document speaks otherwise. northern wall apart, my lords, now we are in a situation, my lords, where we cannot, my lords, separate from each other. The northern wall will continue to exist as a common wall. My lords, that is something I have advised them, that is which we cannot resile from. ಅದು ಏನು ಮಾಡ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ. But the only two remaining issues would be, my lords, the pathway and the drinking water well. The honorable court, my lords, comes to a conclusion, my lords, that since I have installed a pump set.
Records barely noted. I am not satisfied.
Very well.
Call for records.
Grateful.
This matter on 19/1/26.
Grateful.
53. Sumukha.
I appear, my lords. Last time, my lords, issued notice.
ಬಂದಿದಾರಲ್ಲ. Other side also present.
Yes. This is a case where, my lords, the suit for partition is filed. Page 63 is the genealogical tree. It's page 63. Chandrasekhar Bhatta, my lords, the father. Then Indramma, my lords, is the mother. She files the suit seeking for partition.
Mother.
Lords, I am the defendant number 1, Manjula. Then, my lords, defendant number 2, 3 and 4, my lords, are the other sisters. Subsequently, my lords, the defendant number 2, 3 and 4 transpose themselves as the plaintiffs. And, my lords, I have objected to the partition on the ground that the two properties, lords, along with certain amounts, were, my lords, bequeathed through the will by the father. Lords, the will, my lords, contains two parts. Lords, one of the property, my lords, is bequeathed in favor of defendant number 1, Manjula. That is the appellant hearing. Then, my lords, another property, my lords, has been bequeathed in favor of another daughter. And so far as, my lords, the FDs are concerned, lords, it was around 1 lakh or 1,50,000. 50,000 is received, my lords, by 50,000 each received by the other two daughters. And the leftover amount, my lords, was with the mother. Lords, the court below, my lords, refuses, my lords, the decreed the suit solely on the ground that the original will is not produced. Lords, I have produced the certified copy of the will, and, my lords, I have also summoned the officer, lords, from the sub-registrar's office. Thereafter, my lords, the trial court holds that the original will is not produced, and accordingly the contention in relation to the will cannot be, and accordingly, my lords, the suit for partition is decreed.
What happened to that will, original will?
Lords, the original will, my lords, I have taken a specific contention that it is remained with the mother. And I do not, my lords, have the copy of the will also. But however, my lords, kindly see
whether any provision is made to the mother in the will.
My lords, that is 50,000 rupees.
Only amount.
Only amount. And the two properties, my lords, which were given, my lords, under the will in favor of two daughters, the khata of which, my lords, has been entered into by the concerned municipal authority, referring to the will itself, not only in name, lords, even in so far as the other.
Now you are arguing that it is in the custody of the mother.
Lords,
but you are not stated anything. That's what the observation.
Lords, the observation is made that I have not pleaded in the written statement. Lords, to that extent, but otherwise, my lords, I have produced the registered will. It is not, my lords, unregistered will.
Not only written statement, even in your affidavit also.
That I have not suggested, my lords.
Even in even in her affidavit, in lieu of examination in chief, she has not stated the will is in possession of the original plaintiff. In para 18.
Para 13 also, my lords.
Para 18.
Para 18.
That is the observation.
Yes.
You are not pleaded that original is with the mother.
Lords, I have para 13, my lords, may kindly be seen, my lords.
13.
Para 13 also. On the other hand, the learned counsel for the defendant has argued that the plaintiff cannot seek for partition in respect of the suit schedule property as the will dated 8/4/2009 has been acted upon by the parties. Elaborating his submissions, he has argued that there are no suspicious circumstances surrounding the will Neither the original plaintiff nor the transposed plaintiffs have pleaded anything regarding the will. They have not disputed the will by way of pleadings. He has further argued that the will is in possession of the original plaintiff and the will has been proved as per the requirement of law, and therefore the suit is liable to be dismissed. My lords, similarly, my lords, para 15 also. In order to prove her case, the defendant Srimati Manjula has examined herself as DW1 and two witnesses by name Dinesh and KR Nagaraja as DW2 and 3. In her evidence, she has also got marked Exhibit D1 to 11. Documents Exhibit D1 is the mutation order extract dated 10/11/2012. Exhibit D2 is the tax assessment register extract dated 6/5/2016, which shows an extent of 650 square feet in the suit schedule property is standing in the name of the defendant. Exhibit D3 is the corresponding document to Exhibit P3. Exhibit D4 is the official memorandum dated 27/9/2016, issued by Assistant Executive Engineer, Mangalore Electricity Supply Company. Exhibit D5 to 8 are electricity bills. These documents appears to have been produced in proof of the defendant's possession of written statement scheduled property. Exhibit D9 is the original sale deed dated 2/6/2003, through which B.S. Chandrasekhar Bhatt had purchased the suit schedule property. Exhibit D10 is the copy of the Aadhaar card. D11 is the death certificate of one Suryakanta Sheth, who is stated to be one of these attesting witnesses to the said alleged bill. A perusal of the cross-examination of DW1 shows that the Exhibit D1 to 11 are not disputed. However, what is paradoxical is that the defendant has not produced the alleged will dated 8/4/2009 on which her entire defense is based. Lords, the examination also, Lords, kindly see the evidence at the next page. Para 16, Lords, next page it is recorded. ನನ್ನ ಗಂಡ ಒಂದು ವಿಲ್ ಮಾಡಿ ಸಬ್ ರಿಜಿಸ್ಟರ್ ಕಚೇರಿಯಲ್ಲಿ ನೋಂದಾಯಿಸಿದ್ದಾರೆ ಅಂದರೆ ನನಗೆ
para 16 first ಓದಿ.
Para 16.
Learned counsel for defendant
in the argument has submitted that the original will is in possession of plaintiff Srimati Indramma. This argument cannot be countenanced for two reasons. Firstly, there is no pleading in a written statement to that effect. Secondly, no suggestion of such kind was made to PW1 in the course of cross-examination. Learned counsel for the defendant has extensively cross-examined PW1 Indramma before Learned Court Commissioner. A perusal of cross-examination shows that he has made much effort to take admissions from PW1 with respect to the existence of alleged will dated 8/4/2009. However, no unequivocal admission is elicited from the mouth of PW1 with respect to such a will. In the cross-examination relating to the suggestions made by learned counsel for defendant, the PW1 has stated as follows: ನನ್ನ ಗಂಡ ಒಂದು ವಿಲ್ ಮಾಡಿ ಸಬ್ ರಿಜಿಸ್ಟರ್ ಕಚೇರಿಯಲ್ಲಿ ನೋಂದಾಯಿಸಿದ್ದಾರೆ ಎಂದರೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. RCC ಮನೆಯ ಖಾತೆ ಮಂಜುಳಾ ಅವರ ಹೆಸರಿನಲ್ಲಿದೆ ಎಂದರೆ ಸರಿ. ಸಾಕ್ಷಿಯು ಸ್ವಯಂವಾಗಿ ಹೇಳುತ್ತಾರೆ, ಗಲಾಟೆಯಾದ ನಂತರ ಮನೆಯ ಖಾತೆ ಮಂಜುಳಾ ಅವರ ಹೆಸರಿಗೆ ಆಗಿರುವುದು ಗೊತ್ತಾಯಿತು. ಹಿಂದಿನ ಮನೆಯನ್ನು ನನ್ನ ಗಂಡ ನನ್ನ ಮಗಳು ಜಯಲಕ್ಷ್ಮಿಗೆ ಡಿಫೆಂಡ್ ನಂಬರ್ 3 ಅವರಿಗೆ ವಿಲ್ ಮಾಡಿರುತ್ತಾರೆ ಎಂದರೆ ಮಾಡಿರಬಹುದು. So far as my lords that property is concerned,
ನನಗೆ ಗೊತ್ತಿಲ್ಲ.
No, I have produced, my lords, the khata register or the extract where they clearly mention that it is based on the will itself. Otherwise, my lords, there is no question of, my lords, entering somebody else's name, my lords, unless and until even my consent is also taken by the municipal authority. Whatever is convenient to them, my lords, they admit. And so far as, my lords, so far as my property is concerned, they say that there is no will. And it is, my lords, his self-acquired property. Plus the original, my lords, the certified copy of the will, my lords, has been produced, but that has not been looked into or taken note of, my lords, by the trial court. My lords, even in the next page also, my lords, the evidence 8/4/2009 ನನ್ನ ತಂದೆ ಮಾಡಿರುವ ವಿಲ್ ಪ್ರಕಾರ ಒಂದನೇ ಪ್ರತಿವಾದಿಯ ಹೆಸರಿಗೆ ಒಂದು ಭಾಗ ಮತ್ತು ಜಯಲಕ್ಷ್ಮಿಯ ಹೆಸರಿಗೆ ಒಂದು ಭಾಗವನ್ನು ನೀಡಲಾಗಿರುತ್ತದೆ ಎಂದರೆ ವಿಲ್ನ ಬಗ್ಗೆ ನನಗೆ ಯಾವುದೇ ಮಾಹಿತಿ ಇಲ್ಲ. ಮಂಜುಳಾ ಮತ್ತು ಜಯಲಕ್ಷ್ಮಿ ವಿಲ್ನ ಆಧಾರದ ಮೇಲೆ ಖಾತೆ ಮಾಡಿಸಿಕೊಂಡಿದ್ದು, ಈ ಬಗ್ಗೆ ನಿಮ್ಮ ತಕರಾರು ಇದೆಯೇ ಎಂದರೆ ತಕರಾರು ಇರುತ್ತದೆ. ವಿಲ್ ಅನ್ನು ಪ್ರಶ್ನಿಸಿ ಇಲ್ಲಿವರೆಗೂ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ದಾವೆ ಸಲ್ಲಿಸಿಲ್ಲ ಮತ್ತು ಖಾತೆ ಬದಲಾವಣೆಯ ಬಗ್ಗೆ ಸಂಬಂಧಪಟ್ಟ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಇಲ್ಲಿವರೆಗೂ ವ್ಯಾಜ್ಯ ಸಲ್ಲಿಸಿಲ್ಲ ಎಂದರೆ ಸರಿ. ಸಾಕ್ಷಿ ಸ್ವತಃ ವಿಲ್ ಮತ್ತು ಖಾತೆಯ ಬಗ್ಗೆ ಮಾಹಿತಿಯೇ ಇಲ್ಲದಿದ್ದ ಕಾರಣ ನಾವು ಯಾವುದೇ ವ್ಯಾಜ್ಯ ಸಲ್ಲಿಸಿಲ್ಲ ಎಂದು ಹೇಳಿದರು. Even after that also there is no, my lords, steps taken to challenge that. ವಿಲ್ ಆಧಾರದ ಮೇಲೆ FD ಮೊತ್ತದ ಪೈಕಿ ನಾನು 50,000 ಮತ್ತು ವಿಮಾ 50,000 ಪಡೆದುಕೊಂಡಿದ್ದೇವೆ ಎಂದರೆ ವಿಲ್ ಆಧಾರದ ಮೇಲೆ ಪಡೆದುಕೊಂಡಿಲ್ಲ, ಆದರೆ ಹಣ ಪಡೆದುಕೊಂಡಿದ್ದೇನೆ. That was clearly, my lords, mentioned, indicated in the will itself. ದಾವಾ ಸ್ವತ್ತು ನನ್ನ ತಂದೆಯ ಸ್ವಯಾರ್ಜಿತ ಆಸ್ತಿಯಾಗಿದ್ದ ಕಾರಣ ಅವರ ಇಚ್ಛೆಯ ಅನುಸಾರ ವಿಲ್ ಮಾಡಿದ್ದಾರೆ ಅಂದರೆ ಸರಿ ಇಲ್ಲ. ನನ್ನ ತಂದೆ ನಮ್ಮ ಕೊನೆಯ ಇಚ್ಛೆಯಂತೆ ಮಾಡಿದ ವಿಲ್ಗೆ ಅನುಗುಣವಾಗಿ ನಾವು ಸಹ ಹಣ ಪಡೆದುಕೊಂಡಿದ್ದು ಮತ್ತು ಸ್ವತ್ತಿನ ಖಾತೆ 1ನೇ ಪ್ರತಿವಾದಿ ಮತ್ತು ಜಯಲಕ್ಷ್ಮಿ 3ನೇ ಪ್ರತಿವಾದಿ ಹೆಸರಿಗೆ ವರ್ಗಾವಣೆಯಾಗಿ ಅವರೇ ಅದರ ಸ್ವಾಧೀನದಲ್ಲಿದ್ದಾರೆ ಸರಿ. The only, my lords, exception that has been raised, my lords, is that original will is not produced. It is a registered will, my lords. I have summoned the documents and as well as, my lords, the concerned authority.
That's all? Yes.
There is no basis for leading secondary evidence, my lord. For leading secondary evidence, they ought to have made all the abatements either in the pleadings or in their affidavits, which are missing, my lord. Based on this, my lord, that the certified copy of the will, alleged will, has not been marked in evidence at all. When a document is not even marked in evidence, there is no question of looking into the veracity of the will. It never arose in this case, my lord. Rightly, both the trial court and the lower appellate court have held that he has not made any abatements about where the will is, which came to be a crucial factor, my lord, while deciding both these matters. Our ಹೇಳ್ತಾರೆ ತಾಯಿ ಹತ್ರ ಇತ್ತಂತ. When mother was alive, when she was put into the box, not even a single suggestion was made to her that the will is with you, and nor did they take any notice. If my lord, according to them, will was with the mother, they should have taken a notice under CPC for production of will. No such notice is taken, and no abatements is made. My lord, when there is no notice, no abatements are made, secondary evidence cannot be led, my lord. And when there was no document marked, then the question of proving the will never arose. My lord, as per the trial court and lower appellate court judgments, all the daughters or all the children of the father have got equal rights now, my lord. It is not in exclusion of anyone.
That's all. Third, this matter is listed for admission. I heard the counsel appearing for the appellant and also the counsel appearing for the respondent. This second appeal is filed against the concurrent finding. The factual matters of case of plaintiff before the trial court that is the wife of late B.S. Chandrasekhara Bhatt, and all the defendants are the daughters of the plaintiff, and she is entitled for 1/5 share in the suitable property and also sought for consequential relief of permanent injunction restraining the defendants from dispossessing her from the RCC house situated in the suitable property and also alienating the said property in favor of third parties. It is her case that her husband died on 12/8/2012, leaving behind her and also the defendants as her legal heirs. The scheduled suitable property consists of main house and an outhouse. The main house, being RCC house, is in the occupation and possession of the plaintiff, and at the same time outhouse portion, namely house with mangrove tiled roof, is in the occupation of defendant number 1 and 3. It is also her case that defendants, by colluding each other, have got changed the khata of RCC house in the name of defendant number 1 and outhouse in the name of defendant number 3. It is also her case that on 13/5/2016, the defendant number 1 along with her son attempted to dispossess her from said RCC house, but she could manage to thwart such attempts with the help of neighbors. It is also the case of the plaintiff that suitable property, being the self-acquired property of her husband B.S. Chandrasekhara Bhatt, is in joint possession and enjoyment of plaintiff and defendant. The suitable property remains unpartitioned and plaintiff is entitled for 1/5 share. In response to the suit summons, defendant number 1 and 4 entered appearance through their respective counsel and filed written statement contesting the suit. In the written statement filed by the first defendant, the relationship between the parties and the scheduled property was cell-code property of Chandrasekhar Bhatt are admitted. At the same time, she has denied rest of the allegations of plaintiff. The specific case is that Chandrasekhar Bhatt, who is none other than her father, executed registered will dated 8/4/2009, bequeathing one portion of the social property which comprises RC's house in her favor and another portion consisting of house in favor of third defendant. In addition to that, various bank deposits belonging to him were bequeathed in favor of plaintiff Srimati Indiramma and defendant number 2 to 4. The property which the first defendant claims to have acquired through will is described in the written statement. And hence contend that when the property was disposed of through testamentary document, that is will, and the plaintiff and defendant number 2 to 4 have clear knowledge about the said fact, and further contend that parties have also acted upon in terms of the will, and hence there cannot be any relief of partition. The trial court, having considered both the pleadings of the parties and also the defendant, framed the issues and allowed the parties to lead evidence. The trial court, having considered both oral and documentary evidence, that is additional issue number 3 as well as issue number 1 and 2 framed earlier, considered the factual aspects and documentary evidence available on record, particularly taken note of the evidence of PW1 as well as the evidence of DW1, and DW1 evidence and documents are also discussed in paragraph number 15. The trial court taken note of that original will was not produced before the court, and only an attempt is made to produce the certified copy, and also taken note of it is not the case of the defendant number 1 that the original will is in the custody of the plaintiff, and only during the course of argument the said contention was taken, and there was no any pleading in the written statement as well as in the oral evidence of the DW1 before the court, and even not suggested to the PW1 that original will is with the custody of the plaintiff. And having considered the material on record, even though witnesses have been examined, not accepted the case of the defendant and granted the relief of 1/4 share each in the social property to the plaintiff and defendant, and though other daughters have arrived as defendant but subsequently that transposed to them as plaintiffs other than number 1. Being agreed by the said judgment and decree, an appeal is filed before the appellate court in RA number 18 of 22, and the appellate court, having considered the grounds which have been urged in the appeal memo, formulated the point whether the trial court erred in decreeing the suit for partition and allotting 1/4 share each to transpose the plaintiff number 2 to 4 and defendant, and whether it requires interference of this court. The trial court also, having considered both oral and documentary evidence on reappreciation of both oral and documentary evidence, confirmed the judgment of the trial court in coming to the conclusion that trial court has not committed any error in coming to such a conclusion, and particularly taken note of the evidence available on record and overall appreciation of evidence in no ways substantiate that the father had left the will with respect to the social property. The first appellate court also comes to the conclusion that the defendant number 1 has utterly failed to prove that exhibit D2 and exhibit D3 have seen the light of the day in pursuance of the will in question. The defendant number 1 also fails to produce the original will. On the other hand, claims that the original will was with her mother and thereby taking inconsistent stand. Though PW2 Nagaratna admitted getting the amount from the bank, there is nothing to show that the amount was got released by PW2 on the basis of the will. Original plaintiff as well as PW2 have withstood the rigor of cross-examination. In other words, the defendant number 1 has failed to substantiate that the transposed plaintiff number 2 to 4 and the original plaintiff had the knowledge about the will, and all of them have acted upon the said will after the death of the testator. And the same has been discussed in paragraph number 27 and comes to the conclusion that the contention of the appellant cannot be accepted and accepted. Main contention of the counsel appearing to the appellant in this second appeal, that both the courts have committed an error in not considering the secondary evidence, that is the certified copy of the will produced to sub-registrar by way of summoning the document, which has the characteristics of a public document under section 17 of the Indian Evidence Act. And also counsel vehemently contend that both the courts erred in not giving much credence to the evidence of the scribe, who clearly deposed that will was signed by the executor and the witnesses in his place. And also counsel would vehemently contend that both the courts below erred in ignoring the fact that beneficiaries under the will have received the benefits conferred upon them under the will, which includes receipt of the amount kept in fixed deposit and getting the kata executed in relation to the property in their favor. And both courts failed to consider the material on record in a proper perspective. Per contra, the counsel appearing to the respondent would vehemently contend that when the defendant contended that there was a will, ought to have produced the will before the trial court, and the same is not produced and the will is also not marked. The counsel also would vehemently contend that though it is contended during the course of argument that will is in the custody of the mother, but not summoned the same from the mother by causing any notice. And apart from that, in the written statement as well as in the oral evidence, no such pleading is taken. And when the will is propounded, ought to have proved the same by summoning. Even if it is not within the custody of the defendant, ought to have given notice to the person who is having the custody, and the same is also not done. And hence, the very contention of the appellant cannot be accepted. Having heard the appellant counsel and also the counsel appearing to the respondent, and there is no dispute with regard to the relationship between the parties. It is also not in dispute that the plaintiff herself categorically pleaded in the plaint that social property belongs to the Chandrasekhara Bhatta. It is also not in dispute that Chandrasekhara Bhatta died, leaving behind the wife and 4 children. The plaintiff is the mother, plaintiff is the wife of Chandrasekhara Bhatta, and defendant number 1 to 4 are the daughters of the said Chandrasekhara Bhatta. No doubt the plaintiff, while filing the suit, arrayed all the daughters as defendant, but defendant number 1 only contested the case by filing the written statement and propounded the will. It has to be noted that will is not marked before the trial court, and also it is contended that will is in the custody of the mother, but no such pleading in the written statement or in the chief evidence, or even any suggestion was made to the PW1 of the court that the will is in custody of the plaintiff. And when such being the case,
Para 12 minutes. Para 12
ಏನು
ಅಲ್ಲ ಅದರಲ್ಲಿ ಲಾಸ್ಟ್ ಸೆಂಟೆನ್ಸ್ ಅಲ್ಲಿ
Para 12 of trial court.
Para 12 minutes at page number 29.
Trial court, first appellate court.
Minutes in the OS minutes.
OS.
Para 12. She has unsuccessfully made efforts to get marked the certified copy of the will before the court without there being any complaints to the rules relating to production of secondary evidence. And this court by the order dated 14/12/2018.
ಅಂದ್ರೆ ನೀವು ಸೆಕೆಂಡರಿ ಎವಿಡೆನ್ಸ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ನೀವ್ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ?
ಅಲ್ಲ
ಅದನ್ನೇ ಅವ್ರು ಹೇಳಿದ್ದು. ಕಸ್ಟಡಿಲಿ ಇಲ್ಲ ಅಂತಂದ್ರೆ ನೀವು ನೋಟಿಸ್ ಕೊಡ್ಬೇಕು, ಸಮನ್ ಮಾಡ್ಬೇಕು, ಅದ್ ಯಾವ್ದು ಮಾಡಿಲ್ಲ ಸೆಕೆಂಡರಿ ಎವಿಡೆನ್ಸ್ ಲೀಡ್ ಮಾಡಕ್ಕೆ.
I have placed on record, my lords, along with the appeal now, lords, these certified copy of the will also.
Sentence. Plaintiff, and nothing is made any effort to even for production and marking of secondary evidence and not complied with the procedure for getting marked the secondary evidence, and unless the same is not proved and effort is made to mark the certified copy and the same is not marked, and when all these efforts were not made by the defendant and hence the same and hence the contention of the defendant is not accepted. Even for examination of 2 witnesses as DW 2.3, and in the absence of will, their evidence cannot be looked into. Even trial court also in detail discussed in paragraph number 16, even extracted the cross examination of PW1. The suggestion was made and specifically admitted PW1 that she took the amount of rupees 50,000, but not on the basis of the will, she categorically stated. And when such denial is made, and also nothing is elicited from the mouth of PW1 regarding the very execution of the will, when there is no unequivocal admission on the part of PW1 with regard to the will is concerned and the same is not proved. And I do not find any error on the part of the trial court as well as the first appellate court in considering both oral and documentary evidence as well as the reappreciation made by the appellate court. And appellate court also considering the issue number 1 and 2 with regard to the admission of the parties that the suitable property was the self-acquired property. No error can be found with the said order of the trial court and the same is observed in paragraph number 26. Apart from that, with regard to the will is concerned, also detailed discussion is made in paragraph number 27. And also taken note of that PW2 Nagaratna admitted getting the amount from the bank. There is nothing to show that the said amount was got released by PW2 on the basis of the will. And even for taking of that amount also, even if the plaintiff taken the money based on the will, ought to have made effort by the defendant to summoning of those documents, and the same is also not placed before the court. When there is no material with regard to the will is concerned, I do not find any error on the part of the trial court and first appellate court in appreciating both oral and documentary evidence, and hence I do not find any ground to invoke section 100 of CPC. In view of the discussions made above, I pass the following order. Second appeal is dismissed.
There is also an application for production of document that may also be considered, my lords.
A number 3
ಅಲ್ಲ, ಅದರಲ್ಲಿ will ಅನ್ನ certified copy ಇದನ್ನು produce ಮಾಡಿದೆ and other documents by which, my lords, there is a reference to it that it is based on the
ಅದು ನೀವು ಆಲ್ರೆಡಿ ಹಾಕಿದಿರಲ್ಲ ಅಲ್ಲೇ
ನಾವು ಹಾಕಿದೀವಿ ಅದಕ್ಕೆ
Now they are
ಹಾಕಿದಿರಿ. Both the courts have not allowed you to
ಅಲ್ಲಲ್ಲ ಅಲ್ಲಿ ತಗೊಳ್ಳಿಲ್ಲ. They did not, my lords, allow me to ಹಾಕಿ
ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಮಾರ್ಕ್ ಮಾಡಕ್ಕಲ್ಲ ಅಲೋನೆ ಮಾಡಿಲ್ಲ ನೀವು.
ಮಾಡ್ಲಿಲ್ಲ.
ಮತ್ತೆ ಇಲ್ಲ ಹೆಂಗ್ ಮಾಡೋದು ನಾವೀಗ ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಅಲ್ಲಿ? ನೀವು ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಅದನ್ನ ಅಟ್ಲೀಸ್ಟ್ ಚಾಲೆಂಜ್ ಮಾಡ್ಬೇಕಿತ್ತು, ಅದು ಮಾಡಿಲ್ಲ. When the document of certified copy was not admitted before the trial court, ought to have challenged the same. In second appeal ಅಲ್ಲಿ ನಾವೇನ್ ಮಾಡೋದು? Thoroughly.
At that point in time, lords, they did not.
Disposal of the second appeal, question of considering the pending IS doesn't arise.
ಡಿಲೇ ಒಂದು ಕಂಡೋನ್ ಆಗ್ಬೇಕು.
Delay ಇದೆಯಾ?
Delay.
Hold on, A number 1 of 25 and there is a delay of 153 days in filing the second appeal, and for the reasons stated in the application and affidavit, delay is condoned. Order sheet al madam.
54. Seal number 54, Shankarachar.
For the appellant, my lord, kindly pass with the matter, my lord. And up in some other court.
Madam, 434, no pass over.
On tomorrow, my lord. Have it on tomorrow.
Ena?
Tomorrow, my lord.
No such tomorrow. ಇವತ್ತು ರೀಚ್ ಆಗಿದೆ ಹೇಳಿ.
I'll up in some other court.
I will adjourn the cast on cast ಇಲ್ಲ ಅಂದ್ರೆ. Item number 1 only 25 kuntas only. Item number 2 to 8 ಕೊಟ್ಟಿದ್ದಾರೆ. Item number 1 only 25 kuntas ಮಾತ್ರ ಕೊಟ್ಟಿದ್ದಾರೆ. Modified 1/3. Sealed it is binding. ಹೇಳಿ. Appellant counsel ಪ್ರಾಕ್ಸಿನ ನೀವು? Proxy counsel seeks time at 4:35 and urgent on cost of rupees 5,000 payable at registry. List this matter immediately after winter vacation.
P5, Prasanna VR.
Hand over the possession.
Defendants, second appeal, my
Be
lords.
scheduled property.
Concurrent finding. Not the plaintiffs filed a suit for possession based on the alleged title, claiming that the defendant was permitted to occupy the premises in B schedule. And as the defendant has not surrendered, a legal notice was issued.
Terminated the tenancy.
Yes. It is not a tenancy, it is a permission license. Yes. The defendant filed a return statement contending that her father was in possession prior to the death of the father of the plaintiffs, Ali Abba, in the sense 1976. And subsequent to the death of the defendant plaintiff's father, the one of the plaintiffs, plaintiff number 9, executed an agreement of sale in favor of the defendant on 12/9/1992 and continued her possession as a part performance under section 53A of TPI. And that suit is barred by law of limitation. The trial court framed issues and 2 witnesses were examined on behalf of the plaintiff. The PW2 is the person who executed an agreement of sale, exhibit D34. Of course, he denied the execution of agreement of sale. And on the other hand, I have produced a document to show that I have been in possession since years together. And based on an agreement of sale, I got transferred the kata, got the power connection, and continue to be in possession since several years, perfecting my title. The trial court, by the judgment impugned, decreed the suit, observing that I did not raise the plea of adverse possession, and license is validly terminated, withdrawn by issuing a notice. That was called in question before the first appellate court. First appellate concurred with the finding of the trial court. Kindly see para number 14 of the trial court judgment, page number 52, my lords.
Admission is extracted.
In the cross examination of para number, DW1 admits that ನನ್ನ ತಂದೆಗೆ ಅಲಿಯಬ್ಬರ್ ಅವರು ವ್ಯಾಜ್ಯದ ಮನೆಗೆ ಬಂದು ವಾಸವಾಗಿರು ಅಂತ ಹೇಳಿದ್ರು ಅಂದ್ರೆ ಸರಿ. ಎಷ್ಟನೇ ಇಸವಿಯಿಂದ ಆ ರೀತಿ ಅನುಮತಿ ಕೊಟ್ಟಿದ್ದರು ಎಂದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಆಗ ನಾವು ಅಲಿಯಬ್ಬರ್ ಅವರಿಗೆ ಯಾವುದೇ ಬಾಡಿಗೆ ಕೊಡ್ತಿರಲಿಲ್ಲ. ಆಗ ದಾವಾ ಮನೆ ಹಂಚಿನ ಚಾವಣಿ ಮನೆ ಆಗಿತ್ತು ಎಂದರೆ ಸರಿ. ದಾವಾ ಮನೆ ಮೊದಲು ಯಾವ ರೀತಿ ಇತ್ತೋ ಈಗಲೂ ಅದೇ ರೀತಿ ಇದೆ ಎಂದರೆ ಸಾಕ್ಷಿ ರಿಪೇರಿ ಮಾಡಿರುತ್ತೇವೆ. In the sense, after several years, I continue to be in possession, perfecting my title, ignoring the agreement. The trial court holds that the agreement of sale is not proved, and there is no signature of plaintiff number 9 in the first page of the agreement. If we ignore the agreement of sale, exhibit D34, I have perfected my title because my possession is relates back the death of the father of the plaintiff. Therefore, this fact is admitted. I myself admitted I was in possession since several years. They have not taken any steps, either withdrawing the permission or.
Have you taken any steps based on the agreement?
No.
Then
that is not taken. But agreement is held not proved.
Your pleading is that there is an agreement of sale.
Of course, it is disbelieved. I could not be able to prove the agreement.
Made the part payment also.
Yes.
What effort you made
out of 40
to enforce that agreement?
Yes. Yes. Of course, I could not able to establish the agreement, but I can establish. I have proved that my possession is continuous, uninterrupted, with the knowledge of the plaintiffs since several years, more than 12 years. It is sufficient to hold that I have perfected my title, though there is no claim, counterclaim or suit.
Counterclaim, no pleading at all. Perfection of the title by adverse
Even
possession.
a limitation.
Adverse possession also.
Even in the absence of pleading, the court can take cognizance about the maintainability of the suit.
Even though there is no pleading.
ಅಲ್ಲ, ಅದು ಲಿಮಿಟೇಷನ್ ಇಶ್ಯೂ, ಅದಕ್ಕೆ pleading ಇಲ್ದಿದ್ರು ಕೂಡ it is whether the suit itself is maintainable or not. The of course trial court has held against me.
ಏನಿಲ್ಲ, ಖಾಲಿ ಮಾಡ್ಕೊಡೋದಷ್ಟೇ. You enjoyed.
1976 ಅಲ್ಲಿ ಅವರು ತೀರೋಗ್ತಾರೆ. ಅದಕ್ಕಿಂತ ಮೊದಲೇ ನಮ್ಮವರಿಗೆ
for a longer period. Told. This matter is listed for admission. I heard the counsel appearing to the appellant. This second appeal is filed against the concurrent finding. The factual matrix of case of plaintiff before the trial court in OS number 82 of 2015, seeking the relief of possession, specifically pleaded before the trial court that plaintiffs are the owners of the plaint A and B scheduled property, and further contended that he has terminated the permission of the defendant by issuing a notice dated 18/7/2014, and defendant contend that plaintiff number 9 executed an agreement for sale dated 12/8/1992 on behalf of all the heirs of his father, agreeing to convey the said 11 cents and plaint B scheduled house for a consideration of rupees 40,000, and out of the said consideration received rupees 23,000 in cash. And having considered this pleading, the trial court has framed the issues, and even additional issue also framed with regard to the value of the property as well as the termination of legal notice, and allowed the parties to lead evidence and plaintiff examined. Plaintiff number 1 is examined as PW1 and got exhibited 5 documents as exhibit P1 to 5. And also Plaintiff number 9 examined as PW2 and closed their side. On the contrary, defendant herself examined as DW1 and got marked 34 documents exhibit D1 to 34. The trial court, having considered both oral and documentary evidence available on record, particularly the contention which was taken by the plaintiff and defendant, admittedly there is no dispute with regard to the title of the suit scheduled property, that is A and B scheduled property, and only defense taken by the appellant defendant that there was an agreement of sale and his possession is continuous and uninterrupted, and not pleaded any plea of adverse possession, but main contention is that there was an agreement and the same was executed by plaintiff number 9. The trial court also even taken no admission of the DW1 in paragraph number 14, which is extracted, and also the conclusion that the suggestion was made that he permitted him to reside in the plain scheduled property, and further stated that Ali Abba and his wife told them that they will sell the plain scheduled property but do not know in which year they have stated so. And also the trial court discussed with regard to the document of the sale agreement, that is dated 12/8/1992, and he mainly relies upon the document as exhibit D34, but he has failed to identify the signature therein by the plaintiff number 9, and even plaintiff number 9 also examined as PW2, and nothing is elicited with regard to this sale agreement executed, and hence comes to the conclusion that sale agreement is not proved, and also receipt of the earnest money and the same is also not proved, and hence comes to the conclusion that when the notice was issued and permission is withdrawn, and particularly taken note of the material available on record considering issue number 4 and 5 in paragraph number 20, the admission on the part of the DW1, and the said admission clearly goes to show that plaintiff schedule house has all the basic amenities. The said admission given to DW1 clearly shows that plaintiff B scheduled property will fetch a rent more than rupees 1,000, and plaintiff is claiming 1,000 per month as mean profit. However, nothing to believe that as on the date of suit also the plaintiff B scheduled property fetched the rent of rupees 1,000. However, taken note of the granting of mean profits of 500 and allowed the suit directed the plaintiff defendant to vacate the vacant possession of the plaintiff B scheduled properties to the plaintiff within a month, and also ordered to pay the mean profits of rupees 3,000 for the period of 4/8/2014 to 31/10/2014, and further directed to pay an amount of rupees 500 as mean profits. Being agreed by the same, an appeal is filed before the appellate court in RA number 35 of 23, and the appellate court, having considered the grounds urged in the appeal memo, formulated the point for consideration whether the appellant made out the grounds to interfere with judgment and decree of the trial court. On appreciation of both oral and documentary evidence, first appellate court also taken note of the admission on the part of DW1, and also with regard to the agreement is concerned, and no steps was taken even enforce the agreement, and the same is discussed in paragraph number 25, and also in paragraph number 26 considered the material on record. It goes to show that plaintiff A scheduled property was originally purchased by the father of the plaintiff by name Ali Abba as per sale deed dated 11/6/1992, and also he died intestate, and having considered all this material comes to the conclusion with regard to the ownership is concerned, even discussed with regard to section 53A of per part performance, and detailed discussion was made regarding oral and documentary evidence, and confirmed the judgment of the trial court, and nothing is placed on record even for having paid the amount of earnest money of rupees 23,000 as against 40,000, and hence confirmed the judgment of trial court that there was no such any agreement. Being agreed by the said judgment and decree, present second appeal is filed before this court. The main contention of the appellant counsel that both the courts have committed an error in granting the relief as sought by the plaintiff, and fails to take note of the fact that the defendants established the factum of uninterrupted peaceful possession of the plaintiff be scheduled property for more than 12 years, which impliedly shows the defense of adverse possession. And also counsel would vehemently contend that the plaintiff remains silent from the date of death of their father on 28/11/76 till 18/7/2014 when the suit is filed, and also before that legal notice was issued. But the trial court and appellate court also not considered the material on record with regard to the sale agreement dated 12/8/1982. And hence this court has to admit and frame substantive question of law. Having considered the arguments made by the appellant counsel and also the pleadings of the parties, is very specifically made in the plaint that they are the owners of plaint A and B scheduled properties, and also no dispute with regard to the ownership is concerned, and only contention of the appellant defendant is that there was an agreement of sale, and in order to substantiate the same, nothing is placed on record except producing of the document, and even for payment of the earnest money also nothing is placed on record. And even it is the claim of the defendant that the said sale agreement was executed by PW9, and PW9 is also examined as PW2 before the court, and even both court taken note of even signature of the PW9 also not identified and marked, stating that there was a sale transaction. And in order to prove the factum of sale agreement, nothing is placed on record except delaying upon document exhibit D34, and hence both courts rightly comes to the conclusion that sale agreement is not proved. The other contention is that he has perfected the title by adverse possession, but to that effect also there is no any pleading and also the evidence. And when it is pleaded that he is in possession of the property based on the sale agreement, he cannot contend that he is perfected the right by way of adverse possession. The other contention is that both the courts have committed an error in passing an order, and possession even not disputed from 1976 after the death of the father, and mere continuation of possession by the plaintiff cannot be a ground to confer any right in favor of the appellant. And when such being the case, when the legal notice was issued before filing the suit and withdrew the permission which was given to him, and he did not vacate the same, and hence approached the court, and when all the defenses were met by the trial court and appellate court, I do not find any ground to admit frame any substantive question of law, and both question of fact and question of law are considered by the trial court and appellate court, and hence not a case to invoke section 100 of CPC. In view of the discussion made up, I pass the following order. The second appeal is
56. Girishwar Adara.
The defendant second appeal, my lord.
Record bandidiya, dismissed to reverse to owner.
It's a divergent findings recorded by both the courts below. The suit filed by the plaintiff for seeking the relief of declaration injunction based on the sale deed executed by this vendor.
Now, what is the reason given by the trial court in coming to the conclusion owner and
Para number 21, my lord.
first appellate court?
First appellate court. Para 23, my lord.
23.
Para number 19.
In order to prove the case, got examined himself as PW1 and PW7, and documents.
Original documents are not produced. Based on the grant certificate, he has claimed the ownership over the property. And the schedule is different in the exhibit P1 and as well as the schedule mentioned in the plaint. Earlier, they have filed the suit for seeking permanent injunction. Said suit came to be dismissed. Subsequently, appeal has also filed. Appeal also dismissed. And vendor of the plaintiff is also filed a suit for seeking permanent injunction. Said suit is also dismissed. Thereafter, the present suit came to be filed for seeking relief of permanent injunction as well as a declaration. The trial first appellate court only come to the conclusion that based on the identification of boundary is not required to come to the conclusion for granting the declaratory relief. Based on said observation, suit came to be decreed.
Earlier suit only for bare injunction. Now they have filed the suit for declaration. How it attracts section 11?
It is earlier for the very same property they have filed the suit
Maybe
for
same
injunction.
property, but relief is different.
Relief is different, my lordship, but the schedule is.
I ordered the appellant counsel and also the counsel appearing to the respondent, and there is a divergent finding, and that the first instance trial court dismissed the suit. First appellate court reversed the same and granted the relief that the respondent is a owner, and permanent injunction also granted. and hence matter requires reconsideration. Admit the following substantive question of law arises for the consideration of the second appeal. Whether the first appellate court committed an error in granting the relief of declaration and permanent injunction in considering the documents of exhibit P1 to 7 based on the grant made in favor of the father of the respondent, Allah?
Yes, my lord.
In respect of survey number 174,
Yes, my lord. 174, there later it is renumbered as 339.
Respondent has purchased the suit schedule property in the year 2000.
grant of sale
Grant, earlier
Purchase,
grant and
earlier grant.
grant, thereafter it has been.
Respondent purchased from the grantee.
from the grantee.
From the grant.
ಹಂಗೆ ಹೇಳಿ ಅಲ್ಲಿ ಅಲ್ಲಾಗಾರ ನೋಡಿ ಏನಾಯ್ತು ಮೇಡಮ್ ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಗ್ರಾಂಟ್ ಅಂತ ಹೇಳಿದ್ನಲ್ಲ ಅವ್ರು ಗ್ರಾಂಟ್ ಅಂತಂದ್ರು ಅದಕ್ಕೆ ಗ್ರಾಂಟ್ ಅಲ್ಲ ಗ್ರಾಂಟ್ ಮೇಡ್ ಇನ್ ಫೇವರ್ ಆಫ್ ದಿ ವೆಂಡರ್ ಆಫ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ based on document exhibit P1 to 7 ಅಲ್ಲ P1 to 7 in respect of survey number 170
Old survey number 174, new survey
ಒಂದಲ್ರಿ ಸರ್ವೆ ನಂಬರ್ಸ್ ಏನ್ ಹಾಕೋದ್ ಬೇಡ
339.
ಒಂದೇ ಸರ್ವೆ ನಂಬರ್ ರೀ 339 ಸರ್ವೆ ನಂಬರ್ 339 earlier it was
174
and whether such finding given by the first appellate court amounts to perversity. That's
stay my lord, they have on the basis of the first appellate court or
ಏನ್ ಮಾಡಿದಾರೆ ಅವರು
position ಗೆ they have to interfere with my
ಪೊಸಿಷನ್ ಹೆಂಗ್ರಿ ಮಾಡ್ತಾರೆ
ಅಲ್ಲ ಅವ್ರು ನಮಗೂ ಬರಬೇಕು ನಮ್ದು ನಮ್ ಕೊಡಿ ಅಂತ ಮೈ ಪ್ರಾಪರ್ಟಿ ಇಸ್
ಮಿಟ್ ಆಯ್ತಲ್ಲ ಈಗ ಏನಾಯ್ತು ಇನ್ನೇನು ಏನ್ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿದಿರ ನೀವು
ಇಲ್ಲ ಸ್ವಾಮಿ ಹೆಂಗ್ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಇಲ್ಲ ಏನು
ಅಲ್ಲ
ಮಾಡಿದಾರ ಅಷ್ಟೇ
ಇದ್ರಲ್ಲಿ ಏನು
strength of this order trying to interfere with my property, my lord.
There is no pleadings at all.
Records are received and now need of filing of paper book. List the matter for in the 4th week of January for final hearing.
Please.
Maintain status quo. Otherwise they have to.
Delay there, heard on I number 1 of 25, there is a delay of 10 days and delay is condoned.
ಅವ್ರು ನಮ್ಮ ಪ್ರಾಪರ್ಟಿಗೆ ಬರ್ತಾ ಇದಾರೆ ಸಮಯ ಡಿಕ್ಲರೇಷನ್ on the basis of the declaration.
No pleadings at all. ಪ್ಲೀಡಿಂಗ್ಸ್ ಎಲ್ಲ ಇಲ್ಲ ಎಲ್ಲೋ ನನ್ನ ಪ್ರಾಪರ್ಟಿ ಎನ್ಕ್ರೋಚ್ ಮಾಡ್ತಾರೆ ನನ್ನ
ಸರ್ವೆ ನಂಬರ್ ಇರೋದೇ 339 ನಿಮ್ಮ ಪ್ರಾಪರ್ಟಿಗೆ ಹೆಂಗ್ ಬರ್ತಾರೆ
ಅಲ್ಲ ನಮ್ದ್ರಲ್ಲಿ 1 ಎಕರೆ ಬಂದಿದೆ ಅಂತ ಅವ್ರ 8 ಎಕರ್ಸ್ ಇದೆ ಅಲ್ಲ ಅದರಲ್ಲಿ they are trying to claim.
ಏನಾಗುತ್ತೆ ಸ್ಟೇಟಸ್ ಕೋ ಕೊಟ್ರೆ ಮತ್ತೆ ಅಲ್ಲಿ ಕಿತ್ತಾಡ್ತಾರೆ ಅದಕ್ಕೆ ಬೇಡ
ಸ್ಟೇ ಕೊಟ್ಬಿಡಿ
ಸ್ಟೇಟಸ್ ಕೋ ನೋ ಮೀನಿಂಗ್
ಸ್ಟೇ ಗ್ರಾಂಟೆಡ್ ವಿತ್ ರೆಸ್ಪೆಕ್ಟ್ ಟು ದಿ ಫಸ್ಟ್ ಅಪೀಲ್ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅಂಡ್ ಡಿಕ್ರಿ ಮೇಲೆ
ನೋಡ್ರಿ ನಿಮ್ ಸೂಟ್ ಫಸ್ಟ್ ಇಟ್ ವಾಸ್ ಡಿಸ್ಮಿಸ್ಡ್ ಫಸ್ಟ್ ಅಪೀಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ರಿವರ್ಸ್ ಮಾಡಿದ್ದಾರೆ ಈಗ ಇಬ್ರು ಕಡೆಗೂ ಇದೆ ಅವ್ರ ಕಡೆಗೂ ಇದೆ ಇವ್ರ ಕಡೆಗೂ ಇದೆ ಹೌದಾ
57
ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಜನವರಿ ಲಾಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಏನಾಯ್ತು
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ they have not signed submission, they are not at all settled the matter. Execution petition pending before the trial court, let them settle the issue before the trial court itself.
As per the commissioner's court report,
partition
partition commissioner's court commissioner has appointed and report has been filed. According to his valuation slip is around 16 lakh citizen. As per the 16, I am ready to pay the 50%.
For the square feet malad, let them settle the issue.
Are entitled for half share each in the suit shell property.
Half share I am ready.
You know
50% I am ready.
Yen 50% ಅಂದ್ರೆ
half share the value of the amount is repaid the ready amount.
ಅಂದ್ರೆ ನೀವು suit for
value of the property is suit schedule property is 42 into 120. 5040 square feet ಆಗುತ್ತೆ
5040 square feet. ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ಗೈಡ್ಲೈನ್ಸ್ ವ್ಯಾಲ್ಯೂ ಏನೋ ತರ್ಸ್ಕೊಂಡಲ್ಲ ಏನಾಯ್ತು
ಇಲ್ಲ ಗೈಡ್ಲೈನ್ಸ್ ತರಿಸಿಲ್ಲ ಸಮ್ ಓನ್ಲಿ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡಿ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡಿದ್ರು ಆ ಬೇಸಿಸ್ ಮೇಲೆ ಸ್ಕ್ವೇರ್ ಫೀಟ್ ಇಸ್ ಅರೌಂಡ್ 300 rupees is commissioner's report also be find around it comes to the 16 lakhs. I am ready to pay 8 lakhs 7.5 lakh.
ಅದೇ ದುಡ್ಡು ನಾವೇ ಕೊಟ್ಬಿಡ್ತೀವಿ ಅದೇ ದುಡ್ಡು ನಾವೇ ಕೊಟ್ಬಿಡ್ತೀವಿ ಅಷ್ಟೇ ದುಡ್ಡು ನಾವೇ every stage may not they made this type of settlement. This is from the beginning. It's a brother, not any other person.
So ibru brothers
it's a very clear. Earlier my lord written statement they are saying that plot is my own property. Now my lord they filed an application saying that plot is he has stated that plot we purchased the property. Altogether different. Simply dragging the issue. And now my lord they have said that they have settled the issue. Before the trial court, per square feet 3,800 rupees he is ready to pay.
3,000?
800 rupees, he is ready to pay.
ಹಾ.
Now, my lord, he said
ಮುನ್ನೂರು
that
ರೂಪಾಯಿ.
16,000.
ಹಾ.
I am ready to purchase the entire property.
ಹಾ.
And then
Market value ಇರೋದೇ ಅಷ್ಟು.
ಆಯ್ತು ನಿಮ್ಗೆ ಜಾಸ್ತಿ ಸಿಗುತ್ತಲ್ಲ, ಜಾಸ್ತಿ ಕೊಡ್ತಾರಂತವ್ರು.
Where I constructed the house,
ಇದೆಯಲ್ಲ.
house has been constructed.
ಹಾ?
House has been constructed.
ಯಾವ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡಿದ್ ನೀವು?
19 ಅಲ್ಲಿ.
19.
Court commission itself has filed a report.
2019.
ಹಾ. Court commission itself has filed a report stating that the property worth is.
ಆಯ್ತು ನೀವು ಬಿಲ್ಡಿಂಗ್ ಕಟ್ಟಿದೀನಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ನಾನು 300 ರೂಪಾಯಿ ಕೊಡ್ತೀನಿ ಅಂದ್ರೆ ಹೆಂಗ್ರಿ ಯಾವ ಒಪ್ಕೋತಾರೆ? ಅಟ್ಲೀಸ್ಟ್
Commissioner's report itself is there.
ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್ ಇದೆ, ಆಕ್ಚುಯಲ್ ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ ಏನಿದೆ ಅದನ್ನ ಆಫರ್ ಮಾಡಿ.
Market value it's 300 rupees is square feet is there.
ಅಲ್ಲ ಅವ್ರು ಜಾಸ್ತಿ ಕೊಡ್ತಾರಂತ, 500 ಕೊಡ್ತಾರಂತ, ನೀವು ತಗೋತೀರಾ? ಮತ್ತೆ there must be some reasonable ಇದು
petition trial court ಅಲ್ಲಿ ಇದೆ.
ಹಾ.
Same ಅಲ್ಲಿ ಸೆಟಲ್ ಮಾಡ್ಕೊಳ್ಳೋರು ಮಾಡ್ಕೊಂಡ್ಲಿ.
ಹಾ. ಎಕ್ಸಿಕ್ಯೂಷನ್ ಆಲ್ರೆಡಿ ಹಾಕಿದ್ರಂತಲ್ಲ, ಸೆಟಲ್ಮೆಂಟ್ ಅಲ್ಲೇ ಮಾಡ್ಕೊಳ್ಳಿ.
Here itself I'll report in.
3,800 rupees ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿ ಅಶ್ಯೂರೆನ್ಸ್ ಕೊಟ್ಟು ಇಲ್ಲಿ ಬಂದಿದ್ದಾರೆ.
ಹಾ.
After stay order, my lord, they are not before the trial court. That's why, my lord, he is.
ಹೇಳಿ ಬೇಗ, ಇಲ್ಲ ಅಂದ್ರೆ ಡಿಸ್ಪೋಸಲ್.
Another I'll pay 1.5 lakh. Another 1.5 lakh I'll pay.
ಅವ್ರು ಅದನ್ನೇ ಕೊಡ್ತಾರಂತ, ಅವರೇ ಕೊಡ್ತಾರಂತ, ಏನ್ ಮಾಡ್ತೀರಿ? ತಗೊಳ್ತೀರಾ? ತಗೊಳ್ಳಿ, ಕೇಸಲ್ಲಿ ಏನಿಲ್ಲ. ಪ್ಯಾರಾ 11 and 12 of the trial court order ನೋಡಿ. Father property was allotted to the father of the plaintiff and defendant. Even transferring the property also consent was given. Consent ಮೇಲೆ ಅವನು ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿಸ್ಕೊಂಡಿದ್ದಾನೆ. Exhibit D1 dated 5/8/91. It is seen that plaintiff and his brothers consented for change of khata in the name of the defendant pertaining to site number so and so resolution. These are the reasons 11 and 12. He cannot knock off the property of the brothers also.
Where the application, I had filed an application for order 41 rule 27 before the first appellate court.
ಆಯ್ತು, ಏನ್ ಮಾಡ್ಬೇಕು? ಅದು ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದೆ that will not wield the result of the appeal ಅಂತ. 41 rule 27 ಯಾವಾಗ ಬರ್ತದೆ ಅಂದ್ರೆ, if any germane issues involved between the parties, then only court can consider 41 rule 27. As a routine cannot be considered.
As per the court commission's report.
Comply order 41 rule 27 AAA. ಹೌದಾ? ಹಾ, ಮತ್ತೆ
where the commission's report has been filed before the FDP proceedings. For that report itself I am agreeing for the settlement.
ಅಲ್ಲಿ ನೋಡ್ಕೊಳ್ಳಿ, ನಿಮ್ಮ ಎಕ್ಸಿಕ್ಯೂಷನ್ ನೋಡ್ಕೊಳ್ಳಿ, ಆಯ್ತಾ?
3,800 rupees more than the Bangalore city rates is there Shivamogga.
ಶಿವಮೊಗ್ಗ ಸಿಟಿನ ಇದು?
ಸ್ಕ್ವೇರ್ ಫೀಟ್ ಇರೋದು.
ನೆನೆ ನಮ್ಮ ಮನೇನ ಪೇಪರ್ ನಾನು ನೋಡಿದೆ. ಶಿವಮೊಗ್ಗ ಸಿಟಿ ಎಂಟೈರ್ ಇಂಡಿಯಾದಲ್ಲಿ 6ನೇ ಸಿಟಿ ಹ್ಯಾವಿಂಗ್ ಗುಡ್ ಇದು ಏನು ಎನ್ವೈರನ್ಮೆಂಟ್. ಈ 3 ದಿವಸದಿಂದ ಐ ರೆಡ್ ದಿ ಪೇಪರ್. ಅರ್ಲಿಯರ್ ಚನ್ನರಾಯಪಟ್ಟಣ ಇತ್ತು, ಈ ಸರಿ ಶಿವಮೊಗ್ಗ ಸಿಟಿ ಇಸ್ ದ 6th place in entire India having good environment.
The matter may be referred to.
ಜಾಸ್ತಿ ಕೊಟ್ರೆ ಅಟ್ಲೀಸ್ಟ್, ಇಲ್ಲ ಅಂದ್ರೆ ಅವರೇ ಕೊಡ್ತಾರ, ನೀವೇ ಕೊಡಿ ಅರ್ಧನ ಅಷ್ಟೇ ಅವರಿಗೆ.
3,800 rupees is high rate.
ಆಯ್ತು,
ಅವರು ಮಾರ್ಕೆಟ್ ರೇಟ್ ಇನ್ನೂ ಜಾಸ್ತಿ ಇದೆ. ಬ್ರದರ್ಸ್ ಅಂತ ಎಸ್ ಅಂತ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ. ಅವ್ರು ಹೇಳ್ತಿದ್ರು 3,800. ಐ ಆಮ್ ಲೋಕಲ್ ಎಕ್ಸ್ಪರ್ಟ್, ಐ ನೋ ವೆರಿ ವೆಲ್.
ಆಯ್ತು, ಈಗ ಅವ್ರು ಒಪ್ಕೊಂಡಿದ್ರಲ್ಲ.
ಅವ್ರು ಒಪ್ಕೊಂಡಿದ್ರು.
ಅಲ್ಲ ಸರಿ, ಈಗ ನೀವು 3,800 ಕೊಡ್ತೀರಾ, ತಗೋತೀರಾ?
3,800 ಕೊಟ್ಟು ತಗೊಂಡು ಅವ್ರು ಅಷ್ಟೊಂದು
ಬಿಟ್ಕೊಟ್ಟು ತಗೋತೀರಾ? ಮತ್ತೆ 3,800 ಅಲ್ಲಿ ಕೊಡ್ತಾರಂತಲ್ಲ.
The building value has to be.
Beginning malad is making the same submission malad since from the beginning ಇದೆ.
300 ಆಯ್ತು, ಅವ್ರು 3,800 ಕೊಡಕ್ಕೂ ರೆಡಿ ಇದ್ದಾರೆ ನಿಮ್ ಕ್ಲೈಂಟ್. ಇಟ್ ಶೋಸ್ ಹೌ ಈಸ್
left to the court, left the court may be decided.
ಅಷ್ಟೇ, ನಾನು ಮಾಡ್ತೀನಿ ಈಗ ಅಷ್ಟೇ. ತಗೊಳ್ಳಿ. The appellant
only one when the matter may be referred to the possibility of settlement, anything.
Settlement ಆಗಲ್ಲ, ನಾನೇ ಸುಮಾರು ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೀನಿ ನಿಮ್ಗೆ. ನೀವು ಕೇಳಿದ್ಮೇಲೆನೆ ನಾನು ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೀನಿ. ಮೋಸ್ಟ್ಲಿ ಇದು 3rd time or 4th time ಸೆಟಲ್ಮೆಂಟ್ ಗೆ.
Is it second time?
Second ಎಲ್ಲ ಆರ್ಡರ್ ಶೀಟ್ ನೋಡಿ.
Regarding settlement is the second time. I had made my efforts, man.
From the beginning they insisting that IA. That IA is altogether different. The WS is concerned a lot is one property. And take that a lot, we purchase the property from the defendant. Only
the matter may be referred to here itself, the mediation any next week, any date may be.
5/11 ರಲ್ಲಿ ನೀವೇ ಕೇಳಿದ್ರಿ.
Let them.
There is an element of settlement and seeks time to report the same. Accordingly, time is granted as sought.
Let them.
And once again on 2011,
Trial court execution petition is there.
this is third time, 8/12. Last time ನೀವು ಹೇಳಿದ್ರಿ no settlement ಅಂತ. ಅದಕ್ಕೆ ಇವತ್ತಿಗೆ argument ನಾನು ಓದ್ಕೊ
Last time it's a well calculation has been, what is the market value to assess it has been today.
ಆಯ್ತಲ್ಲ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪೆಂಡಿಂಗ್ ಇದೆಯಲ್ಲ ಅಲ್ಲೇ ಕೊಡಿ ರೇಟ್ ಏನಾದ್ರು ಮಾತಾಡ್ಕೊಳ್ಳಿ ಇಬ್ರು ಅವ್ರು 3800 ಕೊಡ್ತಾರೆ ನೀವು 300 ಅಂತಿದ್ದೀರಿ ಅಲ್ಲೇ ಡಿಸೈಡ್ ಮಾಡ್ಕೊಳ್ಳಿ ತಗೊಳ್ಳಿ. This matter is listed for admission. I heard the counsel appearing for the appellant and also the counsel for the respondent. This appeal is filed against the concurrent finding. The trial court granted the relief of partition and declaration that plaintiff is entitled for half share in the suit settled property. The main contention of the plaintiff that suit settled property is a joint family property of plaintiff and defendant and is allotted to the joint share of plaintiff and defendant and partition deed dated 2/7/1991. And also case of the plaintiff that he along with defendant is in joint possession and enjoyment of the suit settled property and the defendant took the contention that this own property and trial court taking into note of material available on record and also the pleadings framed the issues and allowed the parties and GPA holder of the defendant got examined as DW1 and produced documentary evidence exhibit D1 to 27 and on the other hand plaintiff got marked document exhibit P1 to P10. The trial court having considered both oral and documentary evidence comes to the conclusion that property belongs to both the plaintiff and defendant and answered the issue number 1 and 2 and though defendant could contend that it is a self-acquired property and the same is answered against him by particularly taking note of the admission and also the evidence available on record. In paragraph number 11, PW1 stated that site number 9 was allotted to the father of the plaintiff and defendant and which was exchanged to site number 105 and same came to be exchanged to the suit settled property. This shows that the suit settled property is the basic towards the grant of site number 9 and also taken note of exhibit D1 is the consent on the basis of which Kata came to be affected in the name of defendant as per exhibit D1 dated 5/8/1991. It is seen that plaintiff and his brothers consented for change of Kata in the name of the defendant pertaining to site number 105. Exhibit P2 is the resolution as per which site number 105 was exchanged to site number 228/17 and mutation was effected in the name of the defendant void MR number 5 of 2001-2002 dated 23/7/2012. And also exhibit D3 is the endorsement issued by the Grama Panchayat and particularly taking into note of all these materials, court comes to the conclusion that the claim of the defendant that the same is a self-acquired property is not accepted. On the other hand, trial court granted the relief of the partition and declaration declaring that the plaintiff is also entitled for half share over the property and even paragraph number 18 and 19 indicted discussed the same with regard to under exhibit P4 the plaintiff his father and Ishwarappa Satish were given shares. He admitted that suit came to be decreed on the basis of the Palupatti and considering all this material granted the relief. Being agreed by the said judgment and decree, an appeal is filed in RA number 15/21 and appellate court also considering the grounds which have been formulated the point whether the plaintiff proved that half share in Kaneshmari number 105 measuring 42 feet into 120 feet allotted to his share in Jubani Hisa Palupatti dated 2/7/1991 and subsequently said the property was got exchanged in respect of property 105 exchange with Sugar Grama Panchayat, Suguru Grama Panchayat and suit property that is Kata number 228/17 measuring 42 feet into 120 feet allotted in the name of defendant and also whether the defendant proves that suit settled property is his self-acquired property and considering the material available on record, trial court first appellate court on reappreciation of both oral and documentary evidence answered the point as affirmative and contention of the defendant is not accepted in particularly paragraph number 4. All documents were taken note of and also taken note of exhibit D1 is an unregistered document. Plaintiff has contended that D1 has been created behind his back and Kata on the basis of the said document was also created behind his back and particularly considering the admission on the part of PW1 and DW1 and exhibit D1 is an unregistered document and also Material clearly discloses that during the lifetime of Basappa Patel, partition was taken place in writing on 2/7/1990. In the said partition, properties were given to plaintiff, defendant, and other brothers Satish and Ishwarappa. And all these factors were taken note of by the first appellate court. And in paragraph number 24, considered the evidence of DW1 source that admitted the Palapatti taken place as per Exhibit P4, and in the said Palapatti site number 1 was also shown. And also with regard to the exchange of property was considered by the first appellate court. Also, the evidence of DW1 also shows that site number 9 was exchanged for site number 105 during the lifetime of Basappa Patel, and thereafter site number 105 was exchanged for site number 228/17, that is the suit property. And considering all this material comes to the conclusion that trial court has not committed any error in appreciating both oral and documentary evidence. The counsel appearing for the appellant would vehemently contend that both the courts have committed an error in granting the relief of half share in favor of the respondent, and first appellate court not justified in confirming the judgment and decree passed by the trial court without meeting the reasons given by the first appellate court, and also contend that the scope of section 96 is not exercised. And also counsel would vehemently contend that the principles enumerated under Order 2 Route 2 of Code of Civil Procedure would bar the institution of a second suit and warrant rejection of the plaintiff filed by the plaintiff oblique respondent herein OS number 129 of 2018. And both the trial court and appellate court have not considered the material on record. The counsel appearing for the respondent would vehemently contend that no dispute with regard to the relationship between the parties, and also no dispute with regard to the earlier. There was a partition and admission was also taken note of by the trial court with regard to the allotment of property as well as exchange of property, and both oral and documentary evidence was considered by the trial court and appellate court. Having considered the submission of appellant counsel and also the counsel appearing for the respondent, and particularly pleading of the plaintiff before the trial court, and specific pleading was made by the plaintiff that suit settled property belongs to the plaintiff and defendant, and particularly specific our is also made that the said property is a joint family property of plaintiff and defendant, and though defendant took the specific contention that it is his self-accord property, the trial court in paragraph number 11, 12 taken note of the fact that site number 9 was allotted to the father of the plaintiff and defendant, which was exchanged to site number 105, and same came to be exchanged to the suit settled property. Now the suit settled property is the exchange property, and also even taken note of the transfer of property in favor of the defendant with the consent, and in terms of exhibit D1 also affected the mutation in the name of the plaintiff in MR number 5 of 2001-2002 dated 27/3/2012, and both oral and documentary evidence were also considered by the trial court, and also taken note of admission on the part of DW in the cross examination in paragraph number 14, and also in paragraph number 18-19 considered oral and documentary evidence. Even first appellate court also having reassessed the material available on record, particularly in paragraph number 23 taken note of evidence that during the lifetime of Basappa Patel, partition was taken place in writing on 2/7/1991, and also taken note of document exhibit D1 is an unregistered document, and when there was an admission on the part of DW1 with regard to the Palupatti taken place as per exhibit P4, and in the said Palupatti site number 9 was also shown, and subsequently the same was got exchanged, and the same is considered by the first appellate court. And when such finding is given by the trial court as well as the first appellate court, I do not find any perversity in the said finding, and both courts taken note of question of fact and question of law, and hence not a case to invoke section 100 of CPC. In view of the discussions made up, I pass the following order. The second appeal is dismissed. Remaining saku 510 pass over ಬೇರೆ ಇದೆಯಾ ಎಲ್ಲ after winter vacation including pass ಎಲ್ಲ pass over ಎಲ್ಲ
Field number 6, my lord. Pass over matter, my lord. Is an interim order need to be
first ಒಂದ್ ಕಡೆಯಿಂದ pass over ಬನ್ನಿ ಮೇಡಮ್.
Serial number 2, my lord.
ಹಾ ಹೇಳಿ ಅಂತ
Steps to litigation.
ತಗೊಂಡಿದ್ದೀರಾ? Appellant counsel submits the steps are taken and hence issue notice against R1 and R3 ಅಷ್ಟೇನಾ? R1 and R3 ಮಾತ್ರ ಅಲ್ಲ, returnable by 19/1.
My lord, complaint, my lord, office subject.
6 ಏನು?
Office objection complaint, my lord, only sets of documents need to be produced.
Comply ಮಾಡಿದಿರಾ?
Comply ಮಾಡಿ.
Appellant counsel submits that office objection is complied and hence office is directed to verify and put.
My lord, notice is to be issued, my lord.
ಯಾರಿಗೆ?
All the respondents.
Post the matter for admission.
ಅಲ್ಲ, admit ಆಗಿದೆ ಸ್ವಾಮಿ.
Admit ಆಗಿದೆಯಾ?
Admit ಆಗಿ ಇಂಟ್ರಿ ಆರ್ಡರ್ ಇದೆ. IAS ಕಾಪೀಸ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು PF ಕೊಟ್ಟಿದ್ದೀವಿ.
IAS ಏನದು?
IA for condemnation of delay furnish ಮಾಡಿಲ್ಲ ಅಂತ.
ಸರ್ ಐಎ ಹಾಕಿದ್ದಾರೆ ಸರ್ ಅದನ್ನ.
Notice on IA na?
ನೋಟಿಸ್ ಆನ್ ಐಎ.
If complied, issue notice against the respondents.
My lord, interim order
notification ಆಗಿಲ್ಲ. Admission ಆಗಿಲ್ಲ ಅಂತಾರಲ್ರಿ.
ಬರೀ ನೋಟಿಸ್
ಮತ್ತೆ?
Notice ಆಗಿದೆ, interim order extension. Interim order granted.
Notice ಆಗಿದೆಯಾ? Issue notice ಅಷ್ಟೇ. If office objections complied, issue notice.
Draw the decree till next date of hearing ಅಂತ ಇದೆ.
The interim order granted earlier. ಅಲ್ಲ ರೀ, ನೀವು not to draw ತಗೊಂಡು ಯಾಕೆ PF ಕೊಟ್ಟಿಲ್ಲ?
ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ, IA ಮಾತ್ರ ಕೊಟ್ಟಿಲ್ಲ.
ಯಾಕೆ ಕೊಡ್ಲಿಲ್ಲ? ಎಲ್ಲಾನು ಕೊಡ್ಬೇಕಲ್ಲ. 5 sets.
By mistake it happens.
ಏನ್ ಮಿಸ್ಟೇಕ್? interim order ತಗೊಳ್ಳೋದು ಈ ಆಟ ಎಲ್ಲ ಆಡೋದಾ?
By mistake it happens.
ಮತ್ತೆ you will not extend the interim.
My lord,
you have not paid the PF properly.
PF have paid, my lord.
Proper PF ಕೊಟ್ಟಿಲ್ಲ.
Only IA
8 sets of copies ಕೊಟ್ಟಿಲ್ಲ.
My lord, only today I have furnished, my lord. Today I have furnished, my lord. Kindly apologize, it is my mistake, my lord. Kindly, my lord, it's a substantial.
If complied, issue notice. Tenable by 19(1).
My lord,
interim order granted earlier is extended till next date of hearing.
ಐಎ ಮೇಲೆ ಕಂಪ್ಲೈ ಮಾಡಿ.
ಈ ತರದೆಲ್ಲ ಗೇಮ್ ಪ್ಲಾನ್ ಮಾಡಿ ಕೊಡೋದಿಲ್ಲ, ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡೋದಿಲ್ಲ interim order. Interim order ಮಾಡಿದ ತಕ್ಷಣ you should comply. Notice ಕೊಡಬೇಕು, ಹೋಗ್ಬೇಕು, ಕಮ್ಯುನಿಕೇಟ್ ಆಗ್ಬೇಕು ಅವರಿಗೆ.
Number 8.
Appearing for appellant in this case.
ಹೇಳ್ರಿ ಏನು?
PF paid, my
First
lord.
time.
PF paid, my lord.
Counsel submits that PF paid and hence issue notice against the respondents. Written by 19(1).
My lord, the respondent number 2 filed a FDP, my lord.
ಯಾವ್ದ್ರಲ್ಲಿ? Notice overly, notice overly ಏನ್ ಮಾಡಂಗಿಲ್ಲ.
32.
Date may be fixed, my lord.
ಎಷ್ಟು 32 ನಾ?
32.
In this case, the respondent.
ಏನ್
32 I request for Monday, my lords. ಅವರು ಸೆಟಲ್ಮೆಂಟ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಸರ್, ಅದಕ್ಕೆ ವೆರಿಫೈ ಮಾಡ್ಬಿಟ್ಟು I will submit on Monday.
Petition, my lord.
ಏನ?
ಸೆಟ್ಲ್ ಆಗಿದೆ ಸರ್ ಮ್ಯಾಟ್ರಿ.
ಅಲ್ಲ ಅವ್ರು ಸೆಟ್ಲ್ ಆಗಿದೆ ಅಂತ
ಹೇಳಿ.
I will verify.
ಯಾವಾಗ ರಿಪೋರ್ಟ್?
Monday ಇಡ್ಬೋದು ಸರ್. ನಾನೇ ಕೇಳ್ಬಿಟ್ಟು ಹೇಳ್ತೇನೆ.
ಆಯ್ತು. Both counsel submit that matter is settled and hence list this
My
matter.
lords, ಅವರು ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿದ್ರು, ನಂಗೆ ಗೊತ್ತಿಲ್ಲ. I have to verify it for that purpose. ನಾನು ವೆರಿಫೈ ಮಾಡ್ಬಿಟ್ಟು ಹೇಳ್ತೇನೆ ಅಂತ.
Execution petition ಅಲ್ಲಿ ಸರ್ already we have taken the
possession ಕೊಟ್ಟಿದ್ದಾರಾ?
Possession ಕೊಟ್ಟಿದ್ದಾರೆ.
ಮತ್ತೆ ಇನ್ನೇನಿದೆ?
Verify it, my lords. I don't know. ಅವರು ಬೀಗ ತೋರಿಸಿದ್ರು.
Certified copy ಇದೆ ಸರ್.
Called on Monday, my lords.
Counsel for the respondent would submit that possession is taken in the execution petition and counsel for the
I'll
appellant.
verify it and I will submit on Monday.
Before the local adalat, my lords, matter has been settled. They are also be.
ಯಾವಾಗ ಅದು? ಲೋಕ ಅದಾಲತ್ ಅಂದ್ರೆ
16/3/2024 ಅಲ್ಲಿ.
ಮತ್ತೆ 16/3/24.
ಏನು ಹೇಳಿಲ್ಲ ಸರ್.
And hence counsel is directed to verify and submit. List this matter day after tomorrow.
Please.
Next.
35.
My lord, for the appellant.
35. ಹೇಳ್ರಿ ಏನು?
ಅದರಲ್ಲಿ ಡೈವರ್ಜೆಂಟ್ ಪೈನಿಯು ರಿಗಾರ್ಡಿಂಗ್ ಐಟಮ್ ನಂಬರ್ 5 ಪ್ರಾಪರ್ಟಿ ಬಗ್ಗೆ ಮಾತ್ರ.
ಆಯ್ತು. List this matter after winter vacation.
43.
Applying for the appellant, my lord.
43.
ಅದು ಅಷ್ಟೇನಾ?
ಆಚಾರ್ಯ.
ಏನಾಗಿದೆ ಅದು? ಇದು ಅಷ್ಟೇ. List this matter after winter vacation.
45.
After winter vacation. ಯಾರ್ಯಾರು ಪಾಸ್ ಓವರ್ ಎಲ್ಲ after winter vacation. ಪಾಸ್ ಓವರ್ ಮಾಡೋದು ರೀಚ್ ಆಗಲ್ಲ ಅಂತ. ನೆಕ್ಸ್ಟ್.
ಸರ್ ಇದೆಲ್ಲ 50.
58, 59 also after winter vacation.
58, my lords.
58 to winter vacation.
My lords, our respondent number 1.
ಏನಾಯ್ತು? 60.
My lord, 58.
58 after winter vacation.
Appeal has turned infructuous. Appeal has turned infructuous. Execution proceedings are satisfied.
They say they have taken possession in execution. That does not mean my second appeal will not become infructuous.
Lord, there was an IA which was filed in an execution petition challenging that order. My lord, RA was filed first appeal challenging that RS. This present RSA is being filed. Now the execution petition in itself is satisfied. Possession has already been taken.
Satisfied.
Even objectors application ಹಾಕಿದ್ರಾ?
Objectors.
That is rejected.
ಆಗಿಲ್ಲ ಸ್ವಾಮಿ. ಬರೀ affidavit.
Preliminary inquiry was done.
ಈ possession ಅನ್ನ ತಗೊಂಡಿದಾರಂತಲ್ಲ?
ತಗೊಂಡಿದ್ದಾರೆ.
ತಗೊಂಡಿದ್ರೆ ಏನಾಗುತ್ತೆ? ನನಗೆ if your lordship allows my second appeal, I am entitled for restitution.
After winter vacation ನೋಡಿ.
My lords, the respondent number 1 name as Padmanabh J. My lords, it may please this honorable court. 58.
ಪದ್ಮನಾಭ್ ಜೆ ಅಂತಿದೆ.
ಅದನ್ನ ಅಶ್ವಿನ್ ಜಿ ರಾಜ್ ಅಂತ ಮಾಡ್ಬೇಕು ಸ್ವಾಮಿ.
ಏಕೆ ಪದ್ಮನಾಭ್ ಅವರು ಇಲ್ವಾ?
My lords, Ashwin G. Raj is the one who is filed the wakalat.
ವಕಾಲತ್ ಯಾರು ಹಾಕಿರೋದು? ಪದ್ಮನಾಭ್
Ashwin G. Raj, no. Ashwin G. Raj, no.
ತಗೊಳ್ಳಿ. Counsel for R1 submits that wakalat is filed by Ashwin
G. Raj.
G. Raj.
Please, my lords.
And not by Padmanabha J. and wrongly shown the name of counsel Padmanabha J. And hence the registry is directed to verify and correct the same. And if submission is correct, delete the name of Padmanabha J and show the name of Ashwin G. Raj.
My lords,
For
my
R1.
lords, if my lords may permit me, my lords, connected matter.
ಯಾವ್ದ್ರಲ್ಲಿ?
Idralle, connected matter, there, it was listed last week, my lords. Your lordship were about to dismiss that petition, my lords, and withdrawal memo was filed as a appeal has turned infraction. My lords may permit me, I'll just.
ಈಗ withdraw ಮಾಡಿದಾರ ಅವರು?
ಮಾಡಿದ್ದಾರೆ. Connected matter has been withdrawn. This matter has to be, my lord.
ಆಯ್ತು, ನೆಕ್ಸ್ಟ್ ವಿಂಟರ್ ವೆಕೇಶನ್ ಬಂದಾಗ ಕೊಡಿ ಅದನ್ನ.
Very well, very well.
ಆಯ್ತು. 60, ಏನಾಯ್ತು?
They have sent me the, yesterday night, they have sent me the schedules. 10 days.
10 days ಇಲ್ರಿ, ವೆಕೇಶನ್ ಇರೋದು ಬರೀ ಇನ್ನು ಇರೋದೇ ಒಂದು ವಾರ. ಮಾಡಿ ಅದನ್ನು ಮಾಡಿ ರಿಪೋರ್ಟ್ ಮಾಡಿ. ಯಾವಾಗ? ನೆಕ್ಸ್ಟ್ ವೆಡ್ನೆಸ್ಡೇ. Third, appellant counsel submits that almost matter is settled and going to settle only in respect of one of the party and going to file compromise petition on yavat madam 15/12 next Wednesday 18/12.
62 final disposal matter. Particular
ಎಲ್ಲ after winter vacation.
Date may kindly be given, my lord.
ಯಾವ್ದಾರು ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಹೇಳಿ.
76 ಮಾಡ್ದಾಗ
ಇಲ್ಲ ನಾನೇ ಕರ್ದು ಬಿಡ್ತೀನಿ. 62.
Yes, my lord.
ಏನದು?
Matter involves urgency, revocation, probate.
ಅರ್ಜೆನ್ಸಿ ಎಲ್ಲ after winter vacation.
Date on court please.
ನಾನು ಡೇಟ್ ಕೊಡಲ್ಲ. ನೆಕ್ಸ್ಟ್ ರೋಸ್ಟರ್ ಜಡ್ಜ್ಗೆ ಮೂವ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅಲ್ಲಿ ಆ ಕೋರ್ಟ್ ಅಲ್ಲಿ. ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಯಾರು ರೋಸ್ಟರ್ ಜಡ್ಜ್ ಬರ್ತಾರೋ, ನಾನೇ ಬಂದ್ರೆ ನಾನು ಮುಂದೆ ಮೂವ್ ಮಾಡಿ ಕನ್ಸಿಡರ್ ಮಾಡ್ತೀನಿ. ಯಾಕೆಂದ್ರೆ ಇಲ್ಲಿ RS ಗೆ ನಾನು ಒಬ್ಬನೇ ಇರೋನು, ಅದಕ್ಕೇನೆ ಅಡ್ಮಿಷನ್ಸ್ ಎಲ್ಲ ಡಿಸ್ಪೋಸಲ್ ಮಾಡಕ್ಕೆ. ಎಲ್ಲರಿಗೂ WP-ನೇ ಬೇಕು, ನಾವೇನ್ ಮಾಡೋಣ? ಎಲ್ಲ ಮೊನ್ನೆಲ್ಲ ಪೇಪರ್ಲು ನೋಡಿದೆ, ಯಾರೋ 20,000 30,000 ಅಂತ ಏನೇನಾಯ್ತು. ಅದಕ್ಕೆ ಹೇಳಿಸ್ಬೇಕು, ಅವ್ರಿಗೆ ಕೂರ್ಸ್ಬೇಕು ಅಂತಿದ್ದ RS RF ಅಂಡ್ ಕ್ರಿಮಿನಲ್ ಅಪೀಲು ಅಂತಕ್ಕೆಲ್ಲ ಕುತ್ಕೋಬೇಕು.
63 ಮಲಾಟ್ಸ್ ಫಾರ್ ಅಪೆಲೆಂಟ್ ಮಲಾಟ್ಸ್ ಅದರಲ್ಲಿ NOC ವಕೀಲರನ್ನ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ. ಸುಹಾಸ್ ಜಿ ಅಂತ ನೇಮ್ ಬರ್ಬೇಕು. ದಿವ್ಯಾ ಕೆ ಅಂತ
ಎಲ್ಲಿದೆ? ಸುಹಾಸ್ ಜಿ ನ 63 ನಲ್ಲಿ ಯಾವ್ದು ಕನೆಕ್ಟೆಡ್ ಅಲ್ಲ?
ಕನೆಕ್ಟೆಡ್ 3 ಇದೆ.
ಫಾರ್ ದ ಕ್ರಾಸ್ ಸಬ್ಜೆಕ್ಟರ್ ಮಲಾಟ್ಸ್
ನಿನ್ನೆ NOC ವಕೀಲರನ್ನ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ.
ಯಾವ್ದ್ರಲ್ಲಿ
ಸರ್ ದಿವ್ಯಾ ಕೃಷ್ಣ ಅಂತ ಇದೆಯಲ್ಲ, ಅವರು ಇರ್ತಾರೆ NOC ಹಾಕಿದ್ದಾರೆ ಅಂತ.
ಯಾರು ಹಾಕಿರೋದು NOC?
ನಾನು NOC ವಕೀಲರನ್ನ
ಪುಟಪ್ಪ ಆಗಿಲ್ಲಲ್ಲ ಇನ್ನೂ.
ನಿನ್ನೆ
ಹಾಕಿರ್ ಪುಟಪ್ಪ ಬೇಕು. ಓ, ಹೈಕೋರ್ಟ್ ಅಷ್ಟೊಂದು ಫಾಸ್ಟ್ ಆಗಿದೆ ಅಂತ ಅಂದ್ಕೊಟ್ಟಿದ್ದೀರಾ? ಬರ್ಲಿ ಬಂದಾಗ ನೋಡಿ. ಲಿಸ್ಟ್ ಮಾಡ್ರೆ ಆಫ್ಟರ್ ವಿಂಟರ್ ವೆಕೇಶನ್. ಆವಾಗ್ಲೂ ಬಂದಿಲ್ಲ ಅಂದ್ರೆ ಮೆನ್ಷನ್ ಮಾಡಿ. 64 ಆಫ್ಟರ್ ವಿಂಟರ್ ವೆಕೇಶನ್ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಏನಾರು ಇದ್ರೆ ಮೆನ್ಷನ್ ಮಾಡಿ. ಬಟ್ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಆಲ್ರೆಡಿ ಇದೆಯಾ? ಆಯ್ತು. ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಂತ ಇಲ್ಲಲ್ಲ? ಆಯ್ತು. ನೆಕ್ಸ್ಟ್ 65 ನಾಗರತ್ನ SK ಆಫ್ಟರ್ ವಿಂಟರ್ ವೆಕೇಶನ್.
66 Hangamesh RV
after winter vacation. 67 after winter vacation.
I filed an application for extension of interim order of stay.
ಹಾಕಿದೀರಾ? ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಆಗಿತ್ತಾ? ಯಾವಾಗ ಅದು ಕೊಡ್ಲಿಲ್ಲ? ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಗ್ಲಿಲ್ಲ? ಎಷ್ಟು ಡೇಟ್ ಅಲ್ಲಿ ಆಗಿಲ್ಲ?
I think
ಹೇಳಿದಿರಾ ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ಹೋಗ್ಲಿ?
application ಅಲ್ಲಿ
ನೋಡಿ ಮೇಡಮ್, ಆರ್ಡರ್ ಶೀಟ್ ನೋಡ್ರಿ ಇದೆಯಾ? ಎಲ್ಲ ತರಬೇಕಾ? ಆಯ್ತು. ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಗ್ರಾಂಟೆಡ್ ಅರ್ಲಿಯರ್ ಇಸ್ ಎಕ್ಸ್ಟೆಂಡೆಡ್ ಟಿಲ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್. ನೋಡಿ, ಏನಾದ್ರು 3-4 ಸರಿ ಆಗಿದ್ರೆ ಅದೊಂದ್ಸರಿ ನೋಡ್ಬಿಡಿ. 3-4 ಸರಿ ಆದ್ರೆ ಅದರ್ ಸೈಡ್ ಹಿಯರ್ ಮಾಡ್ದಲ್ಲೇ ಮಾಡಲ್ಲ. ಒಂದ್ಸರಿ ಏನಾದ್ರು ಮಿಸ್ ಆಗಿದ್ರೆ ಅಥವಾ 2 ಸರಿ ಮಿಸ್ ಆಗಿದ್ರೆ ಮಾಡ್ತೀನಿ. ಆಯ್ತಾ?
application file ಮಾಡಿದ್ರು 24/9/2025.
ಅಯ್ಯ ಹಾಕಿದಾರೆ ಮೇಡಮ್, ಎಷ್ಟು ಸರಿ ಆಗಿಲ್ಲ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಅಂತ ನೋಡಿ ಅಂತ ಹೇಳಿದೆ. ಆಯ್ತು.
ಬಂದಾಗ್ಲೂ ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡಿ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ತಗೊಂಡು ಹೋಗ್ತಿದ್ರು ಅವರು. ಅದೇನು ಮಾಡಕ್ಕಾಗಲ್ಲ. ಆಯ್ತು.
ಅದರ್ ಸೈಡ್ ಹೇಳಿದೀನಿ ಅಂತ.
They are aware of it.
ಆಯ್ತು ತಗೊಳ್ಳಿ. 68 ಯಾವ್ದ್ರಲ್ಲಿ ಇದೆ? ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆಂಡೆಡ್ ಲಿಸ್ಟ್ ಆಫ್ಟರ್ ವಿಂಟರ್ ವೆಕೇಶನ್. ಕೃಷ್ಣಮೂರ್ತಿ ಹಾಸ್ಯಗಾರ್.
Please, ma'am, I am for the appellant.
After winter vacation.
70.
70 ಅಲ್ಲಿ ಒಂದು ಸ್ಮಾಲ್ ಸಬ್ಮಿಷನ್
ಹೇಳಿ.
70 ಅಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಸ್ಟೇ ಆದ್ಮೇಲೆ ಅವ್ರ ಪೇಪರ್ ಬುಕ್ಸ್ ಹಾಕ್ಲಿಲ್ಲ. ಪೇಪರ್ ಬುಕ್ಸ್ ಆದ್ಮೇಲೆ ಆಫೀಸ್ ಅಪ್ಲಿಕೇಶನ್ಸ್ ಕಂಪ್ಲೀಟ್
ಹಾಕಿದೀವಿ ಮೇಡಮ್. only 2 pages printing ಅಲ್ಲಿ ಮಿಸ್ ಆಗಿದೆ ಲಾಟ್. ಅದು ಸ್ಟಿಕ್ ಮಾಡಕ್ಕೆ ಅದು
ಮಿಸ್ ಯಾಕೆ ಮಾಡಿದ್ರಿ? ಉದ್ದೇಶಪೂರ್ವಕವಾಗಿ ಮಾಡ್ತಾ ಇದ್ರಿ ಅಂತ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ತಗೊಂಡ್ಮೇಲೆ
genealogical fee
ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ.
Yes my lord.
ಇಲ್ಲ ಸ್ವಾಮಿ ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ದಯವಿಟ್ಟು
ಕಂತ
dismiss
ಇಲ್ಲ, ಸರಿ ಇಲ್ಲ, ಅಟೆಂಡ್ ಮಾಡಿ ಒಂದ್ ವಾರ ಟೈಮ್ ಕೊಡ್ತೀನಿ.
Yes, my lord.
Appellant paper book already filed, but there is a objections by the office and hence given 1 week time to comply with office objections on the paper book.
ಲಾಸ್ಟ್ ವೀಕ್ ಕೊಟ್ಟಿದ್ರು ಸ್ವಾಮಿ, ಅವ್ರು ಬೇಕಾದ ಇಂಟೆನ್ಷನಲ್ ಆಗಿ ಇದು ಮಾಡ್ತಾರೆ.
ಅದು
ಮಾಡ್ಲಿಲ್ಲ
ಹಂಗೆ
ಅಂದ್ರೆ dismiss
ಮಾಡಿದಾರಾ?
ಮಾಡ್ಸಿ ದಯವಿಟ್ಟು.
ಹಿಂದಿನ ಸರಿ ಇದೆಯಾ ಮೇಡಮ್?
ಹೌದು
ಪೇಪರ್ ಬುಕ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆಯಾ ಮೇಡಮ್?
ಇದೆ ಸ್ವಾಮಿ, ಫೈಲ್ ಮಾಡಿದಾಗಿಂದಾನು ಇದೆ ಸ್ವಾಮಿ.
ಬಂದಿಲ್ಲ my lord, register ಮುಂದೆ ಬಂದಿಲ್ಲ.
ಕೊಡಿ ರಿಜಿಸ್ಟರ್ ಅಲ್ಲ, ನಮ್ಮ ಮುಂದೆನೆ ಬಂದಿದೆ.
ಕೋರ್ಟ್ ಮುಂದೆನೆ ಬಂದಿದೆ ಅಮ್ಮ.
ನಮ್ಮ ಮುಂದೆ ಬಂದ್ರೆ ನೀವು ಕಂಪ್ಲೈ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಇವತ್ತು ಕಾಸ್ಟ್ ಹಾಕ್ತೀನಿ.
Senior designated advocate ಮಾಡೋ
ನನಗೆ ಗೊತ್ತಿಲ್ಲ, ಕಾಸ್ಟ್ ಹಾಕ್ತೀನಿ ಇನ್ ಕೇಸ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಅರ್ಲಿಯರ್ ಆರ್ಡರ್
ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ ದಯವಿಟ್ಟು.
ಓದ್ಸೋದೇನು ಸೇಮಾ? ಕೊಡಿ.
ಹೌದು ಸ್ವಾಮಿ, ಹೌದು
ಕೊಡಿ.
1 ವೀಕ್ ಟೈಮ್ ಕೊಟ್ಟಿದ್ರು ಸ್ವಾಮಿ, ಮಾಡಿಲ್ಲ ಅವ್ರು.
ಇಲ್ಲ my lord, change ಇದೆ.
In spite of this court given time to comply with objections with regard to the paper book on 24/11/25 till date not complied, and hence on cost of rupees 1,000 another 1 week time granted to comply with the same. List this matter on 18/12
please.
71 R Gopal, ಎಲ್ಲ approve intervacation. 72 also
73
same, ಎಲ್ಲ intervacation. 73 74
entry ಮಾಡಿ.
ಏನ entry ಮಾಡಿದ್ಯಾ? 74 entry ಮಾಡೋ granted earlier is extended till next date of hearing. ಜೆ ಕೀರ್ತಿ entry ಮಾಡಿದ್ಯಾ?
ಡೇಟ್ ಮೇ ಬಿ ಫಿಕ್ಸ್.
ಡೇಟ್ ನಾನು ಫಿಕ್ಸ್ ಮಾಡಕ್ ಆಲ್ರಿ, ನೆಕ್ಸ್ಟ್ ಬಂದಾಗ ಕೇಳ್ಕೊಳ್ಳಿ. ಪ್ರತಿ ಸರಿ ಎಷ್ಟು ಸರಿ ಹೇಳಿ, ನಾನು 5:15 ಆಯ್ತು, ಮಧ್ಯಾಹ್ನ 2 ಗಂಟೆವರೆಗೆ ಕೂತ್ ಮಾಡಿದೀನಿ. ಆವಾಗ ಅರ್ಧ ಗಂಟೆ, ಇವಾಗ ಅರ್ಧ ಗಂಟೆ, ಮತ್ತೆ ಈಗ ಬೇರೆ ಸಾಟರ್ಡೇನು ಕೂತ್ಕೊಳ್ಳಿ ಅಂತ. ಹಾ 75 ಎಂಟ್ರಿ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಆಫ್ಟರ್ 76
ಅಲ್ಲಿ
ಆಫ್ಟರ್ ವಿಂಟರ್
76 ಎಂಟ್ರಿ
ಮಾಡಿದ್ಯಾ?
ಪ್ಲೀಸ್
ಎಂಟ್ರಿ ಮಾಡ್ರೆ granted extended till next date of hearing.
ಪ್ಲೀಸ್
ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಎಲ್ಲ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿರ್ತೀವಲ್ಲ ಮೇಡಮ್, ಅವೆಲ್ಲ ಡೇಟ್ಸ್ ಕೊಡಿ, ಮುಂದಿನ ಡೇಟ್ಸ್. ಇಲ್ಲ ಅಂದ್ರೆ ಫೈಲೇ ಬರಲ್ಲ, ಹಂಗೆ ಎತ್ಸಿಟ್ಬಿಡ್ತಾರೆ. ಯಾವ್ದಾವ್ದು ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿದೀವಿ ಅವಕ್ಕೆಲ್ಲ ಡೇಟ್ ಕೊಡಿ.
19th
ಇಲ್ಲ ಅಂದ್ರೆ ಫೈಲೇ ಬರಲ್ಲ ಕೋರ್ಟಿಗೆ.
ಸರ್ ನೀವು ಅದು ಹೇಳಿದ್ರಲ್ಲ ಸರ್.
ಹ್ಮ್ ಹ್ಮ್
2823
ಹ್ಮ್ ಇದಾರ ಅವರು ಇದಾರ? ಆಯ್ತು, ಅವ್ರು ಬಂದು ತಕರಾರು ಹಾಕ್ತಿರ್ಬೇಕು. ಆಯ್ತು, ಅಲೌಡ್ ಅಂತ ಹೇಳ್ಬಿಡಿ, ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿ. ಯಾಕೆಂದ್ರೆ ಅವ್ರು ಬಂದಿಲ್ಲ, ಇದ್ದು ಇಲ್ಲ, ತೊಗೊಳ್ಳಿ. ಅದ್ರಲ್ಲಿ ಹಾಕೋಬೇಡಿ. ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ಅಪ್ಲೆಂಟ್ ಫೈಲ್ಸ್ ಅನ್ ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಎಂಟ್ರಿ ಮಾಡರ್ ಅಂಡ್ ಕೌನ್ಸಿಲ್ ಅಪಿಯರಿಂಗ್ ಕಾಪಿ ಸರ್ವ್ ಮಾಡೋರು ನೋಡಿ. ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್
ಮಾಡಿದ್ದಾರೆ, ಇಮೇಲ್ ಅಲ್ಲಿ ಮಾಡಿದೀನಿ.
is served the application through email and counsel for the respondent is absent and hence interim order granted earlier is extended till next date of hearing ಅಂತ ಮಾಡಿ ಡೇಟ್ ಕೊಡಿ. ಎಲ್ಲ 19 ಜಾಸ್ತಿ ಆಗ್ಬಿಟ್ವೇನಪ್ಪ, ಬೇರೆ ದಿವಸ ಕೊಡ್ತೀರಾ ನೋಡಿ.
ಅದೇ ಸರ್, ಎಲ್ಲ 18 19 ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಎಲ್ಲಾನು ಜಾಸ್ತಿ.
ಆಯ್ತು, 19 ಕೊಟ್ಟಿರಿ, ಆಮೇಲೆ ನೋಡ್ಕೊಳ್ಳಿ ಅವ್ರು ಬಂದು.
ಕೋರ್ಟ್ ಆಫೀಸರ್ 68 ಸೀರಿಯಲ್ ನಂಬರ್ ಏನಾಯ್ತು?
67 ಅಲ್ಲಿ ಒಂದು ನಿಮಿಷ ಇರುತ್ತೆ. ಅಲ್ಲ, ಡಿಸ್ಪೋಸ್ ಇದಾಗಿ ಇಂಟ್ರಿ ಮಾಡ್ರಿ ಎಕ್ಸ್ಟೆನ್ಷನ್ಗೆ. 68 ನೀವು ಬರ್ದಿ ಕೊಟ್ಟಿದ್ರಲ್ಲ ಸರ್.
68 ಗೆ
19/1 ಒಂದು ನಿಮಿಷ ಇರಮ್ಮ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ 68 ಗೆ
ಡೇಟ್ ಆಫ್ ಫೈಲಿಂಗ್ ಗೊತ್ತಾಯ್ತು. ಆಫೀಸ್ ಸರ್ಡ್ ಅಂತ ಇದೆ.
ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ 68 ಏನಾಯ್ತು
ಹೇಳಿ?
68 ಮೇಡಮ್.
ಸರ್ಡ್ ಅಷ್ಟೇ ಕಣ, ಅದು ಇಮೇಲ್ ಅಲ್ಲ. ಇಮೇಲ್ ಇರೋದು ಅಫಿಡವಿಟ್ಗೆ ಇಮೇಲ್ ಅಂತ ಹಾಕಿದ್ದಾರೆ. ಇದಕ್ಕೆ ಸರ್ಡ್ ಅಷ್ಟೇ. ಸರ್ಡ್
ಅದು ಇಮೇಲ್ ಬಿಡ್ವಾ?
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಹೇಳಿ
ಮೇಡಮ್, ಇದು 68 ಆಫ್ಟರ್ ವಿಂಟರ್ ವೆಕೇಶನ್.
ಆಫ್ಟರ್ ವಿಂಟರ್ ವೆಕೇಶನ್ ಅಲ್ಲ, 19/1/26 ಅದು ಇಂಟ್ರಿ ಆರ್ಡರ್ ಇದೆಯಲ್ಲ ಸರ್.
19/1.
ಓಕೆ,
ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್.
ಮೇಡಮ್ ಇದು ಇಂಟ್ರಿ ಮಾಡೋಣ ಒಂದೊಂದು ನೀವು ಹೇಳಿಲ್ಲ ಒಂದೊಂದು ಇವಾಗ ಇಲ್ಲ ಅಂತ
ಇಲ್ಲಮ್ಮ ಯಾವ್ದ್ರಲ್ಲೂ ಇಲ್ಲ ನಾವ್ ಹೇಳಿದ್ರಲ್ಲಿ ಬಿಟ್ರೆ ಇನ್ಯಾವ್ದು ಹೇಳಿಲ್ಲ.
ಎಕ್ಸ್ಟೆನ್ಷನ್ ಒಂದೇ ಹೇಳಿ.
74, 76 ಅಲ್ಲಿ ಬಿಟ್ರೆ ಇನ್ಯಾವ್ದ್ರಲ್ಲೂ ಹೇಳಿಲ್ಲ. ಕರೆಕ್ಟ್.
ಎಕ್ಸ್ಟೆನ್ಷನ್
ಎಕ್ಸ್ಟೆನ್ಷನ್ ಒಂದು 67 ಅಲ್ಲಿ ಹೇಳಿದ್ರು, ಯಾಕಂದ್ರೆ ಅವ್ರು ಆಗಿರ್ಲಿಲ್ಲ, ಇವಾಗ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡಿದ್ದಾರೆ.
ನೀವು ನೋಡಿದ್ರೆ ಅದು ಇದೆಯಾ ಮತ್ತೆ ಅದ್ರಲ್ಲಿ
ಇಲ್ಲ 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 ಇಲ್ಲ
ವಾಪಸ್ ಕೊಟ್ಟು
ಇಲ್ಲ ವಾಪಸ್ ಕೊಟ್ಟೆ ನಾನು. ಲಾಸ್ಟ್ ಮೂಮೆಂಟ್ ಹಿಂಗೆ ಮಾಡ್ತಾರೆ. ಯಾವ್ದಮ್ಮ?
ಹೇಳ್ಬಿಟ್ಟು ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು.
70
68 ಅಲ್ಲಿ 70
70 ಇಲ್ಲ ಅಂತ ವಾಪಸ್ ಕೊಟ್ಟಿದ್ದು.
70
ಇಲ್ಲ ಇಸ್ಕೊಂಡಲ್ಲ 70 ಅಂತ ಹೇಳ್ಬಿಟ್ಟು.
ನೀನು ಕನ್ಫ್ಯೂಸ್
70
ಮಾಡ್ಕೊಂಡ ಯಾವ್ಯಾವ್ದು
ಓಕೆ
ಗೊತ್ತಾ?
70 ಓಕೆ ಓಕೆ
ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್
70
ಮಾಡ್ಕೊಂಡಿದ್ಯಾ?
ತೆಗೆದ್ವಿ. ಪೇಪರ್ ಬುಕ್ ಗೆ 1 ವೀಕ್ ಟೈಮ್
ಅಷ್ಟೇ.
ಅದೇ
ಆಯ್ತಲ್ವಾ? ಇಲ್ಲ ಕಣೆ, ಇವಾಗ ಎತ್ತಿರೋದು ಈಗ ಹೊರಗೋದ್ರು. ಹೋಗು, ನಾಳೆ ಸಿಗ್ತೀನಿ.
ಮೇಡಮ್ 69ರಲ್ಲಿ ಡೇಟ್ ಏನು ಕೊಟ್ಟಿಲ್ಲಲ್ಲ?
ಇಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ.
ಓಕೆ ಥ್ಯಾಂಕ್ ಯು.
ಓಕೆ.